we'll go through it multiple rounds. In the first round, we'll understand at superficial level. In the next round, we'll go to the deeper levels and so on. Okay, and so on. So in the first go, what we'll understand here is which are the 6 fundamental rights, or how many fundamental rights are there basically. So basically there are 6 fundamental rights. Okay, basically there are 6 fundamental rights. 6 fundamental rights. So probably in our high school days and primary days also we have learnt about the fundamental rights, but the extent to which we used to learn in our high school days and now it will be different. Okay, it will be different. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. So these are the 6 fundamental rights. Okay, these are the 6 fundamental rights. Now, right to equality, article number 14 to 18, they deal with right to equality. Right to equality. Article number 19 to 22 deal with right to freedom. Article number 23 to 24, they deal with right against exploitation. Article number 25 and 25 to 28 deal with right to freedom of religion. Okay, you should not get confused here. Okay, because here it is freedom of religion, it is just plain freedom. Right to freedom of religion. Okay, religion. Cultural and educational rights, article number 29 and 30. Right to constitutional remedies, article number 32. Okay, 32. So in the first round, what you should be able to tell is, if I ask you about right to equality, range of articles.
14 to 18.
14 to 18. Next, right to freedom.
19 to 22.
19 to 22. Right against exploitation.
23, 24.
24. Right to freedom of religion.
25,
25 to
28.
28. Next, cultural and educational rights. 29 and 30. Right to constitutional remedies. 32. So this will be the first round. Okay, this will be the first round. So originally in 1950, when Constitution came into force, there was also one more right called as right to property. Okay, right to property. It was also a fundamental right. It was also a fundamental right. But now, right to property is not a fundamental right. So what is right to property? Why it is not a fundamental right? Again, detailed discussion. We will be doing it later on. But for time being, we shall understand that right to property, originally it was a fundamental right. Now it is not a fundamental right. Okay, but whether it is present in the Constitution, yes. So was deleted from the list of fundamental rights by 44th amendment. So this 44th amendment you should know. Okay, through which amendment right to property was deleted as a fundamental right. Article number, amendment 44. Okay, in 1978. So it is made a legal right under Article 300A in Part 12. It means presently if you want to read about right to property, so where we can find?
Legal right.
Article number 300A, in which part?
12.
Part 12. Okay, part 12. Now we have already become aware of few of the parts. So part 1 deals with Union and its states. Part 2 deals with citizenship. Part 3 deals with fundamental rights. Part 4 deals with DPSP. Part 4A deals with fundamental duties. Okay, one by one we shall start connecting the dots. Okay, dots. So right to property is present in which part?
12.
Part 12. Which article?
300A.
300A. Whether right to property is a fundamental right?
No.
No. So whether it is present in the Constitution?
Yes.
Yes. So whenever some rights which are present in the Constitution and they are not present in the article number 12 to 35, we call them as what? Legal right, and we also call it by an alternative name called as constitutional right. So these are the most confusing things. Okay. So whether fundamental rights are constitutional rights? Yes, because fundamental rights are part of the Constitution. Whether all constitutional rights are fundamental rights?
No.
No. Okay. So there are some constitutional rights which are not fundamental. Example, right to property. Because right to property is present in the Constitution, but it is not a fundamental right. Okay. So this right which is present in the Constitution but not as part of the fundamental rights, it is also called by an alternative name called as legal right. Okay, legal right. So all the fundamental rights, they broadly fall under constitutional right. They also broadly fall under legal right. Okay, but right to property, it is not a fundamental right, it's a constitutional right. Okay, it can also be called as a legal right. On top of this, again, if you have some kind of confusions, you will suppress those confusions. You will not try to explore more about these things. So, okay, legal right, constitutional right, those who want to become a constitutional expert, those who want to argue in the Supreme Court or High Court in some cases, so they need to have a deeper understanding. Here what we are expected to become, we are expected to become jack of all the subjects. Okay, ultimately we want to crack the examination. So here we need to know where we have to stop. Sometimes what happens, we will not be able to understand some concepts completely. At a superficial level we will be able to understand. It is not that we will not be able to understand at a deeper level, we will be. But if we spend time in understanding at a deeper level, then other parts of the subject, they will get compromised. Other subjects, they will get compromised, and at the time of the examination we will not be able to revise. Okay, revise. Hence we will stop here itself. So right to property is a fundamental right?
No.
No. Right to property is a constitutional right?
Yes.
Yes. Right to property is a legal right?
Yes.
Yes. Okay, yes. So that much information would be sufficient. Some of the features of fundamental rights. Okay, features of fundamental rights. Some fundamental rights are applicable only to citizens. Only to citizens of India. Some to all persons, whether they are citizens of India or foreigners, okay, or legal persons like companies. Okay, some rights, they not only extend to an individual, they also extend to a company. For example, Infosys, TCS, LIC, all their companies, right? So they too have rights. So some are individual rights, some are organizational rights. Some are applicable only to Indians, some are applicable to Indians as well as foreigners. Okay, foreigners. Not absolute. Okay. So yesterday we discussed, again we will be discussing, for example, article number 19, right to freedom of speech and expression. So by using this right, so whatever opinion gets generated in my mind, so whether I will deliver, okay, you can, but there are some restrictions. Okay, there are some restrictions. If you feel like using an abusive word against others, you cannot use it. Okay, because there are certain restrictions. So none of the fundamental rights are absolute. They are not absolute. For every fundamental right, there is a restriction, and this restriction should be reasonable. It should be reasonable. Okay, reasonable. So whether the restriction is reasonable or not, who is going to decide it?
Court.
Decided by courts. Okay, courts. Now, for example, if we take right to freedom of speech and expression itself, someone says that, okay, you cannot use abusive words against others. So can it be considered as a reasonable restriction? Yes. Whatever the mistake the government commits, you should just close your eyes. You should never criticize the government. Can it be considered as a reasonable restriction?
No.
No. Now, which one should be considered as a reasonable restriction? Who is going to decide it?
Courts.
Courts are going to decide whether the restriction imposed is reasonable or not. Okay, reasonable or not. Next, why we require reasonable restrictions? Why we require reasonable restrictions? To strike a balance between the rights of individuals and society as a whole. Okay, society as a whole. Now, sometimes the rights of an individual will collide with the rights of the society. Okay, rights of the society. Now I will say, it's my wish. It's my wish, I will wear whatever dress I like. Okay, you and I will roam naked in the Vidyagiri states. Okay, so this is my right. We cannot claim that because we also have a larger society. We also have a larger society. So here, both of them, they will clash. Hence, we require reasonable restrictions. Okay, we can claim we can have reasonable restrictions. So there are somewhat, for example, coastal areas where there are no places, where there are no people residing. In such places, you can enjoy like anything. But where civilized society exists, so whenever you are exhibiting your right, so there should be reasonable restriction. I just gave you an example. Why? To balance the rights of individuals and the rights of the society as a whole. Okay, rights of society as a whole. Between individual liberty and social control. Okay, social control again. If you start using abusive words in the public, okay, so public might become angry and it might lead to clashes and all. So to maintain that social order control, we require reasonable restrictions. Okay, reasonable restrictions. Again, the examination, they are not going to ask such kind of questions. At a superficial level, we need to know that yes, whether fundamental rights are absolute. No, they are not absolute. So there are reasonable restrictions. In the mains, we have to quote Why reasonable restrictions are required? Because to strike a balance between individuals' rights and rights of the society. To strike a balance between individual liberty and social control. Okay, individual liberty and social control. So liberty means freedom. Okay, freedom. Some are available against arbitrary actions of the state. Some against state action and against private individuals. Okay, against private individuals. So here state means
Government.
we are speaking about government. Okay, some action against state and some against private individuals. Okay, private individuals. Now, for example, next we will be discussing about article number 15 and 16, right to equality. Okay, right to equality. In that equality sense, we come across a concept called as somewhere reservation. Okay, reservation. Now, whether the provision of reservation in India exists only in the government sector or also in the private sector? Only in the government sector. Governmental sector. Now, someone, if he goes and files a case in the Supreme Court, saying that when I was joining Infosys or TCS, they did not consider the reservation criteria and they did not hire me. Okay. So, whether such kind of right he claim against Infosys or TCS?
No.
They are private companies. Okay, they are private companies. So, if in the government recruitment, when government is recruiting for UPSC or KPSC or any other examination, if they do not make any kind of provision for reservation, can he go and file a case against the government? Yes, because it is constitutionally mandated that there should be a reservation for scheduled caste, scheduled tribe, or women. So all these things, whatever reservations are there, so he can go and file a case in the court. Okay. So here what we understood is reservation is a right which a person can claim only in government jobs. He cannot claim reservation in private jobs. So it means this is a right which are available only against state. Okay. So arbitrary action, I will just take this example. In the notification, government will not make any kind of reservation provisions. So that is the arbitrary action of the government. Means whatever it feels, as per its whims and fancies, it is releasing the notification. But as per the constitution, it has to include the provisions of reservation. So and so seats are reserved for scheduled caste, so and so seats are reserved for scheduled tribe, so and so seats are reserved for OBC. So without such kind of taking all those things into account, if it releases a notification, then it will be considered as arbitrary action of the state, arbitrary action of the government. At that time, what you can do, an individual can file a case against the government. But an individual, can he file a case against the Infosys or TCS, any private company? No. Okay. It means this is an example of a right which is available only against the state and not against the private entity. Okay, not against the private entity. Some against state action and against private individuals. Okay, private individuals. So we shall take an example. Now you will take train as an example and a hotel as an example. Okay, train. So train, whether it belongs to government or it belongs to private entity?
Government.
It's a government entity. So if we take any of the hotels in the Vidyagiri, so they are all
Private entity.
okay, private entities. Now tomorrow when someone is traveling in the train, so let's assume a ticket clerk will come and he'll ask for his religion or caste. Oh, you belong to so and so caste, so and so religion, you are not supposed to board the train. You please get out of the train. Okay. If someone does it, can he go and file a case against the TT? When he files a case against the TT, whether it will be against an individual or against the government?
Individual.
It will be against the government, because TT is a government representative. When you are filing a case, it will be against the government, not against the TT, because you are discriminating. Okay, you are discriminating. So we have article number 16, discrimination related article is there. Again we will be discussing. Now similarly, let's assume you will go to one of the hotels in Vidyagiri. So as soon as you go, he will ask your name. So based on your name itself, he will come to a conclusion to which caste you belong. So he will say, so such caste people are not allowed in our hotel. Okay, he is discriminating. Can you file a case against him? Yes. Okay, you can file a case against him. So this discrimination, even though he is private party, can you file a case against him? Yes. So some rights, they are not only available against the state, they are also available against the state, private party. Okay, private party. So which rights are available against the state? Which rights are available against both state as well as private entity? That we will be discussing in detail. Okay, in detail. But here what we understood, in the forthcoming discussions, the articles which follow, few of the fundamental rights are available only against state, few of the fundamental rights are available against both state as well as against the private entity. Okay, against the private entity. Okay, private entity. Okay. Rights available against state's action violated by private individuals. No constitutional remedies, ordinary legal remedies. So now we will not understand here because we need to discuss about the article number 32. 32 called as right to constitutional remedies. Okay, right to constitutional remedies. Now, for example, I took the example of what hotel in Vidyagiri. If you go, okay, and let's assume you belong to scheduled caste or scheduled tribe, and the owner of the hotel will not allow you, saying that you belong to scheduled caste, you are not allowed to enter the hotel. Now you will go and file a case against him. Now question is whether you can go and file the case directly in Supreme Court and High Court, or you can also go and file a case in the ordinary Taluk Court and District Court. Okay. Now when we start discussing about article number 32, okay, that is right to constitutional remedies. Okay, right to constitutional remedies. So directly we can go to Supreme Court and High Court. But here in case of this discrimination based on caste, there is a separate law for it. That is SC/ST Atrocities Act. So under that act, what he can do, he can file a case in the police station. Then the case will be taken to Taluk Court and all. Okay. So there is a slight difference. So now at this point, we will not go into those deeper aspects. Okay. For time being, we will not understand this statement completely. Once we discuss about article number 32, then we will get a clear picture. Okay. We will get a clear picture. Okay. Some are negative in character. Some are positive in character. Some fundamental rights are negative, some fundamental rights are positive. Now what do we understand by the term negative here? While discussing about a topic called as parliament, at the conclusion we discussed some points, okay, which are the factors which limit the sovereignty of parliament. Can parliament make any laws as per its whims and fancies? Whatever comes to its mind, can it make such kind of laws?
No.
There are some limiting factors, right? Which are those limitations?
Motion adjournment.
Yes, fundamental rights, written nature of the constitution, federal system. So these are the limitations. So there we heard that fundamental rights act as a limitation. Fundamental rights act as a limitation. Now one of the fundamental rights says that right to freedom of speech and expression. Whatever comes to your mind, you have that right to express it. So let's take an example of a newspaper, The Hindu or Indian Express, some newspaper. So they will write an article criticizing the government for one of its policies. For example, it has not implemented the national education policy properly, or it has not constructed any infrastructure related project like road properly. So they will write an article. Okay, they will write an article. So now if parliament brings a law saying that no newspaper should criticize the government, no newspaper should criticize the government. So can parliament bring such kind of law?
No.
Can parliament bring a law saying that no newspaper has the right to criticize government? Can parliament bring the law? No. Parliament cannot bring that law. Why?
Freedom of speech.
Because if parliament tries to bring that law, it violates which article? Article number 19, which we will be discussing later on. Okay, later on. So article number 19, it places a restriction on the powers of the parliament. It places a restriction on the powers of the parliament. So in this fashion, there are some fundamental rights which restrict the power of the parliament to make the laws. Okay, to make the laws. So hence they are negative in character. Okay, so some character place the limitations on the authority of the state. They cannot make laws, they cannot enforce the laws as per their expectations. So hence they place restriction. So which are those laws which place restriction, which are the articles which act in negative fashion? We will be looking into it later on. Others positive, conferring certain privileges on persons. So when we are saying positive, it is not positive with respect to government, it is with respect to individual. Okay, so fundamental rights have been classified into positive and negative. Positive from whose perspective? Individual's perspective. Negative from the government's perspective. So when we say government's perspective, fundamental rights is going to impose limitation, restrictions on the parliament. When we say positive, it is going to confer additional rights on the individuals. Okay, on the individuals. Okay, individuals. So are justiciable. Already we have seen, can move courts. If fundamental right is violated, what we can do? We can go to courts. Okay, we can go to courts. Are defended and guaranteed by Supreme Court. Very important. Okay. aggrieved can directly go to Supreme Court. Now next, when we start discussing about the fundamental rights, right to equality, right against exploitation, right to freedom of speech and expression, okay, if any of these rights get violated, so I mentioned about an example. So a Hindu editor will write an article against the government. Now next day the police force will come and they will arrest the Hindu editor and they will put him in jail. Now he has to go to court for remedy. So now where he can go? He can either go to Supreme Court or High Court. So both the Supreme Court and High Court, they are the protectors. Okay, they are the protectors. So an aggrieved can directly go to Supreme Court, and also later on we'll see that he can also go to High Court. Okay, so in the Supreme Court and High Court, that case will be taken, and they will see whether the government has arrested under the proper law or not, and in this fashion justice will be delivered. Okay, justice will be delivered, not necessarily by way of appeal. So next, when we start discussing about the Supreme Court, High Court and subordinate courts, so we have Supreme Court here, we have High Court, we have District Court, we have Taluk Court, and so on. So what is way of appeal? Now whatever the decision you have got in the Taluk Court, if you are not satisfied, you will appeal in District Court. Whatever the decision the District Court has given, if you are not happy, you will go to High Court. If you are not happy, you will go to Supreme Court. So if you are not satisfied with the Supreme Court's decision, there is no other option. So whatever the judgment the Supreme Court gives, that is final. Okay, that is final. So here, when your fundamental rights get violated, you need not necessarily go from District Court to High Court and then to Supreme Court. Directly you can go to Supreme Court. Okay, but these are all theoretical aspects. It is not as easy as we anticipate. Okay, if this was the case, then every individual in this country would have directly approached the Supreme Court. These are all theoretical aspects. It is not that easy. Okay, that easy. Again, we will be discussing later on. So next is from the exam point of view. If they ask you who is the defender and guarantor of the fundamental rights? Supreme Court. Okay, Supreme Court. So when a fundamental right is violated, a person has to first go to High Court, and if he is not satisfied, then he can go to Supreme Court. Okay, he can directly go to Supreme Court, not necessarily by way of appeal. Not sacrosanct or permanent. So fundamental rights, whatever were available in 1950, so whether they are sacrosanct means can they not be changed, or can they be changed? They can be changed. So the not sacrosanct or permanent means the same. It means whenever a requirement arises, whenever a need arises, so these fundamental rights can also be changed. Okay, they can be altered, they can be amended. They can be amended. So Parliament can curtail by constitutional amendment. So already at the superficial level, we have seen about the constitutional amendment. But again, in the forthcoming classes, we will be discussing about a separate topic called as constitutional amendment. Okay, amendment. So we have discussed about the different types of bills also while discussing about Parliament. So which are the different types of bills? Ordinary bill, money bill, financial bill 1, financial bill 2, constitutional amendment. So in these type of bills, which type of bill requires a prior recommendation of the President? Money bill, one more. Financial bill 1. In which type of these bills is there a provision of joint sitting? Ordinary bill and next? Finance bill 1 and finance bill 2. Among which of these bills can be introduced only in Lok Sabha?
Money bill.
Yes, money bill and financial bill 1. Okay, financial bill 1. So constitutional amendment bill, it has to be introduced only in Lok Sabha. True or false? It can be introduced in Rajya Sabha. So introduction of constitutional amendment bill requires prior permission of the President. True or false? False. Okay, false. So the constitutional amendment bill has to be passed. Okay, as per article number 368. So what kind of majority is required? Generally, special majority is required. Okay, special majority is required. So here they say that fundamental rights are not sacrosanct. They can be changed. They can be amended. So how you can change? Through ordinary bill you can change?
No.
Through money bill you can change?
No.
Through finance bill 1 and 2 you can change? No. Through constitutional amendment bill you can change. Okay, change. Without affecting basic structure. Okay. So which article of the Constitution consists of the term called as basic structure? Okay. Our Constitution does not have a term called as basic structure in any of its articles. In any of its articles. Then the term basic structure, it came through which judgment? Keshwanand Bharati case. In which year? 1973. Okay, 73. So what does Keshwanand Bharati case say? Can you amend the Constitution?
Yes.
Yes, you can amend the Constitution. But you should keep in mind that whenever you are amending, whenever you are changing, whenever you are altering the Constitution, it should not affect the basic structure. Now, whether the Keshwanand Bharati case has given the detailed list of what constitutes basic structure? No, they are not given detailed provisions about the basic structure. So how did we come to know about the various provisions of the basic structure? Through various subsequent Supreme Court judgments. Through various subsequent Supreme Court judgments, we came to know that, okay, these are part of the basic structure. But there is no clear list indicating that these are the provisions which are part of the basic structure. Okay, basic structure. So this we have understood. So now what we understood? Whether fundamental rights are sacrosanct?
Not.
No. Okay, can they be amended?
Yes.
To any extent?
No.
No. What we have to keep in mind? Basic structure. Okay, basic structure. Next, suspended during national emergency, except article number 20 and 21. So these things now you will not understand. We will discuss a separate topic called as emergency provisions. Okay, we will discuss a separate topic called as emergency provisions, center-state relations, interstate relations, emergency provisions. At that time we will see that these fundamental rights can be suspended. Okay, can be suspended. What is the meaning of suspension? How does the suspension take place? All these things we will be discussing in detail once we start discussing about emergency provisions. Okay, emergency provisions. So for time being, I'll skip it. So this also will skip it. Not important. Okay. So under article number 33, later we will see that these fundamental rights, they can be restricted. To whom it can be restricted?
Parliament.
Paramilitary forces, armed forces. Okay. Now, like an individual civilian, we have more rights. Right to freedom of speech and expression. If an army personnel also exercises his right, saying that I too have the right to freedom of speech and expression, he'll make a YouTube video. So look at our gun. So they are all stored here. Look at the bullets. They are here. Our helicopter is standing there. If all this sensitive information, because of his right to freedom of speech and expression, if he expresses it in the form of a video or any other media, then what happens? The enemy nation will get access to this information, and it will become very easy for them to what? Make an attack. Okay, make an attack. So hence there are restrictions on armed forces, paramilitary forces, police forces and intelligence agencies, okay, intelligence services. So they do not have right as a civilian that we enjoy, okay, that we enjoy. Then can we make a video on where the bullets are stored and where the guns are stored? No, we cannot make, because we do not have access to that place. Okay, they have access to that place, but they cannot do it because there are restrictions. Okay, there are restrictions. So generally when it comes to fundamental rights, so restrictions are more on the military person or on the civilian. So we are all civilians. So restrictions are more when it comes to enjoyment of fundamental rights on military personnel. Okay, military personnel and police personnel. Again, we will be discussing under article number 33. Most of them directly enforceable. Okay, directly enforceable. So few of the fundamental rights means directly whenever it gets violated, you have to go. You can go to Supreme Court and High Court. But few of the fundamental rights directly you cannot go. You require a special law. Okay, special law. Again, about these things we will be discussing later on. Okay, we will be discussing later on. Now we will start with article number 12. So article number 12 reference we saw while discussing which concept? Direct principles of state policy. So there under which article? Article number 36. So article number 36 speaks about the definition of state. But what did they mention? The definition is same as that of the definition of the state present in fundamental rights, article number 12. So this is the article number 12. Okay, article number 12. So under article number 12, so definition of state includes government of India. Okay, so when we say government of India, it may be executive or it may be legislative. So what do you understand by legislative organ of government of India? Government of India, central government. Which is the legislative organ?
Parliament.
Parliament. Okay, it is Lok Sabha and Rajya Sabha. So when I use this term state, we may be referring to Lok Sabha or we may be referring to Rajya Sabha. Okay, or in general we may be referring to Parliament. What is executive?
Council of Ministers.
Council of Ministers headed by
Prime Minister.
Prime Minister. So when we say state, we may also be referring to the executive as well. Okay, it depends upon the context where you are discussing. Okay, so when we are making a reference to the Council of Ministers, can we call it a state? Yes, a state. The definition of state also includes government and legislative organs of the state. Okay, here state means state government. Karnataka state government, Maharashtra government, Manipur government. So if we consider Karnataka as an example, okay, so which will be the government of Karnataka? Executive body, that is State Council of Ministers. Which will be the legislative organ of state? MLAs, members of legislative assembly and legislative council. So when we say definition of state, it's a very broader definition. It includes central government as well as state government. It includes legislative organs as well as executive organs. Okay, executive organs. It also includes local authorities. It includes panchayats. It includes municipalities. So district boards. Now these things will lead to confusion. You just ignore them. Local authorities means which we are aware. We are aware of panchayats, gram panchayat, taluk panchayat, district panchayat. We are aware of municipalities. So even these municipalities also come under the definition of state. Okay, definition of state. Other authorities, this is also very important. They may ask a question in prelims. Statutory is not of or make it as or. Non-statutory authorities like LIC. So Life Insurance Corporation of India, it's a government company. Okay, even that is considered as state. Even that is considered as state. So can we use Infosys? Can we consider Infosys as a state?
No.
Because it's a private entity. Okay, private entity. Can we consider BSNL as a state?
Yes.
Yes. So ONGC. Okay. ONGC is against a government company. It is also considered as a state. According to Supreme Court, even a private body or any agency working as an instrument of the state falls within the meaning of the state under article number 12. Very important. Now, any of you have passport, hold passport? Okay. So whenever this passport processing takes place, so where does the passport processing takes place? Yes. So passport seva kendra, right? So I don't know now exactly, but when I was processing my passport, I remember that this has been, the work has been channelized to or outsourced to TCS. Okay. So TCS company is involved in processing the passport related data and all. Okay. So when we went to passport seva kendra, so it was they were the TCS employees who are outsourced to the government. Now, TCS is a private company. Can we consider it as a state? No. But now TCS is working, okay, is working on a government project. Now, in this context, whosoever is working in TCS on that particular project, they are also considered as part of the state. So, this is the definition of Supreme Court. Supreme Court has said that even a private body or agency working as an instrument of state falls within the meaning of the definition of state. Okay, state. Now, in the examination, they may ask you, only executive organs fall under the definition of state under article number 12. False. Only executive body? No. Even legislative bodies as well. Okay. Only legislative bodies fall under the definition of state and not executive bodies. False. Only central and state legislatives and executives fall under the definition of state, and what panchayats and municipalities are excluded. False. All of them, they fall under the definition of state. Okay, definition of state, very important. Okay. Next, article number 13. Okay, article number 13. So a very important article. Okay, very important article. So here, if you have any kind of doubts while discussing also, you should raise the doubts because it's very important. Now this concept which we are going to discuss, so it will get connected to every other topic we will be discussing, which we will be discussing in the forthcoming classes. Okay, forthcoming classes. Declares that all laws inconsistent with or in derogation of any of the fundamental rights shall be void. Shall be void. Now, okay, now we have not yet discussed about the fundamental rights, right? So, in article number 24, next we will be discussing article number 24. So, article number 24 says that prohibition of employment of children below the 14 years of age. Article number what? 24 says that a child below 14 years of age should be prohibited from employment in hazardous activities. Okay, there is a provision here, article number 24, again we will be discussing later on, but we want to connect to this topic. Now let's assume central government parliament will bring a law. Okay, will bring a law just to make the discussions easier. Parliament is never going to bring such kind of law. I am just trying to use this example so that it becomes easier. Now parliament, let's assume it brings a ordinary law. Okay, ordinary law saying that Employment Act 2025. So initially it will be in the form of a bill, then it will become act. For this bill to become act, what is the process involved? It has to be passed in Lok Sabha. It has to be passed in Rajya Sabha or Lok Sabha. Then it should come to Lok Sabha and Rajya Sabha with what kind of majority? Simple majority. And finally it has to be signed by President. Then it will become act. Okay, act. So in this act, there are various sections. Section 1, section 2 and so on. Okay, there are hundreds of sections. Let's assume there is one section here which is section 10. Section 10 says that those who are below 12 years, they cannot be employed in factories. Those who are below 12 years, they cannot be employed in factories. Means what does it mean? Those who are above 12, those who are 13 years old, so they can be employed. Okay, as per this law, below 12 years should not be employed. Means above 12 years, a person who is a child who is 13 years old, he can be employed. But what does the constitution say? After 14 years itself, a person can be employed. Now, whether there is inconsistency between this ordinary law and constitution? Yes. So this ordinary law, this is fundamental law. Fundamental law is constitution, this is ordinary law. Okay, ordinary law. Now, this article number 13 says that, declares that all laws inconsistent with or in derogation of any of the fundamental rights shall be void. Now, the law which I have taken here as an example, okay, that is Employment Act, whether it is consistent with the Constitution? No. Whether it is, now I will not use the term Constitution, whether it is inconsistent with the fundamental rights? No. Okay. Declares that all laws inconsistent with or derogatory of the fundamental rights shall be void. So, this law should become invalid. This law should become invalid. Okay, invalid. But already already Lok Sabha has passed the bill, Rajya Sabha has passed the bill, and President has signed it. Okay. Now, who has the power to declare that this law is invalid? Okay, both Supreme Court and High Court have this power to declare that this law is invalid. Okay, invalid. Now, Supreme Court and High Court, while deciding this law as valid or invalid, it is not necessary that it should declare the entire law as invalid. There are 100 sections. Okay, there are possibilities that it may declare the entire law as invalid. All the 100 sections are invalid. But what it can do, it can just say section 10 is invalid, rest all the things are okay. Rest all the things are okay. Okay. So this decision can be made by both Supreme Court as well as High Court. So that is the meaning of article number 13. Declares that any law inconsistent with or in derogation of any of the fundamental rights shall be declared void. Okay, void. So who can do it? Both Supreme Court as well as High Court can declare it. So this process of studying whether the law is consistent with the fundamental rights or not, whether the law is consistent with the Constitution or not, okay, that process is called as judicial review. Okay, so with this example you try to retain the content. Okay, trying to check whether the given law is consistent with the fundamental rights or not, so consistent with the Constitution or not, that process is called as judicial review. Okay, judicial review. So who is involved in the process of judicial review?
High Court, Supreme Court.
Supreme Court and High Court is involved in the process of judicial review. Okay, judicial review. Now we shall think from the exam point of view. Which article of the Constitution mentions about judicial review?
13.
Yes. There is no article in the Constitution wherein we will find the mention of the term called as judicial review. The term judicial review is not explicitly mentioned in the Constitution. Very important point. Okay, very important point. Basic structure doctrine, it is not mentioned in the Constitution. Nowhere it is present. Similarly, the term judicial review is nowhere present in the Constitution. But which article expressly provides for the doctrine of judicial review? Article number 13. There is a very thin line. So in the examination if they ask, so whether the term judicial review is present in the Constitution? No. Is there any article which provides for the provision of judicial review? Yes. Which article?
13.
Article number 13. Okay, article number 13. Article number 13. Okay. So this power of judicial review has been given to Supreme Court. It has been given to High Court as well. Who has given? Constitution has given. So Constitution has given this power to Supreme Court through which article? Article number 32. It means article number 32 confers the power of judicial review on Supreme Court. Similarly, article number 226 confers the power of judicial review on High Court. Okay, on High Court. Okay, High Court. So that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. So we saw the example, right? So that law, whether it violated the constitution,
Yes.
whether it violated the fundamental rights.
Yes.
So which particular article it violated? Article number 24. Okay, article number 24. Okay, in such case, so both Supreme Court and High Court can declare a law as invalid. Okay, now it depends. If a person takes the case directly to Supreme Court, then Supreme Court will decide. If the person takes the case first to High Court, then the High Court will decide. But both of them have the power of judicial review. Power of judicial review. Okay. Yes.
Who will take the case to Supreme Court or High Court, sir?
Any of the private parties, we can take the case. We can file a case against the government saying that this law violates the constitution.
For example, if a bill is passed and it has become act.
What?
So
A
if
bill has
it
become
is
act? Okay.
So a normal person, anyone can take, or Supreme Court itself will.
No, Supreme Court itself will not take. Any of the normal person, okay, they will file a case. Generally what happens is, it depends upon the government. If BJP government has brought the law, okay, so the Congress members, what they will do, they will take this law to the court. If Congress government is in power, so BJP people will take this law to the court. So this is how it happens. But on top of that, there are many NGOs, non-governmental organizations. So if they think that this law is affecting the fundamental rights, so they will take such kind of laws to the court. Okay, there is no restriction. Anyone can take the case to the court, either Supreme Court or High Court. Yes. Once the judgment has been given by High Court, yes, we can go to Supreme Court. If the High Court decides, then it can be appealed in Supreme Court. That can be appealed in Supreme Court. There are many cases wherein High Court has given the judgment and the Supreme Court has reversed the judgment. Okay, so such instances are also available. Okay, available. So term law given wider connotation. So here, okay, we'll just focus on two aspects because we'll get confused. So while discussing about the parliament, we discussed about an act and we discussed about rule. Okay, we discussed about a term called as subordinate legislation. Do you remember subordinate legislation? What is subordinate legislation?
Work under the executive.
Detailed rules and regulations. Okay, so when we say making a law, who will make the law? Lok Sabha will pass, Raj Sabha will pass, and next president will sign. So the bill will become act. So this we call it as law making. But who will make rules? Now we have seen, right, ministries. How many ministries are there in India? 53 ministries. And I asked you to make a list of all the ministries. 53 ministries. Now if every law is administered by one or the other ministry. Okay. Now policy is administered by Home Ministry. Health related vaccines are administered by Health Ministry. Okay, Ministry of Health and Family Welfare. So now for example, we have made a, let's assume Health Act 2025. Health Act 2025. Okay, so here we will be having section 1, section 2 and so on. Next, detailed rules and regulations will be made by whom? Health Ministry. Health Ministry. So what you will do? So Health Act 2025 rules. Rule 1, Rule 2 and so on. Okay, and so on. So we learnt about the judicial review process, right? So what we can challenge in the court, whether we can challenge only this main law or can we also challenge the rules? Rules also. So that much understanding would be sufficient. So when you are challenging in the court, okay, saying that it is violating the fundamental rights, so you need not necessarily challenge permanent laws like Health Act, you can also challenge rules. You can also challenge rules. You can also challenge executive orders, okay. So executive orders, bylaw, etc. So it will lead to confusion. It will lead to confusion for time being because we have not yet discussed all the aspects. You just focus on two things. One is permanent law, another one is rule. So when it comes to judicial review process, when we are filing a case, it can be both in the context of permanent laws as well as with respect to rules. Okay, with respect to rules. Next, constitutional amendment. Now, ordinary law, in the example that we discussed, that was Employment Act. That is an ordinary law or constitutional amendment law? It is ordinary. Now, supposedly, if there is a constitutional amendment, and through constitutional amendment, they will change some part of the constitution. So, can we challenge constitutional amendment in the Supreme Court and High Court, saying that it is violating some of the fundamental rights? So, this was the question which came in front of the Supreme Court. Okay, Supreme Court. So, there are various judgments, but we look into the only final judgment. Okay. So, Supreme Court in Keshwanand Bharati case 1973 said that even constitutional amendment acts can be challenged if it violates fundamental rights. If it violates fundamental rights that form part of the basic structure and can be declared as void. A very important point to note. For example, now from article number 12, 13, 14, 15, 16 and so on, 21, 22, 23, 24 till 32, 33, 34, 35. So just to make our discussions easier, let's assume 22 and 23, they are part of basic structure. All the 33 and 34, they are part of basic structure. All the other articles, they are not part of the basic structure. Let's just assume. Okay. Now, what did the Supreme Court say in Keshwanand Bharati case? If the constitutional amendment, if it brings any changes to article number 22, if it brings any changes to article number 23, if it brings any changes to article number 33, if it brings any changes to article number 34, then such amendments can be challenged in court. Okay. Because these four articles, they are part of the basic structure. But if a constitutional amendment, if it tries to change article number 35 or 32 or 21, so such constitutional amendments cannot be challenged in courts because they are not part of the basic structure. So Keshwanand Bharati case, in Keshwanand Bharati case, what the Supreme Court said? Whether constitutional amendments can be challenged? Yes. Whether all the cases? If it violates fundamental rights that form part of the basic structure, and such amendments can be declared as void, as invalid, as illegal. Okay, illegal. Now the next question is, which of these fundamental rights form part of the basic structure? I have taken just imaginary example. Which are the fundamental rights which are part of the basic structure? Okay, there is no such standard list. Okay, there is no such standard list saying that these are the fundamental rights which are part of the basic structure. Then how will we understand? So whenever Supreme Court gives a judgment, there are many judgments. In the subsequent judgments, it will mention, okay, right to equality is a part of a fundamental right. Sorry, it's a part of the basic structure. Then we'll understand, okay, right to equality, it cannot be modified. So here there are bit complexities. We will not go into that complex web. We will only understand at a superficial level. That's very important. Okay. So let's revisit once again. Okay. Whether the term basic structure is present in the Constitution? No. The term basic structure came through which judgment? Keshwanand Bharati case. So what are the various provisions part of the basic structure? Whether they have been listed in any part of the Constitution? No. Do we find a detailed list of such things? No. How do we understand that any provision is part of the basic structure? Through many Supreme Court judgments. Now, whether an ordinary law can be subjected to judicial review? Yes. Whether a constitutional amendment can be subjected to judicial review? Yes. So, whether all constitutional amendments can be subjected to judicial review? Yes, they can be subjected to judicial review. But which can be declared as invalid? Only the constitutional amendments which alter the fundamental rights which form part of the basic structure. Then which are the fundamental rights which are part of the basic structure? We don't know. Okay, we don't know. We'll stop here itself. We'll not try to explore and try to find the list of fundamental rights which are part of the basic structure. You'll not get that list. Okay, you'll not get that list. Okay. Okay. So we understood a few of the very important things. Okay. Article number 12, definition of state. Article number 13, explicitly we found the term called as judicial review. Explicitly it has been mentioned, yes or no? No. The term judicial review is nowhere present in the Constitution. Article number 13 provides for the provision of judicial review, because in the examination they will cause such kind of confusion. Deliberately, intentionally, as per the Constitution, it says that judicial review so and so. No. In Constitution there is no term called as judicial review. So the article number 13 provides for the provision of judicial review. Okay, provides for the provision of judicial review. Okay. So already we have made the first round. In the first round we discussed what?
Parliament.
The range of articles which deal with right to equality. Which are the range of articles? 14 to 18. Next, right to freedom.
9 to 22.
19 to 22. Next, right against exploitation.
23, 24.
23 and 24. Right to freedom of religion.
25, 28.
25 to
28.
28. Next, 29 and 30.
Cultural and
Cultural and educational rights. Next, 32. Constitutional remedies. Now, few of the rights we have missed here. Article number 31.
right to property.
No. Okay. Article number 31 no longer exists. Now you will not worry about those things, because human brain always it tries to find the missing information. Okay. So we discussed all the articles. We have listed all the articles from 14 to 32 except 31. So what does 31 deal with? You'll just ignore it. It's not important. Okay. What does 33 deal with? We'll see later on. 34, 35 not important. So whatever will be discussed here, that would be more than sufficient. Some irrelevant articles that just exist, so they do not have any kind of relevance from the exam point of view. We will not focus on those articles. Okay, we will not focus on those articles. Now we will go for the second round. Okay, we have one more third round. Okay, first round, second round, third round. Because in one go, if we try to learn all these things, then it will become very difficult. So I have made it as multiple rounds. Okay, multiple rounds. So in the second round, article number 14 to 18. 14 to 18. Article number 14 says equality before law and equal protection of laws. Okay. Now you will not understand what is equality before law, what is equal protection of laws. Now we will not understand. Later on we will understand again when we start going into the deeper level with respect to article number 14. But yes, at this point of time, just we will retain the information. Which article deals with equality before law and equal protection of laws? Article number 14. Article number 15. Prohibition of discrimination on grounds of race, religion, caste, sex or place of birth. Okay, there should be no discrimination based on race, there should be no discrimination based on religion, caste, sex or place of birth. So for example, I took the example of a hotel. So if you go to a hotel, so he should not prohibit you from entering the hotel based on your race, based on the color of your skin, based on your religion, based on your caste, based on your sex, male or female, based on your place of birth. Okay, place of birth. Okay. Next, article number 16. Equality of opportunity in matters of public employment. What is public employment?
Jobs.
Government jobs. So when it comes to government jobs, there should be equality of opportunity. So each and every individual should get equal opportunity. Now when we go and start discussing in detailed manner, at that time we will understand. So the provision of reservation, okay, in favor of scheduled caste, in favor of scheduled tribe, women, OBC. So whether it is against article number 16 or it is aligned with article number 16. You should never consider it as against article number 16. Okay, it is aligned, it adheres to article number 16. Okay, because there are limited reasonable provisions made. So that we will see later on. So equality of opportunity means you cannot say that as a general merit candidate, so some of the seats are being bagged by scheduled caste, scheduled tribe, OBC, women. No, you cannot say that because it is in tandem with article number 16. So now at a superficial level, we shall focus article number 16, equality of opportunity in matters of public employment. Okay. Next, abolition of untouchability and prohibition of its practice. Okay. So a practice untouchability. So people belonging to some caste, so they were not touched. So people never used to mingle with them, never used to have or dine with them. So all these problems. So that is dealt by article number 17. Okay. Abolition of untouchability and prohibition of its practice. Okay, practice. Article number 18. Abolition of titles except military and academic. Okay. So we have heard about the titles, right? Doctor, okay, professor. So these are all titles. So and next other titles, for example. Okay, those cannot be used. Bharata Ratna. Okay, again there is a restriction. We will be discussing about later on. So previously titles Raja, Rajadi Raja, Raja Marthanda. Okay, such kind of titles you cannot use. Okay, you cannot use except military. For example, Marshal, Wing Commander. So those titles can be used. Academic, Doctor can be used. Apart from these, no titles can be used. Article number 18. Article number 14. What does it say?
Equality before law.
Equality before law and equal protection of laws. 15.
Discrimination.
Prohibition of discrimination on grounds of race, religion, caste, sex or place of birth. Next.
16
16.
public. Equal opportunity.
Equality of opportunity in matters of public employment.
employment.
17.
Untouchability.
Untouchability. 18. Abolition of titles.
Titles.
So in the first level, if you are able to recall, so that would be sufficient. Again, the next level we'll see. And next, fundamental rights. In few of the other institutes, what I have heard is, so they engage their classes for 15 to 20 days. Okay, 15 to 20 days. Every Supreme Court judgment, so they will discuss in detail. Okay, in detail. But here we are not going to do that exercise. Okay, hardly 2 days we'll complete the fundamental rights, because the Supreme Court judgments which have been quoted in Lakshmikant, they are not beneficial from the prelims point of view. In the mains point of view, whenever you are quoting a judgment, hardly 2 or maximum 3 lines would be more than sufficient, not more than that. Okay, if you study each and every judgment to such a detailed extent, then probably you will become an expert lawyer. Okay, lawyer who can argue in the court of law. But here our goal is not to become a lawyer, right? Our goal is to crack the examination. So hence we have to understand the exam's demand and we have to prepare accordingly. Okay, prepare accordingly, because each one of the aspirant, they have the same set of resources. Lakshmikant, each individual, all the aspirants, they refer the same book. There is no other alternative book for Lakshmikant, that is Lakshmikant. For polity, apart from Lakshmikant, there are few other books, but the most famous is Lakshmikant, and no book has arrived in the market which can beat Lakshmikant. Okay, but in spite of that, all the aspirants, when every year they appear for the examination, they are not going to mark all the polity questions correct. Many of them, they mark a wrong choice in spite of going through Lakshmikant for multiple rounds. Why? Because in the end moment, they will not be able to revise. Why they will not be able to revise? Because there is a bulky content. In this bulky content, we have to prioritize the things into what is important from the examination point of view and what is not relevant. Okay, what is not relevant. So these things that we discussed, it's important. Next. Okay. Right to freedom. So again, this is the first round, not second round. So article number 19 to 22, we already seen. Protection of rights of freedom of speech and expression. So within article number 19, we have speech and expression, assembly, association, movement, residence, profession. Okay. So first is speech and expression, means whatever thoughts you have, so you should be able to express it freely. Whether it's absolute? No. It's not absolute. Again, there are reasonable restrictions. What are those reasonable restrictions? We'll be looking into it later on. Assembly. Okay, assembly means a group of people standing together and having discussion. So do we have such kind of freedom for assembly? Yes. Okay, freedom of assembly is there. Again, with reasonable restrictions. Means when you are assembling, can we carry arms? No. Okay, without arms, there are reasonable restrictions. Next, association. For example, you will be forming some kind of organization called as political party, Congress, BJP. All these are associations. Okay, ABVP. So all these are associations. So whether such kind of associations can be formed? Yes. So again, it comes under right to freedom. Okay, right to freedom. Next, movement. So in India, can we move from one part of the country to other part of the country without any kind of restrictions? Yes, without any kind of restrictions, we can move from one part of the country to other part of the country. But again, for everything there is an exception. Okay, but now we will not discuss in detail. For example, if you go to northeast, whether northeast is part of India? Yes, it's part of India. But even to enter few areas, we have to take a special permission. Okay, there are some areas called as in Manipur, Arunachal, not Manipur, Nagaland, we require inner line permit. Okay, so what I am saying is, for everything there is a restriction. Okay, but in general, whether we have right to freedom of movement in India? Yes, we have right to freedom of movement. Residence. So can any citizen reside in any part of the country? Yes, he can reside in any part of the country. Okay, reside in any part of the country. So can a person involve himself in any kind of profession? Yes, he can involve in any kind of profession, provided he should have the qualification. Okay, so without qualification, he cannot claim that I want to treat the patients. Okay, he need to have the qualification either BAMS or MBBS. Okay, in that fashion, after necessary qualifications are met, then a person can practice any profession throughout India. Okay, throughout India. Next, article number 20, protection in respect of conviction for offences. So we will be discussing in detail later on. So article number 21, a very important article. Every alternative year there will be a question on it. Okay, but question will not be directly based on the content which is present here. It is based on various Supreme Court judgments. Okay, so this article, protection of life and personal liberty. Okay, it has so many rights within it. but they are not been mentioned explicitly in the Constitution. They are not been mentioned explicitly in the Constitution. Now in 2018 a case came, so based upon that a new right got added. For example, now I'll ask you a question. Right to marry a person of one's choice, whether it will come under article number 19 or article number 21. Right to freedom or right to life and liberty. Okay, so we get confused, but right to marry a person of one's choice, whether it is present in the Constitution, no, it's not present in the Constitution. But Supreme Court through its judgment, it said that right to marry a person of one's choice, it broadly falls under article number 21, that is right to life and liberty. Okay, liberty. Explicitly, right to marry a person of one's choice is not present in the Constitution, but Supreme Court has given the interpretation, so hence it is part of article number 21. Okay, so the case is Hadia case in Kerala. So one of the Hindu girl was converted into Islam. That case, her father took the case to High Court and then to Supreme Court. In the Supreme Court, the case was ruled saying that right to marry a person of one's choice, it broadly falls under article number 21. Okay, 21. Next, there is one more judgment called Puttaswamy judgment. Okay, Puttaswamy judgment. Right to privacy. So whether right to privacy is mentioned anywhere in the Constitution? When we go through the fundamental rights, nowhere you will find right to privacy kind of thing. But in the Puttaswamy judgment, so Supreme Court ruled that right to privacy, it broadly falls under which right? Article number 21. Okay, 21. In this fashion, Supreme Court through its various judgments, it can do the interpretation and add few extra things. Okay, right to environment. Right to environment falls under which article? Article number 21. Because proper environment will lead to what? Proper life. Okay, life and liberty. So in this fashion, again we will be discussing. Again, that entire list is not required. So recent, whatever is there in the current affairs, whatever you are reading in the newspaper, if you are able to connect to the static aspects, that would be more than sufficient. Okay, sufficient. Next, right to elementary education. See here, it is 21A. Previously it was not there, afterwards it was added through amendment. Which amendment? We will be looking into it later on. Okay, later on. Next, 22. Protection against arrest and detention in certain cases. So this article number 22 also we will be discussing in detail in the forthcoming class. Okay, forthcoming class. So today we shall close here itself. So before we close, can we quickly recall? So which all article deals with right to equality? 14 to 18. Next, right against exploitation. Yes, right against exploitation. 23, 24. Right to constitutional remedies. 32. Right to freedom of religion. 25 to 28. Right to freedom. 19 to 22. Abolition of titles. 18. Abolition of untouchability.
17.
Equality of opportunity in public employment. 16. Okay. Next, equality before law and equal protection of laws. 14. Prohibition of discrimination. 15. Okay. Now you got an idea, right, how you are supposed to prepare. If I ask you the article number, you should be able to tell the corresponding provision. If I tell you the provision, you should be able to recall the corresponding article. So this exercise we are not going to do for the entire Constitution. All the 400 articles we are not expected to retain. Preamble will memorize. Fundamental rights, article number and provision. DPSP, article number and provision. After this, hardly around 10 more articles, not more than that. So for this entire polity subject, hardly we will be memorizing around 50 to 60 articles, not more than that. Okay, because majority of the aspirants, when they start the journey, so we have that initial aspiration, that enthusiasm will be there. So whatever is there below the sun, everything I should occupy. I should become master. In the very first attempt, I should crack the examination. So it happens. But honestly, only those who are not occupied with such kind of thoughts, they will be able to crack in the very first attempt. Because there is a hell lot of information only in polity. Again, if you go to history, modern, medieval, ancient, so much of information is there. So only those will succeed in the first attempt who have learned the art of prioritizing the content from the exam point of view. Okay, prioritizing from the exam point of view. Okay, so we shall stop here itself. Again, we shall continue discussion in the next class. So if you have any kind of doubts regarding the discussion that we had till now, so you can raise the doubts, otherwise we can close. Yes? Any doubts? No. So we shall close then. So welcome to Paritranaya. This is the 11th day, I guess, right? Yes, you can mute it. So in yesterday's class we started with fundamental rights. Before that we discussed about DPSP, Directive Principles of State Policy. I think we already completed with the preamble as well. Preamble, and we have completed the topic called as Parliament. Right? So what is Parliament? Lok Sabha, Raj Sabha and President. What is Union Executive? Yes. President, Vice President, Council of Ministers, Attorney General of India. Yes. CAG is not part of CGI. There is no post called CAG, Comptroller and Auditor General of India. But he is not part of the executive. He is not considered as part of Union Executive. Okay. But generally in our discussions, when we refer to a term called as executive, we refer to Council of Ministers. Okay, Council of Ministers. So yesterday we started with fundamental rights. So fundamental rights have been borrowed from which country? Fundamental rights. Irish? We have borrowed these concepts from USA. So from which country we have borrowed, or from Ireland what we have borrowed? DPSPs we have borrowed from Ireland or Irish Constitution. Okay. So yesterday we started with the fundamental rights. In the first round what we learnt? The range of articles. So right to equality is dealt by which all range of articles? 14 to 18. Next. Right to freedom, article number 19 to 22. Next. Right against exploitation, 23 and 24. Next. Yes. Right to freedom of religion, 25 to 28. Next we discussed about cultural and educational rights, article number 29 and 30. So finally we discussed about what? Constitutional rights or right to constitutional remedies, article number 32. Okay, 32. Next we started with the second round. In the second round we discussed about right to equality. Okay. So what does article number 14 indicate? Equality before law and equal protection of laws. Next, article number 15, prohibition of discrimination on grounds of race, religion, caste, sex or place of birth. 16, yes, equality of opportunity in matters of public employment. 17, abolition of untouchability. 18, abolition of titles. Okay, titles. Next we started with right to freedom, first round. So right to freedom of what all aspects it consists of? Speech, association, movement, residence, profession. Okay. Assembly, profession. Okay, profession. So these things we discussed. Next, just at a superficial level, we discussed what is article number 20, 21, protection of life and public liberty, 21A, elementary education, protection against arrest and detention in certain cases, article number 22. Okay, 22. So we are not yet completed with the second round. Okay. So right against exploitation. So internally it consists of two articles, article number 23 and 24. So while discussing about the other aspects, so we have come across these provisions, we have discussed at a superficial level. So article number 23 says prohibition of traffic in human beings and forced labor. So what is forced labor? When you make someone to work forcefully for less salary or without salary. So all of them they come under forced labor. And if they are unwilling to work but still you make them to work, that is an example of forced labor. Okay, forced labor. Next, traffic in human beings. What is traffic in human beings? So selling of human beings, okay, trade in human beings, we generally refer to it as trafficking. Okay, trafficking in human beings. Next, article number 24, prohibition of employment of children in factories, etc. at a superficial level. So it deals with employment of children in factories. Okay. In the third level we will be discussing in detail. Okay, in detail. Next, right to freedom of religion, article number 25 to 28. Okay, article number 25 to 28. Article number 25, freedom of conscience and a free profession, practice and propagation of religion. Okay. So freedom of conscience means you may be having an ideology that I believe in Hinduism, I believe in Islam, I believe in Christianity. It's your conscience. No one can question it. No one can question your belief. So freedom of conscience and free profession. Okay, so you can freely profess which religion you belong to, whether you belong to Hinduism or Islam or Christianity and so on. And you are free to practice your religion. Okay. And next, you can propagate. So whatever the good ideas are there of your religion, you can also propagate or you can disseminate the message to others. Okay, message to others. Article number 26, freedom to manage religious affairs. So religious affairs in the sense, let's take the example of a temple in Hinduism and mosque in Islam. Okay, so how to manage the temple affairs, when to open the temple, when to open the mosque, so at what time prayer has to be done. So all these are religious affairs. So to perform those religious affairs, we have right to what? Freedom of manage religious affairs, freedom to manage religious affairs under article number 26. Next, freedom from payment of taxes for promotion of any religion. So when someone is collecting taxes, and that too for the promotion of any particular religion, so you cannot be forced to what? Pay that tax. Okay, pay that tax. Freedom from attending religious instruction or worship in certain educational institutions. Okay, so let us assume there are some educational institutions which are dominated by a particular religion. It may be Hinduism, means those who belong to Hindus, so such kind of the institution may be dominated by Hindus, or the institution may be dominated by Muslims. So whichever institution might be, wherever you are working, you should not be forced to attend religious instruction. Okay, religious instruction. For example, if a person belonging to other religion, Islam or Christianity or Buddhism, so they should not be forced to attend the religious instruction being given in a Hindu college. Similarly, in the Islam school or college, so a Hindu or a Christian should not be forced to attend the religious instruction. So that is article number 28. Okay, 28. So article number 25 to 28, that much superficial information will be sufficient. Again, we will be discussing in detail. Next, cultural and educational rights. Article number 29 and 30. 29 says protection of language, script and culture of minorities. Okay, so very broader term, language. Okay, so language, script and culture of minorities means attempt should be made to protect the language, script and culture of minorities. So we understand what is language, we understand what is script. What do we understand by culture? Okay, so it has a very broader meaning. So culture includes our eating habits, it includes dance, drama, everything. Okay, so attempt should be made by the government to protect the language, script and culture of minorities. Okay, minorities. So here when we look at these minorities, so the minorities are two types. One is religious minority. Okay, for example, those practicing Islam are religious minority in India. Those practicing Christianity, they are religious minority in India. And also linguistic minorities. For example, if you look at Karnataka state at the border areas, in the northern part of Karnataka, so we share border with Maharashtra. So in the border areas, people who speak Marathi, they are linguistic minority. They are linguistic minority. Similarly, if you go to southern part of Karnataka, at in some districts, there may be people who speak Malayalam. So they are linguistic minorities. Similarly, in some parts of Kerala, okay, in the northern part of Kerala, there may be some people who speak Kannada. So they are linguistic minorities in those states. Okay, in those states. So in this fashion, attempt has to be made by the government to protect the language, script and culture of the minorities. Right of minorities to establish and administer educational institutions. So minorities will have the right to establish and administer their educational institutes. For example, if you look in the surrounding, in Bijapur we have SICAB, so it's a minority institution. So if we go to Shravana-Belagola, so there we have a minority institutions. So they have the right to establish their own institutions, okay, own institutions. And finally, we have right to constitutional remedies, okay, constitutional remedies. So these are very important. So right to move the Supreme Court for the enforcement of the fundamental rights, including the writs of. So whenever your fundamental right gets violated, okay, whether it is the right under article number 14, 15, 16, 17, 18 or 29, 30, any of these rights when they get violated, okay, so you can go to Supreme Court. So Supreme Court has been given this power, what, to give justice to the people under article number 32, okay, article number 32. So an example of a violation of a right, already we have seen. Now article number 19 says freedom of speech and expression. Now supposedly a person, let's assume a editor of a newspaper, he writes an article against the government, okay, against the government. Now if the writer is arrested saying that he has written an article criticizing the government, so if the police arrests him, then what happens? He can go to Supreme Court saying that my fundamental right has been violated. Which fundamental right? Article number 19. Okay, article number 19. So when he is going to the Supreme Court, so I have just given you one scenario. There are different scenarios wherein a person can go to Supreme Court. Okay, based on different reasons. Okay, reasons. So when he is going to Supreme Court to file a case, we will not call it as a case. Generally we call it as a case, right? Whenever we have any kind of problem, when we are going to file a petition in the Supreme Court or High Court or any of the courts, we call it as a case. A case is being filed. But when your fundamental right gets violated, and when you are filing a petition or case in the Supreme Court or High Court, we will not call it as a case, rather we will call it as a writ. We will call it as a writ. Okay, writ. So there are different types of writs. One is habeas corpus, another one is mandamus, prohibition, certiorari, quo warranto. Okay, quo warranto. Now you will not understand. So when we start discussing these provisions one by one, so gradually you will get hold of of all these concepts. Okay, of all these concepts. So when your fundamental right gets violated, you can go to Supreme Court under which article? Under article number 32. Means the Supreme Court can give you the remedy. But when you file a case, you will not call it as case. What you will call it as? Writ. There are different types of writs. Okay, habeas corpus, mandamus, prohibition, etc. Okay, etc. One famous writ is habeas corpus. You might have even seen in films. So have you watched a movie called as Jai Bhim in Tamil? Jai Bhim movie you watched? Okay. So that movie is based on habeas corpus. So habeas corpus says that if someone is arrested and kept in some unknown place, okay, unknown place, then Supreme Court or High Court will give a direction. Wheresoever he may be, you bring him and make him stand in front of me. He should be made to be present here in physical mode. Okay, physical mode. So for that a writ is issued. That is called as habeas corpus. Okay, habeas corpus. Again we will be discussing in detail. Okay, we will be discussing in detail. So now we have completed the second round. So none of these fundamental rights can be memorized or understood in one go. This reality we have to understand. So today I am able to recall all these fundamental rights because there is an effort of past around 15 to 16 years. Okay, so it need not happen to you overnight. It will take its own course of time, because fundamental rights is not the only concept. There are many other concepts to be read, learnt, memorized and all. So don't set the ambitious goals that within a span of 2 to 3 days I have not been able to reach the goal. Okay, that's not possible. So it requires multiple go. Okay, only when you go through it multiple times, then you will be able to store the information. And no doubt there are some psychological techniques, there are some mnemonics techniques that we can use to make the learning process easier. Okay, easier, but it cannot happen overnight. Okay, it will take its own course of time. Okay, so that reality we have to understand. So after the second round, will we be able to recall the provisions? Article number 14, equality before law, equal protection of the laws. Article number 15, yes, prohibition of discrimination on grounds of race, religion, caste, sex or place of birth. 16, yes, equality of opportunity in matters of public employment. Next, abolition of untouchability. Next, abolition of titles. Okay, titles. Now initially few of you might be able to recall. Now if I directly ask you which provision article 24 deals with? Child, because already we have discussed multiple times. Article number 27. It's part of the freedom of religion, but you will not be able to exactly recall. It will cause confusion. So to retain the information for a very long period of time, you can use certain psychological techniques. Okay, techniques. So few of the techniques which I have learnt, I will be sharing here. Gradually you should start using such kind of practices if it is beneficial. Okay, because human memory is very complex. So all of us, even though the cerebral system is same, but the way it functions is very different. Some of us, we have photographic memory. Means once we have a look into any of the content, very easily we will be able to comprehend, digest and will retain for a long period of time. And some of them, they cannot do it. It will be difficult. They have to practice, they have to make revision, and then they will be able to register that information and retain it for a very long period of time. So if I consider myself, so I do not hold that photographic memory. Okay, in just one look I cannot retain the information. So I require some extra methods to store the information for a long period of time. Okay, long period of time. Now for example, if we start with right to equality, we already discussed right to equality. And later on, so in today's class I will be using exclusive English, but later on when we start discussing in Kannada as well, so at that time we will be taking the examples in Kannada, in mother tongue. Okay, that will be what more easier. So here, if we take right to equality, article number 14, 15, 16, 17, 18. 14 deals with equality before law, equal protection of laws. 15, prohibition of discrimination. Here what I will do is, I will go with identification of a keyword. Now one person may identify one keyword, another person may identify different keyword, but I will here identify keyword called as discrimination. And if you search in the internet also, majority of them they have taken the same keyword. Discrimination will be the keyword in article number 15. If I go to article number 16, equality of opportunity. So I will take opportunity. Someone else may take public employment. Again it depends. Next, 17, untouchability. What will be the keyword here? Some of them might take abolition. Okay, again it depends. So I will take untouchability. Next, abolition of titles. So if you take abolition as the keyword, what happens? It repeats in article number 17 and 18. It leads to confusion. Now these are the keywords which will not lead to any kind of confusion. Okay, confusion. So here, discrimination, opportunity, untouchability, titles. So these are the keywords. Okay, these are the keywords. Now using these keywords, initially when we are learning fundamental rights, we can create a story. Okay, we can create a story. For example, so discrimination, opportunity, what? Untouchability, titles. So first I can jumble it. How? So when you follow this untouchability, it means you are discriminating someone. Okay. So you are discriminating someone. So such things should not happen. We should give an equal opportunity to everyone. So this is one way of forming the story. There are different ways. Okay. But in the internet generally what they will do is they will take the mnemonics methods wherein it starts with the first letter. So if we follow that first letter, so first here we have D, here we have next O, U, next T. Something doubt. Okay, doubt. Now with this it will help you to retain the content and recall the content very easily. Article number 14 we know, equality before law and equal protection of laws. Next, when it comes to D, so what is D? Just memory, your brain will start thinking, okay, it is discrimination. So what happens to discrimination, whether it has to be promoted or prohibited? Prohibited. Next, going to next term, opportunity. So what opportunity they are speaking about? Okay, they are speaking about the employment opportunities. Where? In private sector or public sector? In public sector. Next, U, untouchability. Okay, so untouchability will promote or you will avoid or prohibit? Okay, abolition of untouchability. That exact word abolition is not important. We want to overcome untouchability, that's it. That abolition, the term is not important. Next, titles. T. Okay, abolition of titles. Okay, abolition of titles. So in this fashion, if you go to the next, okay, now we want to remember this. Okay, initially it will be difficult. Speech and expression, assembly, next association, movement, residence, profession. So you can form some kind of stories here. Okay, you can form some kind of stories. You can go to your school days. So generally in the school days, every day before your first class there will be assembly. Yes. Okay. In the assembly, when you speak, what happens? In the assembly session, if you speak, probably your teachers may punish you. So you are not supposed to speak in the assembly. So in this fashion, you will try to form a story. You will try to form a story. Okay. So now teacher will say, in the assembly, you are not supposed to speak and associate with other students. In the assembly, you are not supposed to speak with the other students and you should not form any kind of association during the assembly. Okay, assembly. And teacher will say, if you speak, I will make you move out of this place itself. I will make you move out of this place. Then you have no other option. You have to go to your resident. Okay, you have to go to your home. Okay. So in this fashion, when we use the words and try to frame a story, that will be what the learning exercise will be more enticing. Okay. Especially when we form stories in the mother tongue. Okay. Especially when we form stories in mother tongue, it will be more interesting. Okay. It will be more interesting. Okay. More interesting. in this fashion, what you can do is you can just give a try for all of these things. Okay, today you can just give a try, identify the keywords in each one of these articles. Okay, I can give you some clue, but these stories, if they are built by yourself, then it will help you to retain the content for a very long period of time. That will help you to retain the content for a very long period of time. Okay, long period of time. Okay. So today, will you do this work? Can you just give a try to identify the keywords in each of the articles? Okay, so you can give a try. So before we continue, okay, so fundamental rights to citizens only versus citizens plus foreigners except enemy aliens. So here, these are the fundamental rights which are available only to citizens. These are the fundamental rights available only to citizens. So these are the fundamental rights available to both citizens plus foreigners except enemy aliens. So in foreigners, some countries they have good relationship with India. Some countries do not have good relationship with India. For example, Pakistan, it does not have good relationship with India. Okay, if it comes to USA, it has a good relationship with India. So the USA citizens who are present in India, they are called as friendly aliens. The Pakistani citizens who are present in India, they are called as enemy aliens. So these provisions, they get applied to Indian citizens plus friendly aliens, but not to enemy aliens. Okay, enemy aliens. So here, what is article number 15? Discrimination. 16. Yes, equality of opportunity. Yes, freedom of religion. Protection of language. Okay, protection of language. Establish educational institutions of their own. Okay, own. So in this fashion, you should be able to recall all these provisions. This is very important. In the examination, they may give you few fundamental rights, and they may ask which of the fundamental rights are applicable only to Indian citizens. Which of the fundamental rights are applicable to Indian citizens as well as foreigners. Okay, as well as foreigners. Okay, foreigners. So before we start with the next, right to equality. Okay, right to equality, I would like to give you some work, okay, which is related to other subject, but very important from exam point of view. And these things, they cannot happen overnight. Okay, so gradually it has to be prepared. Okay, gradually it has to be prepared. So later on I'll be sharing you a link as well. Okay, link as well. So exam point of view, ಕೆಲವೊಂದಿಷ್ಟು ಟಾಪಿಕ್ಸ್ ನಾವೀಗ ನೆಕ್ಸ್ಟ್ ಡಿಸ್ಕಸ್ ಮಾಡ್ತೀವಲ್ಲ, ಸೊ ಇಟ್ ವಿಲ್ ಬಿ ಅಬೌಟ್ ಎನ್ವೈರ್ಮೆಂಟ್. ಓಕೆ, ಎನ್ವೈರ್ಮೆಂಟ್ ರಿಲೇಟೆಡ್ ಈಗ ಕೆಲವೊಂದಿಷ್ಟು ಟಾಪಿಕ್ಸ್ ಬರ್ತಾವೆ. ಹೆಂಗೆ ಪಾತ್ರ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ಹತ್ರ. ಓಕೆ, ಇಂಡಿಯಾದಾಗ ಒಂದು 55 ರಿಂದ 57 ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ಪ್ರತಿ ವರ್ಷ ಜಾಸ್ತಿ ಆಗ್ತಿರ್ತಾವೆ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್. ಆಮೇಲೆ ಒಂದು 100 ರಿಂದ 110 ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ಸ್. ಓಕೆ, ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ಸ್. ದೇರ್ ಆರ್ ಅರೌಂಡ್ 80 ರಾಮ್ಸಾರ್ ವೆಟ್ಲ್ಯಾಂಡ್ಸ್. ಓಕೆ, ರಾಮ್ಸಾರ್ ವೆಟ್ಲ್ಯಾಂಡ್ಸ್ ಅಂತ ಬರ್ತಾವೆ. ಆಮೇಲೆ ಒಂದು 18 ಬಯೋಸ್ಪಿಯರ್ ರಿಸರ್ವ್ಸ್. ಸೊ ಭಾಳಷ್ಟು ಜನ ಆಸ್ಪಿರೆಂಟ್ಸ್ ಏನು ಮಾಡ್ತಾರಪ್ಪ ಅಂತಂದ್ರೆ, ಅವು ಒಮ್ಮೆ ಲಿಸ್ಟ್ ನೋಡಿ ಅಂಜಿ ಬಿಡ್ತಾರೆ ಅವ್ರು. ಅಂದರೆ ಅವ್ರು ಅಷ್ಟು ಪ್ರಿಪೇರ್ ಮಾಡೋಕೆ ಹೋಗಿಲ್ಲ. ಅವ್ರು ಹೆಂಗೆ ಮಾಡ್ತಾರಪ್ಪ, ಕರೆಂಟ್ ಅಫೇರ್ಸ್ ಅಂತೇಳಿ ಯಾವುದೋ ನ್ಯೂಸ್ ಪೇಪರ್ದಾಗ ಬಂದದ್ದು, ಯಾವುದೋ ಒಂದು ಮ್ಯಾಗ್ಝಿನ್ದಾಗ ಬಂದದ್ದು ಅಂತ ಅಷ್ಟೇ ಒಂದು ಓದುವಂಥ ಪ್ರಯತ್ನ ಮಾಡ್ತಾರೆ. ಬಟ್ UPSC ಅಂತ ಆ ಥರ ಕೇಳಂಗಿಲ್ಲ. ನಾನು ನಿಮಗೆ ನೆಕ್ಸ್ಟ್ ಕ್ವಶನ್ ಪೇಪರ್ ಥ್ರೂ ತೋರಿಸ್ತೇನೆ. ಸೊ ದ ಥಿಂಗ್ಸ್ ವಿಚ್ ಆರ್ ನಾಟ್ ಪಾರ್ಟ್ ಆಫ್ ದ ಕರೆಂಟ್ ಅಫೇರ್ಸ್, ಇವನ್ ಕ್ವಶನ್ಸ್ ವಿಲ್ ಬಿ ಫ್ರೇಮ್ಡ್ ಆನ್ ದಟ್. ಸೊ ಅದಕ್ಕೆ ನಿಮ್ಮ ತಲೆಗಿಂದ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ರಿ, ನಾ ಇವತ್ತಿಲ್ಲ ನಾಳೆ ಒಂದು ಬೈ ಹ್ಯಾಟ್ ಮಾಡಬೇಕು. ಓಕೆ, ಹೆಚ್ಚು ಕಡಿಮೆ ಎಲ್ಲ ಸೇರಿಂದ 200 ಲಿಸ್ಟ್ ಆಗ್ತಾವೆ, ಬಟ್ ಒಂದೇ ದಿವಸ ಮಾಡೋಂಗಿಲ್ಲ. ಸೊ ಆ್ಯಸ್ ಇಟ್ ಈಸ್ ಫೇಮಸ್ಲಿ ಮೆನ್ಷನ್ಡ್ ದಟ್ ರೋಮ್ ಕೆನಾಟ್ ಬಿ ಬಿಲ್ಟ್ ಇನ್ ಅ ಡೇ. ಸೊ ಒಂದೇ ದಿವಸಕ್ಕೆಲ್ಲ ಮುಗಿಸ್ಬೇಕಿದ್ದು ಯಾರು ನಿಮ್ಗೆ ಚಾಲೆಂಜ್ ಮಾಡತ್ತಿಲ್ಲ. You take your own course of time. You take 5 days, 10 days, 15 days, 20 days. Okay. So there is a famous saying in English. You know, if you cannot fly, what you will do? Run. If you cannot run, walk. If you cannot walk, crawl. But whatever you are doing, keep moving forward. Then keep moving forward idla adu bhal important. Okay, bhal important. So ಅದಕ್ಕೆ ಯಾಕೆ ಈಗ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡತ್ತೀನಿ ಪಾತಾರೆ. So gradually you can start the process. Okay, you can start the process. ಸೊ ಇದೊಂದು ಅಫಿಷಿಯಲ್ ಗೌರ್ಮೆಂಟ್ ಸೈಟ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ದ ಮತ್ತು ಬೇರೆ ಭಾಳಷ್ಟು ಸೈಟ್ಸ್ ಇರ್ಬೋದು, ಬಟ್ ಜನರಲಿ ನಾವು ಪ್ರಿಪೇರ್ ಮಾಡಿದ್ದೆಲ್ಲ ಅಂತ ಐ ಬಿ ಪ್ರಿಪೇರಿಂಗ್ ಫ್ರಮ್ ವಾಟ್ ಅಥೆಂಟಿಕ್ ಗೌರ್ಮೆಂಟ್ ಸೈಟ್ಸ್. ಓಕೆ, ಅಥೆಂಟಿಕ್ ಗೌರ್ಮೆಂಟ್ ಸೈಟ್ಸ್. ಎಸ್, ಈಗ ಸದ್ಯ 58 ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ನಾವು. ದೇರ್ ಆರ್ 58 ಟೈಗರ್ ರಿಸರ್ವ್ಸ್. ಸೊ ಇವತ್ತು ಹೋಗಿ ನೀವು ಮನೆಯೊಳಗೆ ಹೋಗಿ ಏನು ಮಾಡ್ಬೇಕಪ್ಪ ಅಂತಂದ್ರೆ, ಒಂದು ಇಂಡಿಯಾದ ಮ್ಯಾಪ ಈ ಥರ ಒಂದು ಇಂಡಿಯಾದ ಮ್ಯಾಪ ನಿಮ್ಗೆ ತೆಗಿಯಕ್ಕೆ ಬರ್ತಿತ್ತು, ಸ್ವಂತ ಕೈಲಿ ತೆಗೀರಿ. ಬೈ ಚಾನ್ಸ್ ತೆಗಿಯಕ್ಕೆ ಆಲಿಕತ್ತವ್ರು ಅಂತ ರೆಡಿಮೇಡ್ ಮ್ಯಾಪ್ ಸಿಗ್ತಾವೆ, ತೊಗೋರಿ. ಆರ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ಮ್ಯಾಪ್ ಅಲ್ಲ, ಬ್ಲ್ಯಾಂಕ್ ಮ್ಯಾಪ್. ಒಂದು ಬ್ಲ್ಯಾಂಕ್ ಮ್ಯಾಪ್ ತೊಗೋತೀರಿ. ಆರ ಸ್ಟೇಟ್ ಡಿಮಾರ್ಕೇಶನ್ ಇದ್ರೂ ನಡೀತೈತಿ. ಆರ ಸ್ಟೇಟ್ಸ್ ಬರ್ದಿರಬಾರ್ದವ್ರು, ಇಲ್ಲಿ ಹಿಮಾಚಲ ಪ್ರದೇಶ, ಇಲ್ಲಿ ಕರ್ನಾಟಕ, ಯಾಕಂದ್ರೆ ಅದೆಲ್ಲ ಸ್ಪೇಸ್ ಕನ್ಸ್ಯೂಮ್ ಮಾಡ್ತೈತಿ. ಒಂದು ಬ್ಲ್ಯಾಂಕ್ ಮ್ಯಾಪ್ ತೊಗೋತೀರಿ. ವಿಲ್ ಟೇಕ್ ಅ ಬ್ಲ್ಯಾಂಕ್ ಮ್ಯಾಪ್. ಓಕೆ, ಇಫ್ ಯು ಆರ್ ಕಂಫರ್ಟೇಬಲ್ ಡ್ರಾಯಿಂಗ್ ಆನ್ ಯೋರ್ ಓನ್, ಇಟ್ ವುಡ್ ಬಿ ಬೆಟರ್. ಓಕೆ, ಇಟ್ ವುಡ್ ಬಿ ಬೆಟರ್. ನೆಕ್ಸ್ಟ್ ಎಕ್ಸಸೈಸ್ ಏನು ಮಾಡ್ತೀರಪ್ಪ ಅಂತಂದರೆ, ಸೊ ಯು ವಿಲ್ ಗೋ ಥ್ರೂ ದೀಸ್ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್. ಓಕೆ, ಇಲ್ಲಿ ಲಿಸ್ಟ್ ಐತಿ, ಮ್ಯಾಲೂ ಲಿಸ್ಟ್ ಐತಿ. ಸೊ ಇಲ್ಲಿ ಒಂದು 2-3 ರೌಂಡ್ ಮಾಡ್ತೀವಿ. ಫಸ್ಟ್ ರೌಂಡ್ ಅಷ್ಟೇ. ಓಕೆ, ಫಸ್ಟ್ ರೌಂಡ್ ವಿಲ್ ಸ್ಟಾರ್ಟ್ ವಿತ್ ಫಸ್ಟ್ ರೌಂಡ್. ವಾಟ್ ಇಸ್ ಇಟ್ ಫಸ್ಟ್ ರೌಂಡ್? ಸೊ ನಾಗಾರ್ಜುನ ಶ್ರೀಶೈಲಂ ಟೈಗರ್ ರಿಸರ್ವ್. ನಾಗಾರ್ಜುನ ಶ್ರೀಶೈಲಂ ಟೈಗರ್ ರಿಸರ್ವ್ ಇದು ಯಾವ ಸ್ಟೇಟ್ ಒಳಗೆ ಐತಿ? ಆಂಧ್ರ ಪ್ರದೇಶ್. ಕಮಲಾಂಗ್ ಟೈಗರ್ ರಿಸರ್ವ್ ಅರುಣಾಚಲ್ ಪ್ರದೇಶ್. ನಮ್ಮದಪ್ಪ ಟೈಗರ್ ರಿಸರ್ವ್ ಅರುಣಾಚಲ್ ಪ್ರದೇಶ್. ಪಕ್ಕೆ ಟೈಗರ್ ರಿಸರ್ವ್ ಅರುಣಾಚಲ್ ಪ್ರದೇಶ್. ಓಕೆ, ಸೊ ಈ ಥರ ನೀವು ಇವೇನು 57 ಟೈಗರ್ ರಿಸರ್ವ್ ಅದಲ್ಲ, ಇವು 57 ಟೈಗರ್ ರಿಸರ್ವ್ ನಿಮ್ಗೆ ಹೇಳಕ್ಕೆ ಬರಬೇಕು. ಯು ಶುಡ್ ಬಿ ಏಬಲ್ ಟು ವಾಟ್ ರಿಕಾಲ್ ದ ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಸ್ಟೇಟ್. ಓಕೆ, ಸ್ಟೇಟ್ ಮಾಡ್ಬೋದಾ? ಓಕೆ, ಇದು ವಿಸಿಬಲ್ ಐತೆ ನೋಡ್ರಿ, ಭಾಳ ಸಣ್ಣ ಐತೆ. ಇಸ್ ವಿಸಿಬಲ್? ಓಕೆ, ಸೊ ಏನು ಮಾಡೋದಪ್ಪ, ಫಸ್ಟ್ 30 ಇರ್ತಾನೆ ತೊಗೋತೀನಿ ನೋಡ್ರಿ. ಸೊ 20 ಇರ್ತಾನೆ. ಓಕೆ, 20 ಇರ್ತಾನೆ. ಈಗ ಒಂದು ಎಕ್ಸಸೈಸ್. ಸೊ ಇದು ಯಾವ್ದು ಬೇಕಾದ ಟೈಗರ್ ರಿಸರ್ವ್ ಕೇರ್, ಐ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು ಟೆಲ್ ಯು ದ ಸ್ಟೇಟ್. ಶಾಲ್ ವಿ ಸ್ಟಾರ್ಟ್ ಎಕ್ಸಸೈಸ್ ವಿತ್ ಮೀ ಇಟ್ ಸೆಲ್ಫ್? ಹೇಳ್ಬೋದಾ? ಹೇಳಿ ಟೈಗರ್ ರಿಸರ್ವ್. ಎಸ್, ರಾಜಾಜಿ ಉತ್ತರಾಖಂಡ್. ಬಟ್ ಓಕೆ, ಸ್ಟೇಟ್ ಬರ್ದಿಲ್ಲ ಅಲ್ಲಿ, ನೀವು ವೆರಿಫೈ ಮಾಡ್ಬೇಕನ್ನ. ಇಟ್ಸ್ ಉತ್ತರಾಖಂಡ್. ಎಸ್, BUXA ವೆಸ್ಟ್ ಬೆಂಗಾಲ್. ಎಸ್, ತಮಿಳ್ನಾಡು. ಕಾಜಿರಂಗ ಆಸಾಮ್. ಎಸ್, ಬಾಂಧವ್ಗರ್ ಮಧ್ಯ ಪ್ರದೇಶ್. ಎಸ್, ಮುಕುಂದರ ರಾಜಸ್ಥಾನ್. ಮಾನಸ್ ಟೈಗರ್ ರಿಸರ್ವ್ ಆಸಾಮ್. ಎಸ್, ಕಾವಲ್ ಟೈಗರ್ ರಿಸರ್ವ್ ತೆಲಂಗಾಣ. ಮುದುಮಲೈ ತಮಿಳ್ನಾಡು. ಛತ್ತೀಸ್ಗಢ. ದುಡುವಾ ಉತ್ತರ ಪ್ರದೇಶ್. ಎಸ್, ಇಂದ್ರಾವತಿ ಛತ್ತೀಸ್ಗಢ. ಎಸ್, ಕನ್ಹಾ ಮಧ್ಯ ಪ್ರದೇಶ್. ಎಸ್, ಭದ್ರಾ ಕರ್ನಾಟಕ. ಎಸ್, ಶಾಲ್ ವಿ ಗೋ ಟು ದ ನೆಕ್ಸ್ಟ್ 20? ಕೆಲವೊಂದಿಷ್ಟು ಗೊತ್ತಿಲ್ಲ, ಹೊಸದಾಗಿ ಆ್ಯಡ್ ಮಾಡಿದ್ದು, ಮತ್ತು ಅದನ್ನು ಕೇಳಬಾರ್ದು ನೀವು. ಎಸ್, ಎಸ್, ಪನಾ ಟೈಗರ್ ರಿಸರ್ವ್ ಇಟ್ ಈಸ್ ಮಧ್ಯಪ್ರದೇಶ್. ಅಲ್ಲಿ ಮತ್ತೊಂದು ಪೆಂಚ್ ಐತೆ ಬರ್ತೈತಿ, ಅದು ಮಧ್ಯಪ್ರದೇಶ ಪ್ಲಸ್ ಮಹಾರಾಷ್ಟ್ರ ಎರಡು ಕಡೆ ಶೇರ್ಡ್ ಐತದೆ. ಪನಾ ಇಸ್ ಮಧ್ಯಪ್ರದೇಶ್. ಎಸ್, ಉತ್ತರ ಪ್ರದೇಶ್. ಎಸ್, ಮಧ್ಯಪ್ರದೇಶ್. ಒಡಿಸ್ಸಾ. ಎಸ್, ಮಹಾರಾಷ್ಟ್ರ. ಸತ್ಕೋಸಿಯಾ ಸಾತ್ಕೋಶ್ ಒಡಿಸ್ಸಾ. ವಾಲ್ಮೀಕಿ ಬಿಹಾರ್. ಸಿಮ್ಲಿಪಾಲ್ ಒಡಿಸ್ಸಾ. ವೆಸ್ಟ್ ಬೆಂಗಾಲ್. ಓಕೆ, ಸೊ ಅನ್ನ ಕುದ್ದತೆ ಇಲ್ಲೋ ಅನ್ನೋಕ್ಕಿಂತ ಫುಲ್ ಎಲ್ಲ ಎಂಟೈರ್ ತಿರ್ಬೇಕೈತೆ ಇಲ್ಲ, ಒಂದು 4-5 ಕೇಳಿದ್ರೆ ಮುಗೀತದೆ. ಓಕೆ, ಸೊ ದಿಸ್ ಈಸ್ ಮೈ ಕಾನ್ಫಿಡೆನ್ಸ್. ಓಕೆ, ಆ್ಯಂಡ್ ನನ್ನ ಮೆಮ್ರಿ ಅಂತಲೇ ಬೇರೆದವ್ರಿಗೆ ಕಂಪೇರ್ ಮಾಡಿದಾಗ ಅನಿಸುತ್ತಲ್ಲ, ನನ್ನ ಮೆಮ್ರಿ ಭಾಳ ವೀಕ್ ಐತಿ. ಓಕೆ, ವೆನ್ ಐ ಕಂಪೇರ್ ಮೈಸೆಲ್ಫ್ ವಿತ್ ದ ಅದರ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಆ್ಯಂಡ್ ಆಲ್, ಸೊ ದೇ ಹ್ಯಾವ್ ಫೋಟೋಗ್ರಾಫಿಕ್ ಮೆಮ್ರಿ. ಕೆಲವು ನೋಡಿದ ತಕ್ಷಣ ನೆನ್ಪು ಬಿಡ್ತೈತಿ, ಹಾಗಾಗಿ ನೆನ್ಪು ಉಳಿಯಂಗಿಲ್ಲ. ಬಟ್ ಹಿಂಗೆ ನೆನ್ಪು ಉಳಿಲಾಕ ಏನಿದೆ, ಒಂದು ಸ್ಟಾರ್ಟಿಂಗಲ್ಲಿ ಎಫರ್ಟು ಮಾಡಿದ್ದೈತಿ. ಬಟ್ ಎರಡನೇದು ಏನಪ್ಪ ಅಂತಾರೆ, ಬಿಕಾಸ್ ಆಫ್ ದ ಸೈಕಾಲಜಿಕಲ್ ಟೆಕ್ನಿಕ್ಸ್. ಬಿಕಾಸ್ ಆಫ್ ದ ಸೈಕಾಲಜಿಕಲ್ ಟೆಕ್ನಿಕ್ಸ್ ವಿಚ್ ಐ ಹ್ಯಾವ್ ಲರ್ನ್ಡ್. ಸೊ ಮೇನ್ಸ್ ಒಳಗೆ ನಂದು ಆಪ್ಷನಲ್ ಸೈಕಾಲಜಿ ಇತ್ತು. ಆಮೇಲೆ ನಾ ಪಾರ್ಟ್ ಟೈಮ್ ಐ ವಾಸ್ ಪ್ರಿಪೇರಿಂಗ್ ಪಾರ್ಟ್ ಟೈಮ್ ಬಿಕಾಸ್ ಐ ವಾಸ್ ವರ್ಕಿಂಗ್ ಇನ್ ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜ್. ಸೊ ಅದ್ರ ಜೋಡಿನ ಆಮೇಲೆ ಸಾಯಂಕಾಲ ಬಂದು ಓದುವತ್ನಾಗ ಭಾಳಷ್ಟು ಕಂಟೆಂಟ ಶಾರ್ಟ್ ಟೈಮ್ದಾಗ ರಿವಿಷನ್ ಮಾಡ್ಬೇಕು ಅಂತಾರೆ. ಮತ್ತು ಯಾವ ಟೆಕ್ನಿಕ್ಸ್ ಹುಡುಕಾಡ್ತಿದ್ದೆ. ಬಟ್ ಇದೇ ನಾವು ಒಂದು ಟೆಕ್ನಿಕ್ಸ್ ವಿಚ್ ಐ ಹ್ಯಾವ್ ಬಿಲ್ಟ್, ಇಟ್ಸ್ ವೆರಿ ಯೂನಿಕ್. ಯಾಕಂದ್ರೆ ಭಾಳಷ್ಟು ಜನ ಬೇರೆ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ದಾಗ ಯಾರು ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಲ್ರೆಡಿ ಕಲ್ತು ನಮ್ಮಲ್ಲಿ ಜಾಯ್ನ್ ಆಗ್ಯಾರಲ್ಲ, ಸೊ ದೇ ಹ್ಯಾವ್ ಸೆಡ್ ದಟ್ ದಿಸ್ ಇಸ್ ವೆರಿ ಯೂನಿಕ್ ಆ್ಯಂಡ್ ದೇ ಹ್ಯಾವ್ ಫಾಲೋಡ್ ದಿಸ್ ಟೆಕ್ನಿಕ್ ಆಸ್ ವೆಲ್. ಆ್ಯಂಡ್ ಇಟ್ ಹಸ್ ಬೆನಿಫಿಟೆಡ್ ದಮ್ ಆಸ್ ವೆಲ್ ಇನ್ ದ ಫಿಲ್ಮ್ಸ್, ಇನ್ಫ್ಯಾಕ್ಟ್ ಇನ್ ಫಾರ್ ದ ಮೇನ್ಸ್ ಆಸ್ ವೆಲ್. ಯಾಕಂದ್ರೆ ನೆನ್ಪು ಮಾಡ್ಕೊಂತ ಶಕ್ತಿ ಇದ್ರೆ ಅದು ಭಾರಿ ಹೆಲ್ಪ್ ಆಗೈತಿ. ಸೊ ಸೈಕಾಲಜಿ ಬುಕ್ ಒಳಗೆ 11th ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಬುಕ್ ಐತದ, ಬಟ್ ಫುಲ್ ಡೀಟೇಲ್ ಕೊಟ್ಟಿಲ್ಲ, ಸ್ವಲ್ಪ ಕ್ಲೂ ಕೊಟ್ಟರು ಅವರು. ಬಟ್ ಆ ಕ್ಲೂ ಮೇಲೆ ಏನಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಐ ಹ್ಯಾವ್ ಪ್ಲೇಡ್. Okay, next I have played. So in 2019, I took a leave of 2.5 months. So I revised the content of close to 4 years. ಒಂದು 4 ವರ್ಷದ ಕರೆಂಟ್ ಅಫೇರ್ಸ್ ಓದಿದ್ನಿ, ಎಂಟೈರ್ ಸ್ಟ್ಯಾಟಿಕ್ ಎಲ್ಲ ರಿವೈಸ್ ಮಾಡಿದ್ನಿ. ಸೊ ಎಲ್ಲನೂ ಒಂದು ಕಾನ್ಫಿಡೆನ್ಸ್ ಇತ್ತು ನನಗೆ, ಎಕ್ಸಾಮ್ ಈ ಥರ ಕೇಳಿದ್ರೆ ನಾ ಮಾರ್ಕ್ ಮಾಡ್ಬೋದು ಅಂತೇಳಿ, ಬಿಕಾಸ್ ಆಫ್ ದ ಸೈಕಾಲಜಿಕಲ್ ಟೆಕ್ನಿಕ್ಸ್ ವಿಚ್ ಐ ಹ್ಯಾಡ್ ಯೂಸ್ಡ್. ಸೊ ಆ ಕೆಲವೊಂದಿಷ್ಟು ಟೆಕ್ನಿಕ್ಸ್ ಇಲ್ಲ ಶೇರ್ ಮಾಡ್ತೀನಿ ಅದು. ಓಕೆ, ಆ ಟೆಕ್ನಿಕ್ ಒಂದೇ ಸತಿ ನೀವು ಬರೋಂಗಿಲ್ಲ, ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪ್ರಾಕ್ಟಿಸ್ಡ್. ಅದು ಯಾರ ಪಾತ್ರ, ಯಾರು ಫೋಟೋಗ್ರಾಫಿಕ್ ಮೆಮ್ರಿ ಇಲ್ಲ. ಈ ಕೆಲವರು ಫೋಟೋಗ್ರಾಫಿಕ್ ಮೆಮ್ರಿ ಇದ್ದರೂ ಏನಾಗ್ತೈತೆ ಅಂದ್ರೆ ಅವರು ಮರಿಯುವಂಥ ಚಾನ್ಸ್ ಇರ್ತದೆ ಲಾಂಗ್ ಟರ್ಮ್ದಾಗ. ಬಟ್ ಇಂಥವು ಕೆಲವೊಂದಿಷ್ಟು ಟೆಕ್ನಿಕ್ಸ್ ದೇ ವಿಲ್ ಹೆಲ್ಪ್ ಅಸ್ ಲೈಕ್ ಎನಿಥಿಂಗ್. ಓಕೆ, ದೇ ವಿಲ್ ಹೆಲ್ಪ್ ಅಸ್ ಲೈಕ್ ಎನಿಥಿಂಗ್. ಈಗ ವಿಲ್ ಜಸ್ಟ್ ಗೋ ಬ್ಯಾಕ್ ಟು ದಿಸ್ ಲಿಸ್ಟ್. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಸೊ ವಿಚ್ ಆರ್ ದ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ಪ್ರೆಸೆಂಟ್ ಇನ್ ರಾಜಸ್ಥಾನ್? ಎಸ್, ಹಿಯರ್ ವಿ ಹ್ಯಾವ್ ರಣಥಂಬೋರೆ, ಸರಿಸ್ಕಾ, ಎಲ್ಲಿತ್ರಿ, ರಾಮ್ಗರ್, ಮುಕುಂದರ. ಓಕೆ, ಮುಕುಂದರ. ಮತ್ತೆ ಯಾವ್ದು ಐತಾ? ಬಹುಶಃ ಮ್ಯಾಲೆ ಇರ್ಬೋದು, ನೋಡೋಣ ಮ್ಯಾಲೆ ಐತೆ ನೋಡೋಣ. ಓಕೆ, ಇಲ್ಲ. ಸೊ ದೇರ್ ಆರ್ 4 ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ಇನ್ ರಾಜಸ್ಥಾನ್: ಮುಕುಂದರ, ರಾಮ್ಗರ್, ರಣಥಂಬೋರೆ, ಸರಿಸ್ಕಾ. ನಾವು ದೀಸ್ ಆರ್ ದ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್. ಈ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ನ ನಾವು ರಾಜಸ್ಥಾನ್ ಜೋಡಿ ಅಸೋಸಿಯೇಟ್ ಮಾಡಿ ನೆನ್ಪಿಡ್ಬೇಕಾಗೈತಿ. ಓಕೆ, ನೆನ್ಪಿಡ್ಬೇಕಾಗಿತ್ತು. ಹಂಗೆ ಪ್ರತಿಯೊಂದು ಟೈಗರ್ ರಿಸರ್ವ್ನು ಆ ಸ್ಟೇಟ್ ಜೋಡಿ ಅಸೋಸಿಯೇಟ್ ಮಾಡಿ ನೆನ್ಪಿಡ್ಬೇಕಾಗೈತಿ. ಸೊ ದಿಸ್ ವಿಲ್ ಬಿ ದ ಚಾಲೆಂಜ್. ಓಕೆ, ದಿಸ್ ವಿಲ್ ಬಿ ಚಾಲೆಂಜ್. ಅದಕ್ಕೆ ಭಾಳ ಜನ ಮಾಡ್ತಾರೆ 57 ಮಾಡಂಗಿಲ್ಲ, ಸುಮ್ಮನೆ 5-6 ಮಾಡ್ಕೊಂಬಿಡೋದು. ಎಕ್ಸಾಮ್ ಹಾಲ್ದಾಗ ಹೋದಾಗ ಏನಿಲ್ಲ, ಇವು 7 ಬಿಟ್ಟು ಏನು ಬೇರೆ ಕೇಳಿರ್ತಾರೆ ಅವ್ರು. ಸೊ ಅದಕ್ಕೆ ಎಕ್ಸಾಮ್ ಹಾಲ್ಗೆ ಹೋಗಿಂತ ಮೊದಲು ನಿಮ್ಮ ಕಾನ್ಫಿಡೆನ್ಸ್ ಬೂಸ್ಟ್ ಆಗಬೇಕು. ಯುವರ್ ಕಾನ್ಫಿಡೆನ್ಸ್ ಶುಡ್ ಬಿ ಬೂಸ್ಟೆಡ್. ಸೊ ಹಿಯರ್ ದ ಹ್ಯೂಮನ್ ಬ್ರೈನ್, ಹೌ ಇಟ್ ವರ್ಕ್ಸ್, ಹ್ಯೂಮನ್ ಬ್ರೈನ್ ಯಾವ ಥರ ಫಂಕ್ಷನಿಂಗ್ ಮಾಡ್ತೈತಿ. ಓಕೆ, ಸೊ ದಟ್ ಈಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಸೊ ದಟ್ ಈಸ್ ದ ಪಾರ್ಟ್ ಆಫ್ ಸೈಕಾಲಜಿ. ಓಕೆ, ದಟ್ ಇಸ್ ದ ಪಾರ್ಟ್ ಆಫ್ ಸೈಕಾಲಜಿ. ಸ್ಟಾರ್ಟಿಂಗ್ ಸೈಕಾಲಜಿ ಆಪ್ಷನ್ ತೊಗೊಳೋಕೆ ಗೊತ್ತಿರಲ್ಲ, ಬಟ್ ನೆಕ್ಸ್ಟ್ ನಾನು ತೊಗೊಂಡ್ಮೇಲೆ ಗೊತ್ತಾಯ್ತು ಓಕೆ ಯಾವ ಥರ ವರ್ಕ್ ಆಗ್ತೈತಿ. ಏನು ರೀ, ಯಾವ ರೀ? ಓಕೆ, ಹೊಸದಾಗಿ ಆ್ಯಡ್ ಮಾಡ್ಯಾರ. ಯಾವ ಎಂಟ್ರಿ ನಂಬರ್ ಎಷ್ಟೈತೆ ನೋಡ್ರದ? ಎಲ್ಲೈತೆ ನೋಡ್ರಲ್ಲಿ. ಓಕೆ, ರಥಪಾನಿ, ರಥಪಾನಿಯ ಅಲ್ಲ, ಡೋಲ್ಪುರ್ ಕರೌಲಿ, ರೈಟ್, ಡೋಲ್ಪುರ್ ಕರೌಲಿ. ಸೊ ಅದನ್ನು ಬೇಕಾದ್ರೆ ಆ್ಯಡ್ ಮಾಡ್ತೀನಿ. ಸೊ ಹಂಗೆ ಸ್ವಲ್ಪ ವರ್ಷ ಒಂದು ಕೆಲಸದ ಜಾಸ್ತಿ ಆಗ್ತಿರ್ತಾವೆ. ಎಲ್ಲಿ ಹೋದ್ರದ? ಓಕೆ, ಸೊ ಆಲ್ರೆಡಿ ಇವು 5 ಅನ್ಕ ಇಲ್ಲದಾವು, 4 ಪ್ಲಸ್ ಡೋಲ್ಪುರ್ ಕರೌಲಿ. ಸೊ ಹ್ಯೂಮನ್ ಬ್ರೈನ್ ಇನ್ಫಾರ್ಮೇಷನ್ ಯಾವಾಗ ಹಿಂಗೆ ನೆನಪಿಡ್ತಾರ, ವೆನ್ ಇನ್ಫಾರ್ಮೇಷನ್ ಇಸ್ ಪ್ರೆಸೆಂಟೆಡ್ ಇನ್ ದ ಫಾರ್ಮ್ ಆಫ್ ಪಿಕ್ಚರ್. ಒಂದು ಪಿಕ್ಚರ್ ರೂಪದಾಗ ನಾವು ಅದಕ್ಕೆ ಇನ್ಫಾರ್ಮೇಷನ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ವಿ ಅಂದರೆ ಅದು ಭಾಳ ದಿವಸ ನೆನ್ಪಿಟ್ಕೋತೈತಿ. ಸೊ ದಿಸ್ ಅ ಕಾಮನ್ ಟೆಂಡೆನ್ಸಿ ಆ್ಯಂಡ್ ಇಟ್ಸ್ ವೆರಿ ಈಸಿಲಿ ವಾಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡೇಬಲ್. ಯಾಕಪ್ಪ ಅಂದ್ರೆ ನೀವು ಕ್ಲಾಸ್ ರೂಮ್ದಾಗ ಎಲ್ಲೂ ಕೂತ್ ಕೇಳಿರ್ತೀರಿ, ಒಂದು ತಾಸು ಕೂತ್ ಕೇಳಿರ್ತೀರಿ, ಫಿಲ್ಮ್ದಾಗ 3 ತಾಸು ಕೂತ್ ಫಿಲ್ಮ್ ನೋಡಿರ್ತೀರಿ. ಯಾವ್ದು ಅಗದಿ ಈಸಿಲಿ ನೆನ್ಪೋದಿರ್ತೈತಿ ಫಿಲ್ಮ್, ಅಗದಿ ಸೀನ್ ಟು ಸೀನ್, ಆ ಡೈಲಾಗ್ ಟು ಡೈಲಾಗ್ ಪ್ರತಿಯೊಂದು ನೆನ್ಪೋದಿರ್ತೈತಿ. ಇಲ್ಲಿ ಪಾಪ್ ಸರ್ ಅಂತ 1 ತಾಸು ಬಿಟ್ಟು ಎಷ್ಟೆಲ್ಲ ಅವ್ರು ಒದರಾಡಿ ಹೇಳಿದ್ರು ಹಾರ್ಡ್ಲಿ ಒಂದು 2 ನಿಮಿಷದ 3 ನಿಮಿಷದಕ್ಕಿಂತ ಜಾಸ್ತಿ ನೆನಪಿರಂಗಿಲ್ಲ. ಮತ್ತು ಹೋಗಿ ವಾಪಸ್ ನೀವು ರಿವಿಷನ್ ಮಾಡ್ಬೇಕು, ನೆನಪು ಬರ್ತೈತಿ. ಯಾಕಪ್ಪ ಅಂತಾರೆ, ವಾಟ್ಸ್ ದ ಡಿಫ್ರೆನ್ಸ್? ಫಿಲ್ಮ್ ಥಿಯೇಟರ್ದಾಗ ಎಲ್ಲನೂ ಏನು ಪಿಕ್ಚರಲ್ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಇರ್ತೈತಿ, ಇಲ್ಲಿ ಥೆರಾಟಿಕಲ್ ಇರ್ತೈತಿ. ಸೊ ಎಲ್ಲೆಲ್ಲಿ ಪಿಕ್ಚರೈಸ್ ಮಾಡುವಂಥ ಪ್ರಯತ್ನ ಮಾಡಿರ್ತಾರಲ್ಲ, ಅದು ನೀವು ಭಾಳ ದಿವಸ ನೆನ್ಪೋದಿರ್ತೈತಿ. ನೀವು ಕ್ಲಾಸ್ ಯಾರೇ ಟೀಚರ್ಸ್, ಇಫ್ ದೇ ಹ್ಯಾವ್ ಡೆಮಾನ್ಸ್ಟ್ರೇಟೆಡ್ ಸಮಥಿಂಗ್ ದಟ್ ಯು ವಿಲ್ ಬಿ ಏಬಲ್ ಟು ರಿಟೈನ್ ಫಾರ್ ಅ ವೆರಿ ಲಾಂಗ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಓಕೆ, ಲಾಂಗ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಸೊ ಹಂಗೆ ನೀವು ಕನ್ನಡ ಒಂದು ಫೇಮಸ್ ಫಿಲ್ಮ್ ಐತಿ, ಆ ಮಲ್ಟಿಪಲ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಆಫ್ ಫಿಲ್ಮ್ ಮಾಡ್ಯಾರ ಅದನ್ನು, ದೃಶ್ಯಂ ಅಂತೇಳಿ. ಓಕೆ, ಆ್ಯಕ್ಚುಲಿ ಒರಿಜಿನಲ್ ಇಟ್ಸ್ ಅ ಮಲಯಾಳಂ ಫಿಲ್ಮ್. ಸೊ ಮಲಯಾಳಂ ಫಿಲ್ಮ್ ದೃಶ್ಯಂ ಹೋಗಿ ಅಂತ ಕನ್ನಡದಾಗ ಮಾಡಿದ್ರು, ತೆಲುಗುದಾಗ ಮಾಡಿದ್ರು, ತಮಿಳ್ದಾಗ ಮಾಡಿದ್ರು, ಹಿಂದಿಯಾಗ ಮಾಡಿದ್ರು, ಎಲ್ಲ ಲ್ಯಾಂಗ್ವೇಜಾಗ ಹಿಟ್ ಆಯ್ತು ಫಿಲ್ಮ್ ಅದು. ಓಕೆ, ಸೊ ಆ ಫಿಲ್ಮ್ ಸ್ಟೋರಿ ಏನೈತಿ ಬೇಸಿಕಲಿ, ವಾಟ್ ಇಸ್ ದ ಸ್ಟೋರಿ ಲೈನ್? ಎಸ್, ಒಂದು ಬೇಸಿಕಲಿ ಮರ್ಡರ್ ಆಗಿರ್ತೈತಿ. ಸೊ ಆ ಮರ್ಡರ್ ಈ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಮಾಡಿರ್ತಾರೆ, ಅದನ್ನ ಮಾಡಿದ್ದು ತಪ್ಪಿಸ್ಬೇಕಾಗಿರ್ತೈತಿ. ತಪ್ಪಿಸೋದಕ್ಕೆ ಅವ ಏನು ಮಾಡ್ತಾನಪ್ಪ ಅಂದ್ರೆ ಒಂದು ಸ್ಟೋರಿ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾನೆ, ಅದು ಸುಳ್ಳು ಸ್ಟೋರಿ. ಓಕೆ, ಸುಳ್ಳು ಸ್ಟೋರಿ. ಅವ್ನು ಆ್ಯಕ್ಚುಲಿ ಹೋದದ್ದು ಒಂದು 15ನೇ ತಾರೀಕು ಹೋಗಿದ್ದಂದ್ರೆ ಅಲ್ಲಿ ಹೇಳ್ತಾನೋ, ನಾ 10ನೇ ತಾರೀಕು ಹೋಗಿದ್ನಿ, 10ನೇ ತಾರೀಕು ಹೋಗಿದ್ನಿ, 10ನೇ ತಾರೀಕು ನಿಮ್ಮ ಬಸ್ನಾಗ ತಿರುಗಾಡಿದ್ನಿ. ಹಾಂ, ಓಕೆ. ಸೊ 15ನೇ ತಾರೀಕು ಹೋದ್ರೆ 10ನೇ ತಾರೀಕು ಹೋಗಿನೇ ತಿಳೋದು ಆ ಬಸ್ನಾಗ. ಆ್ಯಕ್ಚುಲಿ ಹೋದ 15ನೇ ತಾರೀಕು, 10ನೇ ತಾರೀಕು ನಾ ನಿಮ್ಮ ಹೋಟೆಲ್ ಟಿಫಿನ್ ಮಾಡೀನಿ, 10ನೇ ತಾರೀಕು ನಿಮ್ಮ ಥಿಯೇಟರ್ ಫಿಲ್ಮ್ ನೋಡೀನಿ. ಹಿಂಗೆ ಒಂದು ಸುಳ್ಳು ಸ್ಟೋರಿ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾನೆ. ಸುಳ್ಳು ಸ್ಟೋರಿ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಅದನ್ನು ರಿಪೀಟೆಡ್ಲಿ ಎಲ್ಲರಿಗೂ ಟ್ರೈನ್ ಅಪ್ ಮಾಡ್ತಾನೆ. ತಮ್ಮ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ಗೆಲ್ಲ ಹೇಳ್ತಾನೆ. ಹೊರಗೆ ಹೋದವರೆಲ್ಲ ಸೇಮ್ ಒಂದು ಹೇಳಿ ಅಂತ ಅವ್ರ ತಲೆಯಾಗಿ ಇನ್ಫಾರ್ಮೇಷನ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸ್ಬಿಟ್ಟಿರ್ತಾನೆ. ಓಕೆ, ತಲೆಯಾಗಿ ಇನ್ಫಾರ್ಮೇಷನ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಬಿಟ್ಟಿರ್ತಾನೆ. ನೆಕ್ಸ್ಟ್ ಟೆಸ್ಟಿಮನಿ ಕೊಡಕ್ಕೆ ಬಂದಾಗ ಎಲ್ಲಿದ್ರಿ, 10ನೇ ತಾರೀಕು, 10ನೇ ತಾರೀಕು ಅವ್ನು ಪೂಜೆಗೆ ಹೋಗಿದ್ರಿ. ಓಕೆ, ಹೇಳಿ ಅವ್ನು ತಲೆ ಕೂತ್ಬಿಟ್ಟಿರ್ತಾರೆ, 10ನೇ ತಾರೀಕು ಪೂಜೆಗೆ ಹೋಗಿದ್ದ. ಆಮೇಲೆ ಸೆಕೆಂಡ್ ರೌಂಡ್ದಾಗ ಗೊತ್ತಾಗ್ತೈತಿ ಏನು ಮಾಡ್ಯಾನಪ್ಪ, ಈ ಥರ ಎಲ್ಲ ಗೇಮ್ ಮಾಡ್ಯಾನು. ಸೊ ಅದಕ್ಕೆ ಆ ಎಂಟೈರ್ ಫಿಲ್ಮ್ ಹೆಸರು ಏನು ಕೊಟ್ಟಪ್ಪ ಅಂದ್ರೆ ದೃಶ್ಯಂ. ವಾಟ್ ಇಸ್ ಎ ದೃಶ್ಯಂ? ಓಕೆ ಅದು ಹೇಳ್ತಾರೆ ಅವರು ಸೀನ್ಸ್, ದ ಸೀನ್ಸ್ ವಿಚ್ ಹಿ ಹ್ಯಾಸ್ ಕ್ರಿಯೇಟೆಡ್, ದ ಸೀನ್ಸ್ ವಿಚ್ ಡಸ್ ನಾಟ್ ಎಕ್ಸಿಸ್ಟ್. ಓಕೆ, ಸೊ ಅದಕ್ಕೆ ಫಿಲ್ಮ್ ಹೆಸರು ದೃಶ್ಯ ಮತ್ತೆ ಕೊಟ್ಟರು. ಸೊ ಪಾರ್ಟ್ 1 ಹಂಗೈತಿ, ಪಾರ್ಟ್ 2 ಅಂತ ಅದಕ್ಕಿಂತ ಮತ್ತೆ ಜಬರ್ದಸ್ತ್ ಐತಿ. ಸೊ ನೋಡ್ಬೇಕು, ಯಾರು ನೋಡಿಲ್ಲ ಫಿಲ್ಮ್. ಸೊ ಪಾರ್ಟ್ 1 and 2, ಸೊ ಬೋತ್ ಆಫ್ ದಮ್ ಯು ಶುಡ್ ವಾಚ್. ಸೊ ಆ ಫಿಲ್ಮ್ ಹೆಸರು ದೃಶ್ಯ ಏನಪ್ಪ ಅಂತಾರೆ ಸೀನ್ಸ್. ಬಿಕಾಸ್ ಸೀನ್ಸ್ ಒನ್ಸ್ ದೇ ಆರ್ ರಿಜಿಸ್ಟರ್ಡ್ ಇನ್ ಅವರ್ ಬ್ರೈನ್, ದೇ ವಿಲ್ ಸ್ಟೇ ದೇರ್ ಫಾರ್ ಅ ವೆರಿ ಲಾಂಗ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಓಕೆ, ಲಾಂಗ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಸೊ ಎಲ್ಲೆಲ್ಲಿ ಸಾಧ್ಯತೆ ಇನ್ಫಾರ್ಮೇಷನ್ ನಾವು ಬ್ರೈನಿಗೆ ರಿಜಿಸ್ಟರ್ ಮಾಡುವತ್ನಾಗ ಎಲ್ಲೆಲ್ಲಿ ಸಾಧ್ಯತೆ ಎಲ್ಲೆಲ್ಲಿ ನಮ್ಗೆ ಡಿಫಿಕಲ್ಟಿ ಅನಿಸ್ತೈತಿ, ಅದೊಂದು ಸೀನ್ ಮುಖಾಂತರ ನಾವು ಎಲ್ಲರೂ ಅದನ್ನ ಇನ್ಫಾರ್ಮೇಷನ್ ಪುಷ್ ಮಾಡಿದ್ವಿ ಅಂತಾರೆ, ದ ಇನ್ಫಾರ್ಮೇಷನ್ ಕ್ಯಾನ್ ಬಿ ರಿಟೈನ್ಡ್ ಫಾರ್ ಅ ವೆರಿ ಲಾಂಗ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಓಕೆ, ಕ್ಯಾನ್ ಬಿ ರಿಟೈನ್ ಫಾರ್ ಅ ವೆರಿ ಲಾಂಗ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಬಟ್ ಪುಷ್ ಮಾಡೋದೈತಿಲ್ಲ, ಅಲ್ಲಿ ಎಫರ್ಟ್ ಐತಿ ಸ್ಟಾರ್ಟಿಂಗ್. ಒಂದ್ಸತಿ ಪುಷ್ ಆಯಿತು ಅನ್ಕೋರಿ, ನೀವು ಯಾರೇ ಫೋರ್ಸ್ಫುಲಿ ಇದನ್ನು ಮರೀರ್ಪ ಆದರೂ ಮರೆಯೋಕ್ಕಾಗಿಲ್ಲ. ಬಿಕಾಸ್ ಇಟ್ ವಿಲ್ ಬಿಕಮ್ ಯೋ ಇಂಟಿಗ್ರಲ್ ಪಾರ್ಟ್. ಓಕೆ, ಇಟ್ ವಿಲ್ ಬಿಕಮ್ ಯೋ ಇಂಟಿಗ್ರಲ್ ಪಾರ್ಟ್. ಸೊ ಆ ಥರ ಕೆಲವೊಂದಿಷ್ಟು ಎಕ್ಸಾಂಪಲ್ಸ್ ನೋಡ್ಬೋದು. ಸೊ ಹೌ ಐ ಹ್ಯಾವ್ ಕ್ರಿಯೇಟೆಡ್ ಸೀನ್ಸ್ ಫಾರ್ ಮೈ ಸೆಲ್ಫ್. These scenes are not for you. If you want, you can take it. But these scenes were created for my own memory, so that I can register the information easily. ಈ ಕೆಲವರಿಗೆ ಇದು ಬೇಕಾಗಿಲ್ಲ, ಯಾರು ಫೋಟೋಗ್ರಾಫಿಕ್ ಮೆಮರಿ ಇರುತ್ತೆ ಅವ್ರು ಈಸಿ ನೆನ್ಪಿಟ್ಕೋಬೋದು. ಬಟ್ ಫಾರ್ ದೋಸ್ ಹೂ ಡು ನಾಟ್ ಹ್ಯಾವ್ ದಟ್ ಮೆಮರಿ, ಸೊ ಏನು ಮಾಡ್ತೀವಿ ಅಂತಾರೆ, ಒಂದು ಇಮ್ಯಾಜಿನರಿ ಸ್ಟೋರಿ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತೀವಿ ಇಲ್ಲಿ ಬೈ ಯೂಸಿಂಗ್ ದ ವರ್ಡ್ಸ್ ವಿಚ್ ಆರ್ ಪ್ರೆಸೆಂಟ್ ಓವರ್ ಹಿಯರ್. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಸರಿಸ್ಕಾ, ಈ ಸರಿಸ್ಕಾ ರಾಜಸ್ಥಾನ್, ಸರಿಸ್ಕಾ ರಾಜಸ್ಥಾನ್, ಸರಿಸ್ಕಾ ರಾಜಸ್ಥಾನ್, ದಿಸ್ ಇಸ್ ಅ ರಿಹರ್ಸಲ್ ಮೆಥಡ್. ನಾವು ಪ್ರೈಮರಿ ಡೇಸ್ ಹೆಂಗೆ ಟೇಬಲ್ಸ್ ಕಲಿತೀವಲ್ಲ, 2 1 2 2 2 4 2 3 6. ಓಕೆ, ಯಾರೇ 7 8 ಕೇಳಿದ್ರೆ ಅಂದ್ರೆ 56 ಹಂಗಿಲ್ಲ ನಾವು. 7 1 7, 7 2 14, 7 3 21, ಈ ಥರ ರಿಹರ್ಸಲ್ ಮಾಡಿರ್ತೀವಿ. ಓಕೆ, ದಿಸ್ ಇಸ್ ಅ ರಿಹರ್ಸಲ್ ಮೆಥಡ್ ಥ್ರೂ ವಿಚ್ ವಿ ಹ್ಯಾವ್ ಲರ್ನ್ಡ್. ಓಕೆ, ಸೊ ಈಗ ಜನರಲಿ ಈಗ ನಮ್ಮ ಹ್ಯೂಮನ್ ಬ್ರೈನ್ ಹಂಗೆ ರಿಹರ್ಸಲ್ ಥ್ರೂನ ಕಲಿತಿರ್ತೈತಿ. ರಿಹರ್ಸಲ್ ಥ್ರೂನ ಇಂತಲೇ ಮಲ್ಟಿಪಲ್ ಸತಿ ಓದೋದು, ಅದು ಬ್ಯಾಟ್ ಮಾಡ್ದಂಗೆ ಮಾಡೋದು, ಮತ್ತು ರಿಕಾಲ್ ಮಾಡೋದು, ಬರೀದು, ಈ ಥರ ಮಾಡ್ತಿರ್ತದೆ. ಸೊ ಈ ಥರ ಇದು ಲ್ಯಾಟ್ರಲ್ ಥಿಂಕಿಂಗ್ ಮತ್ತೊಂದು ಮೆಥಡ್ ಇದು. ಓಕೆ, ನೆಕ್ಸ್ಟ್ ವಿಚ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸ್ಕಸ್. ಸೊ ವಿಲ್ ಟೇಕ್ ದಿಸ್ ಕೀವರ್ಡ್ಸ್. ಸೊ ಆ ಥರ ಅಂತ ಸರಿಸ್ಕಾ ರಾಜಸ್ಥಾನ್ ಹಂಗೆ ಮಾಡಂಗಿಲ್ಲ. ಓಕೆ, ಒಂದು ಸೀನ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತೀವಿ. ವಿಲ್ ಟೇಕ್ ಸರಿಸ್ಕಾ. ಇನಿಷಿಯಲಿ ನನಗೆ ಮೊದಲು ಇದು ರಾಮ್ಗರ್ ಇರಲಿಲ್ಲ, ಸೊ ಐ ಹ್ಯಾವ್ ನಾಟ್ ಇನ್ಕ್ಲೂಡೆಡ್ ದಿಸ್ ಆಸ್ ಮೈ ಸ್ಟೋರಿ. ಲೇಟರ್ ಆನ್ ಯು ಶಲ್ ಇನ್ಕ್ಲೂಡ್ ಇಟ್. ಸರಿಸ್ಕಾ, ರನ್ ತಂಬೋರೆ, ಆಮೇಲೆ ಮತ್ತೊಂದು ಯಾವ್ರಿ ಮುಕುಂದರ. ಓಕೆ, ಇವು ಮೂರು ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಒಂದು ಸ್ಟೋರಿ, ಒಂದು ಇಮ್ಯಾಜಿನರಿ ಸ್ಟೋರಿ. ಸೊ ಹೆಂಗೆ ಪಾತ್ರ ಇಮ್ಯಾಜಿನರಿ ಸ್ಟೋರಿ ನಮ್ಮ ಮದರ್ ಟಂಗ್ ಒಳಗೆ ಇರಬೇಕು, ನಮ್ಗೆ ಯಾವುದೇ ಪರ್ಸನಾಲಿಟೀಸ್ ಕ್ಲೋಸ್ ಇರುವಂಥವ್ರು ಇರಬೇಕು, ಗೊತ್ತಿರುವಂಥವ್ರು ಇದ್ರೆ ಈಸಿಲಿ ಸ್ಟೋರಿ ಕ್ರಿಯೇಟ್ ಆಗ್ತೈತಿ. ಸೊ ಇಲ್ಲಿ ಏನಪ್ಪ ಅಂತಂದ್ರೆ ಒಂದು ಇಮ್ಯಾಜಿನರಿ ಸ್ಟೋರಿ, ಯಾರೋ ಒಬ್ಬ ಕೈಯಾಗಿ ಏನು ಹಿಡ್ದಪ್ಪ ಅಂತಂದ್ರೆ ತಂಬಿಗೆ ಹಿಡ್ಕೊಂಡು, ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ, ಬಟ್ ವಿ ವಾಂಟ್ ಟು ಕ್ರಿಯೇಟ್ ಅ ಸೀನ್. ತಂಬಿಗೆ ಹಿಡ್ಕೊಂಡು, ಸೊ ತಂಬಿಗೆ ಅವ್ರಿಗೆ ಗೊತ್ತೈತಿ. ಓಕೆ, ತಂಬಿಗೆ ಚರಿಗೀಸ್, ಓಕೆ, ಎಲ್ಲ ನೋಡಿದೆವು. ಸೊ ಆ ತಂಬಿಗೆ ಒಳಗೆ ಸಾರು ಐತಿ, ಸಾಂಬಾರ್ ಸಾರು. ಓಕೆ, ತಂಬಿಗೆ ಒಳಗೆ ಸಾರು ಐತಿ. ಸಾರು ಹಿಡ್ಕೊಂಡು ಒಬ್ಬ ಏನು ಮಾಡ್ತಾನಪ್ಪ, ಓಡಾತಾನು. ಸೊ ಯು ಹ್ಯಾವ್ ಟು ವಾಟ್ ಕ್ರಿಯೇಟ್ ದಿಸ್ ಸೀನ್ಸ್. ಒಬ್ಬ ಓಡಾತಾನು. ಓಕೆ, ತಂಬಿಗೆ ಒಳಗೆ ಸಾರು ಐತಿ, ಸಾರು ಹಿಡ್ಕೊಂಡು ಏನು ಮಾಡ್ತಾನು, ಓಡಾತಾನು. ಈ ಓಡುವಂಥವ್ಗೆ ಇಂತಲೇ ಮಾತು ಬರೋಂಗಿಲ್ಲ. ಓಕೆ, ಸೊ ಅವ್ನ ಹೆಸರು ಬಹುಶಃ ನನ್ನ ಹೆಸರು ಕೆಲವು ಪ್ರೀತಿ ರಾಯೇಶ್ ಹೋಗಿ ರಾಜ ಅಂತೇಳಿ ಎಲ್ಲ ಕ್ಲೋಸ್ಡ್ ಸರ್ಕಲ್ ಆಗ್ತಿರ್ತಾರೆ. ಸೊ ಈ ಥರ ತೊಗೊಂಡಾಗ ವಿ ಕ್ರಿಯೇಟೆಡ್ ಅ ಸ್ಟೋರಿ. ನಾವು ದಿಸ್ ಸ್ಟೋರಿ ವಿ ವಾಂಟ್ ಟು ರಿಲೇಟ್ ಟು ದ ಥಿಂಗ್ಸ್ ವಿಚ್ ಆರ್ ಪ್ರೆಸೆಂಟ್ ಓವರ್ ಹಿಯರ್. ಸೊ ವಾಟ್ ವಿಲ್ ಡೂ, ತಂಬಿಗೆ ಓಡೋದಕ್ಕೆ ಏನಂತೀವಿ ನಾವು ಇಂಗ್ಲೀಷಾಗ ರನ್. ಸೊ ವಿಲ್ ಸ್ಪ್ಲಿಟ್ ದ ವರ್ಡ್. ಸೊ ರನ್ ವಿತ್ ತಂಬಿಗೆ. ವಾಟ್ ಈಸ್ ದೇರ್ ಇನ್ ತಂಬಿಗೆ? ಸಾರ್. ಓಕೆ, ದ ಪರ್ಸನ್ ಹೂ ಈಸ್ ರನ್ನಿಂಗ್ ಹಿ ಕೆನಾಟ್ ಸ್ಪೀಕ್, ಯಾರಿಗೆ ಮಾತಾಡಕ್ಕೆ ಬರೋಂಗಿಲ್ಲ, ಮೂಕ. ಓಕೆ, ಇವನ ಹೆಸರೇನು? ರಾಜ. ಓಕೆ, ನಾವು ವಿ ಹ್ಯಾವ್ ಕನೆಕ್ಟೆಡ್ ಟು ದಿಸ್ ರಾಜ 3 ಟರ್ಮ್ಸ್. ಓಕೆ, ಮೂಕ. ಇಲ್ಲಿ ಏನು ಬೇಕಪ್ಪ, ಕಂಪ್ಲೀಟ್ ಬೇಡ, ಬರೀ ಕ್ಲೂ ಕ್ರಿಯೇಟರ್ ಸಾಕು. ಏನು ಸಿಕ್ತು ನಿಮಗೆ? ಮೂಕ, ಮುಕುಂದರ, ರನ್ ವಿತ್ ತಂಬಿಗೆ, ರನ್ ತಂಬೋರೆ, ಸಾರ್ ಸರಿಸ್ಕಾ. ಸೊ ಈಗ ಇನ್ಫಾರ್ಮೇಷನ್ ರಿಜಿಸ್ಟರ್ ಆತ, ಇನ್ಫಾರ್ಮೇಷನ್ ಹ್ಯಾಸ್ ಬೀನ್ ರಿಜಿಸ್ಟರ್ಡ್. ಈಗ ನೆಕ್ಸ್ಟ್ ನಿಮಗೊಂದು 15 ದಿವಸ 20 ದಿವಸ 1 ತಿಂಗಳು 2 ತಿಂಗಳು ಬಿಟ್ಟು ಕೇಳಿದಾಗ ನೀವು ಮತ್ತೊಂದು ಸ್ಟ್ರಗಲ್ ಮಾಡಿ ರಿವಿಷನ್ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ. ಯು ಜಸ್ಟ್ ವಾಂಟ್ ದಿಸ್ ಸ್ಟೋರಿ. ಒನ್ಸ್ ದಿಸ್ ಸ್ಟೋರಿ ಇಸ್ ರಿಕಾಲ್ಡ್ ವೆರಿ ಈಸಿಲಿ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು ರೀಕಲೆಕ್ಟ್ ದ ನೇಮ್ಸ್ ಅಸೋಸಿಯೇಟೆಡ್ ವಿತ್ ರಾಜಸ್ಥಾನ್. ಓಕೆ, ಮುಕುಂದರ, ರನ್ ತಂಬೋರೆ, ಸರಿಸ್ಕಾ. ಓಕೆ, ಸರಿಸ್ಕಾ. ಸೊ ದಿಸ್ ಇಸ್ ಸ್ಟೋರಿ ಬೇಸ್ಡ್ ನ್ಯೂಮೋನಿಕ್ಸ್ ಟೆಕ್ನಿಕ್ಸ್. ಓಕೆ, ಟೆಕ್ನಿಕ್ ಇಟ್ ಹೆಲ್ಪ್ಸ್ ಲೈಕ್ ಎನಿಥಿಂಗ್. ಇದು ಒಂದೇ ಅಲ್ಲ, ಪ್ರತಿ ಒಂದು ಸಬ್ಜೆಕ್ಟ್ ನಾವು ಯೂಸ್ ಮಾಡ್ಬೋದು. ನಾವು ಮುಂದೆ ನೋಡ್ತೀವಿ ಹಿಸ್ಟ್ರಿ ಒಳಗೆ ಕೆಲವೊಂದಿಷ್ಟು ಫ್ಯಾಕ್ಟ್ಸ್ ನೆನ್ಪಿಡೋದು ಎಷ್ಟು ಡಿಫಿಕಲ್ಟ್ ಆಗ್ತಿಲ್ಲ. ಬೈ ದಿಸ್ ಟೆಕ್ನಿಕ್ ವೆರಿ ಈಸಿಲಿ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು ರಿಟೇನ್ ದ ಕಂಟೆಂಟ್. ಪಾಲಿಟಿ ಒಳಗೆ ಮುಂದೆ ಬರುವಂಥ ಕೆಲವೊಂದಿಷ್ಟು ಡಿಫಿಕಲ್ಟ್ ಟಾಪಿಕ್ ಒಳಗೆ ಭಾಳ ಈಸಿಲಿ ನೆನ್ಪಿಟ್ಕೋಬೋದು ನಾವು. ಓಕೆ, ಆ ಸಬ್ಜೆಕ್ಟ್ ಬಂದಾಗಿಂದ ಯಾವ ಥರ ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಹೇಳ್ತಿರತ್ತೆ. ಸೊ ಇಂಥ ಸ್ವಲ್ಪ ಟೆಕ್ನಿಕ್ಸ ಇಫ್ ಯು ಪ್ರಾಕ್ಟೀಸ್, ನೀವೆಲ್ಲರೂ ಇಂಥ ಟೆಕ್ನಿಕ್ಸ್ ನೀವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋಕ್ಕೆ ಶುರು ಮಾಡಿದ್ರಪ್ಪ ಅಂತಂದ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಡೆಫಿನೆಟ್ಲಿ ಬೆನಿಫಿಷಿಯಲ್. ನಾಟ್ ಬರೀ UPSC ಎಕ್ಸಾಮ್ ಪಾಯಿಂಟ್ ಆಫ್ ವ್ಯೂ ಅಂತಲ್ಲ. ಈಗ UPSC ಒಳಗೆ ಮೆಮರೈಸೇಷನ್ ಕಡಿಮೆ ಇರ್ತೈತಿ. ಈಗ ಬೇರೆ ಕೆಲವೊಂದು ಸ್ಟೇಟ್ ಲೆವೆಲ್ ಎಕ್ಸಾಮಲ್ಲಿ ಇರ್ತಾವೆ, ಸಿಕ್ಕಾಪಟ್ಟಿ ಮೆಮರೈಸೇಷನ್ ಫ್ಯಾಕ್ಚುಯಲ್ ನೆನ್ಪಿಟ್ಕೋದಿರ್ತೈತಿ. ಸೊ ಅಲ್ಲಿ ಸಿಕ್ಕಾಪಟ್ಟಿ ಫ್ಯಾಕ್ಚುಯಲ್ ಅಂದ್ರೆ ಏನಪ್ಪ ಅಂತಾರೆ ಎಲ್ಲ ಬಯಾಟ್ ಹೊಡಿಬೇಕಲ್ಲಿ. ಸೊ ಅಲ್ಲಿ ಭಾಳ ಚಾಲೆಂಜಿಗೆ. ಸೊ ಅಂತಲ್ಲಿ ಅಂತ ದಿಸ್ ಟೆಕ್ನಿಕ್ ವಿಲ್ ಬಿ ಮೋರ್ ಬೆನಿಫಿಷಿಯಲ್. ಯಾಕಂದರೆ UPSC ಒಳಗೆ ಕೆಲವೊಂದಿಷ್ಟು ಈ ಥರ ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋದು ಕಡಿಮೆ, ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಬೇಸಿಸ್ ಮೇಲೆ ಇರ್ತೈತೆ. ಬಟ್ ಸ್ಟಿಲ್ ದೇರ್ ಆರ್ ಸಮ್ ಥಿಂಗ್ಸ್ ವಿಚ್ ವಿ ಹ್ಯಾವ್ ಟು ಮೆಮರೈಸ್. ಓಕೆ, ಮೆಮರೈಸ್. ಸೊ ಈಗ ವಿ ಅಂಡರ್ಸ್ಟುಡ್ ಅಬೌಟ್ ಮುಕುಂದರ, ವಿ ರನ್ ತಂಬೋರೆ, ಸರಿಸ್ಕಾ. ಸೊ ಐ ವಾಸ್ ನಾಟ್ ಅವೇರ್, ಬಟ್ ಈಗ ಹೊಸ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ಆ್ಯಡ್ ಆದವು. ಯಾವ ಆ್ಯಡ್ ಆದವು? ರಾಮ್ಗರ್, ವಿಷದಾರಿ ಹೆಂಗೆ ಪ್ರೊನೌನ್ಸ್ ಮಾಡ್ತೀರಿ ನೋಡ್ರಿ. ನೆಕ್ಸ್ಟ್ ಡೋಲ್ಪುರ್, ಕರೌಲಿ. ಓಕೆ ಕರವಲಿ ಇದ್ದಂಥ ಸ್ಟೋರಿಗೆ ಏನ್ರಿ ಇಲ್ಲಿ ಕನೆಕ್ಟ್ ಮಾಡ್ಬೋದು ನೋಡ್ರಿ. ಸೊ ಇಮ್ಯಾಜಿನರಿ ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. ಈಗ ಅವ ಉಡುವತ್ತಾಗ ಅಂತ ಯಾಕೆ ಓಡ್ತಾನೋ ಬಹುಶಃ ಸ್ವಲ್ಪ ಸಾರದ ಟೇಸ್ಟ್ ನೋಡಿರ್ತಾನೋ, ಟೇಸ್ಟ್ ನೋಡಿದಾಗ ಬಹುಶಃ ಖಾರ ಆಗ್ತಿರ್ತೈತಿ. ಓಕೆ ಆಮೇಲೆ ಯಾರೋ ಒಬ್ಬರು ಅಂತಲ ಅವ ಸಾರ ತಮ್ಗಿಯೊಳಗೆ ಹಾಕೊಂಡು ಹೊಂಟ ನೋಡೋದು ಹೇಳೋಣ ಅಂತಲ ಅದು ಯಾರೋ ಕೇಳಿಸಿರ್ತದೆ, ಅದನ್ನ ಮತ್ತೆ ಯಾರನ್ನ ಹಿಡಿದಾರ್ತ ಮತ್ತಷ್ಟು ಓಡ್ತಿರ್ತಾರೋ. ಸೊ ಯಾರೋ ಒಬ್ಬರು ಡೋಲ್ ಹೊಡಿತಿರ್ತಾರೋ, ಇವು ತಮ್ಗಿಯೊಳಗೆ ಸಾರು ಹಾಕೊಂಡು ಹೊಂಟಾನು ಅಂತೇಳಿ. ನಾವು ವಾಟ್ ಯು ಆರ್ ಡೂಯಿಂಗ್, ಯು ಆರ್ ಆ್ಯಡಿಂಗ್ ನ್ಯೂ ಥಿಂಗ್ಸ್. ಓಕೆ ಒಂದು ಕುಡ್ದಾನು ಖಾರತೈತಿ, ಮತ್ತೊಬ್ಬ ಡೋಲ್ ಹೊಡ್ಲಾಯ್ತಾನೆ, ಇವತ್ತು ತಮ್ಗೆ ಸಾರು ಹಾಕೊಂಡು ಓಡಾತಾನೋ ಅಂತೇಳಿ. ಸೊ ನಾನು ಯಾರು ಹಿಡಿತಾರೋ ಅಂತೇಳಿ ಮತ್ತಷ್ಟು ಸ್ಪೀಡ್ ಓಡ್ತಾನೋ. ನಾವು ಯು ಆರ್ ಏಬಲ್ ಟು ಕನೆಕ್ಟ್ ನ್ಯೂ ಇನ್ಫಾರ್ಮೇಷನ್ ಟು ದ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇನ್ಫಾರ್ಮೇಷನ್, ನ್ಯೂ ಇನ್ಫಾರ್ಮೇಷನ್ ಟು ದ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇನ್ಫಾರ್ಮೇಷನ್. ಆ ಥರ ಇನ್ನೇನು ಕನೆಕ್ಟ್ ಮಾಡ್ಬೋದು ನೋಡ್ರಿ. ಹಾಂ ಹಂಗೆ ಹೇಳ್ಬೋದು ನೋಡ್ರಿ. ಸಾರು ಖಾರ ಅಂತಿದ ತಕ್ಷಣ ಅವ್ನು ದೇವ್ರ ಹೆಸರು ತೋತಾನು ರಾಮ ಅಂತೇಳಿ. ಓಕೆ ಅವ್ರು ರಾಮ ಏನು ಹೇಳ್ತಾನು, ಏನು ಕಾಳಜಿ ಮಾಡಬೇಡ, ವಿಷ ಇದ್ರ ಸುಖ ಅದನ್ನ ಅಮೃತಕ್ಕಿಂತ ಕನ್ವರ್ಟ್ ಮಾಡೋದು ಶಕ್ತಿ ನನ್ನ ಕಡೆ ಐತಿ. ಓಕೆ ಸೊ ನೀನು ಕಾಳಜಿ ಮಾಡಬೇಡ, ವಿಷ ಇದ್ದಂಥದನ್ನು ಇಂತಲೇ ಅಮೃತಕ್ಕಿಂತ ಕನ್ವರ್ಟ್ ಮಾಡೋದು ಶಕ್ತಿ ನನ್ನ ಕಡೆ ಐತಿ. ನಾವು ಯು ಹ್ಯಾವ್ ಕ್ರಿಯೇಟೆಡ್ ಅ ಸ್ಟೋರಿ, ನಾವು ಯು ಹ್ಯಾವ್ ಕ್ರಿಯೇಟೆಡ್ ಅ ಸ್ಟೋರಿ. ಈಗ ಇಟ್ ಡಸ್ ನಾಟ್ ರಿಕ್ವೈರ್ ಮೆಮರೈಸೇಷನ್. It does not require memorization. If I ask you to recall the tiger reserves associated with Rajasthan, will you be able to recall? Give a try. Ranthambore, Sariska, Mukundara, Dolpur, Karauli, Ramgarh, Vishtari. ಸೊ ಏನು ಮಾಡ್ತೀರಪ್ಪ ಅಂದ್ರೆ ಇಂಥ ಸ್ಟೋರೀಸ್ ಯಾವ ನೀವು ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಿರಲ್ಲ, ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ರೆ ಸ್ವಂತ ಕ್ರಿಯೇಟ್ ಮಾಡೋ ಭಾಳ ಖುಷಿ ಆಗ್ತೈತಿ. ಅದನ್ನೆಲ್ಲರಿ ಪೆನ್ಸಿಲ್ ಅಥವಾ ಪೆನ್ಲೆ ಬರೆದಿರ್ತೀರಿ. 2019 ಒಳಗೆ ನಾ ಫಿಲ್ಮ್ಸ್ ಪ್ರಿಪ್ರೇಷನ್ ಮಾಡ್ಕೊಂಡು 2.5-3 months ಏನು ಲೀವ್ ತೊಗೊಂಡಿದ್ದಿಲ್ಲ, ಒಂದು ದೊಡ್ಡ ನೋಟ್ಸ ಮಾಡಿದ್ದೆ ಬರೀ ಸ್ಟೋರಿದ. ಇಲ್ಲಿ ಆ್ಯಕ್ಚುಲಿ ಬಾಳ್ಗಳು ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತೇಳಿ ಐ ಗಾನ್ ಟು ಧಾರವಾಡ ಕುಂತು ಓದೋ ಸಂಬಂಧ ಹೋಗೋದ್ನ ಎಷ್ಟು ಕ್ಲೋಸ್ ಪಾದ್ರೆ ಎಷ್ಟು ಎಲ್ಲಿ ಸ್ಟೋರಿ ಇಡ್ಲಾಕೆ ಮನಸ್ಸು ಬರ್ತಿರಲಿಲ್ಲ. ಏನು ಪ್ರಾಬ್ಲಮ್ ಆಗಿತ್ತಂದ್ರೆ ಬುಕ್ಸ್ ಎಲ್ಲ ಬೇರೆ ಕಡೆ, ಆ ಸ್ಟೋರಿದೊಂದು ಫೈಲ್ ನನ್ನ ಕಡೆ. ಓಕೆ ಅಲ್ಲಿ ರೂಮ್ ಶಿಫ್ಟ್ ಮಾಡೋದಿತ್ತು ಧಾರವಾಡದಾಗ. ಹೋಗೋದ್ನಾಗ ಏನಪ್ಪ ಅಂತಂದ್ರೆ ಧಾರವಾಡಕ್ಕೆ ಹೋಗಿ ಶಿಫ್ಟ್ ಆದ್ವಿ, ಎಲ್ಲ ಆಯಿತು. ಮುಂದೆ ಒಂದು ವಾರ ಆಗ್ಬೇಕಂತಲ ಫಸ್ಟ್ ಟೈಮ್ ರೂಮ್ ಹಿಡಿಯೋಕೆ ಹೋಗಿದ್ವಿ, 2 ಸತಿ ಶಿಫ್ಟ್ ಆದ್ನಿ. ಟೆಂಪ್ರರಿ ಸ್ವಲ್ಪ ಬೇರೆ ನಮ್ಮ ಸ್ಟೂಡೆಂಟ್ ರೂಮ್ನಾಗ ನಮ್ಮ ಲಗೇಜೆಲ್ಲ ಇಟ್ಟಿತ್ತು. ಒಂದು ವಾರ ಆಗ್ಬೇಕಂತ ಇನ್ನು ನಮ್ಮ ವೆಪನ್ಸ್ ತೆಗಿನೋ ಅಂತ ಹೇಳಿ ವೆಪನ್ಸ್ ಹುಡ್ಕಾಡಕ್ಕೆ ಶುರು ಮಾಡಿ ಸ್ಟೋರಿ ಎಲ್ಲ ಕಡೆ ರೂಮ್ನಾಗ ಹುಡ್ಕೊಂಡು ಎಲ್ಲಿ ಸ್ಟೋರಿ ಸಿಗಲಿಲ್ಲ. ಓಕೆ ಎಲ್ಲರೂ ಟೆಂಪ್ರರಿ ಮತ್ತೊಬ್ಬ ರೂಮ್ನಾಗ ಇಟ್ಟು ನಾನು ಅಲ್ಲಿ ಹೋಗಿ ನೋಡಿದ್ನಿ, ಅಲ್ಲಿ ಇಲ್ಲ. ಸೊ ವಾಟ್ ಎವರ್ ದ ಸ್ಟೋರೀಸ್ ಆ್ಯಂಡ್ ನಿಮೋನಿಕ್ಸ್ ಆರ್ ಕ್ರಿಯೇಟೆಡ್ ಇನ್ ದ ಫಾರ್ಮ್ ಆಫ್ ಕ್ಲೋಸ್ ಟು 15 to 20 pages ಆಫ್ ಅ ಬಿಗ್ ಫೈಲ್, ಆ ಫೈಲ್ ಮಿಸ್ಸಿಂಗ್ ಆಗಿಬಿಟ್ಟಿತ್ತು. ಒಮ್ಮೆ ಮನುಷ್ಯನ ಕಾನ್ಫಿಡೆನ್ಸ್ ಅಂತ ಫುಲ್ 0 ಲೆವೆಲ್ಗೆ ಬಂದುಬಿಡ್ತು. ಯಾಕಂದ್ರೆ ಕಂಪ್ಲೀಟ್ಲಿ ಐ ವಾಸ್ ಡಿಪೆಂಡೆಂಟ್ ಆನ್ ಇಟ್. ಓಕೆ ಬಟ್ ಮತ್ತೆ ಎಲ್ಲೆಲ್ಲೋ ಕೆಲಸ ಕಡೆ ಬರ್ದಿಟ್ಟಿದ್ನಿ. ನಾನು ಸ್ವಂತ ಮಾಡಿದ್ದು ಸ್ಟೋರಿ ಇದಿಲ್ಲ, ಹೀಗಾಗಿ ವಾಪಸ್ ರೀಕ್ರಿಯೇಟ್ ಮಾಡೋಕೆ ನಾವು ಟಫ್ ಆಗಲಿಲ್ಲ. ಈಗ ಬೇರೆದವ್ರು ಬರ್ದಿದ್ದು ಮಾಡಿದ್ದು ಅನ್ಕೋರಿ, ಇಟ್ ವಿಲ್ ಬಿ ಟಫ್. ನೀವು ಸ್ವಂತ ಮಾಡಿದ್ದು ಈಸಿ ಆಗ್ತೈತಿ. ಬಟ್ ಆಮೇಲೆ ಭಾಳ ದಿವಸ ಆಗ್ಬೇಕು ನೆನಪತ್ತು. ಫಸ್ಟ್ ಟೈಮ್ ರೂಮ್ ನೋಡೋಕೆ ಹೋದಾಗ ಒಂದು ಕಡೆ ಚಾ ಕುಡಿಯೋಕೆ ಏನು ಕೆಳಗೆ ಇಳಿದಿದ್ದಿಲ್ಲ, ಅಲ್ಲಿ ಚಾ ಕುಡ್ದ ಫೈಲ್ ಅಲ್ಲೇ ಇಟ್ಟಿನಿ, ವಾಪಸ್ ಹತ್ತೋತಿ ತೊಗೊಂಡೋಗಿಲ್ಲ. ಆಮೇಲೆ ಫೈಲ್ ಇಂತಲೇ ಮೇಲೆ ಹೆಸರು ಬರ್ದಿಲ್ಲ, ನಂಬರು ಬರ್ದಿಲ್ಲ. ಆಮೇಲೆ ಯಾವ ಹೋಟೆಲ್ಗೆ ಹೋಗಿದ್ದು ನನಗೂ ನೆನಪಿಲ್ಲ. ಆಮೇಲೆ ಫಿಲ್ಮ್ಸ್ ಹೋಗಿ ಮುಗಿದು ಹೆಚ್ಚು ಕಡಿಮೆ 4-4 ತಿಂಗಳು ಆಗ್ಬೇಕು ನೆನಪಾಗ್ತದ. ಸೊ ದಟ್ ವಾಸ್ ಆಫ್ ನೋ ಯೂಸ್. ಓಕೆ ದಟ್ ವಾಸ್ ಆಫ್ ನೋ ಯೂಸ್. ಸೊ ಅಂತೆಲ್ಲ ಸ್ಟೋರೀಸ್ ಅಂತ ಬರ್ದಿಟ್ಟಿನಿ. ಇಟ್ ಬೂಸ್ಟೆಡ್ ಮೈ ಕಾನ್ಫಿಡೆನ್ಸ್ ಲೈಕ್ ಎನಿಥಿಂಗ್. ಓಕೆ ಇಟ್ ಬೂಸ್ಟೆಡ್ ಮೈ ಕಾನ್ಫಿಡೆನ್ಸ್ ಲೈಕ್ ಎನಿಥಿಂಗ್. ಸೊ ಹಿಂಗೆ ಎಲ್ಲೆಲ್ಲಿ ಸಾಧ್ಯತೆ ಇನ್ ಎವ್ರಿ ಸಬ್ಜೆಕ್ಟ್, if you use such kind of techniques, it will boost your memory like anything. Okay, it will boost your memory like anything. So which are the tiger reserves of Rajasthan? Ranthambore, Sariska, yes, Mukundara, Dolpur, Karauli, Ramgarh, yes, Vishdari. Okay, Vishdari. ಮತ್ತು ಯಾವಾಗಲೂ ಹೆಂಗೆ ಪಾತ್ರ ಬ್ರೈನಿಗೆ ಇನ್ಫಾರ್ಮೇಷನ್ ಗೊತ್ತೇನ್ರಿ, ಯಾವುದೇ ನಗು ಅಂತದ, ಖುಷಿ ಕೊಡುವಂಥದ. ಓಕೆ ಇತ್ತಂದ್ರೆ ಭಾಳ ದಿವಸ ನೆನ್ಪಿಡ್ತೀವಿ, ಬೇಸರ ಆಗುವಂಥದ್ದು ನೆನ್ಪಿಟ್ಕೊಳಂಗಿಲ್ಲ. ಓಕೆ ಈ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಮತ್ತೊಂದು ಇಮ್ಯಾಜಿನರಿ, ಮತ್ತು ಇಲ್ಲಿ ಕ್ಲಾಸ್ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದು ಕ್ಲಾಸ್ದಾಗ ಅಷ್ಟೇ, ಆನ್ಲೈನ್ ರೆಕಾರ್ಡಿಂಗ್ದಾಗ ಇಂದು ಡಿಲೀಟ್ ಮಾಡ್ತೈತೆ ಮತ್ತು ನಾನು. ಓಕೆ ಸೊ ಯು ಶುಡ್ ನಾಟ್ ಶೇರ್ ಇಟ್ ವಿತ್ ದ ಎಕ್ಸ್ಟರ್ನಲ್ ವರ್ಲ್ಡ್. ಓಕೆ ಒಡಿಸ್ಸಾ, ಐ ವಾಂಟ್ ಟು ರಿಮೆಂಬರ್ ದೀಸ್ ಥಿಂಗ್ಸ್. ಸತ್ಕೋಶಿಯಾ, ಸಿಮ್ಲಿಪಾಲ್. ಕೆಲಸತೆ ಅಲ್ಲಿ ಸರಿಸ್ಕಾ ಐತಿ, ಇಲ್ಲಿ ಸಿಮ್ಲಿಪಾಲ್ ಐತಿ. ಒಂದಕ್ಕೊಂದು ಎಸ್ ಮೇಲೆ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಿರ್ತಾವೆ, ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತಿರ್ತಾವೆ. ಕೆಲವು ಸಿಮ್ಲಿಪಾಲ್ ಅದಕ್ಕೆ ಏನೋ ಕೆಲವು ರಾಜಸ್ಥಾನ ಅಂತ ಹೇಳ್ತಿರ್ತಾರೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಡೇಸ್ ಒಳಗೆ. ಬಟ್ ಮುಂದೆ ಬರ್ತಾ ಅಂತಲೇ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು ಓವರ್ಕಮ್ ದಟ್ ಪ್ರಾಬ್ಲಮ್. ಓಕೆ ಓವರ್ಕಮ್ ದಟ್ ಪ್ರಾಬ್ಲಮ್. ಸೊ ಇಲ್ಲಿ ನೀವೇ ಏನಾದ್ರು ಕ್ರಿಯೇಟ್ ಮಾಡ್ಬೋದಾ? ಜಸ್ಟ್ ಗಿವ್ ಅ ಟ್ರೈ. ಹಾಂ ಟ್ರೈ ಮಾಡಿರಿ. ಸ್ಮೈಲ್ ಮಾಡ್ಕೋತಾ. ಓಕೆ ಒಡಿಸ್ಸಾದಾಗ ಸ್ಮೈಲ್ ಮಾಡ್ಕೋತಾ ಸತ್ತ. ಗುಡ್. ಸೊ ಇಟ್ ಈಸ್ ಹಿ ಸ್ಟೋರಿ. ನಾವು ವಿಲ್ ರಿಮೆಂಬರ್ ಇಟ್ ವೆರಿ ಈಸಿಲಿ. ಓಕೆ ಒಡಿಸ್ಸಾದಾಗ ಸ್ಮೈಲ್ ಮಾಡ್ಕೋತಾ ಸತ್ತ. ಗುಡ್. ಮತ್ತೆ ಯಾರು ಈ ಥರ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಬೋದಾ? ಟ್ರೈ ಮಾಡಿರಿ. ಕೆಲಸದ ಹೇಳಕ್ಕೆ ಬರ್ಲಾರ್ದಂತ ಇರ್ತಾವೆ. ಓಕೆ, ಯಾರು ಬಂದಿರ್ತಾವೆ ಸ್ಟೋರಿ, ಯಾವ ಶೇರ್ ಮಾಡ್ಬೋದಲ್ಲ ಶೇರ್ ಮಾಡಿ, ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ಎಸ್ ರವಿಚಂದ್ರ. ಎಸ್ ಅಮ್ರಿ ಏನು ಹೇಳ್ಬೇಕಲ್ಲ ಸರ್? ಇಲ್ಲ. ಸೊ ನಾವೊಂದು ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ದೆ, ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ ಮತ್ತೆ ಇಲ್ಲೇ ಶೇರ್ ಮಾಡ್ಕೊ ಹೊರಗೆ ಹೇಳಬಾರ್ದು ಅಂತ ಹೇಳಿ. ಓಕೆ, ಈಗ ಜನರಲಿ ನಮ್ಮ ಕಡೆ ಇರ್ತಾರೆ ಏನಪ್ಪ ಅಂತಾರೆ, ಓಡಿ ಹೋದವರು ಅಂತ ಹೇಳಿ. ಅದೇ ಈ ಥರ ಕನೆಕ್ಟ್ ಮಾಡಿದಾಗ ಭಾರಿ ನೋಡಿರಿ, ನೀವು ಬೇರೆ ಏನು ಹೇಳೋದ್ನಾಗ ಕಿವಿಯಿಂದ ಅಷ್ಟು ಎಕ್ಸೈಟ್ ಆಗಿಲ್ಲ. ಓಡಿ ಹೋದವರು ಅಂದ ತಕ್ಷಣ ಕಿವಿ ಒಮ್ಮೆ ಎಕ್ಸೈಟ್ ಆಗ್ತಾವೆ. ಅರೆ ನೆಗೆಟಿವ್ ಥಿಂಗ್ಸ್ ಏನಿರ್ತಾವಲ್ಲ ನಮ್ಗೆ ಭಾಳ ಜಲ್ದಿ ಎಕ್ಸೈಟ್ ಆಗಿಬಿಡ್ತೀವಿ ನಾವು. ಓಕೆ, ಸೊ ಓಡಿ ಹೋದವರು ಅಲ್ಲಿ ಸ್ಪ್ಲಿಟ್ ದೀಸ್ ವರ್ಡ್ಸ್. ಸೊ ಓಡೋರು ನಡೆಯಂಗಿಲ್ಲ. ಸಾತ್ ಖುಷಿ ಇರ್ಬೇಕಲ್ಲ, ಸಾತ್ ಖುಷಿ ಇರಬೇಕಪ್ಪ ಅಂತಂದ್ರೆ, ಸಾತ್ ಖುಷಿ ಇರ್ಬೇಕಂದ್ರೆ ಏನು ಬೇಕು? ಓಕೆ, ಇನಿಷಿಯಲಿ ಪ್ರೀತಿ ಬೇಕು, ದಟ್ಸ್ ಫಸ್ಟ್. ಬಟ್ ಸೆಕೆಂಡ್ ರೊಕ್ಕ ಬೇಕು. ಓಕೆ, ವಿದೌಟ್ ಮನಿ ಯು ಕೆನಾಟ್ ಸ್ಟೇ ಹ್ಯಾಪಿ ಫಾರ್ ಅ ಲಾಂಗ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಓಕೆ, ಸೊ ಓಡಿ ಹೋದವರು ಸಾತ್ ಖುಷಿ ಇರಬೇಕಪ್ಪ ಅಂತಂದ್ರೆ ಅವ್ನು ಹೋಗುವತ್ನಾಗಿಂತ ಹುಡುಗ ಆಗಲಿ ಹುಡುಗಿ ಆಗಲಿ ಏನಪ್ಪ ಅಂತಾರೆ, ಒಂದು ಪಾಲು ತೊಗೊಂಡು ಹೋಗಿರ್ತಾರೆ. ಯಾರ ಕಡೆ? ಅವ್ರ ಪಪ್ಪ ಕಡೆ ಅಂತ. ಅದು ಎಂಥ ಪಾಲ? ಸಿಂಪಲ್ ಪಾಲಲ್ಲ, ಸಿಂಹದಂಥ ಪಾಲು, ಲಯನ್ ಶೇರ್ ಇರ್ತಿರ್ತೀವಲ್ಲ. ಓಕೆ, ಸೊ ಓಡಿ ಹೋದವರು ಸಾತ್ ಖುಷಿ ಇರಬೇಕು ಅನ್ನೋ ಸಲುವಾಗಿ ಸಿಂಹದಂಥ ಪಾಲು ಅವ್ರ ಮನೆಯಾಗಿಂದ ತೊಗೊಂಡೋಗ್ಯಾರು. ಓಕೆ, ಸೊ ನಾವು ಇಟ್ ವಿಲ್ ಬಿಕಮ್ ಈಸಿ. ಸಿಮ್ಲಿಪಾಲ್ ಒಡಿಸ್ಸಾ, ಸತ್ಕೋಸಿಯಾ ಒಡಿಸ್ಸಾ. ಸೊ ಈ ಥರ ನೀವು ಆ್ಯಡ್ ಮಾಡ್ಕೊತ ಹೋದಾಗ ಏನಾಗಪ್ಪ ಅಂತಾರೆ, ಡೆಫಿನೆಟ್ಲಿ ಯುವರ್ ಮೆಮರಿ ವಿಲ್ ಗೆಟ್ ಬೂಸ್ಟೆಡ್. ಓಕೆ, ಯುವರ್ ಮೆಮರಿ ವಿಲ್ ಗೆಟ್ ಬೂಸ್ಟೆಡ್. ಓಕೆ, ಸೊ ಜಸ್ಟ್ ಈ ಥರ. ಮತ್ತು ಉತ್ತರ ಪ್ರದೇಶ್, ಯಾರೋ ಒಬ್ರು ಇಮ್ಯಾಜಿನರಿ ಏನಪ್ಪ ಅಂತಾರೆ, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಇಲ್ಲೇ ನವನಗರ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಅನ್ಕೋರಿ. ಸೊ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ಗೆ ಹೋಗಿರ್ತೀರಿ, ಹೋದಾಗ ನೆನಪಾಗ್ತೈತೆ ನಿಮ್ಗೆ ಏನಪ್ಪ ಅಂತಾರೆ, ನೀವು ಗುಳಿಗೆ ಯಾವುದೋ ಒಂದು ತೊಗೋಬೇಕಾದಂಥದ್ದು ಮನ್ಯಾಗ ಬಿಟ್ಟು ಬಂದಿರಿ. ಓಕೆ, ಸೊ ಗುಳಿಗೆ ಏನೋ ಇಂಗ್ಲೀಷ್ ಏನತ್ತೀವಿ? ಪಿಲ್ಸ್. ಓಕೆ, ಪಿಲ್ ಏನು ಮಾಡೀನಿ? ಬಿಟ್ಟು ಬಂದಿರಿ. ಎಲ್ಲಿ? ಮನ್ಯಾಗ. ಏನು ಮಾಡ್ತೀರಿ? ಮನೆಗೆ ಏನು ಮಾಡ್ತೀರಿ? ಓಕೆ, ಈಗ ಮತ್ತೆ ಟಮ್ ಮತ್ತು ಬಸ್ ಇರ್ತಾವ್ರಲ್ಲ ಸರ್, ಮತ್ತೆ ಓಡ್ಬೇಕಾಗ ಹಂಗೆ ಕೇಳಬೇಡ್ರಿ, ಇದು ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋ ಸ್ಟೋರಿ. ಸೊ ಓಡ್ತೀರಿ ಮನೆಗೆ. ಓಕೆ, ದೌಡೋಗೆ ಇಂಗ್ಲೀಷ್ ಒಳಗೆ. ಸೊ ದೌಡೋಗೆ ವಿಲ್ ಬಿಕಮ್ ದುಧ್ವಾ ಪಿಲಿಭಿಟ್ ಉತ್ತರ ಪ್ರದೇಶ್. ಓಕೆ, ದುಧ್ವಾ ಪಿಲಿಭಿಟ್ ಉತ್ತರ ಪ್ರದೇಶ್. ಸೊ ಈ ಥರ ಇಫ್ ಯು ಸ್ಟಾರ್ಟ್ ಕ್ರಿಯೇಟಿಂಗ್ ಸಚ್ ಕೈಂಡ್ ಆಫ್ ಸ್ಟೋರೀಸ್ ಫಾರ್ ಎವ್ರಿ ಟೈಗರ್ ರಿಸರ್ವ್ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು ಕ್ರಿಯೇಟ್ ಅ ಸ್ಟೋರಿ. ನೀವು ಬೇಕಾಗುವಂಥ ಸ್ಟೋರಿ ಮಾಡಿದ್ರೆ ಅನ್ಕೋರಿ. ಸೊ ಒಂದು ವಾರ 10 ದಿವಸ ಬೇಡ, ನಾಳೆ ಮುಂಚೆನೇ ಟಾರ್ಗೆಟ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರಿ. ಏನಪ್ಪ ಅಂತಾರೆ, ಐ ಶುಡ್ ಕಂಪ್ಲೀಟ್ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ಅಂತೇಳಿ. ಓಕೆ, ಇದು ಬ್ರೇನ್ ಏನಪ್ಪ ಅಂತ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೇಕು ನಾವು. ಒಂದು ಯಾರು ಇವ್ರದ್ದು ಫಿಲ್ಮ್ ಐತಲ್ಲ, ಯಾವುದದ ಅಮೀರ್ ಖಾನ್ ಅವ್ರದ್ದು, ಆಲ್ ಇಸ್ ವೆಲ್. ಹಾಂ, 3 Idiots. ಸರ್ ಏನು ಹೇಳ್ತಿರ್ತಾರಲ್ಲ ಅವ್ರು, ಬ್ರೇನ್ ಏನೋ ಬುದ್ದು ಏನೋ ಹೇಳ್ತಿರ್ತಾರಲ್ಲ, ಬುದ್ದು ಬನಾವ್. ಓಕೆ, ಸೊ ಏನಪ್ಪ ಅಂತಾರೆ, ಯು ಹ್ಯಾವ್ ಟು ಪ್ರೆಸೆಂಟ್ ದ ಇನ್ಫಾರ್ಮೇಷನ್ ಇನ್ ಅ ವೇ ಇಟ್ ಫ್ಯಾಸಿನೇಟ್ಸ್ ದ ಬ್ರೈನ್. ಸೊ ಒನ್ಸ್ ಯು ಪ್ರೆಸೆಂಟ್ ದ ಇನ್ಫಾರ್ಮೇಷನ್ ಇನ್ ದಟ್ ಫ್ಯಾಸಿನೇಟಿಂಗ್ ವೇ, ಯು ವಿಲ್ ಬಿ ವೆರಿ ಈಸಿಲಿ ಏಬಲ್ ಟು ರೀಕಾಲ್ ದ ಎಂಟೈರ್ ಕಂಟೆಂಟ್. ಓಕೆ, ಸೊ ನಾವು ಬೇರೆದವ್ರ ಕಡೆ ಬೇರೆ ಸ್ಟೂಡೆಂಟ್ಸ್ ಕಲಿಸಿದೆ ಬಂದಾಗ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಿರ್ತೀವಲ್ಲ, ಅವ್ರು ಯಾರೋ ಒಂದು ಟೈಗರ್ ರಿಸರ್ವ್ ಕೇಳೋಣ, ಟೈಗರ್ ರಿಸರ್ವ್ ಸರ್ ರಿವಿಷನ್ ಮಾಡ್ಬೇಕು ರೀ, ಈಗ ಆಪ್ಷನ್ ಹೇಳ್ರಿ. ಓಕೆ, ಸೊ ರನ್ ತಂಬೋರೆ ಟೈಗರ್ಸ್ ಅವರು ಆಪ್ಷನ್ ಹೇಳಿರ್ತಾರೆ ಅವರು, ರಾಜಸ್ಥಾನ್, ಮಧ್ಯಪ್ರದೇಶ್, ಛತ್ತೀಸ್ಗಢ, ಉತ್ತರ ಪ್ರದೇಶದಾಗ. ಅವಾಗ ಆನ್ಸರ್ ಮಾಡ್ತಾರೆ ಇಲ್ಲತ್ತಲ್ಲ, ಒಂದು 80% ಸ್ಟೂಡೆಂಟ್ಸ್ ಇಲ್ಲ ಆನ್ಸರ್, ಬಟ್ ದೇ ಆರ್ ಲುಕಿಂಗ್ ಫಾರ್ ಅನ್ ಆಪ್ಷನ್. ಬಟ್ ಇಲ್ಲಿ ಆ ಥರ ಆಪ್ಷನ್ ಇಲ್ಲ. ವಿದೌಟ್ ಆಪ್ಷನ್ ಯು ಶುಡ್ ಬಿ ಏಬಲ್ ಟು ಟೆಲ್ ದ ಆನ್ಸರ್. ಓಕೆ, ದ ಆನ್ಸರ್ ಈಸ್ ರಾಜಸ್ಥಾನ್. ಸೊ ಈ ಥರ ಒಂದು ಕಾನ್ಫಿಡೆನ್ಸ್ ಬಿಲ್ಡ್ ಆಗಬೇಕು. ಇದು ಪ್ರತಿಯೊಂದು ಸಬ್ಜೆಕ್ಟ್ಗೂ ಹೆಲ್ಪ್ ಆಗ್ತದೆ. ನಾಳೆ ನಾವು ನೆಕ್ಸ್ಟ್ ಜಾಗ್ರಫಿದ ರಿವರ್ ಸಿಸ್ಟಮ್ ಮಾಡಕ್ಕೆ ಶುರು ಮಾಡ್ತೀವಿ. ಭಾಳಷ್ಟು ಜನ ನಾವು ಹೆಂಗೆ ರಿವರ್ ಸಿಸ್ಟಮ್ ಮಾಡ್ತೀವಿ, ನಂಗೆ ಬೇರೆದವ್ರು ಮಾಡಂಗಿಲ್ಲ. ಸುಮ್ಮನೆ ಸೆಲೆಕ್ಟಿವ್ಲಿ ಮೇಲೆ ಅಷ್ಟು ನೋಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. ಸೊ ನಾವು ಭಾಳ ಡೆಪ್ತ್ ಹೋಗ್ತೀವಿ. ಡೆಪ್ತ್ ಹೋದ್ರೂ ನಮ್ಮ ಕಾನ್ಫಿಡೆನ್ಸ್ ಲೆವೆಲ್ ಬೇರೆ ಇರ್ತೈತಿ ಬಿಕಾಸ್ ಆಫ್ ದೀಸ್ ಟೆಕ್ನಿಕ್ಸ್. ಓಕೆ, ಬಿಕಾಸ್ ಆಫ್ ದೀಸ್ ಟೆಕ್ನಿಕ್ಸ್. ಸೊ ನೆಕ್ಸ್ಟ್ ಪ್ರತಿಯೊಂದು ಸಬ್ಜೆಕ್ಟ್, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಇಫ್ ಯು ಟೇಕ್ ಪಾಲಿಟಿ. ಸೊ ಪಾಲಿಟಿ ಒಳಗೂ ಭಾಳ ಬೆನಿಫಿಟ್. ಯಾವ ಥರ ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ. ಈಗ ಪಾಲಿಟಿ ಒಳಗೆ ಸೆಕ್ಷನ್ಸ್ ಬರ್ತಾವೆ, ಆರ್ಟಿಕಲ್ಸ್ ನೋಡಿದ್ವಿ ನಾವು 371, 2, 3 ಹಂಗೆ 371 ಅಂತೇಳಿ ಬರ್ತೈತಿ. 371A, 371B, 371C, 371D, 371E, 371F, 371G, 371H, 371I, 371J. ಕೆ ಐತೋ ಇಲ್ಲೋ? ಇಲ್ಲ. ಈ ಕರ್ನಾಟಕ ರಿಲೇಟೆಡ್ ಒಂದು ಆರ್ಟಿಕಲ್ ಐತೆ ಅವರು 371J. ಸೊ 371A ಯಾವುದು ಡೀಲ್ ಮಾಡ್ತೈತಿ? ಎಕ್ಸಾಮ್ ಕೇಳ್ಬೋದು ಕ್ವಶನ್. B, C, D, E, F, G. ಸೊ ಇದು ನಾರ್ಮಲ್ ನಾವು ಮೆಥಡಾಲಜಿ ಮಾಡಿರ್ತೀವಲ್ಲ, ರಿಹರ್ಸಲ್ ಮೆಥಡ್, 371A ನಾಗಾಲ್ಯಾಂಡ್, 371A ನಾಗಾಲ್ಯಾಂಡ್, 371A ನಾಗಾಲ್ಯಾಂಡ್, 371A ನಾಗಾಲ್ಯಾಂಡ್, ಇದು 4-5 ದಿವಸ ಅಷ್ಟೇ. ಇದು ಲಾಂಗ್ ಟರ್ಮ್ ಮರ್ತು ಬಿಡ್ತೀರ ಅದನ್ನು. ಓಕೆ, ಸೊ ಇಲ್ಲಿ ಆ ಥರ ಟೆಕ್ನಿಕ್ಸ್ ಯೂಸ್ ಮಾಡಿದ್ರೆ ದ ಸ್ಟೋರಿ ಬೇಸ್ಡ್ ಟೆಕ್ನಿಕ್ಸ್, ದ ನ್ಯೂಮೋನಿಕ್ಸ್ ಟೆಕ್ನಿಕ್ಸ್, ವಿಲ್ ಬಿ ಏಬಲ್ ಟು ರಿಟೇನ್ ದ ಕಂಟೆಂಟ್ ಫಾರ್ ಅ ವೆರಿ ಲಾಂಗ್ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್. ಸೊ ಈ 371F ಐತಿ ಇಲ್ಲಿ, ಇಟ್ ಡೀಲ್ಸ್ ವಿತ್ ಸಿಕ್ಕಿಂ. 371G ಇಟ್ ಡೀಲ್ಸ್ ವಿತ್ ಮಿಜೋರಾಮ್. ಓಕೆ, ವೆರಿ ಈಸಿಲಿ ಐ ಆಮ್ ಏಬಲ್ ಟು ರಿಕಾಲ್. ನಾನು ಸಹಿತ ಓದಿಲ್ಲ, ರಿವಿಷನ್ ಮಾಡಿಲ್ಲ, ಬಟ್ ಸ್ಟಿಲ್ ಐ ಆಮ್ ವೆರಿ ಕಾನ್ಫಿಡೆಂಟ್ಲಿ ಏಬಲ್ ಟು ರಿಕಾಲ್ ಬಿಕಾಸ್ ಆಫ್ ಸಚ್ ಕೈಂಡ್ ಆಫ್ ಟೆಕ್ನಿಕ್ಸ್ ವಿಚ್ ಐ ಹ್ಯಾವ್ ಫಾಲೋಡ್. ಈಗ F 371F ಐ ವಾಂಟ್ ಟು ಅಸೋಸಿಯೇಟ್ ಸಿಕ್ಕಿಂ ವಿತ್ ಇಟ್. ಸಿಕ್ಕಿಂ ಇಸ್ ಜೋಡಿ ನನಗೆ ಅಸೋಸಿಯೇಟ್ ಮಾಡಿ ನೆನಪಿಟ್ಕೋಬೇಕಾಗೈತಿ. ಓಕೆ, ನಂದು ಯಾವುದೋ ಇಮೇಜಿನರಿ ಸ್ಟೋರಿ, ಹಂಗೆ ನಿಮ್ದೊಂದು ಬೇರೆ ಸ್ಟೋರಿ ಇರ್ಬೋದು. F ಈ ಜನರಲಿ ಎಕ್ಸಾಮ್ಗೆ ಯಾರು ಹೋಗೋದ್ನಾಗ ಕಾಪಿ ಚೀಟಿ ಒಯ್ತಾರೆ. ಓಕೆ, ಕಾಪಿ ಚೀಟಿ ಯಾಕೆ ಒಯ್ತಾರೆ ರೀ? ಓಕೆ, ಫೇಲ್ ಆಗಬಾರ್ದು ಅಂತ ಹೇಳಿ. ರಿವರ್ಸ್ ಬರಿ, ಪಾಸ್ ಆಗಬೇಕು ಆದ್ರೆ ಫೇಲ್ ಆಗಬಾರ್ದು. ಓಕೆ, ಫೇಲ್ ಆಗಬಾರ್ದು. ಆದ್ರೆ ಒಳಗೆ ಹೋದಾಗ ಎಲ್ಲರೂ ಧೈರ್ಯ ಕೂತು ಬರೀತಿರ್ತಾರೆ? ಇಲ್ಲ, ಒಳಗೆ ಇದು ಡಗ್ ಡಗ್ ಮಾಡ್ತಿರ್ತೈತಿ. ಯಾಕೆ ಪಾತಾರೆ? ಏನು ಅಂಜಿಕೆ ಇರ್ತೈತಿ ಏನು ರೀ? ಸಿಕ್ಕಾಕೋತೀವಿ ನಾವು. ಕೆನ್ ಯು ಕರೆಕ್ಟ್? 371F ಫೇಲ್ ಆಗಬಾರ್ದು ಅಂತ ಕಾಪಿ ಚೀಟಿ ಓದಿರ್ತಿರಲ್ಲ, ಒಳಗೆ ಹೋದಾಗ ಬೈದಿಂದ ಭಯ ಇರ್ತೇನೆ, ಸಿಕ್ಕಾಕೋಬಾರ್ದು. ಸಿಕ್ಕಿಂ F 371F ಸಿಕ್ಕಿಂ, 371F ಸಿಕ್ಕಿಂ. ಸೊ ಈ ಥರ ವೆನ್ ಯು ಟ್ರೈ ಟು ಕ್ರಿಯೇಟ್ ದ ಕ್ಲೂಸ್, ಸೊ ದ ಬ್ರೈನ್ ವಿಲ್ ಈಸಿಲಿ ರಿಜಿಸ್ಟರ್ ದ ಇನ್ಫಾರ್ಮೇಷನ್. ದಟ್ಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಓಕೆ, ದಟ್ಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಈಗ 371G ಮಿಜೋರಾಮ್, ಹೆಂಗೋ ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ. ಮಿಜೋರಾಮ್ G 371G. ಕೆನ್ ಯು ಗಿವ್ ಎ ಟ್ರೈ? ಯಾವುದೊಂದು ಇಮೇಜ್ ಯಾವ ಥರ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಬೋದಾ? ಗುಡ್ ಮಾರ್ನಿಂಗ್. ಎಸ್, ಟು ಸಮ್ ಎಕ್ಸ್ಟೆಂಟ್ ಇಟ್ಸ್ ಗುಡ್. ಗುಡ್ ಮಾರ್ನಿಂಗ್ G M. ಅಲ್ಲಿ ಕನ್ಫ್ಯೂಷನ್ ಯಾವಾಗ ಆಗ್ತೈತಪ್ಪ ಅಂದ್ರೆ ಎಮ್ ಅಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಆಗುವಂಥ ಸ್ಟೇಟ್ ಮತ್ತೆ ಅವರೇ ಬೇರೆ ಇದ್ದು ಅಂದ್ರೆ, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಮಹಾರಾಷ್ಟ್ರ, ಮಣಿಪುರ್, ಓಕೆ, ಮೇಘಾಲಯ, ಮಧ್ಯಪ್ರದೇಶ್, ಕನ್ಫ್ಯೂಸ್ ಆಗೋದು. ಬಟ್ ಇಟ್ಸ್ ಗುಡ್, ದಟ್ಸ್ ಅ ಕರೆಕ್ಟ್ ಮೆಥಡಾಲಜಿ. ಮತ್ತು ಇನ್ನೊಂದು ರೌಂಡ್ ಏನೇ ಮಾಡ್ಬೋದಾ? ನೆಕ್ಸ್ಟ್ ರೌಂಡ್ ಮತ್ತೆ ಟ್ರೈ ಮಾಡ್ಬೋದಾ? ಅವ್ರು ಹೇಳಿ ಗುಡ್ ಮಾರ್ನಿಂಗ್. ಗುಡ್ ಮಾರ್ನಿಂಗ್ ರಾಮ್, ದಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್. ಗುಡ್ ಮಾರ್ನಿಂಗ್ ರಾಮ್. ಹಿಂಗೆ ಒಬ್ಬೊಬ್ರದ್ದು ಒಂದು ಯುನಿಕ್ ಸ್ಟೋರಿ ಇರ್ತವೆ, ಎಲ್ಲರದ್ದು ಒಂದೇ ಸೇಮ್ ಇರಬೇಕಲ್ಲ. ಈಗ ನಾ ಹೆಂಗೆ ನೆನ್ಪಿಟ್ಕೊಂಡಿದ್ದೀಪ್ಪ ಅಂತಾರೆ, ಸೇಮ್ ಐ ಯೂಸ್ ದ ಸ್ಟೋರಿ ಆಫ್ ರಾಮ್. ಸೊ ಜನರಲಿ ಇಂಡಿಯಾ ಒಳಗೆ ರಾಮ್ ಅಂದ್ರೆ ಇಂತ ಭಾಳ ಭಕ್ತಿಪೂರ್ವಕ ಕಾಣ್ತೀವಿ. ಸೊ ಯಾರು ನಾವು ಭಕ್ತಿಪೂರ್ವಕ ಕಾಣ್ತಿರ್ತೀವಲ್ಲ, ಸೊ ವಿಲ್ ನೆವರ್ ಅಡ್ರೆಸ್ ದಮ್ ಇನ್ ಅ ಸಿಂಗುಲರ್ ಟರ್ಮ್ಸ್. ಹೇ ರಾಮ್ ಅನ್ನಂಗಿಲ್ಲ ನಾವು. ಓಕೆ, ನಾವು ಹೇಳ್ತೀವಿ ರಾಮ್ ಜಿ ಅತ್ತೀವಿ. ದಟ್ ಇಸ್ ಅ ರೆಸ್ಪೆಕ್ಟ್ ವಿಚ್ ಇಸ್ ಅಸೋಸಿಯೇಟೆಡ್ ವಿತ್ ರಾಮ್. ಸೊ ರಾಮ್ ಅನ್ನುವಂಥ ಟರ್ಮ ಇಂಡಿಯಾದಾಗ ಯಾವುದೇ ಒಂದು ಸ್ಟೇಟ್ದ ಇಂಥ ಸಬ್ಸೆಟ್ ಇತ್ತು ಅನ್ಕೋರಿ, ದಟ್ ಇಸ್ ಓನ್ಲಿ ಒನ್ ಸ್ಟೇಟ್, ದಟ್ ಇಸ್ ಮಿಜೋರಾಮ್. ಓಕೆ, ಮಿಜೋರಾಮ್ ರಾಮ್ ಜಿ. ಓಕೆ, 371G ಡೀಲ್ಸ್ ವಿತ್ ಮಿಜೋರಾಮ್. ಓಕೆ, 371G ಡೀಲ್ಸ್ ವಿತ್ ಮಿಜೋರಾಮ್. 371F ಸಿಕ್ಕಿಂ. ಓಕೆ, ರಣತಂಬೋರೆ ಸಿಮ್ಲಿಪಾಲ್ ಒಡಿಸ್ಸಾ, ವಾಲ್ಮೀಕಿ ಬಿಹಾರ್. ನೆಕ್ಸ್ಟ್ ಕಾಜಿರಂಗ. ಎಸ್, ಸೊ ಕಾಜಿರಂಗ ಒಳಗೆ 4 ಬರ್ತಾವ್ರಿ. ಎಲ್ಲಿತ್ತು ನೋಡ್ರಿ? ಅಸ್ಸಾಮ. ಅಸ್ಸಾಮ. ಓಕೆ, ಸೊ ಫಸ್ಟ ಎಮ್ ಐತಿ, ನೆಕ್ಸ್ಟ್ ಓ ಐತಿ, ಎನ್ ಐತಿ, ಆಮೇಲೆ ಕೆ. ಸೊ ನಿಮೋನಿಕ್ಸ್ ಒಳಗೆ ಒಂದು ಸ್ಟೋರಿ ಬೇಸ್ ಟೆಕ್ನಿಕ್ಸಾ, ಮತ್ತೊಂದು ಇನಿಷಿಯಲ್ ಲೆಟರ್ ಟೆಕ್ನಿಕ್ಸಾ, ಆಮೇಲೆ ರೀಆರ್ಗನೈಸೇಷನ್ ಟೆಕ್ನಿಕ್ಸಾ. ಓಕೆ, ಈಗೆಲ್ಲರೂ ನಾ ಸ್ಟಾರ್ಟಿಂಗ್ ಲೆಟರ್ ತೊಗೊಂಡು KMNO ಮಾನ್ಯ ತಿಳ್ಕೊರಿ, ಇದು ನೆನ್ಪಿಟ್ಕೊಳ್ಳೋದು ಭಾಳ ಡಿಫಿಕಲ್ಟ್ ಇದು. ಓಕೆ, ಅದ್ರ ಬದಲು ಇದನ್ನು ರೀಆರ್ಗನೈಸ್ ಮಾಡಿ MONK ಮಾಡಿದ್ದು ಅನ್ಕೋರಿ, ಮಂಕ್ ಆಗ್ತದೆ ಇದು. ಓಕೆ, ಮಂಕ್ ಇಸ್ ಅ ಮೀನಿಂಗ್ಫುಲ್ ವರ್ಡ್ ಇನ್ ಇಂಗ್ಲೀಷ್. ಸೊ ಮೀನಿಂಗ್ಫುಲ್ ವರ್ಡ್ಸ್ ಇದ್ದಾಗ ಈಸಿಲಿ ಅಸೋಸಿಯೇಟ್. ಎಲ್ಲ ಕಡೆ ಸೇಮ್ ಥರ ಸ್ಟೋರಿ ಅಲ್ಲ, ವೆರೆವರ್ ವಾಟ್ ಎವರ್ ಇಸ್ ನೆಸಸರಿ ಯು ವಿಲ್ ಟೇಕ್ ಇಟ್. ಸೊ ನಾವು ಎಮ್ ಮಾನಸ್, ಓ ಔರಂಗ್, ನೆಕ್ಸ್ಟ್ ಎನ್ ನಮೇರಿ, ಕೆ ಕಾಜಿರಂಗ. ಇದು ನೆನಪುಳಿಕರ. ನೆಕ್ಸ್ಟ್ ರೌಂಡಿಗೆ ಹೋಗ್ತೀರಿ. ಎಮ್ ಏನ್ರಿದ? ಮಾನಸ್. ನೆಕ್ಸ್ಟ್ ಔರಂಗ್. ನೆಕ್ಸ್ಟ್ ನಮೇರಿ, ಹಾಂ ಕಾಜಿರಂಗ. ಇದು ಸ್ಟೋರಿ ರೂಪ ಮಾಡೋಕೆ ಬೇರೆ ಥರ ಮಾಡ್ತೀರಿ. ನನ್ನ ಮನಸ್ಸು ಯಾಕೋ ಸರಿ ಇಲ್ಲ, ನನಗೊಂದು ಆರೆಂಜ್ ತಿನ್ಬೇಕಂತ ಅನ್ಸಾತತಿ, ಬಟ್ ನಮ್ಮ ಏರಿಯಾದಾಗ ಇಂತ ಯಾರೂ ಆರೆಂಜ್ ಮಾರಕ್ಕೆ ಬರವಲ್ರು. ನಮ್ಮ ಮನ್ಯಾಗಿನವರು ನನ್ನ ಬಗ್ಗೆ ಯಾರು ಕಾಳಜಿ ತೊಗೊಂಡು ಮಾರ್ಕೆಟ್ಗೆ ಹೋಗಿ ಆರೆಂಜ್ ತೊಗೊಂಡು ಬರವಲ್ರು. ಅಂದ್ರೆ how you want to register the information, it is dependent on you. If you are able to recall with the first letters, you can go for monk. If you are not able to do it, you will go for the next round. ಓಕೆ, ಮನಸ್ಸು ಸರಿ ಇಲ್ಲ, ಆರೆಂಜ್ ಬೇಕಾಗೈತಿ, ನಮ್ಮ ಏರಿಯಾದಾಗ ಆರೆಂಜ್ ಯಾರು ಮಾರಕ್ಕೆ ಬರೋಲ್ರು, ನಮ್ಮ ಮನೆಯಾಗಿನವರು ಅಂತ ಯಾರು ನನ್ನ ಬಗ್ಗೆ ಕಾಳಜಿ ಮಾಡಿ ಮಾರ್ಕೆಟ್ಗೆ ಹೋಗಿ ಬರೋಲ್ರು. ಸೊ ನಾವು ಯು ಕ್ರಿಯೇಟೆಡ್ ಅ ಸ್ಟೋರಿ. ಓಕೆ, ಯು ಕ್ರಿಯೇಟೆಡ್ ಸ್ಟೋರಿ. ದಿಸ್ ಈಸ್ ಫಾರ್ ವಾಟ್? Tiger reserves associated with Assam. Okay, Assam. Next, ನಾವು ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ಸ್ ಅಂತ ಕಲಿಯೋತ್ನಾಗ ಹೆಚ್ಚು ಕಡಿಮೆ ಕೆಲವೊಂದಿಷ್ಟು ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ಸು ಇರ್ತಾವೆ. ಓಕೆ, ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ಸು ಇರ್ತಾವೆ. ಇವೆಲ್ಲ ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್ಸ್ ಎಲ್ಲ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ಅದಾವೆ. ಪ್ಲಸ್ ಎಕ್ಸ್ಟ್ರಾ ಮತ್ತೊಂದು ಐತಿ, ಇಟ್ ಇಸ್ ಆಲ್ಸೋ ವಾಟ್ ನ್ಯಾಷನಲ್ ಪಾರ್ಕ್, ದಟ್ ಈಸ್ ದಿಬ್ರು ಸೈಕೋವಾ. ದಿಬ್ರು ಸೈಕೋವಾ. ಓಕೆ, ಸೊ ಏನಾಗ್ತಾರೆ ಮಂಕ್ ಇತ್ಲ, ಈಗೇನಾಯ್ತು ಮಂಕ್ ಡಿ ಆಯ್ತು, ಮಂಕ್ ಡಿ. ಸೊ ಜನರಲ್ ನಮ್ಮ ಸೈಡ್ ಅಂತ ಕೆಲವೊಬ್ರು ಎಸ್ಪೆಷಲಿ ಹುಡುಗಿಯರ ಹತ್ರ ಬೈತಿರ್ತಾರೆ, ಅವ್ರ ಫ್ರೆಂಡ್ಸ್ ಎಲ್ಲ ಬೈಯೋತ್ನಾಗ ಹೋಗ್ಲೇ ಮಂಕ್ ಡಿ ಐತೇಳಿ. ನಾ ಕೇಳಿದ್ದೆ ಮತ್ತು ಐ ಆಮ್ ನಾಟ್ ಶ್ಯೂರ್. ಸೊ ವಾಟ್ ಯು ವಿಲ್ ಡೂ, ಮಂಕ್ ವಿಲ್ ಬಿಕಮ್ ಮಂಕ್ ಡಿ. ಅಂದರೆ ಈ ಥರ ನೀವು ಬ್ರೈನಿಗೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೋದು ಹೋದ್ರೆ ಇನ್ಫಾರ್ಮೇಷನ್ ವಿಲ್ ಬಿ ವೆರಿ ಈಸಿಲಿ ಏಬಲ್ ಟು ಕನೆಕ್ಟ್ ದ ಡಾಟ್ಸ್. ಸೊ ಮಾಡ್ಬೋದು ಎಕ್ಸಸೈಸ್. ನಾಳೆ ಮುಂಜಾನೆ ಏನು ಮಾಡ್ತೀರಿ, ಒಂದು ಮ್ಯಾಪ್ ಸ್ವಂತ ಕೈಲಿ ತೆಗಿಯಕ್ಕೆ ಬಂದ್ರೆ ತೆಗೀರಿ, ಇಲ್ಲಪ್ಪ ರೆಡಿಮೇಡ್ ಮ್ಯಾಪ್ ಇದ್ರು ರೆಡಿಮೇಡ್ ಮ್ಯಾಪ್ ತೊಗೋರಿ, ತೊಗೊಂಡು ಪ್ರತಿಯೊಂದು ಟೈಗರ್ ರಿಸರ್ವ್ ಆ ಸ್ಟೇಟಿಗೆ ಮ್ಯಾಪಿಂಗ್ ಮಾಡ್ತೀರಿ. ಓಕೆ, ಪ್ರತಿಯೊಂದು ಟೈಗರ್ ರಿಸರ್ವ್ ಆ ಸ್ಟೇಟಿಗೆ ಮ್ಯಾಪಿಂಗ್ ಮಾಡ್ತೀರಿ. ಸೊ ಇಫ್ ಯುವರ್ ಫೋಟೋಗ್ರಾಫಿಕ್ ಮೆಮರಿ ಇಸ್ ಗುಡ್, ಇಫ್ ಯು ಆರ್ ಏಬಲ್ ಟು ರಿಕಾಲ್ ಡೈರೆಕ್ಟ್ಲಿ, ದೆನ್ ನೋ ಪ್ರಾಬ್ಲಮ್. ಇಫ್ ಪಾಸಿಬಲ್ ಎಲ್ಲ ಒಮ್ಮೆ 57 ಮಾಡೋಕ್ಕಾಗಲಿಕ್ಕಾರು ಅಟ್ಲೀಸ್ಟ್ ಅರ್ಧದಷ್ಟರೇ ಒಂದು ಟಾರ್ಗೆಟ್ ಹಾಕೋರೆ, ಅರ್ಧದಷ್ಟರೇ ಸ್ಟೇಟ್ಸಿದ್ದು ಏನು ಮಾಡ್ತೀವಪ್ಪ ನಾವು ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ನೆನಪಿಟ್ಕೋಕೆ ಯಾರು ಸ್ಟೋರಿ ಮಾಡುವಂಥ ಪ್ರಯತ್ನ. ಓಕೆ, ಅಲ್ಲಿ ಯಾವುದೋ ಸ್ಟೋರಿ ಭಾರಿ ಶ್ರೇಷ್ಠ ಮತ್ತೊಂದು ಕಡಿಮೆ ಐತಲ್ಲ, ಎವ್ರಿ ಸ್ಟೋರಿ ಇಸ್ ವಾಟ್ ಯುನಿಕ್ ಬಿಕಾಸ್ ಇಟ್ಸ್ ಯೋರ್ ಇಂಡಿವಿಜುವಲ್ ಸ್ಟೋರಿ. ಓಕೆ, ಇಟ್ಸ್ ಯೋರ್ ಇಂಡಿವಿಜುವಲ್ ಸ್ಟೋರಿ. ಸೊ ಎಕ್ಸಸೈಸ್ ಮಾಡ್ಬೋದಾ? ಸೊ ಐಲ್ ಬಿ ಶೇರಿಂಗ್ ದಿಸ್ ಲಿಂಕ್ ಇನ್ ದ ಗ್ರೂಪ್. ಸೊ ಯು ಗೋ ಥ್ರೂ ದಿಸ್ ಲಿಂಕ್. ಸೊ ಎಲ್ಲ ಟೈಗರ್ ರಿಸರ್ವ್ಸ್ ನೋಡಿರಿ, ಇಲ್ಲಿ ಕೆಲವೊಂದಿಷ್ಟು ಏರಿಯಾ ಎಲ್ಲ ಕೊಟ್ಟಾರೆ, ನಾಟ್ ಇಂಪಾರ್ಟೆಂಟ್, ಯು ಜಸ್ಟ್ ಡೋಂಟ್ ಫೋಕಸ್ ಆನ್ ದೀಸ್ ಆಸ್ಪೆಕ್ಟ್ಸ್. ಓಕೆ, ಬರೇ ಟೈಗರ್ ರಿಸರ್ವ್ ಸ್ಟೇಟ್. Okay, your work will be to focus on tiger reserve and state. Okay, state. ಇಲ್ಲ ನಡೀತೈತಿ, ಫಸ್ಟ್ ರೌಂಡ್ದಾಗಿಂತಲ ಅಷ್ಟು ಅಕ್ಯುರೇಟ್ ಏನು ಬೇಕಾಗಿಲ್ಲ. ಓಕೆ, ಅಕ್ಯುರೇಟ್ ಏನು ಬೇಕಾಗಿಲ್ಲ. ಈಗ ಇಲ್ಲೇ ನೀವು ಒಂದು ರೆಫರೆನ್ಸು ಕೊಟ್ಟ, ನಾವು ಇಲ್ಲಿ ಕೆಳಗೆ ಹೋದಾಗ ನಾನು ಶೇರ್ ಮಾಡ್ತೀನ ನಿಮಗೆ. ಓಕೆ, ಇಲ್ಲ ನೋಡ್ರಿ, ಓಕೆ, ಇಲ್ಲೊಂದು ರೆಫರೆನ್ಸ್ ಕೊಟ್ಟಾನ, ಇಲ್ಲಿ ನಂಬರ್ ಬರ್ತಾನೆ ನೋಡ್ರಿ, 31 51 13. ಓಕೆ, 31 51 13. ಸೊ ನೆಕ್ಸ್ಟ್ ನೀವು ಪ್ರಿಪೇರ್ ಮಾಡೋದ್ನಾಗ ಕೆಲವೊಮ್ಮೆ ನಾವು ಭಾಳ ಓವರ್ ಥಿಂಕ್ ಮಾಡಿ ಓವರ್ ಕಾಂಪ್ಲೆಕ್ಸ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ. ಆ ಪ್ರತಿಯೊಂದು ಗೆರಿ ಕೊರದ ಈ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಮ್ಯಾಲಿಂದ ಬರುವತ್ನಾಗ ಫಸ್ಟ್ ಯಾವ್ದು ಬರ್ತೈತಿ, ಸೆಕೆಂಡ್ ಯಾವ್ದು ಬರ್ತೈತಿ. ಸೊ ಆ ಥರ ಕ್ವಶನ್ ಕೇಳ್ಯಾರ ಇಲ್ಲತ್ತಲ್ಲ, ಬಟ್ ಅಗದಿ ಸಮೀಪ ಇದ್ದು ಅಂತ ಒಂದಕ್ಕೊಂದು ಹತ್ಕೊಂಡಿರ್ತಾವೆ ಅಟ್ಯಾಚ್, ಅಂತಲ್ಲಿಂದ ಫಸ್ಟ್ ಮ್ಯಾಲೆ ಯಾವ್ದು ಬರ್ತೀವಿ ಕೆಳಗೆ ಬರ್ತೀವಿ ಹಂಗೆ ಕೇಳಂಗಿಲ್ಲ. ದೇ ಆರ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಟು ಆಸ್ಕ್, ಬಟ್ ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಮೇಕ್ ಇಟ್ ಕಾಂಪ್ಲೆಕ್ಸ್. ಓಕೆ, ಕಾಂಪ್ಲೆಕ್ಸ್. ಸೊ ಇದು ನೋಡುವತ್ನಾಗ ಎಂತಲ್ಲ ಫಸ್ಟ್ ಮ್ಯಾಲಿಂದ ಕೆಳಗೆ ಬರೋದ್ನಾಗ 31 ಬರ್ತೈತೆ, 13 ಬರ್ತೈತೆ, 31 ಆಮೇಲೆ 13. ಸೊ ಇಲ್ಲಿ ಮ್ಯಾಲೆ ನೋಡ್ತೀರಿ 31 ಯಾವುದೈತೆ ನೋಡ್ರಿ ಲಿಸ್ಟ್ ಹೋಗಿಲ್ಲ. ಎಸ್ ಪೆರಿಯಾರ್. 13 ಯಾವುದೈತೆ ನೋಡ್ರಿ, ಕಲಕಾಡ್ ಮುಂದಂತುರೈ. ಸೊ ಕಲಕಾಡ್ ಮುಂದಂತುರೈ ಈಸ್ ಪ್ರೆಸೆಂಟ್ ಇನ್ ತಮಿಳ್ನಾಡು, ಪೆರಿಯಾರ್ ಈಸ್ ಪ್ರೆಸೆಂಟ್ ಇನ್ ಕೇರಳ. ಈಗ ಮ್ಯಾಲಿಂತ್ರ ನಾರ್ತ್ ಟು ಸೌತ್ ಹೋಗೋದ್ನಾಗ ಫಸ್ಟ್ ಬರುದ ಪೆರಿಯಾರು, ಕಲಕಾಡ್ ಮುಂದಂತುರೈ. ಎಸ್ ಇಲ್ಲಿ 13 ಒಳಗೆ ಕಲಕಾಡ್ ಮುಂದಂತುರೈ ಐತಿ, ಇಲ್ಲಿ 31 ಒಳಗೆ ಪೆರಿಯಾರ್ ಐತಿ. ಇಲ್ಲಿ ಜಸ್ಟ್ ಸೀಕ್ವೆನ್ಷಿಯಲ್ ಆರ್ಡರ್ ಕೊಟ್ಟಾರ, ನಾವು ಇಲ್ಲಿ ನೋಡ್ಬೇಕಾಗಿಲ್ಲ. ಇಲ್ಲಿ ನೋಡ್ರಿ ಮ್ಯಾಪ್ 31 ಫಸ್ಟ್ ಬರ್ತೈತಿ, ಆಮೇಲೆ 13 ಬರ್ತೈತಿ. 31 ಒಳಗೆ ಯಾವುದೈತಿ, ಪೆರಿಯಾರ್, ಆಮೇಲೆ ಕಲಕಾಡ್ ಮುಂದಂತುರೈ. ಸೊ ಇಲ್ಲಿ ಮ್ಯಾಪ್ದಾಗ ಇದ್ದಂಥ ಯಾವುದಲ್ಲ ಅದ್ರ ತಕ್ಕಂತೆ ಮಾಡಿಬಿಡ್ರಿ. ಅದಕ್ಕಿಂತ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಡೆಪ್ತ್ ಹೋಗಿ ಲ್ಯಾಟಿಟ್ಯೂಡ ಲಾಂಗಿಟ್ಯೂಡ GPS ಪೊಸಿಷನ್ಸ್ ಎಲ್ಲ ತೊಗೊಂಡು ಎಕ್ಸಾಕ್ಟ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿ ಆ ಥರ ಬೇಕಾಗಿಲ್ಲ. ಓಕೆ, ಆ ಥರ ಬೇಕಾಗಿಲ್ಲ. ವಾಟ್ ಎವರ್ ಇಸ್ ಗಿವನ್ ಹಿಯರ್ ವಿಲ್ ಸ್ಟಿಕ್ ಟು ಇಟ್, ಅಷ್ಟು ಪ್ರಿಪೇರ್ ಮಾಡೋದು. ಆಮೇಲೆ ಅಂದ್ರೆ ಯಾಕೆ ಹೇಳ್ತೀನಿ ಪರ್, ಇನಿಷಿಯಲ್ ಹಂಗೆ ಮಾಡೀನಿ, ಐ ಕಮಿಟೆಡ್ ದಟ್ ಮಿಸ್ಟೇಕ್ ಆ್ಯಂಡ್ ಐ ವೇಸ್ಟೆಡ್ ಮೈ ಟೈಮ್, ಇಟ್ಸ್ ಆಫ್ ನೋ ಯೂಸ್. ಓಕೆ, ಇಟ್ಸ್ ಆಫ್ ನೋ ಯೂಸ್. ಸೊ ಅದಕ್ಕೆ ಆ ಎಕ್ಸಸೈಸ್ ಮಾಡಿರಿ. ಓಕೆ, ಎಲ್ಲೆಲ್ಲಿ ನಿಮ್ಗೆ ಇದು ಹೆಲ್ಪ್ ಸಿಗ್ತೈತಲ್ಲ ತಗೋರಿ. ಬೈ ಚಾನ್ಸ್ ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಎರಡು ಸಮೀಪ ಇರ್ತಾವೆ, ನಿಮ್ಗೆ ಕನ್ಫ್ಯೂಸ್ ಆಗ್ಬೇಕು, ಫಸ್ಟ್ ಮ್ಯಾಲೆ 49 to 48 ಐತೋ, ಸೂಪರ್ಫಿಷಿಯಲಿ ನೋಡಿ ಬರ್ಕೊಂಬಿಡ್ರಿ, ಭಾಳ ಡೆಪ್ತ್ ಹೋಗಿ ಬೇಡ. ಓಕೆ, ಅಂತ ಕೇಳಂಗಿಲ್ಲ. ಓಕೆ, ಅಂತ ಕೇಳಂಗಿಲ್ಲ. ಸೊ ದಿಸ್ ಎಕ್ಸಸೈಸ್, ಸೊ ವಿಲ್ ಯು ಕಂಪ್ಲೀಟ್ ಬೈ ಟುಮಾರೋ? ಸೊ ಟೇಕ್ ಇಟ್ ಎಸ್ ಅ ಟಾರ್ಗೆಟ್. ಆಮೇಲೆ ಈ ಪ್ರೋಕ್ರಾಸ್ಟಿನೇಟ್ ಮಾಡಂಗಿಲ್ಲ, ಇವತ್ತು ಮಾಡೋದು ನಾಳೆ, ನಾಳೆ ಮಾಡೋದು ನಾಡ್ದು, ಆ ಥರ ಅಲ್ಲ. ಈ ಬೇರೆ ಎಲ್ಲ ಯಾವ ಇರ್ತಾವಲ್ಲ ಅದು ಕಡಿಮೆ ಪ್ರಯಾರಿಟಿ ಕೊಟ್ಟು ಇವತ್ತು ಮುಗಿಸ್ಬೇಕು ಇದನ್ನು. ಓಕೆ, ಇದು ಮುಗಿಸ್ಬೇಕು. ಇದು ನಾಳೆ ರಫ್ ಮಾಡ್ತೀರಿ, ಇನ್ನೊಂದು ವಾರ ಬಿಟ್ಟು ಏನು ಮಾಡ್ತೀರಪ್ಪ, ನಾವು ದೊಡ್ಡ ಮ್ಯಾಪ್ ರೆಡಿ ಮಾಡ್ತೀರಿ. ಓಕೆ, ಮ್ಯಾಪ್ ರೆಡಿ ಮಾಡಿ ಸೊ ಯಾರಿಗೆ ಗಿಫ್ಟ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ಗೆ ಒಂದು ಗಿಫ್ಟ್ ಮಾಡ್ಬೋದು, ಇಲ್ಪ ಬೇಡ ನಿಮ್ಮ ಮನೆಯೊಳಗಿಂತ ಒಂದು ಅನ್ಸ್ಕೋಬೋದು. ಸೊ ನೆಕ್ಸ್ಟ್ ಏನು ಮಾಡ್ತೀರಪ್ಪ, ಇನ್ನು ತೆಗೆದು ನೋಡಂಗಿಲ್ಲ. ವಾಟ್ ಎವರ್ ದ ಮ್ಯಾಪ್ ಯು ಆರ್ ಪ್ರಿಪೇರ್ಡ್, ರಿಪೀಟೆಡ್ಲಿ ವಿಲ್ ಗೋ ಥ್ರೂ ದಟ್ ಮ್ಯಾಪ್. ಓಕೆ, ರಿಪೀಟೆಡ್ಲಿ ವಿಲ್ ಗೋ ಥ್ರೂ ದಟ್ ಮ್ಯಾಪ್. ಓಕೆ, ದಟ್ ಮ್ಯಾಪ್. ಸೊ ಬಿಫೋರ್ ವಿ ಬ್ರೇಕ್, ಎಷ್ಟಾದರೆ ಟೈಮು? ಓಕೆ, 10:20 ಆಯ್ತಲ್ಲ, ಇನ್ನು 10 ನಿಮಿಷ ಡಿಸ್ಕಸ್ ಮಾಡಿ ಆಮೇಲೆ ಬ್ರೇಕ್ ಮಾಡೋಣ. ವಿ ಶಲ್ ಟೇಕ್ ಅ ಬ್ರೇಕ್ ಆ್ಯಂಡ್ ದೆನ್ ಅಗೇನ್ ವಿ ಶಲ್ ಕಂಟಿನ್ಯೂ. ಓಕೆ, ವಿ ಶಲ್ ಕಂಟಿನ್ಯೂ. So, we completed the first and second round of the discussion. In the first round, we just saw the range of articles. Article number 14 to 18 deals with right to equality. Next, 19 to 22 deals with right to freedom. Next, 23 and 24 deals with right against exploitation. 25 to 28 deals with right to freedom of religion. 29 and 30 deals with cultural and educational rights. 32 deals with constitutional remedies. Okay, constitutional remedies. Next, in the second round, what we we went at the superficial level, 14, 15, 16, 17, 18, 19 and so on. Now this is the third round wherein we'll go in detail. Okay, wherein we'll go in detail, and this detailed explanation is not important for every article. Not important for every article, but there are some articles which are very important. Okay, very, very important, especially article number 14 and article number 21. Article number 14 and article number 21, they are very important. Okay, they are very important. And here few of the things you will not be able to understand completely in one go. It will take its own course of time. So let's wait. Okay, let's wait. But whatever at the superficial level you are able to connect, that would be sufficient. So article number 14 says, equality before law and equal protection of laws. Equality before law and equal protection of laws. State shall not deny to any person within the territory of India, okay, within the territory of India, so here there are various things that we have to learn. Any person, look at the term called as any person. It means article number 14 applies to only Indian citizens or Indian citizens plus foreigners. Plus foreigners, because it's any person. The term is any person. Otherwise, the term would have been any citizen. Okay, citizen. Here the term is any person. It means article number 14 applies to citizens as well as foreigners. Okay, it applies to Indian citizens as well as foreigners. So, any person should get equality before law and equal protection of laws. Okay, equal protection of laws. So, what does it mean? We will be discussing later. Here the term person means not only individual persons like us, it also means legal persons. For example, statutory corporation. Okay, now we don't know about statutory corporations and all, so later on we'll be discussing. We'll just take a example of a company. For example, TCS is a company, Infosys is a company, Reliance is a company. Okay, company. Next, LIC is a company. So equality before law and equal protection of laws, it not only applies to individuals, but it also applies to companies. It also applies to companies. Okay. It also applies to companies. Next, we'll understand equality before law and equal protection of laws. Okay, equality before law and equal protection of laws with the help of an example. Okay, with the help of an example. Now, we have discussed about the laws. So generally, when we say law, we understand it as act. Okay, a law is an act. So what is the procedure to bring law? Bill has to be passed in Lok Sabha, bill has to be passed in Rajya Sabha, finally President has to sign it. Okay, sign it. So then an act will come which we call it as law. Okay, law. Now, let's assume there is a law. Okay, there is a law. I'll take an individual law. Okay, individual law. So company related law. Company related law. So let us take a marriage related law. Okay, just to make the discussions easier, I'll take a marriage law or Marriage Act. Marriage Act 2025. Okay. So let's assume this is just an imaginary example. Okay, it's just an imaginary example. So they'll say, so generally we come in the marriage law, everything we have in detail about how the marriage should be registered and what should happen if a divorce takes place. All the provisions are present in marriage law. Okay, marriage law. So let's assume that section 1, section 2, there are so many sections. Somewhere in section 10, they say that if Hindu individual gives divorce, he should pay a alimony of 10,000 rupees per month. Okay. This is just imaginary example. Okay, alimony means after divorce every month you have to pay the charges. Okay, that maintenance charges you have to pay, alimony charges. Here, if the Hindu individual gives gives divorce, he has to pay 10,000 rupees as alimony charges every month. Next, if a Muslim gives divorce, he has to pay 15,000 rupees as alimony. If a Christian gives divorce, then he has to pay 13,000 rupees as alimony every month. This is just an imaginary example. Now, one Hindu couple, it goes to the court. Okay, he goes to the court. Now he has to give 10,000 rupees. If a Muslim couple goes, then he has to pay 15,000. If a Christian couple goes, there he has to pay 13,000. So whether all of them are being treated equally in front of law? No. Okay. So now the law which has been brought here, it violates the fundamental right. Which law it violates? Equality before law. Okay. Equality before law. Okay. Equality before law. So this just to make the things easier, I have taken this example. Okay, to make the things easier, I have taken this example. Now, if I consider a company as an example. Okay, so this is an individual. If I take company, for company, for example, income tax law. So software companies, they have to pay a tax of 20%. Next. For example, aviation companies, those who are involved in flight and all, they should pay a tax of 30% on the profit. So, whether both of them are being treated equally? No. So, there is a discriminatory treatment towards the aviation industry because they have been charged more tax. Okay, more tax. So, here also they are not being treated equally before the law. Okay, equally before the law, just to make the things easier. So, this is an indication of equality before law. Okay, you need not perfectly recall an example, just to make the things easier I have taken these examples. Equality before law. Next, equal protection of laws. Okay, equal protection of laws. So let's take an individual example itself. Okay, individual example. So now when a person commits a murder, whether same punishment will be given to all of them? No, it depends upon the situation. Okay, whether he has committed the murder under stress, whether he has committed the murder for revenge, it depends upon the situation. Let's assume there are different acts. Okay, so Revenge Murder Act 2023. Okay, Accidental Murder Act 2022. Okay, 22. So let's assume someone is playing with a knife. Okay, accidentally just playing, but accidentally if the knife hits the other person and if he dies, so there will be a punishment. But here revenge, there will be punishment. So if he has murdered someone for revenge, let's assume the sentence or the punishment is 10 years in jail. 10 years in jail. Now for this accidental murder, if someone commits this murder, so the jail term will be 2 years. Okay, 2 years. 2 years. Now let's take a scenario wherein two people have committed murder. So let's take person A and person B. Okay, person A and person B. Now both of them, they have committed murder with revenge. Okay, with revenge. So previously some bad incidents have taken place and because of that they want to take revenge. Okay, they want to take revenge. Now when they police files the case. While filing, what he will do? So person A is my relative. So rather than filing a case under revenge, he will file a case under section of accident murder. He is not a relative or probably he will not give money. So because of that, this case will be charged under Revenge Murder Act. Now what happens? Person B will have to go to jail for 10 years. Person A will have to go for jail for just 2 years. So both of them are involved in similar kind of situations, but the punishment enjoyed will be different, because what you have done is you have not treated the laws equally. Okay, you have not protected the laws equally. So this is the meaning of equal protection of laws. Okay, equal protection of laws. Now you don't go to the next extent. This much is sufficient, because now many questions will start raising in your mind. So what is the difference exactly? We will not go into it. Just with simple example, we will try to understand the difference, that equality before law. So when it comes to law, each one of the individual will be treated equally, whether he is poor or rich, to whichever caste he may belong to whichever religion he may belong to whichever language he may speak. So without any discrimination, when it comes to law, each one of them are treated equally. So now laws, they have to be equally protected. So this is an example of equal protection of laws. Okay, equal protection of laws. Now few things you have to memorize here. Okay, you have to memorize here. So what is that? Equality before law, it's of British origin. So it originated in Britain. Equal protection of laws has been taken from American Constitution. So we have both equality before law as well as equal protection of laws. But the concept of equality before law, we have taken from Britain. The concept of equal protection of laws, we have taken from America. Okay, America. So what does it mean? Absence of special privileges in favor of any person. Okay, so you are not going to give some special privileges because he is rich. You are not going to give him special privileges because he belongs to a particular religion or particular caste. So absence of such special privileges indicates equality before law. Now from the exam point of view, you shall think. So absence of special privileges in favor of any person connotes with equal protection of laws. True or false? False. It connotes with equality before law. Okay, equality before law. Now while discussing about the preamble, we have come across few terms: absence of special privileges, privileges and all. So you will not jumble all them together and get confused. You leave the preamble topic there itself. Now we are discussing about fundamental rights. You just stick to these content. Okay, this content. So absence of any privileged class indicates equality before law. Equality of treatment under equal circumstances, both in privileges conferred and liabilities imposed by the laws. You will not understand completely. You just collect that example. Okay, Murder Act, Revenge Act and Accident Murder Act. So all the laws have to be protected equally. So this statement is not important. Just leave it. We just leave it. Next, equal subjection of all persons to the ordinary law of the land administered by the ordinary law courts. So whether he is rich or poor, all of them should be subjected to the same law. Again, you need not memorize or try to retain. Not important. Just leave it. Okay. Similar application of the same laws to all the persons who are similarly situated. The same example. When two people have committed the murder for revenge, so both of them should be treated equally. Again, you need not memorize it. Leave it. No person rich or poor is above law. Okay. So no person is rich or poor is above law. It indicates equality before law or equal protection of laws. Equality before law. Now these are two things that you should remember here. One is absence of any privileged class in favor of anyone. Next one is no person is above law. So both of them can be equated with equality before law. The like should be treated alike without any discrimination. Just leave it. Okay, not important. Next, another key term: negative concept and positive concept. So here, don't worry what is negative, what is positive. Just focus which one is a negative concept. Equality before law is a negative concept. Equal protection of laws is a positive concept. Next, aim at establishing equality of legal status, opportunity and justice. Just forget it, don't worry about it. It is an element of rule of law propounded by A.V. Dicey. This is important. This will ignore. Okay, this will ignore. Aim at establishing equality of legal status, opportunity and justice. Not important, just leave it. Okay. Now in the examination, which one is an element of the concept of rule of law? Equality before law or equal protection of laws? Yes, equality before law. Okay. Who propounded it? Who brought this theory? A.V. Dicey. So A.V. Dicey was a British jurist. Okay, British jurist. Okay, British jurist. So now will you be able to recall the important points associated with equality before law? Absence of privilege Class, absence of privileges. Next, no one is above the law. Third one is negative concept. Fourth one is it is the element of rule of law. Okay, rule of law. So similarly, do we have to recall anything in equality, equal protection of laws? There is no specific thing that we have to recall, only except one. What is that? It's a positive concept. Okay, it's a positive concept. Okay, positive concept. So the next part we will discuss after a short break. Okay, we shall take a break. So we were discussing about equality before law and equal protection of laws. Okay. So we saw the difference between equality before law and equal protection of laws with the help of a simple example. Okay. We also saw a few important differences. So which one is a positive concept? Equality before law or equal protection of laws? Equal protection of laws is a positive concept. Which one is a negative concept? Which one is an element of rule of law? Equality before law. No one is above law. Equality before law. Okay, equality before law. So this till this point we have discussed. So next, so it's an element of the rule of law propounded by A.V. Dicey. So who propounded the idea? Who brought the idea called as rule of law? A.V. Dicey. He was a jurist, a judge in Britain. Okay, judge in Britain. Now next, these points are very important. So what does rule of law mean? Okay, there are important features of rule of law. Okay, rule of law. One is arbitrary power. Second one is equality before law. Okay, equality before law. Constitution is the result of the rights of the individual. Constitution is the result of the rights of the individual. So these are the features of what? Rule of law, not equality before law. Okay, these are the features of rule of law. So when I say rule of law, which are the key features? Arbitrary power, whether they should be present or absent. Absent. Equality before law. Next, so Constitution, okay, is the result of all the rights. Is the result of all the rights. Okay, all the rights. So some things you will not understand in detail. At the superficial level you will understand. Arbitrary power. What is arbitrary power? No man can be punished except for a breach of law. Okay, for a breach of law. Again, we shall take a simple example. Now, there is a law. Let us assume Theft Act. Okay, Theft Act. So, if someone is involved in the theft, okay, theft, then he should be punished as per the theft law. Okay, theft law or Theft Act. So, it says that if the value of the amount, the value of the entity stolen is less than 1 lakh rupees, okay, 1 lakh rupees, then he should be punished for 2 months in jail. Just an imaginary example. So let's assume if someone robs a mobile phone whose value is less than 1 lakh rupees. So if the case is filed in the police station, subsequently when he goes to court, so court will award him 2 months of jail. If the value is more than 1 lakh and less than 5 lakh, then he should get a punishment of 5 months in jail. Okay, 5 months in jail. So this is law. Okay, this is law. Now some person, let's assume a person A, he has been caught while robbing a mobile phone. So he was involved in the theft of a mobile phone whose value is 50,000 rupees. The value of the mobile phone which he has stolen, its value is 50,000 rupees. Now the case will be filed in the police station and it will go to court. So now court, what should be the punishment awarded? Less than 1 lakh rupees. 2 months of jail. Okay, 2 months of jail. But if he is awarded a sentence of, let's assume 4 months. Okay, 4 months. What happens? Whether the punishment is as per the law or it is not as per the law. It is not as per the law. So something which is not present in the law, but still you are doing it. It means you are using your power as per your whims and fancies, as per your wishes, okay, without having the basis of the law. That is called as arbitrary power. That is called as arbitrary power. So when you act as per your wishes without following the rules and regulations, without following the law, that is called as arbitrary power. Okay. So when we say rule of law, there should be no arbitrary power. Whatever steps, whatever you are following, it should be as per the law. Okay, as per the law. So that is the meaning of, one of the meaning of rule of law. Okay, so rule of law consists of three entities. The first one is presence of arbitrary powers or absence of arbitrary powers. Absence of arbitrary power. Okay, arbitrary power. So we have already discussed equality before law. Okay, equality before law. So in article number 14, the concept of equality before law, so we have taken from where? From rule of law. In article number 14, we have equality before law and equal protection of laws, right? So this concept of equality before law, we have taken it from a broader concept called as rule of law. Okay, rule of law. This is very important. But the rule of law, it consists of three things. One is equality before law. Apart from that, it has a statement called as absence of arbitrary power. Absence of arbitrary power. Third one, whatever the constitution is there, so all the rights of the individuals together, it will form a constitution. So here you will not get a clear picture. You will get only picture at the superficial level. For example, if we take article number 14, right to equality, article number 15, okay, prohibition of discrimination, article number 16, equality of opportunity, and so on. All these rights together, it will form constitution. All the rights together, it will form constitution. Okay. So constitution is the result of the rights of the individual. So if you are not able to understand also, you just memorize it. You just memorize it. You will by heart it. So as per the rule of law, so which are the three important elements of rule of law? Will you be able to recall here? Absence of arbitrary power. 1, 2, equality before law. Third one is constitution is the result of the rights of an individual. Constitution is the result of the right of an individual. Okay, individual. So in India, we have taken two features of rule of law. We have taken only two features, not all the features. We have taken the first feature. We have taken the second feature. We have not taken the third feature of rule of law. Very important point to know. Very important point to note. So whether in India we have borrowed all the three features of rule of law? No. We have only borrowed two features. One is absence of arbitrary power, we have borrowed. Second one is equality before law, we have borrowed and we have placed it under article number 14. The third one, that is constitution, is the result of the rights of an individual. Okay, this we have not borrowed. Okay, this we have not borrowed. Then what we have taken? Rather, constitution being the source of the individual rights. So in India, we have taken this one. So whether this is part of the rule of law? No. This is not part of the rule of law. What is rule of law? Constitution is the result of the rights of an individual. But what does this statement say? Constitution being the source of the individual rights. So previously we saw that all the rights together, it will form the constitution. But here we are saying constitution is the source of all the rights. So this is part of rule of law. This is not part of rule of law. But in India, which we have borrowed? First one or second one? Second one. Okay, second one. So this clarity is very important. Only first and second elements are applicable to the Indian system. Third one is not applicable to the Indian system. In India, in Indian system, the constitution is the source of individual rights. Okay, the constitution is the source of individual rights. Now I hope you have got a clarity. So we shall revisit the things once again. So article number 14 deals with equality before law and equal protection of the laws. Okay. So no, can you recall the important features of equality before law?
No privilege.
Yes, absence of privileged class to any person, privileges to any, special privileges to any person. One. Next, no person is above the law. Good. Next, third one. It's a negative concept. Fourth one, rule of law. Okay. Now, in this rule of law, we have three important elements. Which are they? Absence of arbitrary power. Second one, equality before law. Third one, constitution is the result of the rights of an individual. So in India, which all things of rule of law will apply? First and second one, that is absence of arbitrary power and equality before law. But the third provision of rule of law will not apply to India. So what feature applies to India? Constitution is the source of all the individual rights. Okay, this much if you understand, it will be more than sufficient. Okay, more than sufficient from both prelims as well as mains point of view. Now here few things will not gain clarity. Still the confusions remain, but now we will not go for exploration and finding of more information. We'll stop here itself. That is very important, because if you start digging deeper, then you will not be able to go to next article, article number 15. You will be stuck here itself. Okay, and this is just part of the syllabus, not entire syllabus. And whatever we have learnt, it is more than sufficient to address any kind of questions which appear on article number 14 in prelims, and the same content can also be used to express our mains answers as well. Okay, mains answers as well. Okay. Supreme Court on rule of law. Okay. Now the most powerful body in India is Supreme Court. Okay, Supreme Court. So who is the final interpreter of the Constitution in India? Supreme Court. So Supreme Court, if it gives any judgment, that is final, no one can question it. And we have seen few examples. Okay, the basic structure doctrine, whether the basic structure doctrine is present in the Constitution? Virtually no. So presently, whether it is part of any of the articles in the Constitution? No. From when did the concept of basic structure come? Keshwanand Bharti case. In which year? 1973. From this we understand that Supreme Court is so powerful. In yesterday's discussion also we saw a concept of judicial review. The concept of judicial review which has been explicitly mentioned in the Constitution. Yes or no? No. The concept of judicial review has nowhere been mentioned in the Constitution. But which article of the Constitution provides for the provision of judicial review? Article number 13. What is judicial review? What is judicial review? The process of studying a law and checking it whether it violates the fundamental rights or not, whether it violates the Constitution or not. If it violates the fundamental rights, if it violates the Constitution, then declaring such law as invalid. Okay, invalid. So that is the overall process of judicial review. Okay, judicial review. So from judicial review, we also understand how powerful the Supreme Court and High Court are. We yesterday also saw that whether constitutional amendment bills can be subjected to judicial review. Yes. Okay. Constitutional amendment bills can also be subjected to judicial review. Now Supreme Court will study and check whether the constitutional amendment alters the basic structure. If it alters the basic structure, what the Supreme Court will do? It will even declare that the constitutional amendment is invalid. Such a powerful body is Supreme Court. Okay, is Supreme Court. Now, in the context of rule of law, we shall see what Supreme Court has said. Here also you will not get a clear picture. But whatever questions I am framing, you just try to notice those questions and try to think from that perspective. Okay, that perspective. So rule of law as embodied in article number 14 is a basic feature of the Constitution. Now you started understanding the things. We have seen that basic structure, whether the basic structure word is present in the Constitution? No. Whether the term basic structure has been defined by the Supreme Court in Keshwanand Bharti case? No. No, they just brought the word called as basic structure. But which all things are part of the basic structure, did they mention? No. Which all things are part of the basic structure, subsequently through many judgments, we understood that these are the basic part of the basic structure. Now, one such thing we have encountered. What is that? Rule of law. So, whether rule of law is a part of the basic structure of the Constitution? Yes. Rule of law is part of the basic feature of the Constitution. So, now tomorrow with constitutional amendment, can we remove a provision called as rule of law from India's Constitution? We cannot remove because it is part of the basic feature. So, here basic feature and basic structure, both of them are same. So, basic feature is part of the basic structure. Basic feature is part of the basic structure. So, now we understood. Now, gradually we will start building this understanding. So, can you recall one feature which is part of the basic structure? Rule of law. Okay, rule of law. Because Supreme Court has already given the judgment that rule of law is part of the basic structure. Okay, basic structure. Hence, cannot be destroyed even by a constitutional amendment. Even a constitutional amendment cannot remove the feature of rule of law from India. Then what is rule of law? What are the features of rule of law? Absence of arbitrary power, equality before law. Constitution is the source of individual. Constitution is source of individual rights? No. No, India, but as per rule of law, Constitution is the result of the rights of an individual. But we have not borrowed this feature. We have borrowed only the first two features. So this clarity, repeatedly when we focus on those aspects, so gradually a clarity will be built. Okay, clarity will be built. Supreme Court in article number 14. Supreme Court held that where equals and unequals are treated differently, article 14 does not apply. So you will not focus on this statement for time being. You will not focus, it's not important. Okay, because here if we stuck here itself, then we will not be able to make progress. While article 14 forbids class legislation, it permits reasonable classification. You will ignore this. Okay, then you might get a question, if we have to ignore this, then why we have included it as part of the notes? Because when you go back, there are very high chances that you will read the Lakshmikant. So while going through the Lakshmikant, if you come across this content, then probably you may feel that this content has been missed out. It has not been missed out. Deliberately, intentionally I have included here to let you know that this part is not important. Because if you what gets stuck here itself, you will not be able to make progress. So once you complete the entire polity, if the time remains, then definitely we shall go with it. But not an important topic, because here we are expected to become jack of all the subjects. So here in your notes itself you will mark that these things are not important. Okay, not important. Now what happens in some other, I should not take the name, okay, in some other institutes what happens? So on article number 14 itself they will spend one full day. So in this fashion, for entire fundamental rights they will spend 15 to 20 days. A very precious time will be wasted, because hardly one question may appear on fundamental right, and that too it may appear or it may not appear. And also from the mains point of view, this deeper level of understanding is not required. Superficially, if you are able to quote article number 14 and one or two statements, that would be sufficient. So this demand, without understanding this demand, if we continue, then we will be stuck in the vicious cycle. Okay, we have to move forward. Okay. So of persons, not important. By the classification, should not important. Okay, not important. Just leave it. So we completed with article number 14. Okay, we completed with article number 14. So can we quickly revise once again article number 14? It deals with equality before law and equal protection of laws. So in this equality before law is a feature of one more broader law, which is that rule of law. So this rule of law has three features. Which are they? Absence of arbitrary power, equality before law, Constitution is the result of the rights of an individual. Okay, result of a right of an individual. But to the Indian system, which all features of rule of law apply? Absence of arbitrary power and equality before law. The third one will not apply. So in third one, which rule applies? Constitution is the source of individual rights. Okay. Now among these two, equality before law and equal protection of laws, which one is a negative concept? Equality before law. Okay. So which one has been we have borrowed from Britain? Equal protection of laws we have borrowed from America. So this clarity would be more than sufficient. Okay, more than sufficient. Okay. Article number 15. Okay, now we are going to the third round. First round, second round is over, and in the third round we completed article number 14. Now we will begin with article number 15. Okay, 15. Now from exam point of view, when you look at the exam point of view, so generally there are very less questions on article number 15. But article number 14, repeatedly questions have appeared. Okay, so relatively it enjoys lesser priority. It means understanding at the superficial level would be sufficient. Understanding at the superficial level would be sufficient. Okay, would be sufficient. First provision prohibits discrimination only by state. Second provision prohibits discrimination both by state and private individuals. So if you remember, in yesterday's class we took an example. Okay. So when you are trying to board a railway, so railway belongs to whom? State or private? State. State means government. So at that time, if someone asks you that you belong to a particular caste, particular religion, you cannot board the train. So whether it is a discrimination? Yes. Discrimination by whom? Private or state? State. Now we took the example of a hotel. Now you want to enter a hotel, the person who is running that hotel, he will say you belong to a particular caste or religion, you are not allowed to enter the hotel. Now here also you are being discriminated. Discriminated by whom? State or private? Private. Now article number 15, it offers protection against both discrimination by state as well as discrimination by private entity. Okay, private entity. State shall not discriminate against any citizen on grounds of race, religion, caste, sex, or place of birth. Okay, place of birth. So for example, if you take the train as an example, so irrespective of your caste, irrespective of your religion, irrespective of your gender, you should be allowed to board the train. Okay, board the train. So this is just one simple example. No citizen shall be subjected to any disability, liability, restriction or condition on grounds only of religion, place of birth with regards to access to public places. Okay, so this is applicable to both what? State and private individuals. So railways, it's in India it belongs to government. If we take hotels as an example, okay, so there may be some hotels which are owned by government. So there your right is available against state, but many hotels which are owned by private individuals, so there your right is available against private entity. Okay, private entity. Okay, this detailed not important. Okay, detailed not important. So article number 15, what we learnt. So protection is available only against state or also against private individual, both against state, that is government, also against private entities. So when I say private entities, it may be an individual or it may be a company okay, company. So in the examination at the superficial level, if you understand, it will be sufficient. So prohibition of discrimination on grounds of race, religion, caste, sex or place of birth. Okay, place of birth. Next, exception. Okay. So I have mentioned that all the rights, fundamental rights in India are absolute. Yes or no? None of the rights are absolute. Every right has an exception. Okay, every right has an exception. State is permitted to make any special provisions for women and children. Okay. So now when you are traveling in a KSRTC bus, generally there are some seats which are reserved for women. Now you will go and sit on that particular seat. And one lady or conductor, someone will come and say, so this seat is reserved for women, so please get up, okay, and please go somewhere else. Now this person will start quoting the constitution. As per the article number 15, there should be no discrimination on grounds of race, religion, caste, sex or place of birth. Now the conductor is discriminating based on what? Gender, because he is a male and he is asking him to vacate the place. So will it be considered as a discrimination? Yes, it will be considered as a discrimination normally, but there is an exception. What is that exception? State is permitted, government is permitted to make any special provisions for women. So as the government has made a special provision and reserved the seat for women, this will not be considered as a discrimination if the conductor asks the male candidate to vacate the place. Okay, to vacate the place. This is an exception. Okay, similarly for children as well. I am just giving an example. Okay. Next, for advancement of any socially and educationally backward classes of citizens. Okay, SCs and STs. For example, now government, let's assume it is giving some kind of scholarship. So it will not give scholarship to everyone. Okay. So now let's assume they give a scholarship to a scheduled caste candidate, they will give a scholarship to scheduled tribe candidate, but they will not give a scholarship to person belonging to general category. Now a general category candidate, can he go and file a case against the government saying that government is discriminating against me, okay, because it is only providing scholarship to scheduled caste and scheduled tribe students and not to me? Yes, normally they can do it. Okay, they can do it. But here there is an exception. Whatever the special provisions are being made for scheduled caste and scheduled tribe, it is an exception. Okay, it's an exception. Hence, you cannot go and file a case against the government saying that your fundamental right, that is article number 15, has been violated. So these are the exceptions that we have to remember. Okay, remember. So socially and educationally backward classes means it may be OBC, okay, SC, ST. So all of them, they come under this category. So this is an exception. Okay, exception. State is empowered to make any special provisions for advancement of any socially and educationally backward classes regarding the admission to educational institutions. Okay. So here, reservation in education. Okay, so when you go to, so reservation is available in both government schools and colleges as well as in private schools and colleges. Okay, schools and colleges. Now there is a reservation for scheduled caste, scheduled tribe, OBC. Now someone from general category, he cannot say that you are giving a reservation to some special people like scheduled caste, scheduled tribe, OBC. So this is a discrimination. Why? Because this is an exception. Okay, who can make a special provision for the welfare of the scheduled caste, scheduled tribe and other backward classes? State. Okay, state. So in education, whatever the reservation is being extended to scheduled caste, scheduled tribe, OBC, women, okay, it will not be considered as a discrimination under article number 15 because this is an exception. This is an exception. Okay, exception. So this superficial understanding would be sufficient. You need not recall each and every line which is present over here. Not important. So here, this is important. Just focus on this line. Private educational institutions including, important. Okay, so when we look at the reservation, so reservation provision, it extends only to government institutions or also private institutions, even private institutions. So this is a keyword which you will retain. So each and every line is not important. Each and every line is not important. So in minority educational institutions, so you cannot force to have a reservation. Okay, so here again we will not go into deeper level. We will not go into deeper level. We will stop here itself. Okay, so here this amendment added through 93rd Amendment Act of 2005, not important. Just skip it. Skip it. Not important. Central enacted Central Educational Institutions Reservation in Admission Act 2006, not important. Okay, so here. Okay. Now presently we have OBC reservation. At the state level it is a bit different from the central level, because in state level under OBC we have multiple castes and all, and if you take it Karnataka as an example, we have 2A, 2B, 3A, 3B in that sense. But in the central government there are only around 5 categories. One is scheduled caste, scheduled tribe, next is economically weaker section, and next physically challenged, that is different, and fifth one is OBC. So in OBC at the central level we do not have like 2A, 2B and all, only one OBC. Across the country whosoever belongs to OBC they will be given one single certificate. So this OBC reservation previously did not exist. It came from 1993 onwards. Okay, 1993 onwards. So what was the reservation provided? 27%. So in the central government reservation is 27% in the education. Okay, 27% in the, here we are speaking about only education. In the next article, we will be discussing about the reservation in employment. Okay, employment. We are only speaking about the education. Now here Supreme Court in some case, we are not worried about the case. Okay, we are not worried about the case. In some case, it came across a term called as creamy layer among the OBCs. Okay, at a superficial level we should understand. So when it comes to SC/ST, when SC/ST members belonging to scheduled caste and scheduled tribe, when they want to secure admission in an educational institute, so do they have to provide income certificate that this is their income? No, there is no income threshold. So whether a person is earning 1,000 rupees per month, 1 lakh per month or 1 crore per month, that does not make a difference. If he belongs to scheduled caste or scheduled tribe, he is entitled for reservation. Okay, irrespective of his what income or economical status. Okay, economical status. But when it comes to OBC, other backward classes, all the OBCs are not entitled for reservation. Okay, so central government has fixed a income threshold. So that varies. Previously it was 6 lakh, presently it is 8 lakh. So if your annual income is less than 8 lakh, then you can claim reservation under OBC. If your annual income is more than 8 lakh, then you cannot claim reservation under OBC. Okay, under OBC. So if your annual income is above 8 lakh, then you will be considered as a creamy layer. Okay, creamy layer in the OBC. So creamy layer in the OBC are not entitled for reservation in the central government, what, education or jobs. Okay, or jobs. A very important point to note. Okay, important point to note. Whether the concept of creamy layer exists in scheduled caste and scheduled tribe? No. Okay, it does not extend to scheduled caste and scheduled tribe. Now, there are so many discussions, so many laws and all they have written. So, all these things are not important. So, 2006, 2003, okay, 1993, all those things are not important. Okay, if we revisit the article number 15 once again, then we will gain a clarity. So, article number 15 speaks about prohibition of discrimination on grounds of race, religion, caste, sex or place of birth. Now, this right whether it is available only against state or also against private individuals. Okay, some rights are available within this, some are available against state and some are available against both state as well as private. Okay, private. Whether this right is absolute? No, there are reasonable restrictions. So what are those reasonable restrictions? Special privileges can be given to whom? Women, children, scheduled caste, scheduled tribe. Later on also OBC, but for OBC 27% reservation with the concept of creamy layer. So these are the keywords. If you are learned, that would be sufficient. Okay, so majority of the aspirants, they will get stuck here itself because they will not be able to understand. So if you have time later on, you can go through Lakshmikant and try to understand the things. You'll get stuck there itself. You will not be able to make progress to the next topic, because few of the aspirants in the previous batches, so who had already taken coaching in some of the other institutes, so when they had joined here, so what I noticed is initially for 1 month they were still reading fundamental rights itself. They were not making progress to the next topic. And every time they used to come to me and they used to ask a doubt, sir, whether right to strike is a fundamental right or not. Okay. So somewhere they were stuck, they were not able to make progress. But fortunately, again, one of the girl, she joined our batch and subsequently there was an improvement in her performance. But this is what happens, because when you don't know about the exam's demand, you'll be stuck there itself. That should not happen. Okay. Now you have a clarity about article number 15, at least from the exam point of view, that would be sufficient. And whatever I have marked as not important, you should also mark it. At time of examination, you should not waste your precious time. You should not waste your precious time. Okay, precious time. So before we go for article number 16, can we have a quick revision of article number 14 once again? Yes, equality before law, equal protection of laws. Which are the features of rule of law? Absence of arbitrary power, equality before law, result of the rights of an individual. So equality before law is a element of rule of law, true or false? Equal protection of laws is an element of rule of law, false. Equality before law is a negative concept. Equal protection of laws is a positive concept. So in India, we have borrowed all the 3 features of rule of law. Which feature we have not borrowed? Rights of an individual. Then what we have adopted? Source of rights of, source of individual rights. Okay, source of individual rights. Okay, source of individual rights. Next, coming to article number 15. Prohibition of discrimination, available both only against state or also against state as well as private entity. State as well as private entity. So what are the exceptions? Women, children, scheduled caste, scheduled tribe, OBC. Okay, OBC with the concept of creamy layer. Rest all the things are not important. Okay, not important. Next, equality of opportunity in matters of public employment. No discrimination on grounds of race, religion, caste, sex, descent, place of birth or residence. Okay, on these basis. Okay, for example, when government is recruiting, let's assume UPSC is recruiting for the civil services examination, or Karnataka government is recruiting for Karnataka administrative service examination, or some other government job. So when they are recruiting, they cannot make a discrimination that you belong to a particular religion, you cannot apply for the job. Okay, you are not male, you are a female, you cannot apply for the job. You belong to a particular caste, you cannot apply for the job. Okay, such kind of restrictions they cannot impose. Okay, cannot impose. So this is specifically with respect to employment, public employment. So now, whether it is applicable against state or both state as well as private entity? Only state, because public employment. In article number 14, it is applicable against both state as well as private entity. But here, it is equality of opportunity in matters of public employment. It means if some private entity, for example, TCS or Infosys, it discriminates. If it says, we cannot hire you because of so and so, then you cannot file a case. You cannot file a case. Okay, cannot file a case. So it's only available against state. Okay, against state. Here also exceptions. Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local or other authority. Okay. For example, now Karnataka government, let's assume they want to hire a particular individual, FDA or SDA. Okay, SDA. Now while hiring, we require a person who is fluent in Kannada, who can speak Kannada, who can write Kannada. But the constitution says that no discrimination on the grounds of race, religion, caste, sex or place of birth. So here the belief is just we are assuming that if he is resident of Karnataka, then probably he will be knowing Kannada in that sense. So we can impose some restrictions. Okay, but who can impose restrictions? Whether Karnataka government can impose? No, it is Parliament. So Parliament can prescribe residence condition. Okay, so again detailed not important. Who can impose residence condition as a exception? Parliament. Okay, Parliament. Next. State can provide. So here state means state government. Okay, so central government or state government can provide reservation of appointments of posts in favor of backward classes that is not adequately represented in state services. Okay, here state means state government, not entire government. So those who are from the backward classes, they may be scheduled caste or scheduled tribe. So in jobs and promotions, they may be given special reservation. This is an exception. Okay, this is an exception. A law can provide that the incumbent of office religious denomination. Okay. A law can provide that incumbent of a office related to religious or denomination, institution or members should belong to particular religion or denomination. This is important. Now let's assume there is a Hindu temple. So a priest is being hired. Okay, priest is being hired. Now can we hire a priest who belongs to, who follows other religion like Islam, Christianity or Buddhism, Jainism? No. He should be aware of the rituals associated with Hinduism. So here, when you make a government notification saying that we are hiring a priest for a particular temple, so can we discriminate saying that only Hindus can apply? Yes, we can discriminate when the government is making the notification, because many of the temples are under the government's control. Now government can explicitly mention that only Hindus are eligible to apply for becoming a priest in this particular temple. Okay, so religion based discrimination is possible. Okay, that is when you are hiring for religious denomination. Okay, religious denomination. Similarly, if someone is being hired for a church, Christian church, so there they can make a discrimination saying that only Christians can apply. Only Christians can apply. So this is an exception. Okay, this is an exception. But within Hindus, they cannot make a discrimination saying that only the upper caste so and so should apply for the position of priest. So and so caste within Hindus, they cannot apply. This discrimination they cannot make. Okay, so this discrimination, caste-wise discrimination they cannot make, but religion-wise discrimination they can make while making the announcement for the appointment of the priest, post of the priest in a temple. Okay, temple. Okay. So when it comes to employment, article number 16 deals with it. Okay, 16 deals with it. So no discrimination, but again there are certain exceptions. Exceptions for scheduled caste, exception for scheduled tribe. So similarly as like article number 15, here also we have exceptions. Here we come across a commission called as Mandal Commission. So repeatedly it appears in the newspaper, Mandal Commission. So it is an important commission. But how question can be framed in the prelims? Mandal Commission is associated with agriculture. Option number 2, associated with banking. Option number 3, associated with OBC. Okay, none of these. OBC. So if this much you are able to identify, that would be sufficient. So Mandal Commission is a commission associated with OBCs. Okay, OBCs. So second backward classes commission is called so because of its chairman BP Mandal. So this entire name not important. Mandal Commission is sufficient. Now generally they are not asked, but there are chances that they may ask that Mandal Commission was constituted during the prime ministership of whom? Morarji Desai in 1979. So this is a key point, just remember, because there are some chances that they may ask. So Mandal Commission was constituted during the Morarji Desai government. So Morarji Desai government means Morarji Desai was the prime minister. Okay, in 1979. Okay, 79. So backward classes commission. So to study the conditions of the backward classes. Okay, backward classes. So here backward classes includes all the OBCs. Okay, all the OBCs apart from the scheduled caste and scheduled tribe, all the other communities who are backward. So backward classes commission, to study them, multiple commissions have been constituted. First commission, second commission and so on. But here we will not focus on first commission. We will also not be interested in the second backward class commission also. We are only interested in Mandal commission. This is second backward classes commission. Okay, but in the examination they will not focus like this. So Mandal commission is the first backward class commission, second backward class commission, or third backward class commission. They are not going to focus it. What they are going to focus? Mandal commission was constituted during the Morarji Desai government. Okay, government. Constituted in terms of Article 40 of the Constitution to investigate the conditions of socially and educationally backward classes and suggest measures for their advancement. Okay, so all these things are not important. If at all you want to retain, so Mandal commission was constituted under which article? Article number 340. Only remember these things. Mandal commission, Morarji Desai, article number 340. Even if it is memorization also, you just memorize it. You don't go into deeper aspects. Okay, don't go into the deeper aspects. So investigate the conditions of socially, educationally, just leave it. It recommended 27% reservation in government jobs. Okay, in government jobs it recommended 27% reservation. Okay, so that the total reservation for all scheduled caste and scheduled tribes and OBCs amounts to 50%. Okay, so OBC reservation 27% plus scheduled caste plus scheduled tribe, all the reservation together, it should not cross 50% of the reservation. Okay, 50% of the reservation. After 10 years in 1990, VP Singh government declared reservation of 27% in favor of OBCs. So even though Morarji Desai government, it brought a commission called as Mandal Commission. So Mandal Commission studied and presented the report as 27% reservation has to be provided. But actually it was implemented during whose tenure? During VP Singh's tenure. Okay, VP Singh's tenure. So can you just identify keywords that we discussed here? Mandal Commission, Morarji Desai, VP Singh, 27%. These are the only 4 keywords that we'll focus. Rest all the things we'll ignore. Okay, we'll ignore. Next, whatever we discussed in article number 15, right? The same will apply here. That is, Supreme Court in Mandal case. So all the OBCs will not enjoy the benefits. Only those who do not belong to the category of creamy layer, they will enjoy the benefits. Okay, they will enjoy the benefits. And also they mentioned in this case that total quota should not exceed 50%. That is OBC plus SC plus ST. All these 3 together should not exceed 50%, but they did not leave there itself, except in some extraordinary situations. It means in some extraordinary situations, it can even cross 50%. In some extraordinary situations, it can even cross 50%. Okay, 50%. So article number 16, what does it say about? Okay, public employment. So whether this right is available against private individuals or private entities? No, only public entities. Okay, whether special privileges can be made for SC, ST, etc. OBC, etc. So OBC, how much reservation? 27%. What is the condition? Creamy layer. So Mandal Commission was constituted during whose tenure? Morarji Desai. It was implemented during whose tenure? VP Singh. So this much information would be sufficient. Also in Mandal case, it was decided that reservation should not cross 50% threshold, including OBC, SC and ST. Okay, SC and ST. So this is about equality of opportunity in matters of public employment. Okay, public employment. Next, we have abolition of untouchability. Okay, abolition of untouchability. So the term untouchability has not been defined in the Constitution. This is very important. So UPSC, it often focuses on such kind of aspects. Okay, whether the term untouchability is present in the Constitution? Yes, it is present. Article number 17 itself says untouchability. Okay, abolition of untouchability. The term untouchability is present in the Constitution. But what is untouchability? Whether it is defined in the Constitution? No. Okay, so one simple example we can easily recall. So someone of a different caste, if they follow that you should not touch me, I will not have dinner with you, I will not come close to you. So this is a type of discrimination, an example of untouchability. But this has not been defined in the Constitution. So in the examination, if they ask, you should be able to recall very easily whether untouchability is defined in the Constitution. No, it is not defined. But the term untouchability is present in the Constitution. Okay, Constitution. Next, or Protection of Civil Rights Act 1955. Okay, So here you just remember this. Even if it is memorization also, memorize it. So Protection of Civil Rights Act 1955, an act is there, an important act, okay, which deals with what scheduled caste, scheduled tribe and other backward classes discrimination and all. So even in this act also, there is no definition of untouchability. Now in the examination, they may frame a statement in order to confuse you like this. So the term untouchability has not been defined in the Constitution, but it is defined in the Protection of Civil Rights Act 1955. True or false? False. It is not defined. Okay, it's not defined. Madras High Court said that it refers to the social and disabilities imposed on certain classes of persons by reason of their birth in certain castes. So Madras High Court has given some kind of definition. Not important. Okay, not important. So whatever the Madras High Court has said, that definition itself is not important. If you have understood the meaning of the term untouchability. Okay, untouchability. Next, Protection of Civil Rights Act 1955. The Act defines civil right as anything accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. The Act declares acts which can be considered as offences. Okay, so only focus on this term. So, Protection of Civil Rights Act . So Protection of Civil Rights Act, it gives shape to Article number 17, because in Article number 17 they have mentioned about untouchability, but they have not defined untouchability. So what are the offences that can be considered as untouchability under Article number 17? Okay, so some of the things have been given here. Okay, have given here, but here also we will not say it as a definition of untouchability. Okay, so this complete thing, no, line by line is not important. Again, the current affairs, whenever we come across protection of civil rights, that would be important. Okay. Now, somewhere if they ask us, so Protection of Civil Rights Act 1955 correlates to which article in the Constitution? Article number 17. That would be sufficient. Whether this Act of 1955 has a definition of untouchability? No. Whether the untouchability term is defined in the Constitution? No. Okay. No. Supreme Court held that the right is available against private individuals and it is constitutional obligation of states to take necessary action to ensure that this right is not violated. Okay, so very important. So, abolition of untouchability, this right is available against state and also against private individuals. Okay, also against private individuals. Okay, so rest all the things are not important. It is constitutional obligation of the states to take necessary action to ensure that it is not violated. It means if someone is practicing untouchability, it is a responsibility of the government to ensure that it does not happen. If someone is involved in such kind of practices of untouchability, then he should be arrested, he should be sent to jail. So all these provisions, all these features should be made by government. Okay, should be made by government. Okay, should be made by government. Next, abolition of titles except military and academic. Abolition of titles except military and academic. Yesterday we saw at the superficial level. So prohibits state, that is government, from conferring any title. So generally government gives some kind of titles, right? Okay. So except military and academic. So military title, can you give an example? Commander, Marshal is an example of military title. So we can give a military title. Academic title? Doctorate. Okay, doctorate. So except these, other titles cannot be conferred. Okay, other titles cannot be conferred. So either it may be on citizen of India or foreigner. It means it prohibits the Indian state, Indian government from giving such kind of status either to Indian or a foreigner. Okay, or a foreigner. Similarly, prohibits a citizen of India from accepting any title from the foreign state. So Indian also cannot get such, should not get such kind of title from other country. He should not get title from other country. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the president. So let's assume a foreigner, a person of, let's assume USA, he is working in India under the Indian government. So how he is working, we shall not worry about it. Even he should not accept any such kind of titles, either in India or other country. If at all he wants to accept, before accepting, he should take the permission of the president. Okay, president. No citizen or foreigner holding any office of profit or trust under the state Okay, so just leave it, not important, just leave it. Hereditary titles of nobility like Maharaja, etc. Okay, such titles are banned. Okay, we cannot have status like Raja, Maharaja, Raja di Raja, such kind of status also, titles we cannot hold. Here a very important point to note. So government every year it gives various titles like Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri. So which is the highest award? Bharat Ratna. Next is Padma Vibhushan. Next is Padma Bhushan. Next Padma Shri. So when government itself is involved in giving such kind of titles, will it violate article number 18? If these awards are considered as titles, then it will violate article number 18. Hence, these awards are not considered as titles under article number 18. Hence, when every year when the government gives, so it does not violate article number 18. Okay, 18. Supreme Court and national awards like Bharat Ratna, Padma Vibhushan, etc. 1996 upheld the validity of them. Means someone challenged in the Supreme Court saying that government is giving awards like Bharat Ratna and Padma Vibhushan, it is violating article number 18. So that case went to Supreme Court. What is the name of that case? Not important. Now like Keshwanand Bharati case, that case will also have a name, but that name is not important. In that case, Supreme Court ruled that whatever the awards are being given by the government, it is correct. There is nothing harm. There is nothing wrong in it. Okay, nothing wrong in it. Award do not amount to titles. Very important. So in the examination, if they ask, so Bharat Ratna and Padma Vibhushan, they constitute title under article number 18. True or false? False. Okay, false. Next. Within the meaning of article number 18, that prohibits only hereditary titles of nobility. They are not violative of article number 18. So these titles, they do not violate article number 18. However, they should not be used as suffixes or prefixes. This is also important. So generally, when we use someone's name, okay, for example, Bharat Ratna, Dr. so and so, we are not supposed to use the prefix. Okay, but generally we use in our day-to-day life. But as per the constitution, we are not supposed to use these awards as prefixes or suffixes. So this is important. In the examination, they may ask. So whether Bharat Ratna and Padma Vibhushan, they constitute titles under article number 18? No. Can they be used as prefixes? No. Can they be used as suffixes? No. They cannot be used. Okay, cannot be used. In this context, national awards. So some discussion about the national awards. Again, we will be discussing as part of the current affairs. Okay, current affairs. So national awards like Bharat Ratna, Padma Vibhushan, when did they start? They started in 1954. Okay, 1954. Janata Party government headed by Morarji Desai discontinued them in 1977. In 1954 it started. They started giving awards like Bharat Ratna, Padma Vibhushan, Padma Shri and all. But in 1977, Janata Party government headed by Morarji Desai, they stopped it. They stopped giving. But again, they were revived again in 1980 by then Indira Gandhi government. Again in 1880, again they started with it. So by this what we understand here is this awarding, so whether it has been remained continuous? No. In between there was a gap from 1977 to 1980. Okay, 1980. So this much information would be sufficient. Okay, this much information would be sufficient. Okay. So what are the important keywords associated with article number 18? Okay, abolition of titles. Whatever the next each and every detail that we have seen, right, whether state can confer it or not, whether a person of Indian origin, he can take the award from the other country, whether a foreigner working in Indian government can he take, so that much detailed information is not important. Okay, what is important here is whether the titles which are given like Bharat Ratna, whether they form part of the titles? No. Okay, no. Whether they have been continuously given from 1954 onwards? No. In between there has been a gap. Okay, there has been a gap. So at this superficial level, if we focus, then that would be sufficient. Okay, that would be sufficient. So we discussed up to article number 18, that is right to equality. Okay, right to equality. So in tomorrow's class, okay, we shall proceed with the next part, that is right to freedom. Okay, right to freedom. Welcome to Paritranaya. So this is day 12, I guess, right? So in the previous class, we discussed about, we are discussing about which topic? Fundamental rights. So we have gone through these fundamental rights in multiple rounds. First round, second round. Now we are discussing in the third round. Okay. So in the first round we saw the range of articles which constitute the fundamental rights. So which part of the constitution deals with fundamental rights? Switch on the mic if possible, if it's not on. On? Okay. There's one mic here. Continue here. Central ದಂಡಿಗಿಟ್ಟರೆ ಬೀಳೋ ಚಾನ್ಸ್ ಇರ್ತೈತಿ, ಬೀಳಾರ್ದಂಗಿಟ್ರೆ. So which part of the constitution deals with fundamental rights? Yes, part 3. So the range of articles which deal with right to equality, right against exploitation, 23, 24, right against constitutional remedies, 32, right to freedom, 19 to 22, right to freedom of religion, 25 to 28, prohibition of children in factories, 24, next right to freedom of speech and expression, 19, untouchability, abolition of untouchability, 17, titles, 18. Then we discussed in the third round about right to equality, right to equality. So in the right to equality we discussed article number 14 to 18, right? So equality before law and equal protection of laws is dealt by which article? 14. So which one is a positive concept? Equality before law or equality before protection of laws? Equal protection of laws is a positive concept. A positive concept. Next, which is a feature of rule of law? No. Equality before law is a feature of rule of law or equal protection of laws? Equality before law. So apart from this equality before law, which are the other features of rule of law? Absence of arbitrary power. Next, constitution is the result of the individual rights. But in Indian system, whether all these three rules apply? So which all we have adopted? Absence of arbitrary power and equality before law. The third one we have replaced it with what? Constitution is the source of individual rights. Okay, source of individual rights. So we discussed about article number 14. Then whether there are any exceptions to article number 15 and 16? So exceptions are in favor of women, children, scheduled caste, scheduled tribe. Okay. So when it comes to OBC reservation, we also came across the concept of creamy layer. Whether the concept of creamy layer applies to scheduled caste and scheduled tribe? No, it does not apply. Okay, it does not apply. So next, the honors like Bharat Ratna and Padma Vibhushan, they constitute title under article number 18. Yes or no? No. Okay, they are not considered as titles. Whether these awards can be used as a prefix and suffix? So when did they start? 1954. So from 1954, there has never been a gap in any of the years. True or false? False. There was a gap during whose reigns? Morarji Desai. Next, Mandal Commission was constituted during whose reigns? Reigns of which Prime Minister? But actually, the recommendations are accepted during the tenure of VP Singh. Okay, VP Singh. Next, we'll begin with article number 19. Okay, we'll start with article number 19. So article number 19 says, yes, protection of rights of freedom. Okay, freedom are protected against only state action and not private individuals. This is important. So in the first and second round, we did not go into these detailed aspects. So right to freedom, article on protection of rights of freedom, they are only available against state, not against private individual. Okay, private individual. For example, if the government makes a law saying that you cannot criticize the government, then they will be infringing which right? Article number 19, right to freedom of speech and expression. Now you can file a case against the government. But if some individual says you cannot use abusive words against me, okay, you cannot say that I have the right to freedom of speech and expression and I will file a case against you so that I can use any kind of words against you. Okay, so it's not available against individual, private individual. It is available against state. Okay, it's available against state. So this is a very important point to note. But if you look at the UPSC question papers, they have never gone into this deeper level. Okay, this deeper level. Probably they are expecting the aspirants to become jack of all the subjects. In that context, probably they might have not asked, but there are chances they may ask. So let's focus from this perspective as well. These rights are available only to citizens and to shareholders of a company. Very important. Okay. So to citizens means they are not available to whom? Foreigners. They are not available to foreigners. Next, shareholders of a company, any of the private company, for example, it may be TCS, Infosys, okay, the shareholders will be there, right? So they will also be having right to freedom of speech and expression, but not against the company, against the state, okay, against the state. For example, now if we take a newspaper like The Hindu, so The Hindu also will have multiple shareholders, okay, multiple shareholders. So when the government imposes restrictions on the newspaper saying that you cannot publish an article against the government, okay, now at that time who will file the case against the government? The shareholders of The Hindu, the shareholders of the newspaper. So hence the shareholders of the company, shareholders of the company. So with one example you will be able to comprehend the things properly. But these are not available to legal persons like companies or corporations, etc. Okay. So some of these rights, they are not available to legal persons like companies or corporations, etc. Here you will get confused. So hence we will not go into deeper aspects. Just at a superficial level we will understand. Okay, we will understand. 19A. So under article number 19, we have discussed about the various freedoms, right? Can you recall once? Speech and expression, association, assembly, movement, yes, residence, and profession, okay, and profession. Now next we will be going into these individual rights one by one. So in the examination they are not going to ask like A, B and C. These are not important. Just I have mentioned here, but this sequential order is not important. So in the examination they are not going to ask, so 19A deals with what, 19B deals with what, 19C deals with what. So to this deeper level they are not going to frame the question. Okay, they are not going to frame the question. Just at a superficial level, if we are able to connect these provisions to article number 19, that would be sufficient. Okay, that would be sufficient. So every citizen has these rights through word of mouth, writing, printing, picturing, etc. Every citizen of this country has the freedom of speech and expression. Means whatever comes to his mind, okay, he can express it. So while expressing, there are different ways of expressing. So mouth, oral expression. Writing, for example, you may write a article in the newspaper, or you may write a blog post. Okay, so all of them they come under writing. Printing, for example, newspaper or book. Picturing. Now you might have seen about the cartoons. Okay, in cartoons when you observe, so they make cartoons of the politicians and all. Okay, so these are the various ways of expression. So when we say right to freedom of speech and expression, it is not confined to oral expression alone. It also extends to written form. It also extends to printing, picturing, YouTube videos, Instagram, Facebook, etc. Okay, etc. Supreme Court held that it includes. This is very important. Okay. Now, in the examination, if they ask you a question, whether freedom of press is a fundamental right. Okay. So it's not mentioned in the fundamental rights. But who is the highest interpreter of the Constitution? Supreme Court. So Supreme Court has construed that freedom of press is a part of freedom of speech and expression under article number 19. Okay, article number 19. So now here sometimes we get confused, means we often ask complex questions to ourselves and we get confused. In the examination, if they ask a question, freedom of press is a fundamental right, true or false? Now you have to assume it as true. Okay, but because Supreme Court has declared it, no? So that's why I am saying we may get confused. Okay, generally they are not going to frame such kind of questions. So if they mention like this, in the Constitution it is clearly stated that freedom of press is a fundamental right, then it will be wrong. Okay, but as per the various Supreme Court judgments, freedom of press is a fundamental right. If they mention, then it's correct. And generally they will not frame such kind of question, confusing questions. For example, once they have asked a question, probably I have not shared, right to marry a person of one's choice is a fundamental right under which article? 21. In that fashion, they may frame a question like this. Freedom of press can be considered as a fundamental right under which article? Article number 19. Okay. But before they ask the question, we start asking questions to ourselves and we get confused. So such kind of confusing questions UPSC is never going to frame. Okay, never going to frame. So if at all they frame also, explicitly if they ask like this, so this freedom of press is clearly mentioned in the Constitution? No, it is not mentioned in the Constitution. It has been construed, it has been interpreted by the various Supreme Court judgments. Which Supreme Court judgment? We are not worried about it. Okay, we are not worried about the exact Supreme Court judgment. There are few judgments of whom we should worry about or we should care about. For example, Keshwanand Bharti. Similarly, there are few other cases. So we need not have information about each and every case. Okay, we need not have information about each and every case. So, right against tapping of telephonic conversations. Okay, so when two people are having conversation over the phone, so someone might tap, especially government entities might tap and listen to the conversation. So that is a part of privacy. Okay, but I will not use the term privacy. So tapping of telephone conversations of someone, so that is not allowed, that is prohibited. Under which article? Article number 19. Okay, article number 19 through Supreme Court judgment. It is not directly mentioned. Okay, directly mentioned. Right to telecast. No government monopoly on electronic media. Okay, so this means telecast of, it may be news or it may be any other forms of entertainment information. Right to telecast means only government does not have the monopoly. Even private people can also start the television channels and they can broadcast. Okay, that they can broadcast. Right against bandh called by a political party or organization. Now let's assume one of the political party, it may be BJP, it may be Congress or it may be JDS. So if they call a bandh, okay, bandh. So you have a right against that bandh, means we do not require that bandh. Okay, so that is also recognized as one of the fundamental right under article number 19. Okay, 19. Not right to bandh, right against bandh. For example, if someday if something has kept as bandh, so at that time there will be no transportation facility, probably there will be no hospital facility. So all these things will be there, right? So people of this country, they have the right against such bandh. Means they can file a case against the government for giving permission for such kind of bandhs. Okay, for such kind of bandhs. Right to know about government activities. So government is involved in so many activities. So right to know about these activities is also a fundamental right. Okay, is also a fundamental right. So this right has been specifically given shape with the one of the act called as Right to Information Act. So under Right to Information Act, what you can do? You can write a letter to the government saying that I want so and so information under the Right to Information Act. So this right has got a clear form in the form of RTI Act 2005. 2005. Freedom of silence. So do you have the freedom of silence? Yes. Now here sometimes you may get confused. So freedom of silence is identified as a right under article number 19 or article number 21, right to life and liberty. Okay, it is identified under article number 19. The right to privacy is identified as a freedom under article number 21. So the things where we may get confused, so there we will segregate and make an effort to ensure that they are properly segregated under respective articles. Okay, respective articles. Now right to demonstration and picketing, but not right to strike. Now you cannot give a clear example as to what is demonstration and what is picketing. Picketing already when we start discussing about the modern history, we will see that there are multiple such examples of picketing. So I will just tell you. Now someone wants to close the wine shop. So what they will do? They will go and stand in front of the wine shop and they will say, shut down the wine shop in a polite manner. So that is an example of picketing. Okay, picketing. So demonstration. So publicly we will demonstrate some of the mischiefs of the government. If a government is involved in corruption, so you will demonstrate in the form of a drama or something else. But it does not include right to strike. So if tomorrow someone asks you whether right to strike is a fundamental right, it's not a fundamental right. So whether you have the right of demonstration, yes. Whether you have right of picketing, yes. So these rights have been identified under which article of the Constitution? Article number 19. Okay, article number 19. State can impose reasonable restrictions on the exercise of this right. This is also very important. So none of the fundamental rights are absolute. Okay, every fundamental right comes with the restrictions which are reasonable. Who is the deciding authority to tell whether the restriction is reasonable or not? Supreme Court. Okay, Supreme Court, even in fact High Court as well. Okay, High Court as well. So state can impose reasonable restrictions. So who can impose reasonable restrictions? State. That is government. On the exercise of this right on the grounds of sovereignty and integrity of India. Okay. So when you are expressing something, okay, as a freedom or a right to freedom of speech and expression, that should not compromise the sovereignty. That should not compromise the integrity of India. Example, now someone who has a access to sensitive information, like where are our defense installments, where are our radars, where are our helicopters. If such information, if someone makes a video and makes it viral, then what happens? The enemy nation may get access to such kind of sensitive information, and they may make an attack on India. Okay, they can wage a war on India. So now your freedom of speech and expression is becoming a threat to India's sovereignty. Okay, if someone attacks India, then probably in the upcoming days they may take complete control of India under them. So that should not happen. So your freedom of speech and expression should not compromise with the sovereignty of India. Okay, so in such fashion you should use the right under article number 19, that is right to freedom of speech and expression. Security of the state. Okay, security of the state. So there are some things which will overlap. For example, security of the state and public order, and almost most of them, they mean the same. So when the security or government can be endangered, for example, someone will let's say he will create a false information message against the government, and he will push the people to go against the government, rebel against the government. So now when you make such kind of things, so you are endangering the state, you are imposing, you are becoming a threat to the security of the state. Okay, that is also not allowed. So some of these things will overlap. Okay, will overlap. Friendly relations with foreign states. Okay, sometimes the information which we express, so in the history there might have been some blunders. For example, if we take the example of India and Japan. Okay, India and Japan. So there is a mystery around the disappearance of Subhash Chandra Bose. Okay, how did Subhash Chandra Bose disappear? There is a theory that he died in plane crash, but we are not sure about his death. So some of this information is present with the document, present with the government in classified form. So classified form means that information should not be revealed to the external world. Probably if that information is revealed to the external world, then chances are that in modern days our relationship with Japan may get spoiled. So whatsoever has happened in the history, now sometimes we have to ignore it. Okay, ignore it. So some sensitive information or your freedom of speech and expression should not cause should not strain the relationship which we are enjoying with the foreign states. I am just giving you an example. Okay, giving an example. Public order. Okay, public order means so law and order should be maintained. So someone should not through provocative speeches force the people to engage in communal violence and all. Okay, so that is to maintain public order. Decency or morality. Okay, so in public we need to be aware of what kind of words we have to use. If you start using abusive words, then it will not be decent. Okay, it will spoil the morality. So that should also not be compromised. Contempt of court. So when we discuss about the judiciary, that is Supreme Court and High Court, we will be discussing about the contempt. There are various kinds of contempt. One is civil contempt, another one is criminal contempt. Okay, so when you do not obey the orders of the Supreme Court or High Court, that is also considered as contempt. And also when you explicitly criticize the Supreme Court and High Court or other judiciary, that is also considered as contempt. So there is a difference, criminal contempt and civil contempt. So once we start discussing about the judiciary, we will discuss about the differences between these two contempts in detail. Okay, in detail. For time being, we shall understand that under article number 19, so if you are involved in contempt of court, okay, so contempt of court is one of the reasonable restriction. Okay, reasonable restriction. Defamation. Okay, so defamation means you will spoil the image of someone. Okay, so using a freedom of speech and expression, you cannot tarnish the image of other personality. Okay, other personality. So that is also not allowed. Incitement to an offense. So almost it means same. So when you force someone to involve in some kind of violence or offense, okay, that is also not allowed. Okay, not allowed. Now repeatedly these things do appear in the newspaper. Repeatedly these things, they do appear in the newspaper, but never a question has been asked in the prelims on the reasonable restrictions that are there for article number 19. Never they asked. Okay, never they asked. But however, as it repeatedly appears in the newspaper, I will urge you to remember all these reasonable restrictions for freedom of what? Speech and expression. Okay, speech and expression. So can you recall the reasonable restrictions which are available for freedom of speech and expression? Okay, should not sovereignty and integrity of India. Public order. Yes. Defamation. Contempt of court. Good. Yes. Relationship with foreign countries. Incitement to offence. Next. Yes. Security of the state. So when you look at the statements, if you are able to identify, that would be sufficient. Okay, that would be sufficient. From mains point of view, when you are writing the answer, so you should be able to quote few of these points. So the article number 19, right to freedom of speech and expression, it is not absolute. So it comes with its own reasonable restrictions. So which are those reasonable restrictions? At least one or two you should be able to quote. But from CLIMS point of view, I'll urge you to recall. You should be able to recall all these reasonable restrictions. So when we are preparing for the prelims, they may ask like this: consider the following 1, 2, 3, 4. How many of the above act as reasonable restrictions for freedom of speech and expression under article number 19? So to address such kind of questions, if we have a clear-cut idea of all these various reasonable restrictions, then we can answer such kind of questions with full confidence. Okay, full confidence. Next, article number 19. Article number 19. Freedom of assembly. Again, that B is there, right? It's not important. That order is not important. Okay, assembly. Every citizen has the right to assemble peacefully and without arms. Okay, so assemble means many people joining together and at a particular place. There is an assembly. So we have the right of assembly, but can we carry arms with us? No. If you carry arms, then probably it may become a threat to the society. It may endanger the public order. So without arms. Okay, without arms, very important. It includes the right to hold public meetings. Can you hold public meetings under article number 19? Yes. Demonstrations? Yes. Take out processions? Yes. So almost most of them, they seem they appear same. So demonstrations, what you can assume as an example is drama. So publicly you will display a drama. There is an example of demonstration. Okay, procession, we move from one place to another place. Whether it includes right to strike, because right to strike is not identified as a right, is not identified as a fundamental right. Right to picketing? Yes. Okay, right to picketing is there. Right to demonstration? Yes. This freedom can be exercised only in public land, very important. Okay, so can you exercise right to freedom on this road, Vidyagiri road? Yes. Again, there are reasonable restrictions which we will see later on. Okay, so you can assemble here because the road belongs to public. Can you go in this neighboring site and you can go for a right of assembly? No. Okay, you have to seek the permission of the owner. So this right is available only in what? Only in public land, not in private land. Okay, not in private land. This right does not include right to strike. So see here, there also we saw, here also again we are seeing it. Right to strike is not recognized as a fundamental right under article number 19. Okay, under article number 19. So same, state can impose reasonable restrictions on the exercise of this right on grounds of sovereignty and integrity of India, public order. Okay. In 19A, we saw so many points. Here there are only 2 points. Now often we get confused whether we should be able to segregate. So exact segregation is not important. Whatever the points you have learnt under article number 19A, reasonable restrictions, those things you keep in mind, okay, that would be sufficient. You need not specifically segregate for 19A and 19B. It will lead to confusion. UPSC is not going to go to that deeper level. So when the contents start overlapping, okay, then the confusions will start. So here they will overlap. These 2 points are also present under the reasonable restrictions of 19A. Hence there will be a confusion. So you need not focus on that. You just remember those things, that will be sufficient. Now what kind of complex questions you will build to yourself is, whatever the points they have mentioned there under 19A, tomorrow if they frame a question like how many of them act as a reasonable restriction for assembly. Okay, now you will get confused. So they are not going to frame such kind of questions. So in one go you need not do it. First you will do only for 19A. Gradually you will prepare the reasonable restrictions for others. Okay, for others. Okay. So section 144 of the Criminal Procedure Code. Okay, we call it as CRPC, Criminal Procedure Code. Now generally few of the aspirants, they have this confusion. So who is most powerful, a DC or an SP when it comes to maintaining of law and order? Yes. So both of them are powerful positions, but in some aspects, so IAS has more powers than an IPS. Okay, an IPS. For example, to maintain law and order. So generally we have heard about a section called as section 144. Many times we have heard. So we call it as generally curfew kind of thing. Okay, so that is imposed under section 144. So this section 144 cannot be imposed by SP. It can be imposed only by a DC. Okay, so here we call district magistrate. So district magistrate means DC. Okay, DC. Under this, a magistrate can restrain an assembly, meeting, procession, etc. to handle unwanted situations. Okay, under section 144 of the CRPC, so DC, that is magistrate, district magistrate, can impose an order saying that people cannot gather even in the public places. So why? To handle unwanted situations. Unwanted situations. For example, if communal violence are going on, in order to halt that communal violence, he can impose section 144. Okay, 144. So during COVID, so one act was invoked. So all the DCs became powerful. That was Disaster Management Act. Okay, Disaster Management Act. Okay, Disaster Management Act was invoked during COVID-19 to handle the situation. Under the section 141 of the IPC, under this, an assembly of 5 or more persons become unlawful in few situations. Okay, so more than 5 people or more than 5 people cannot gather at a particular place. So section 141 of the IPC. But generally, when we hear about section 144 of the CRPC. We have rarely heard about section 141 of the IPC. So hence, it is of low priority. So the upper one, section 144 of CRPC is important. In the exam, they may confuse you. Section 144 of IPC. No, section 144 of Criminal Procedure Code. Now you don't dig deeper and try to understand what is the difference between IPC and CRPC. So tomorrow, if you are fortunate enough or if you wish to become an IPS, so there you will be learning about the detailed provisions of CRPC, IPC, everything. But as a generalist, we don't know about which service we are going to be allotted. Okay, first we want to crack the examination, so we'll stop here itself. Okay, we are not going to dive deeper into each and every sections of IPC and every section of CRPC. Okay, CRPC. So those who are involved in profession of law, so they need to know about all these things. So we are not going to practice law, right? So anyone harbors such kind of dream to practice law? Law. Do you have that aim to practice law? No, right? Okay. Article number 19C, freedom of association. Okay. Now assembly is different, association is different. So association means forming a group which is of permanent nature. Right to form associations and unions. Okay. Right to form associations and unions. For example, you might have heard about the trade union who are involved in strikes. Okay. So even a political party is an association. It's an association. BJP, Congress, JDS. Includes the right to form political parties. Okay, companies, societies, clubs, trade unions, etc. Okay, so right to form a political party is a fundamental right under which article? Article number 19. So broadly it falls under article number 19. Okay, so right to form a company, article number 19. Okay, 19. It also covers the negative right of not to form or join an association or union. Let's assume you are not interested to join any of the organization. So no one can force you to join that organization. Okay, even not to join is a right. Okay, not to join an association is also a fundamental right. Okay, is also a right. State can impose reasonable restrictions on the exercise of this right on the grounds of sovereignty and integrity of India, public order, morality. So in the first, right to freedom of speech and expression, how many reasonable restrictions are there? Count wise? Yes. How many reasonable restrictions were there? 9. Second one? 2. Here? Okay. So here exactly you need not segregate, because in one go if you try to do this, it will lead to confusion. Okay, it will lead to confusion. So sovereignty and integrity of India, public order and morality. So whatever the organization that you are going to form, for example, whether terrorists have an right to form association? No, because what it will do? It will become a threat to sovereignty of India. It will become a threat to sovereignty of India. Okay, public order. Now an organization will be formed which will be involved in some kind of violence. Okay, so we do not have such kind of right to form an organization which is involved in violence, which becomes a threat to the public order. Okay, public order. Right to obtain recognition of the association is not a fundamental right. Okay, now you will form an association. Okay, you will form an association. For example, BJP, Congress, JDS, you have formed an association. So you will force the government that it has to be identified. Okay. So it is left to the government whether to identify it or not. You cannot claim it as a right that you should identify my organization. Okay, it is not a fundamental right. Okay, it's not a fundamental right. So right to form association is a fundamental right, but identification, recognition as an organization, that is not a fundamental right. It is at the mercy of the government. So government may recognize or it may not recognize it. Okay, it may not recognize it. Supreme Court and trade unions. So generally you might have heard about the trade unions. So people who are involved in trade and factories. So whenever there is a strike and all, you might have heard about the trade unions. Okay, trade unions. So we will be discussing about the various trade unions also in the forthcoming discussions as part of the history and also as part of the current affairs. Okay, current affairs. Held that trade unions have no guaranteed right to effective bargaining or the right to strike or right to declare a lockout. This is very important. Okay. Now generally trade unions, for example, in India the famous trade union, there are so many trade unions, international ITU is there, many trade unions are there. So what they will do to get their demands satisfied, they will make a lockout. Means on that day they will decide that they are not going to work in the factory. Okay. And next they may go for strike, or they may also try to bargain with the owners of the factories. So none of these are covered under the fundamental right. Okay, these are not guarantees as per the Supreme Court. Okay, as per the Supreme Court. The right to strike can be controlled by an appropriate industrial law. Okay, so if they try to strike, then it can be controlled by an appropriate industrial law. So this detailed explanation, you just ignore it. Again, it will lead to confusion. Okay, not important. So the right to strike is a fundamental right? No, it's not a fundamental right. The fundamental right. Freedom of movement. Every citizen to move freely throughout the territory of India. Okay, so a person residing in Karnataka can go to Punjab, a person residing in Assam can come to what, Maharashtra. So there is what, right to freedom. Underlines the idea that India is one unit so far as the citizens are concerned. So India is one entity. Okay, one entity. And we also seen that whether India has dual citizenship or single citizenship provision. Single citizenship. So purpose is to promote national feeling and not parochialism. Okay, if state-wise, if we do not permit one person to go to another state, then it will promote regionalism. But here we want to promote nationalism, so that a person should be able to freely travel from one part of the country to other part of the country. So it promotes national feeling. Okay, promotes national feeling. Here also, state can impose reasonable restrictions on the exercise of this right. Okay, interests of general public. So this interest of general public, it has not been defined. It has not been defined. So just at a superficial level, if the right to movement, if it affects the public interest in any part of the country, then it should not be allowed. So this has not been defined, so not important. Protection of interest of scheduled tribe. This is very important. This we have to remember. Okay, because in certain areas where scheduled tribes are residing, so I don't know whether here it is there or not, but as part of the current affairs it appears. Okay. So as part of the current affairs it appears. So there are few areas, probably in some class we discussed. There is a area called as inner line permit. Inner line permit. It is called as ILP. Okay, ILP.
IAS coaching.
ಹೌದು ಸರ್. ಹಾಂ ಹೌದು ರೀ.
ನಮ್ಮ ಮಗಳ ಬಿ ಮುಷಲ್ರಿ.
ಹೌದು ರೀ ಸರ್, 12 1 ಗಂಟೆಗೆ ಭೇಟಿ ಆಗ್ಬಿಟ್ಟು ಕ್ಲಾಸ್ ಮಾಡತ್ರಿ ಈಗ. ಹಾಂ ರೀ, 12 ಇಲ್ಲಿ ಆಚೆ ಕಡೆ ಆಫೀಸ್ ಐತೆ ಸರ್ ನಮ್ದು. ಇದು ಈಚೆ ಕಡೆ ಆಫೀಸ್ ರೀ. ಹಾಂ, ಇಲ್ಲೇ ಆಫೀಸ್. 12 1 ಗಂಟೆಗೆ ಬರಲಿ ಸರ್ ಪ್ಲೀಸ್.
ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು ಬರ್ರಿ
ಸರ್. ಹಾಂ, ಕ್ಲಾಸ್ ಮಾಡತ್ರಿ ಈಗ, ಅದಕ್ಕೆ ಥ್ಯಾಂಕ್ ಯು. So we were discussing about inner line permit. So there are some states in northeast, okay, Nagaland, Assam, Manipur, and recently few more states have been added. We'll be discussing in detail. So whether Nagaland, Manipur and Assam, they are part of India? Yes, they are part of India. So as per the right to movement, any citizen of this country should be able to move from one part of the country to other part of the country without any kind of special permissions and all. But here, to enter few areas of Nagaland and Manipur, you have to take a special permission from the government. That is called as inner line permit. So why they have made so? To protect the scheduled tribes. Okay, scheduled tribes. So protection of interests of the scheduled tribes is one of the reasonable restriction for what? Right to movement. Okay, right to movement. So these detailed provisions are not important. Entry of outsiders in tribal areas is restricted to protect the distinctive culture, language, customs and manner, etc., and to safeguard the traditional vocation and against exploitation. So these line to line things, these are not important. Okay. Protection of interests of the scheduled tribe is one of the reasonable restriction for freedom of speech and expression. Yes, freedom of association, freedom of assembly, freedom of movement. Okay, freedom of movement. So here you will remember specifically, there that specificity is not important. So here also they have never asked a question, but it is important. Whenever a special provision is made for a scheduled tribe, it becomes very important from exam point of view. Okay, whenever a special provision is made for a scheduled tribe, it becomes very important from exam point of view. Okay, point of view. Supreme Court and prostitutes. So held that freedom can be restricted on the grounds of public health and in the interest of public morals. So this is also important. So in prelims I am not sure whether they are going to ask, but in the mains you can quote. So whether prostitutes can move in any part of the country? No, they cannot move because the restriction is public health. Probably if they move to any part of the country, then chances are that the person who will have sexual intercourse with these people, they may get affected with HIV. Okay, HIV. So based on public health and public morals, so the movement of prostitutes can be restricted as per the Supreme Court judgment. As per the Supreme Court judgment. Bombay High Court validated the restrictions on the persons affected by HIV/AIDS. Okay, probably someone took the case to what? Bombay High Court. So that we want right to movement, people are restricting. So Bombay High Court ruled that that can be restricted because when a person affected with AIDS, if he comes in contact with the other person, then there are very high chances that that disease may spread. That disease may spread. So these examples, there are very less chances that they can ask in prelims, but we shall be ready. Okay, we shall be ready. So whether reasonable restrictions can be imposed on the movement of prostitutes? Yes. Reasonable restrictions can be imposed on the movement of persons affected with HIV/AIDS? Yes. Whether reasonable restrictions can be imposed on the persons affected with COVID-19?
It's not.
Yes. Okay. No Supreme Court, High Court has yet given the judgment, but reasonable restrictions can be imposed, and that is what we witnessed in 2020 and 21 during COVID years. Okay, during COVID years. Has two dimensions. Has two dimensions. Internal, right to move inside the country. Article 19 protects it. So this is a very important point to note. External, right to move out of the country and right to come back to the country. This is not dealt by article number 19, it is dealt by article number 21 and not article number 19. This is very important. So question has never been asked, but if at all they ask. So right to move out of the country and come back to the country is covered under article number 19. True or false? False. It is covered under article number 21. So article number 19 deals with only movement within the country. Okay, within the country. Next, freedom of residence. Okay, residence. Every citizen has the right to reside and settle in any part of the country. Okay, we have the right to reside and settle in any part of the country. So a person who is residing in presently Karnataka, he can go and settle in Punjab. A person who is living in Uttar Pradesh, he can come to Kerala and settle in Kerala. There are no restrictions. Has two parts. Reside, stay at any place temporarily. So term reside indicates temporary. It means you have the right to stay temporarily and also settle, to set up home of domicile at any place permanently. Okay, so it means freedom of residence, it covers both temporary stay, that is residence, and also permanent, that is settle. Okay, settle. Promotes nationalism and avoids narrow-mindedness. Okay. So it promotes nationalism. Okay, so when you are permitted to settle in any part of the country, it promotes nationalism. How it promotes nationalism? So these detailed aspects are not important. So by this time we will be able to connect with the help of an example. State can impose reasonable restrictions on the exercise of this right on the grounds of interest of general public. Where did we see interest of general public? This kind of reasonable restrictions where we saw freedom of movement, right? So it does not have any definition, so we'll not worry about it. We'll not worry about it. Protection of interest of scheduled tribe. So where we saw freedom of movement. Similarly here in freedom of residence also, this is a reasonable restriction to protect the interests of scheduled tribe. Now these things, whether they are important, now you should tell me. Okay, completely not important. Article number 19E. 19E. Article number 19E. Again, E, that alphabet is not important. Freedom of profession. Okay, profession. All citizens have the right to practice any profession or to carry on any occupation, trade or business. So any person can carry out what? Any profession. He may be doctor, he may be a lawyer, okay, he may be a engineer, and he may carry out any kind of trade and business. Okay, trade and business. But again, qualification should be there. Okay, to become a lawyer, he should have completed law. To become an engineer, he should be an engineering graduate. To become a doctor, he should be a graduate either in BAMS or MBBS. Okay, MBBS. Even BHMS as well. So state can impose reasonable restrictions on the exercise of this right on the grounds of interest of national general public. Okay, not important. Left. State is empowered. This is important. Prescribe qualifications. Okay, so you can involve yourself in any profession, but for that basic qualification is required. Who is going to set that qualification requirement? State. That is, government is going to set it. Carry on by itself any trade, business, industry or service, whether to the exclusion, complete or partial of citizens or otherwise. This point is also important. Now what the government can do is, it has a special power. It can say that some business can only government can involve, private entities cannot involve. Okay, cannot involve. It can specify. For example, few decades back, telecom was the industry which was only open to government sector. Means only BSNL can operate the telecom related infrastructure and telecom facilities. Okay, telecom facilities. So such a restriction can be imposed by whom? State. Okay, state. So this was an example of socialism. Okay, socialism. But later on in 1991, again we will be discussing about the policies in economics. So we shifted to what? It was diluted. Okay, some of the capitalist aspects so start creeping into the Indian system. So now India has a what kind of economy? Socialist economy or capitalist economy? Yes, it's a mixed economy. Okay, even though in the preamble the term socialism exists, but in India the economy is a mixed economy. Okay, mixed economy. So state government can say that this is the business, only I can do it, you cannot do it. Okay, so this restriction can be imposed by state. Thus state is not required to justify its monopoly. Now I took the example of BSNL, right? So only government can involve itself in such kind of services. It need not give any kind of justification. For example, if you presently look a sector like atomic energy, okay, atomic energy or nuclear energy. So can a private entity involved in atomic energy in India? Now presently we have nuclear power plants. Okay, so all of us we have heard about the power plants, right? So power plants, because of the power plants we receive electricity. So the predominantly the power plants which are present in India are what kind of power plants? Thermal power plants. Okay, so because of the coal, so energy is generated and electricity is generated and we get it. Okay, we get it. There is a small share, around 2% of the electricity generated in India, it comes from nuclear power. Okay, nuclear power. So wherein uranium is used as a fuel and then electricity is generated. How it is generated, we will not worry about it for time being. But close to 2% of the India's electricity is generated by uranium. Okay, uranium. Now, who owns the thermal power plants? Government or private sector? Both government and private sector own thermal power plants. Okay. When it comes to solar power plants, who own them? Both government and private. There are some solar plants which are owned by government, some solar plants which are owned by private entities. Okay, private entities. When it comes to nuclear power plants, they are completely owned by government. None of the nuclear power plants in India are owned by private entities because they are not permitted. So they are not permitted. So here you understand that there is a monopoly of the government over the nuclear power plants. So now government need not give an explanation. So because of the security of the nation, we are keeping our monopoly. So it need not give any kind of explanation. Okay, need not give any kind of explanation. Next, when we say profession, this profession does not extend to immoral activities. For example, trafficking in women and children. So person will say, so I am engaged in a profession wherein I purchase the human beings in India and I'll sell them in Bangladesh or Pakistan or Afghanistan. Okay, so that will not be called as a profession. That is illegal. So immoral activities, you cannot involve yourself in immoral activities and claim the right of profession under article number 19. Okay, 19. Or danger, harmful drugs or explosives, etc. So those who are involved in trading of harmful drugs and explosives, so that cannot be considered as a profession under article number 19. State can absolutely, not limited, state can absolutely prohibit these or regulate them through licensing. Okay, regulate them through licensing. So licensing not in case of trafficking in women and children, licensing in case of explosives, licensing in case of harmful drugs. Okay, sometimes harmful drugs also have application in the medical field. So hence their trade is required. Okay, their trade is required, but it will be regulated through a license. Regulated through a license. So trafficking in human beings, women and children, it is nowhere regulated. There is no license issued in India, either in India or any of the countries. Okay, any of the countries. Yes. So next we will start discussing about article number 20. Article number 20. Protection in respect of conviction and offences. Okay, conviction and offences. So there has never been a question on article number 20 till now. If you look at the entire question paper from 1990s to 2025, there has never been a question on article number 20. Okay, 20. Now we'll discuss it, but you also need to understand the exam's demand. Okay. Now majority of them, they think that probably UPSC was waiting for me in 2026 to set a question on article number 20, and they'll try to dig information to the deeper level. Okay, so please don't give such kind of intuition mind. In the worst case, even if they ask what a difficult question on article number 20, we'll skip it. Okay, just because they are not asked this year, they may ask to a deeper level, so we'll not try to explore more on this. Okay, more on this, and also based on the previous year trend, we need to know that it enjoys a lesser priority from exam point of view. Okay, exam point of view. But there are some important points here. Grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. So here we have to understand multiple things. One is it extends to an individual, it also extends to an organization. It extends to Indian citizen, it also extends to a foreigner. Okay, a foreigner. All of them can claim rights. Okay, claim rights. What is that? Arbitrary and excessive punishment. Arbitrary and excessive punishment. Yesterday we saw the example of arbitrary. So whatever they feel is good, so as per that they are going to give the judgment. That is called as arbitrary and excessive. For example, the imaginary example which we took, Murder Act. Okay. Anger Murder Act. Okay. So you lost your emotional control, you became very angry and you murdered someone. So as per this law, a person should be given maximum of 5 years of imprisonment. Okay. For 5 years he has to be sent to jail. But now, while giving the punishment, let's assume he is being given 15 years of jail. So what does it mean? It's arbitrary. Means whosoever is giving the judgment, so as per his whims and fancies he is giving. Because as per the law, he should be given only 5 years. And also it is excessive. He should be given only 5 years, but he is being given the punishment of 15 years. So such kind of arbitrary punishments, excessive punishments, to avoid that, a person will get a right under article number 20. Article number 20. Okay, so it applies to legal person like a company as well. Company as well. Okay. So if you look at the company as an example, so let's assume company is involved in a fraud. Okay, probably they might have diverted their income source and they might have reduced the taxes which they are paying to the government. Now tomorrow if the government comes to know about the fraudulent activities of this industry, so what the government can do, it can punish, it can bar the industry for 5 years. It means 5 years it cannot sell any of its items. Now they are to be barred for 5 years, it is written in law. But if the government says that you are permanently barred, then what happens? It's more than what is written in law. It is arbitrary. Okay, arbitrary. So this is an example of a punishment for an organization. No ex post facto law. No ex post facto law. conviction only as per the law in force at the time of commission of act. No greater penalty than the prescribed by the law in force at the time of the commission of act. Ex post facto law, that imposes punishment retrospectively upon acts already done, that increases punishment retrospectively upon the acts already done. Okay, so here we'll just understand with the help of an example. Okay, with the help of an example. So let's assume Rape Act 2011. Okay, so one act which deals with the rape. So person who is involved in rape, so as per this act, he should be sentenced for a jail of 10 years. Okay, he should be sent to jail for 10 years. Okay, 10 years. Let's assume, so rape occurs in 2021. Okay, 21. Now, what will be his sentence? For how many years? For 10 years. So let's assume in 2022, Rape Act Amendment 2022. Now what they will do is, they will enhance the punishment for rape, jail for 20 years. The original law was brought in 2011. As per that law, 10 years. Rape happened in 2021. The law was amended in 2022 and was enhanced to 20 years. Now the person who is involved in this case, person 1, okay, person 1, he should be given what, how many years? 10 years. But you will start a trial. So these rape trials and all, they do not just complete in what, 5 months or 6 months. It may take 1 year or 2 years or 3 years. Let's assume in 2022 the trial is happening. All of a sudden this new law has been brought. Okay, so they are not yet given the final judgment. Now, what should be the punishment for him? 10 years or 20 years?
10 years.
10 years. So this is the meaning of no ex post facto law. This is the meaning of no ex post facto law. Now, a person who is involved in rape, let's assume this is brought on January 1. On January 2, someone commits rape. Now, he will be given a punishment of 20 years. Okay. So, at the time of committing that mistake, conviction as per the law in force at the time of the commission of the act. At the time of the commission of the act, whatever punishment is there, the same punishment he or she should get. No greater penalty than that prescribed by law in force at the time of the commission of the act. So at that time the act said only 10 years. Okay, only 10 years. So here I have written the meaning of the ex post facto law, that imposes punishment retrospectively. So there are some laws, for example in this example we took, right? So if this law is ex post facto law, then in the law what we will do is Rape Amendment Act 2022, in the law I will write, this will apply to all the cases starting from 2015. In the law itself I will mention, it will apply to all the cases which have taken place from 2015. Now what happened? 2021, the case which was there, now it will start getting applied to him as well. Okay, So this law is called as retrospective law. So which goes back in time and starts applying, that is called as retrospective law. Okay, retrospective law. So here they say that there should be no retrospective law. Okay, retrospective law. So here there is a very thin line, very thin line. What is that? Enactment of ex post facto law prohibited on criminal laws. Okay. For example, the thing which we discussed, rape, it comes under criminal offence. Okay, criminal offence. Again there is a restriction. What is that? Prohibits only conviction or sentence under ex post facto law. Okay. Does not prohibit the trial thereof. Okay. Does not prohibit the trial thereof. Already if the judgment has been given, then it will not apply. But if the judgment has not been given, then it may apply. Okay, it may apply. But I already mentioned, UPSC has never asked a question on article number 20. Now there may be few points where it may start confusing you. So don't try to hunt answers for the same and try to waste your time. We'll stop here itself. Okay, we'll stop here itself. So Enactment of ex post facto law, it is prohibited on criminal laws except in few cases. Which are those cases? The detailed explanation not required. Not prohibited on civil laws or tax laws, very important. Okay, when it comes to civil laws, any other, for example, property related law, tax laws. So, ex post facto law can be applied on tax law, and this is the major reason of dispute between the companies and the government. Now, generally, government what it will do? It will bring a new kind of tax. Okay, it will bring a tax in 2023, so 25, saying that Income Tax Act 2025. Now you have brought the law in 2025. So from this year onwards, a company should pay taxes. But in law, what they will mention, the company should pay the taxes from 2021 onwards. Means whatever the profits it has been making from 2021, on all the profits, it has to pay the taxes. So this is called as retrospective tax. Okay, retrospective tax. So whether it is favorable to government, yes, obviously government will get more revenue, it will be favorable to government. Whether it will be favorable to company?
No, sir.
No. When you bring such kind of law, whether a person who is willing to start a new company, will he come forward to start a new company?
No, sir.
No, because he'll be scared. Today I'll bring a new business, but tomorrow if the government starts imposing retrospective taxes, then I'll face losses. So when we start discussing about the economic related topics, we'll understand there are certain threats, there are certain challenges which prevent the entrepreneurs from starting the new enterprises. Okay, so this is one of the challenge. So here what we'll understand here is, so ex post facto laws are prohibited on criminal laws. You just forget about all of them. Are prohibited on criminal laws, but they are not prohibited on civil laws or tax laws. Okay, tax laws. Protection under this provision cannot be claimed in case of preventive detention. Protection under this provision cannot be claimed under preventive detention. So, preventive detention, this term is very important. A question has been asked on preventive detention, but not in article number 20, under article number 22. Okay, 22, but you shall understand about preventive detention. Now, someone will be arrested and put in jail often after they commit some kind of sin or some kind of, if they are involved in criminal activities or some other activities, for example, rape, murder, theft, etc. Now, before they commit any kind of such kind of activities, before they are involved in such kind of activities, so government will fear that they may get involved. Okay, and before that itself, they'll arrest and they'll put them in jail. So you might have seen, if there is some festival going on in a native place and all, there will be few people who will be arrested and they will be put in jail until the festival is over, because they should not cause harm to the public. Okay, they should not get involved in such kind of activities. So without committing any mistake, so thinking that they may commit, some people will be arrested and put into jail. Okay, that is called as preventive detention. We want to prevent the crime that is going to happen in the future. Okay, so detention means you are going to put them in the jail, preventive detention. So in case of preventive detention, what you can do, you can bring ex post facto law. Okay, for example, if a preventive detention law says that a person can be put in jail only for 1 month. Okay, 1 month, but ex post facto law can make the changes and they can say that he can be put in jail for 2 or 3 months. Okay, 2 or 3 months. Again, we will not worry about those detailed aspects. We shall understand what is preventive detention. Okay, preventive detention. So, protection under this provision cannot be claimed in case of preventive detention. Means article number 21, protection, cannot be claimed under preventive detention. Okay, preventive detention. So again, some things you will not understand here. You will not understand completely. Okay, and you will not go into the exercise of finding extra information to understand it completely. Whatever partial understanding you have, gained, with that understanding itself, we shall continue. Okay, we shall continue. Next, no double jeopardy. No person shall be prosecuted and punished for the same offence more than once. So let's assume a person is charged of theft. He is involved in some kind of theft, robbery. So he is already punished for 5 months. For the same case, he should not be arrested and punished one more time. Okay, one time crime, only punishment once, not twice. Okay, no double jeopardy. Available only in proceedings before a court of law or judicial tribunal. Okay, not important. Not available in proceedings before a departmental or administrative authorities, as they are not of judicial nature. So this detailed information not important. Okay, no double jeopardy is present on which article? Article number 21. Okay, article number 21. This detailed aspects, it is not important from exam point of view. Okay, not important from exam point of view. Okay, even if you want to go, you just memorize it. What you will memorize? Available only in proceedings before a court of law or judicial tribunal, not available in proceedings before an administrative authorities. So what is administrative authority, what is judicial proceeding, that detailed, that minute difference is not required. Otherwise altogether if you accord less priority also, it's okay. Because in the history they were never asked a question on article number 21. Even if they ask, it will be at the superficial level. 20? Article number 20. They have never asked a question on article number 20. So even if they ask, it will be at the superficial level. Okay, superficial level. No self-incrimination. No self-incrimination. Okay. No person accused of any offence shall be compelled to be a witness against himself. Okay. You might have seen in the court of law that someone cannot give a testimony against himself. Even if he gives also, it will not be accepted in court of law. There should be some third party who should act as a what? Witness. Okay. Now because of the police torture, there will be self-confession, right? So that will not be acceptable. So no self-incrimination. No person accused of any offence shall be compelled to be a witness against himself. Compelled. He should not be forced. Whether voluntarily he can give a witness against himself, yes, that is okay. Okay. But how will you distinguish whether it is voluntary or whether it is compelled? Okay. That will be a challenge. So in the police station he will say that I will obey, but in front of the court he will go and say, no, yesterday I was given a third degree treatment by police, hence I have accepted it, otherwise I have not committed this crime. Okay. So it's very difficult to distinguish. Extends to both oral evidence and documentary evidence. Okay. So no self-incrimination, it extends to not only oral evidence but also documentary evidence as well. Okay. He should not be forced to provide any of the documentary evidences. Again, theoretically, we will not go into practical aspects. Does not extend to compulsory production of material objects, compulsion to give thumb impression, specimen signatures, blood specimens, etc. So we said that he cannot be forced to give a oral testimony, okay, that I have committed such kind of murder and all. If tomorrow we want to check your blood samples and match with the blood samples which are available at the crime site, then he cannot say that no, I am not ready to give my blood samples. Okay, so blood samples can be extracted from him. Next, thumb impression. Now we want to check whether his impressions are there at the crime site. Okay, so at that time he cannot say no, I am not going to give. So whatever the freedom he has, it cannot be extended to these things. Only orally you cannot force him, but he should be ready to give all these thumb impression, blood samples, all those things. He should be government should be able to extract it. Compulsory exhibition of body means he should expose all these body parts so that when the investigation is going on, so they should be able to check it. Extends only to criminal proceedings, does not extend to civil proceedings. So they are never asked, but just remember this information. Okay. So what we are discussing here, which point? No self-incrimination. It extends only to criminal proceedings. Okay. So it does not extend to civil proceedings. What is civil proceeding, criminal proceeding? Criminal is an example of, for example, murder. It's an example of a criminal proceeding. Somewhere a case related to property, it's a civil proceeding. Okay, civil proceeding. So at the superficial level, you just memorize it. What is that? It does not extend to civil proceeding. It extends to criminal proceeding. Okay, criminal proceeding. And in the end moment, there is so much information that you are supposed to revise. If you do not get time to revise these things, you will skip altogether article number 20 itself. Okay, altogether article number 20 itself you will skip if you do not have sufficient time, and if you think that going through this content will lead you to confusion. Okay, lead you to confusion. Article number 21, a very important article from exam point of view. Repeatedly questions do appear on this article number 21. Okay, 21. So here in the book or in the original constitution they are given just one single line, that is protection of life and personal liberty. But Supreme Court through its interpretations, it has given a wider meaning to this term. Okay, wider meaning to this term. No person shall be deprived of his life or personal liberty. Deprived of his life means we should not take someone's life. We should not take someone's freedom except according to procedure established by law. If you want to deprive someone of his life, that is if you want to kill someone, then it should happen as per the procedure established by law. So what is the procedure established by law? A FIR should be filed in the police station. Next, investigation should take place. After that, a trial should happen in the court, and then the court will give the judgment that on so and so day he should be hanged. Then on the hanging day, he should ask them his last wish. Okay, so all those things, and then finally he will be hanged. This is procedure established by law. Means, can you take the life? Yes, but as per procedure established by law. Okay, procedure established by law. So when police are involved in encounter, so whether it is procedure established by law? No. Hence it is called as extrajudicial killings. Whenever police encounter take place, actually in the law it is not permitted, because it is considered as extrajudicial killings. Why extrajudicial killings? Whenever you want to deprive a person of his life, the process involved is first you should file a FIR against him. Then investigation will start taking place. Then they'll file a charge sheet. After that charge sheet, the trial will go in the court. Finally, court should give the judgment. Based on the judgment, they should be executed. Okay, executed. I'm just giving an example. So similarly, if you want to take someone's freedom, that is, freedom means, let's assume a person who is walking freely in the society, he has freedom. But if he is imprisoned, if he is put in jail, then his freedom is lost. So you can put a person in jail only as per the procedure established by law. Okay, if you don't like a particular person, you cannot forcefully, arbitrarily take that person and put him into custody. So whether you are taking a life or whether you are taking a person's freedom, it should happen as per the procedure established by law. A very important point. Available to citizens as well as non-citizens. Okay, very important. So this right to life and liberty, it extends to both Indian citizens as well as foreigners. Okay, as well as foreigners. Okay. Now here, few things that we will be discussing here. I will be highlighting few aspects. We will be only focusing on those aspects. Okay. Rest all the things we'll just ignore. Okay, ignore. Now this Gopalan case, especially the case, you can quote it in mains. From prelims point of view, they are not going to ask you about the Gopalan case. Okay, Gopalan case. So as we discussed about the Keshwanand Bharati case, right? Similarly, there was one more case called as Gopalan case. Okay, Gopalan case. Supreme Court took a narrow interpretation in Gopalan case. Okay, in Gopalan case. Next, in Maneka Gandhi case, it took a wider interpretation. So this case is in 1978, that Gopalan case was in 1950. So there a narrow interpretation, here the wider interpretation. Which is a recent judgment, the latest judgment? Maneka Gandhi case. So what will hold true presently? Whatever the judgment that the Supreme Court has given in the Maneka Gandhi case. Okay, Maneka Gandhi case. So whatever the Supreme Court has given here, this is correct. This will hold true now. Okay, hold true. But just to connect these things, we shall discuss about the above Gopalan case. So here we need to understand that Gopalan case is not that much important. Okay, because the present we will be following the judgment given in the Maneka Gandhi case. So took a narrow interpretation. Protection available only against arbitrary executive action, not available against arbitrary legislative action. Okay, so these things you will not understand in detail at this point of time. Well, it will take some more time. I'll try to take an example. To some extent you will be able to understand, but not completely. Okay, not completely. So in Gopalan case, what the Supreme Court said? Protection available only against arbitrary executive action, not against arbitrary legislative action. Okay, legislative action. This means state can deprive the right to life and personal liberty of a person based on law. This is because of the expression procedure established by law in article number 21. So what is explicitly mentioned in article number 21? Procedure established by law. Okay, procedure established by law. Now, we will understand with the help of an example. Theft Act 2025. Theft Act 2025. Pencil theft. Okay. Mobile theft. Next. car theft, gold theft. I have just taken a imaginary example. So section 1 deals with pencil theft, section 2 deals with mobile theft, and section 3 deals with car theft, and section 4 deals with gold theft. Okay, gold theft. Now in section pencil theft, they say that if a person has stolen a pencil, then he should be given 1 slap, so that next time he should not steal. Next, under mobile theft, he should be kept in jail for 5 days. Okay, for car theft, so he should be kept in jail for 30 days. So gold theft, depending upon the quantity of gold, okay, depending on the quantity of gold, some punishment will be there. Okay, some punishment will be there. Now here we say procedure established by law. Whatever has been mentioned in law, the punishment will be given. If it is 1 day, 1 day. If it is 3 days, 3 days, 5 days, 5 days. So as per the procedure established by law, punishment will be given. Okay, punishment will be given. Now here, arbitrary executive action, arbitrary legislative action. Okay, arbitrary legislative action means they will bring the law as per their whims and fancies. Who is going to bring the law? Parliament. Lok Sabha will pass the bill, Raj Sabha will pass the bill, and President will sign it. Okay, they'll sign it. So they will not give a second thought whether this much punishment is required or not. They'll just bring the law. Okay, they'll just bring the law. For example, instead of 1 slap, let us assume they'll bring a arbitrary law saying that a person who is involved in theft, he should be given 5 years of jail. Five years of jail. But do you think it is fair enough for a person who has just stolen a pencil? Okay, 1 slap was okay, but now they have made a law for stealing 1 pencil, he will be given 5 years of imprisonment. Probably they may give they may defend like this. Tomorrow person today who is stealing a pencil, tomorrow he may steal gold. So in that perspective, let us give a big sentence, okay, big punishment, but it is not fair. We understand that it is not fair. Okay, anyone who closely observes it, he will come to a conclusion that it is not fair. Okay, it's not fair. But as per the Gopalan case, it said that arbitrary action is not good. Arbitrary action means already in the pencil theft case, we shall go to the previous one. We shall go to the previous example, slap. It was mentioned only 1 slap. But in the arbitrary action, not 1 slap, you hit him 10 times. Okay, in law it has been mentioned as only 1 slap, but the Council of Ministers, we call it as executive, right? So even police officer is a part of the permanent executive. Now a higher official will tell to the constable, give him 10 slaps. So now this is arbitrary action. Arbitrary what kind of action? Legislative action or executive action? Executive action. Law says that only 1 slap should be given, but he was given 10 slap. So this is arbitrary executive action. Now can we file a case against the police in the court saying that my rights have been infringed? Yes. Because as per the law, you should be given only 1 slap, but police have given you 10 slaps. Okay, you can file a case against the police in the court of law because protection is available against arbitrary executive action. Okay, arbitrary executive action. Now, arbitrary legislative action. We shall come to the second case, 5 years of jail. Now, someone will go and file a case against the parliament, against the government, saying that everyone knows that for stealing a pencil, so 1 slap or 10 slaps would have been sufficient. 5 years of jail is not required. Okay, can we file a case against the government saying that the legislative action of the government is not fine? Okay, so here protection is not available against arbitrary legislative action. So when 5 years of imprisonment was given, okay, one was made as part of the section 1, so it is arbitrary. Whether it is arbitrary means legislature, that is parliament, has made a law as per its whims and fancies. Whatever it wishes, it has brought in the form of a law. Now in Gopalan case, Supreme Court said that you have a right against arbitrary executive action, 10 slaps instead of 1 slap. But in case of arbitrary legislative action, you do not have any kind of rights. So whatever is written in the law, the same should be followed. Because in India, article number 21 says procedure established by law. Article number 21 says procedure established by law. Whatever is written in the law, you have to just follow it. Okay, follow it. So this was the interpretation made by the Supreme Court in which case? Gopal case. But which judgment we should follow? The recent judgment. So what does the recent judgment say? So this procedure established by law, it is slightly different from the expression due process of law contained in American Constitution. Hence, the validity of the law cannot be questioned on the ground that the law is unreasonable, unfair, or unjust. So, we are still speaking about which case? Gopal case. So, here they are saying that in India it is procedure established by law, but in America they follow due process of law. In due process of law, what they can do is they can challenge arbitrary executive action. They can also challenge arbitrary legislative action. Someone can go and file a case in the court saying that 5 years of imprisonment for a single or stealing of one single pencil, it's not fair, it's unfair, okay, it's unreasonable, it is unjust, because in America there is a due process of law, okay, due process of law. In India, procedure established by law. So this was the reason given by Supreme Court in Gopalan case, okay, in Gopalan case, held that personal liberty means only liberty relating to person or body of the individual. So, personal liberty means physically you should not be harmed, okay, even if you do not understand the deeper level also, just ignore it. So, personal liberty means only liberty relating to the person or body of the individual, okay, individual. Next, Maneka case, are very important. Supreme Court overruled its judgment. So, Supreme Court has the power. When we start discussing about the Supreme Court, we will be discussing the power to review its own judgment. So, whatever the judgment the Supreme Court had given in Gopalan case, that judgment was reversed, it was changed and took wider interpretation. So in Gopalan case, Supreme Court had took a narrow interpretation. Here they took a wider interpretation. So what was that wider interpretation? Right to life and personal liberty can be deprived by a law provided the procedure prescribed by the law is reasonable, fair and just. So whatever has been given in the law, it should be reasonable, it should be fair and just. It means, in other words, it has introduced the American expression due process of law. In the Indian Constitution, under Article number 21, we have only procedure established by law. But who is the final interpreter of the Constitution? Supreme Court. So Supreme Court in Maneka Gandhi, it brought the features of due process of law in India. It brought the features of due process of law in India. Okay, law in India. Hence, protection available not only against arbitrary executive action, but also against arbitrary legislative action. Now, we should be, if someone asks us a question, presently in India, under Article number 21, whether protection is available only against arbitrary executive action, or also protection is available against arbitrary legislative action as well? Both. Because we will not take the Gopal case, we will take the recent case, that is Maneka Gandhi case. So this is the final thing that you are supposed to remember from prelims point of view. That background is important from mains point of view, from understanding point of view. But from the exam point of view, what we are supposed to retain is, we are supposed to focus on these points. We are supposed to focus on these points. So very challenging points, only if we try to connect with the help of an example, then we will be able to understand. Otherwise, majority of the aspirants, what they do is, they will skip this part. They will skip this part. You should not skip. With the help of an example, now I hope you are able to connect. So that much information would be sufficient. Okay, sufficient. Held that right to life is not merely confined to animal existence or survival. Okay, just bodily I am not harmed does not indicate right to life. Okay, right to life. It gives few features. What is that? Right to life also includes right to live with human dignity. Okay, I am physically fit, but no one is respecting me. So it is not a life with dignity. So life should be with dignity. So that is, life with dignity is also part of the Article number 21, right to life and liberty. Right to all those aspects of life which go to make a man's life meaningful, complete and worth living. So right to life does not mean only the physical existence. It extends to all things which makes the life meaningful. So to make the life meaningful, what are the various aspects apart from health?
Respect.
Okay, education, health, okay, society, relationship, marriage. So all these things, they will make a worth living. So all these are included as part of the right to life. Okay, right to life. Ruled that personal liberty is of widest amplitude and covers a variety of rights which were reaffirmed in the subsequent cases. Okay, subsequent cases. So personal liberty in subsequent other cases. So Supreme Court has held that. So they are all part of the right to life. An example, right to privacy. As we discussed, right to privacy is a right under which article? Article number 19 or 21? 21. Right to environment, article number 21. Right to marry a person of one's choice, Article number 21. Now for every these rights, there is a case. For example, right to marry a person of their choice. It came under a case called as Hadiya case. Okay, Hadiya case. But here we are not interested in these cases. When they come as part of the current affairs, we will be focusing. But from the exam point of view, if you focus especially prelims. So right to marry a person of one's choice. Article number 21. Next, right to environment. Freedom of press.
19.
Article number 19. If you are able to segregate, if you are able to differentiate, that would be more than sufficient. Okay, that would be more than sufficient. So this is about article number 21. Right to life and liberty. So here two important judgments, Gopalan case, Maneka Gandhi case. So narrow interpretation in which case?
Gopalan.
Gopalan case. So in Gopalan case, it upheld procedure established by law or due process of law? Procedure established by law. So as per the Gopalan case, you can challenge both arbitrary executive action and arbitrary legislative action. You can only challenge arbitrary executive action. You cannot challenge arbitrary legislative action. But in Maneka Gandhi case, you can challenge both arbitrary executive action as well as arbitrary legislative action. And in Gopalan case, only they gave importance to physical well-being. But in case of Maneka Gandhi case, anything which makes the life worth living. So all those aspects are considered as part of right to life and liberty. So hence, right to privacy is part of right to life and liberty. Right to proper environment. Only if the environment is proper, then if it is clean, then we can have a proper life. So right to environment is part of right to life and liberty. Only if you marry a person of your choice, then you can be happy. So hence it is covered under right to life and personal liberty. Okay, personal liberty. So this was about article number 21. Okay, 21. So we shall take a break. So if you have any kind of doubts with respect to the discussions that we had at this point, till this point of time, you can raise the doubts. Otherwise, we can break.
Sir, what's the difference between strike and assemble?
Strike and?
Assemble.
No, when people assemble, they can be involved in different activities. They can be involved in a demonstration. For example, they may perform a public drama saying what the government is doing. So strike means, so exact difference we should not worry. Strike means you have seen, people will be involved in procession. Sometimes they may even call band. Okay, they may throw stones. So all these are part of strike. So you will not go into the exact meaning of strike. What you will at a superficial level, whether strike is permitted as per the law, as per the constitution? No, strike is not permitted. Okay, procession is permitted? Yes. Demonstration is permitted? Yes.
Without arms we can strike.
Yes.
Without arms we can.
No. Without arms also, we will not use the term strike. If you use the term called as strike, it is not permitted. If you use a term called as strike, it is not permitted. Okay, it is not permitted. Again, we will not go into practical aspects. Some of these we will be learning from theoretical perspective. If you try to dig deeper, I am telling you will be stuck in that particular article. You will not move to the next article itself. So that should not happen. So the same happened with one of our students who joined here in 2021. Okay, so from she had already completed her coaching in 2 institutes, one in Dharwad and one in Bangalore. And third time she came to Bagalkot. Accidentally she was just going through Vidyagiri and she wanted to join our library. And she used to mention, sir, if I have doubts, any kind of doubts, can I ask you? Yes, please, you can ask. So for continuously for 1 month, she was in fundamental rights, and at least 2 to 3 times she asked the same question, whether right to strike is a fundamental right or not. Okay, it means for close to 15 to 20 days, she was stuck there itself. She was not able to make progress. Then with subsequent discussion, conversation with her, I understood that she has not gone to any other topic except fundamental rights. Okay, so that should not happen. So whichever information you are trying to explore more, if you don't get information, you will suppress there itself, because it will compromise the preparation of the other topics of the same subject, and also it will compromise the preparation of the other subjects as well. Okay, now you just convince yourself, right to strike, whether it is a fundamental right? No. Right to procession? Yes. Right to band? No. Okay. Right against band? Yes, it's a fundamental right. So in this perspective, at the superficial level, we will understand.
Sir, we can challenge basic structure articles in the court.
Basic structure articles? No, we cannot, because already it has been declared as the basic structure. It cannot be challenged. It cannot be challenged. Even if you challenge also, the court will say that it is part of the basic structure. So we are not going to entertain that case. We are not going to entertain the case pertaining to either arbitrary action or legislative action. Legislative action. Yes. So we were discussing about
Article 20.
article number 21. Right to life and personal liberty. So here we discussed about concepts like procedure established by law and due process of law. Okay. So India, originally we have only procedure established by law in article number 21, but through which judgment we also introduced the concept of due process of law? Maneka Gandhi case. So as per the Maneka Gandhi, the case which has been the recent case, so in India we can challenge only arbitrary executive actions, or also we can challenge arbitrary legislative actions. Okay, we can challenge both arbitrary executive actions as well as arbitrary legislative actions. So as per the Maneka Gandhi case, whether right to life extends only to the physical body, or it also has other dimensions. It also has other dimensions. So in this other wider dimension, we have right to privacy, we have right to environment, right to marry a person of one's choice, and so on. Okay, and so on. So next we shall move with next fundamental right, that is right to education. Right to education. So article number 21A. So it means originally this was not part of the constitution, later on it was introduced. So states that state shall provide free and compulsory education to all children until the age of 6 to 14 years. Okay. So from 6 to 14 years, in between this range, whatever the children are there in this country, they should get free education and also compulsory education. Free education as well as compulsory education. Okay, compulsory education. In such manner as the state may determine. Means in what order we have to give, whether the compulsory education should happen only in government schools or also in private schools. So these detailed provisions will be made by state, that is government. Okay, government. Next, only elementary education, a fundamental right. Okay, only till 8th standard. Okay, 8th standard, that will be the fundamental right. From high school, from 9th, 10th, 11th, 12th, higher professional education and all, they are not considered as part of the fundamental right. So not higher or professional education. Okay, professional education. It means a person who want to pursue his primary, that is first standard, second standard, third standard up to 8th standard, if he does not have any kind of schools in the nearby also, he can ask the government that provide me the school. I want to learn. Okay, I want to complete my primary education. But for high school education, he cannot claim it as a right. For high school education, he cannot claim it as a right. So now this article number 21A, it was added through 86th Constitutional Amendment Act of 2002. So this amendment is also equally important. Okay, we already seen few amendments. For example, 42nd Amendment, 44th Amendment, and here it is 86th Amendment. Okay, 86th Amendment. Through 86th Amendment Act of Constitutional Amendment Act of 2002, so article number 21A was introduced in the Constitution. Okay, introduced in the Constitution. Before this, there was a provision under article number 45, DPSP, hence was not enforceable. So we discussed about the directive principles of state policy, right? So now under article number 45, what we have? Children till 6 years of age. Previously, what? Compulsory education till 14 years of age, it was part of the DPSP. Now it has been removed from there and it has been made a fundamental right. Okay, fundamental right. So when it was a DPSP, we cannot force the government to implement it because it is non-enforceable. But once it has become a fundamental right, so compulsorily we have to implement it. Okay, implement it. Change the subject matter of article number 45, DPSP. State shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. Okay, now DPSP, article number 45, what we have? Till 6 years of age, state should provide support. Okay, under DPSP. So till 6 years of age, whether it is compulsory for the government to support? No, because it is DPSP. But from 6 to 14 years of age, it is compulsory because it's a fundamental right under article number 21A. Okay, 21A. So added a new fundamental duty under article number 51A. For 86th Constitutional Amendment, it also added a new fundamental duty. So this duty we have not discussed while discussing about the fundamental duties. So what is the duty? It shall be the duty of every citizen of India to provide opportunities for education to child or his ward between age of 6 to 14 years. Now fundamental right says government should make the provision to give education to the children from 6 to 14 years of age. But if the parents of these children, either parents or those who are taking care of them, if they are not sending their children to the school, then we cannot ensure the education. So at one side it is the right where government should compulsorily provide it. On the other hand, it should be also the duty of the parents to send their children to schools. Okay, schools. So it was also added through 86th Constitutional Amendment Act. Okay. So 86th Constitutional Amendment Act, what we have seen, it has made changes to fundamental rights, especially article number 21A. it has also made changes to directive principles of state policy. It has made changes to article number 45 and article number, it has added extra fundamental duty. Okay, fundamental duty. Supreme Court judgment of 1993. So this background, it is not that much important. We'll discuss, but not important. Supreme Court in 1993 itself had recognized fundamental right to primary education and the right to life under article number 21. So before article number 21A was introduced, in 1993 itself, Supreme Court had recognized right to primary education as a fundamental right. Okay, fundamental right. So, Supreme Court in 1993 itself, it had recognized it as a fundamental right. Okay, right. But explicitly it was included in the Constitution through which amendment? 86th Constitutional Amendment. Okay, 86th Constitutional Amendment. Right to free education until he or she completes the age of 14 years. So this was part of the Supreme Court judgment. Okay. Thereafter, after 14 years of age, right to education is subject to the limitations of the economic capacity and development of the state. So these all things the Supreme Court had given in its judgment in 1993, not important. Just write it as not important. Okay, not important. Earlier judgment of 1992 declared that there was a fundamental right to education up to any level, including professional education like medicine and engineering. Court overruled this earlier judgment. So in 1992 also Supreme Court had given a judgment that any education, not only primary education, any education should become a right. But in 1993, it had overruled this earlier judgment also. So 1992 judgment as well as 1993 judgment which we saw, both of them are now not important. Okay, especially from the prelims point of view, not important. When you are quoting from the mains point of view also, you will say that only one line. In 1993, Supreme Court had made right to education as a fundamental right under article number 21. One line is sufficient. So through 86th Constitutional Amendment, it was explicitly added as a fundamental right under article number 21A. Okay, 21A. So these are the things that we have to understand from our prelims and mains point of view. What has to be extracted from prelims point of view, and in what fashion points have to be quoted in mains. Okay, points have to be quoted in mains. So all these things, detailed discussion is not important. Okay, not important. Next, article number 22. Okay, article number 22, important. In the recent, I think 2023 question paper, there was a question on what? Article number 22. So it was a bit challenging question. Okay, bit challenging question. Prior to this, very rarely questions were asked. But in 2022, a question was asked which was bit complex. Okay, bit complex, and also the question was related to current affairs. So once we conclude with the discussion of the fundamental rights topic, then we shall discuss the questions, previous year questions on this topic. Okay, then we will gain more clarity. Okay, more clarity. Protection against arrest and detention. Protection against arrest and detention. So in article number 20, what we saw? Okay, conviction. So often we get confused between article number 20 and 22. Okay, often we get confused. Okay, but gradually when you go for multiple revision, you will be able to segregate or identify the differences between article number 20 and 22. So protection against arrest and detention. Okay, arrest and detention. So arrest also we know, detention means putting you in jail. Okay, in jail. So when it comes to detention, that is putting you in jail, there are two types of detention. One is punitive detention, another one is preventive detention. So what is punitive detention? You are involved in some kind of crime. Okay, so an FIR will be filed against you in the police station. Investigation will take place. A charge sheet will be filed in the court. In the court, trial will take place. After trial, court will give the judgment. So because of that judgment, you will be in jail. That is called as punitive detention. So punishment after trial and conviction in court. Conviction means after the court has given the final judgment. Now if you take jail as an example, okay, jail, whether all the people who are in jail are convicted persons? Whosoever are in jail, whether they are convicted? No. Then who are the other people? We call them as under trials. Okay, under trials. Still in the court, the process is going on. In one single day, court is not going to give the judgment. So today they will hear partially and they will say your next hearing is on August 20th, December 20th. So it will be postponed. Okay, sometimes even years together. Okay, even years together. So when this process is going on in the court, we call it as a trial. We call it as a trial. So after completion of the trial, when the final judgment is given and punishment is given, that we call it as conviction. Okay, conviction. So when you look at the jail, there are people who are convicted. After final judgment has been given, even convicted people are in jail, and even under trials are also in jail. Under trials are not put in police station. See, police station is different, police station prison is different, jail is different. Okay, so jail is different. So in the police station lockup, hardly 1 or 2 days they will stay. Rest all the time they will be in the jail. Jail is different from police station lockup. Okay, lockup. So these differences we have to understand. So punitive detention means punishment after trial, conviction by the court. Conviction by the court. Preventive detention, detention without a trial and conviction by court. Means you are putting someone in jail, okay, without a trial. Means you are not taking them to court. Okay, there is no trial. Okay, no process is going on, but still they are in jail. This is called as preventive detention. Example, the people, those who are involved in terrorist activities. Okay, terrorist activities. So before conviction, before trial also they will be put in jail. This is an example of preventive detention. Okay, preventive detention. Preventive detention. So here, purpose is not to punish a person for past offence. So in case of preventive detention, it is not to punish the person for whatever mistakes that he has committed. Okay, whatever mistake he has committed, but to prevent him from committing an offence in near future. He should not commit any kind of offence in the near future. To prevent that offence, we place him in jail. That is called as what? Preventive detention. Okay. So you understood the term called as punitive detention. Another one is preventive detention. Okay, preventive detention. It is only precautionary and based on suspicion. So you do not have solid evidence. Precautionary. Something should not happen. So based on suspicion, okay, you suspect someone and you put him in jail. That is called as preventive detention. Okay, preventive detention. Article 22 has 2 parts. Okay, Article 22, there are 2 parts. First part deals with cases of ordinary law. Second part deals with cases of preventive detention law. Okay, preventive detention law. So an example of a ordinary law is Murder Act. Murder Act 2024. It's an ordinary law. Okay. Here after the murder has taken place, under some charges you will arrest a person. Next, for example, Rape Act 2025. Theft Act, okay, 2023. So there are various acts called as ordinary acts. Okay, ordinary acts. There are few examples of preventive detention laws also. So So this is imaginary law. We will be looking into real laws later on. So here, as per the Terrorism Prevention Act, you will arrest a person and put in jail without any trial, thinking that he may become he may be involved in some kind of offence. So before committing the crime itself, you are going to arrest him and put him in jail. So this is an example of a preventive detention law. So here, a person has already committed a murder, a person is involved in rape, a person is involved in robbery. Okay, already crime has taken place. Then you are going to arrest him and put him in jail. So these are the examples of ordinary laws. This is an example of a preventive detention law. So whenever there is a law, there are 2 types of laws. One is preventive detention law, another one is ordinary law. So in ordinary law, a person will be arrested and put in jail only after he has committed the offence. But in preventive detention law, even before the committing of the offence, based on suspicion, we are going to arrest him and put him in jail. Okay, put him in jail. Put him in jail. Okay. First part, dealing with cases of ordinary law. Okay, we are dealing with the cases of ordinary law. For example, Murder Act. Okay, we will take Murder Act. So within Murder Act, there may be various sections. For example, Section 1. If the murder is because of revenge, if the murder is because of revenge, so 5 years jail. Section 2, accidental, okay, so 2 years jail. I am just taking an imaginary example. Okay, there will be slight difference. We'll also be looking into the laws as well. So in this format, law will be there. So now person, let us assume he has committed a murder. Now we don't know whether he has committed for revenge sake or it was an accident or it was an accident. First someone will file a FIR in the police station. So based on the FIR, first information report, so in the FIR the police will write, so he is charged under section 1 of the murder act. Okay, if it was because of revenge, otherwise they'll book like this, he is charged under section 2 of the murder act. So it also depends on the police officer. Okay, so if police officers want to make the person give a lesser punishment, then he may book him under section 2. Okay, otherwise he will book him under section 1. Okay, I am just giving you an example. Okay, example. Now a person is arrested, let's assume either section 1 or section 2 of the murder act. Okay, murder act. So let's assume this person is person A. Person A is arrested under murder act. It may be either section 1 or section 2. Confers rights on person who is arrested or detained under any law. Okay, we are dealing with ordinary law. So now this section, article number 22, it gives person A the following rights. So person A, now we are discussing, he is arrested under which law? Ordinary law or preventive detention law?
Ordinary law.
Ordinary law. So in this example we have taken murder act. Okay, murder act. Now article number 22 of the constitution, it gives some power to person A. Okay, person A. So what is that power? Right to be informed of the grounds of arrest. Now someone has filed a FIR in the police station. Okay, some person, let's say, for example, Sai Prasad has filed a case against person A. Okay, saying that person A has committed the murder. Now police will all of a sudden they will go and arrest him. He is not even aware why they are arresting. So he should be informed. If he asks the policeman, why you are arresting me? Whether you are arresting me for robbery, whether you are arresting me for theft, or whether you are arresting me for murder, or whether for rape, because he is not aware. So he should be informed that you are being informed, you are being arrested because of murder. Because of murder. Okay. So she has a right to be informed. Okay, informed. Right to consult and be defended by a legal practitioner. Okay. So if he says that I want a lawyer, if he says he wants a lawyer, then a lawyer has to be provided to him. A lawyer has to be provided to him and be defended by a legal practitioner. So if he says that I want a lawyer, so his charges also you should bear it. Okay, so the government should bear his charges, the lawyer charges as well. Okay, lawyer charges as well. Just I am giving an example. Okay, right to be produced before a magistrate within 24 hours. Now you may get confused when we were speaking about a magistrate at that time. We were speaking about district magistrate. So here when I say magistrate, we are speaking about judge. A person whosoever has been arrested on any of these cases, ordinary cases, he should be produced before the judge within 24 hours. Okay, within 24 hours, excluding the journey. Now let's assume a person has committed a murder in Bagalkot and he has gone to what? Bangalore. Now police will somehow come to know that he is in Bangalore. Now to travel from Bangalore to Bagalkot, it will take close to 12 hours. So we have to produce him before the judge within 24 hours. So that journey of 12 hours from Bangalore to Bagalkot will not be included as part of this 24 hours. Will not be included as part of the 24 hours. Okay, hours. Right to be released after 24 hours unless the magistrate authorizes further detention. So police will arrest the person and they will produce him in front of the judge within 24 hours. Now if the magistrate, the judge says that there is no problem with him, then police have to leave him. Now it is left to the judge. Judge, what he can say? He can say there are two things. Again, here we will connect the current affairs part. Okay, we will connect the current affairs part. So judge may give the person to police custody, or judge may say judicial custody. So very important terms. So these are not present in Lakshmikant, but in current affairs they do appear. So hence I have taken here. Okay, hence I will be discussing here as well. So within 24 hours, the person who has committed the murder or on whom there are allegations that he has committed the murder, he is taken to the magistrate, that is judge. Now judge, what he will do? Either he will say, no, there is no problem with him, he has not committed, you can leave him. Or he can say, keep him in police custody. Or he may say, keep him in judicial custody. So police custody means that person will be taken back to police station. Judicial custody means he will not be in the judge's home. Okay, so where he will be kept? He will be kept in jail. He will be kept in jail. So a person who has against whom there are allegations. So what he will wish for? Whether he will wish for police custody or judicial custody. Generally, people will wish for judicial custody, because in judicial custody a person will be in jail. So you cannot make a third degree treatment on him. You cannot extract the information from him. But if he goes to police custody, then police will use their own methods to extract the truth. Hence, a person will be interested to secure a judicial custody rather than police custody. But it is what? Discretion of the judge. So the judge may ask, may give a police custody or judicial custody. So on this even a question has appeared. So during police custody, where will be the person? With police or in the jail? Okay, police custody, in police custody, whatever that prison is there, we will not call it as jail. Jail means a central place where all the culprits are present. Okay, all the convicted are present, that is jail. So in police custody, the person will be what? Detained in the police station. In judicial custody, the person will be sent to jail. And if the police want to ask any kind of questions to the person who is in judicial custody, police have to take the permission of the judge. Without the permission of the judge, police cannot ask a question to a person who is in jail. Okay, who is in jail. So right to be released after 24 hours unless the magistrate authorizes further. These safeguards are not available to. Okay, the above things that we have discussed, they are not available to enemy alien. Who is enemy alien? Now yesterday we discussed Indian as well as Indian citizen as well as foreigner. Within foreigners, there are friendly aliens and enemy aliens. For example, if we do not have a good relationship with Pakistan, so if a Pakistan person is being arrested, okay, so he comes under enemy alien. If a US citizen is arrested in India, he comes under friendly alien. So the above points that we discussed, which all points we discussed? 1, 2, 3, grounds of arrest. Next, defended by legal practitioner. Right to be produced within 24 hours. Okay, so released within 24 hours if the magistrate does not authorize further detention. So these protection are not available to a person who is arrested and if he belongs to Pakistan. If he belongs to Pakistan, then those our provisions are not available. But if he belongs to US, if he is a US citizen, then they are applicable. They are applicable. One more is a person arrested or detained under a preventive detention law. We saw, right? So Terrorism Prevention Act. We took an imaginary example while discussing this is a Preventive Detention Act. Under this act, if a person is arrested, then he need not be informed about what are the reasons for arrest. Okay, he need not be produced in front of the magistrate within 24 hours. Okay, within 24 hours. So these above things, they apply only to people who have been arrested under ordinary law, and also these are applicable only to people of Indian citizens as well as friendly aliens, not to enemy aliens. Okay, not to enemy aliens. So this is a very important point to note. Supreme Court ruled that it does not cover arrest under the orders of court, civil arrest, arrest on failure to pay the income tax, deportation of an alien. Okay, so all these things, they are not covered under article number 22, the orders of court. So court itself orders a person to be arrested. Okay, so at that time these protections are not available. Civil arrest, just ignore it. Arrest on failure to pay the income tax. So person has not paid the income tax. At that time, if the police go and arrest him, then he cannot claim the above rights. Why you have informed me, taking that to the magistrate, all those things are not applicable. Okay, not applicable. Next, deportation of an alien means you want to send a person to his native country. That is called as deportation. Okay, there also it is not applicable. But these points in general, they are not important. We just ignore it. Okay, they are not important. Just ignore it. Okay, ignore it. They apply only to an act of criminal or quasi-criminal nature or some activity prejudicial to the public interest. Okay, public interest means whatever the provisions we have discussed here, so they apply to an act of criminal or quasi-criminal nature or some activity prejudicial to public interest. So do not focus much on this point, just ignore it. Otherwise you will get confused, you will be stuck here itself, not important. Okay. So we discussed the first part of the section 22, which deals with which detention? Punitive detention. Okay, punitive detention. Next we will discuss the second part, which is with respect to preventive detention law. Okay, preventive detention law grants protection to persons who are arrested or detained under a preventive detention law. Okay, preventive detention law. So this is available to both citizens as well as aliens. Okay, aliens. So what are the protection available to person who has been arrested under preventive detention law? The detention of a person cannot exceed 3 months. Okay, so we have saw the difference between punitive detention and preventive detention. In preventive detention, to prevent the future offense, you are arresting him. There has been no court trial, still you have kept him in jail. So in this fashion, how many days you can keep him in jail without sending him for trial? 3 months. Okay, 3 months. In case of ordinary law, 24 hours. Within 24 hours, he has to be produced in front of the magistrate. But here, without producing him in front of the court, he can be kept in jail for 3 months. Okay, for 3 months. Unless an advisory body reports sufficient cause for extended detention. It means he can be kept beyond 3 months also. A person who has been arrested under preventive detention without trial, he can be kept beyond 6 months also, beyond 3 months also, but it requires a special recommendation by a advisory body. So an advisory body says that 3 months is not sufficient, for few more months he has to be kept in jail. Okay, kept in jail. So this detailed clause is not important. Detailed clause is not important. Board is to consist of judges of a high court. So this advisory board, which is giving the suggestion that you can keep him for more than 3 months. Okay, more than 3 months. So this advisory board, it consists of judges of high court. Okay, judges of high court. Okay. Here there is a bit confusing part. Grounds of detention has to be communicated to the detained, the person who is being detained. Okay, detained. So why they have arrested him or her? They have to communicate to him. But what we have seen above, they are not applicable to people who have been arrested under preventive detention. So here a slight confusion will arise. So you don't go into deeper aspects. You look at the second term. However, the facts considered to be against the public interest need not be disclosed. In the first line they say, what are the grounds for arrest? They have to be communicated. In the second line they say, if it hurts the public interest, then it need not be disclosed. So you ignore the first point, you just consider the second point. It means in ordinary law, compulsorily the grounds of detention has to be communicated to the person who is arrested. But here it is not compulsory to communicate the grounds of arrest to the person who has been detained. So you will not focus on this aspect. Okay, this aspect. Detained should be afforded an opportunity to make a representation against the detention order. Okay, so here a confusion will arise. Okay, slight confusion. What is that? Now in the previous ordinary law, what we saw is he has a right to be defended. In the ordinary law, if a person is arrested under the Murder Act, then what happens? If he says that I want a lawyer, okay, government should hire a lawyer for him, and he has to argue on behalf of him. Okay, on behalf of him. But here that facility is not available. But if he wants to hire a lawyer on his own, with his own money, okay, then such facility should be afforded. Okay, such facility should be afforded. In previous what we saw, ordinary law, if he says that I want a lawyer, government should hire a lawyer and give it to him, defend him. But here government will not hire a lawyer and give it to him. But if he says that I am ready to bear the expenditure, okay, then a facility should be provided, a facility should be made. Okay, so this is a very minute difference, an important difference that we have to understand. Under ordinary law, when a person is put in jail, then it becomes his right. It becomes his right to ask the government, give me a lawyer. Okay, but under preventive detention, it is not his right to ask the government to give him a lawyer. So what he can request is, so provide an opportunity so that I can hire a lawyer. I can hire a lawyer. Okay, lawyer. Okay. So article number 22, it also authorizes the parliament. Okay, so constitution has given power to the parliament, what? to prescribe circumstances and the classes of cases which a person can be detained for more than 3 months under preventive detention law without obtaining the opinion of an advisory board. So previously what we saw, a person who is arrested under preventive detention, so maximum he can be kept in jail for how many months? 3 months. If you want to keep him in jail beyond 3 months, whose advice is required? Advisory board. So consisting of judges of high courts. Okay. But if you want to keep him in jail beyond 6 months without the advice of the advisory board, then who has the power? Okay, Parliament has the power to make a law. In that law, they will mention that a person can be detained beyond 6 months without the permission of the advisory board. Okay, these things are bit complicated. Okay, bit complicated. You will not be able to connect the dots in one go. It will take time. Okay, it will take time. The maximum period for which a person can be detained in any classes of cases under preventive detention law. So the law which the Parliament can make, it can specify. So beyond 3 months, how many months you want to keep a person in jail without a trial, the Parliament can specify in the law itself. Okay? In the law itself. The procedure to be followed by an advisory board in an inquiry. So these detailed things not important. Just leave it. Okay, just leave it. So before we discuss 44th constitutional amendment. Okay. See here, 44th constitutional amendment. It says that has reduced the period of detention without obtaining the opinion of the advisory board for 3 to 2 months. However, this provision has not been yet brought into force. Hence, the original period of 3 months still continues. So, as the original period still continues, this entire information, 44th constitutional amendment, 2 years, all these things is not important. Because it has not come into force. So, this information itself is not important from exam point of view. Okay, either from the prelims point of view or mains point of view, it is not important. Okay, not important. Division of legislative power with respect to preventive detention between Parliament and state legislatures. So while discussing about the Parliament, we have seen the division of power between the centre and the state. So which part of the constitution or which provision in the constitution divides the powers between the centre and the state? 7th schedule. Okay, 7th schedule consists of how many lists? 3 lists. Union list, state list and concurrent list. Can you recall one example of a union list subject? Defense. One example of a state list subject? Police. One example of a concurrent list subject?
Education.
Yes, electricity, education. These are part of what? Concurrent list subject. So now who can make laws on preventive detention? Parliament can make or state legislature can make. Okay, Parliament. So that we shall see. Division of legislative powers with respect to preventive detention between Parliament and legislatures. It means there are some preventive detention laws on some subjects can be made by Parliament. Preventive detention laws on some subjects can be made by state legislatures. So what exactly is the difference? We shall see. So when it comes to these things, that is defense, foreign affairs, security of India. So for example, preventive detention law with respect to defense, preventive detention law with respect to foreign affairs, preventive detention law with respect to security of India. So who can make laws?
Parliament.
Whether state legislature can also make? No. It's Parliament's exclusive authority to make a law of preventive detention for the reasons connected with these things. Only Parliament can make. State legislature cannot make laws. Okay, state legislature cannot make laws. Parliament and states can concurrently make a law of preventive detention for the reasons connected with security of a state. So here state means state government. State government. Maintenance of public order. Okay, law and order. So maintenance of supplies and services essential to community. For example, if I consider Bagalkot as a community, supplies essential to a community means, for example, onion, okay, oil. So all these are essential for our community. So maintenance of supplies. So if they want to make anything, any law related to it, okay, any law related to it, so both Parliament and state legislature can make. So UPSC has not gone to this deeper level. Okay, this deeper level they are not gone. They asked a question, but the question is related to current affairs. Okay, the question is related to current affairs. That also we shall have a discussion. But at the time of examination, you should be able to prioritize, because if you go into deeper aspects, what happens? You will be stuck there itself. You will not be able to make the revision in a faster manner. Okay, in a faster manner. So hence you have to understand that when it comes to making laws of preventive detention, so whether it is the exclusive power of parliament or also states enjoy some power. States also enjoy power. And we saw that there are some subjects on which exclusively only parliament can make law, and there are few subjects on which state legislatures can also make law. Okay. Example, security of state, maintenance of public order, and maintenance of supplies and services. Okay. Preventive detention laws made by parliament. So, parliament, has it made some preventive detention laws? Yes. So, by using the powers given under which article of the constitution? Article number 22. By using the powers given by the constitution under article number 22, parliament has made few preventive detention laws. Which are they? Terrorist and disruptive activities prevention. Okay. We call it as TADA Act. Now repealed. Means this act no longer exists. Okay. No longer exists. Okay. No longer exists. So in such act, what the parliament can say? What can it do? Normally, as per the constitution, a person cannot be put in jail for more than 3 months. To extend beyond 3 months, you have to take the permission of the advisory board. But in TADA Act and all, what they will do, beyond 3 months also, you will put them in jail without the opinion of the advisory board, because they have made a new law for it. So the TADA law was criticized because some of the government agencies, they misuse the power. They used to keep the people in jail for years together without any trial. So there were many people who suffered. Because of that, there were protests even in parliament as well. Hence, the TADA Act was repealed. Okay, repealed. But whether it is important from exam point of view, because the act is repealed, even though the act is repealed, the act repeatedly appears in the newspaper, especially in the context of editorial articles. So once we start discussing about the newspaper articles, we will be discussing about the editorial articles. Even though it is repealed, generally the person who is writing the article, he will make comparison with the previous laws. So TADA, it repeatedly appears. Okay, repeatedly appears. So TADA is an example of a preventive detention law made by the parliament, but now it is repealed. Next, Prevention of Terrorism Act, POTA 2002. It is also now repealed. Okay, repealed. Next, National Security Act, NASA 1980. Okay, 1980. Unlawful Activities Prevention Act, UAPA 1967, amended 4 times. This is the one which is presently active, and it appears most frequently in the news. Okay, more frequently in the news. So all the terrorism related cases. So terrorism related cases, they are filed under Unlawful Activities Prevention Act. Okay, whenever we catch a terrorist, so we have to file a case, right, in the police station, and when you are going for a trial in the court, there should be some section. So under which section of the which act he will be tried? A terrorist Unlawful Activities Prevention Act. Okay, Prevention Act. So in the examination, supposedly if they ask you, if they give you around 4 or 5 acts, and if they ask you to identify which of the above are preventive detention laws, so you should be able to identify. So at least this information is written. TADA, Terrorism and Disruptive Activities Prevention Act, Prevention of Terrorism Act, POTA, National Security Act, NASA, Unlawful Activities Prevention Act, UAPA, which is presently active. This is very important among all of them. Okay, among all of them. Okay, all of them. Unfortunate that no democratic country in the world has made preventive detention as an integral part of the constitution as has been done in India. So this is an important point. So probably they may ask in prelims as well, but they have never asked. So the constitution of the other countries, they have not included the provision of preventive detention in the constitution itself. But here in India, we have included the provision of preventive detention in the constitution itself. Okay. So tomorrow in the examination, they may make a statement. There is no other country in the world which has made preventive detention as integral part of their constitution. True or false? True. Okay. So India is the only country which has made preventive detention as part of its constitution. Okay. It is unknown in USA. So in USA's constitution, there is no law called as preventive detention. But they have their own laws, that is different. But for time being, from theoretical perspective, we shall understand that there is no preventive detention law in USA. Okay. USA's constitution. In India, preventive detention existed even during British rule. So India got independence in 1947, but before that also, during British era also, we had preventive detention laws. It means before they committed any kind of offence, they used to get arrested. So example are Bengal State Prisons Regulation Act of 1818, Defense of India Act 1939. So even these examples also you please retain from exam point of view. This is also important. Okay, this is also important. Yes. So we discussed about article number 22. So 22, it deals with two types of detention. Which are they? Punitive detention, preventive detention. So punitive detention is the detention under which laws? Ordinary laws. So preventive detention is under preventive detention laws. So when it comes to punitive detention, a person enjoys more rights. Which are they? He should be informed. Okay, he should be taken to the magistrate within 24 hours. So whether it is compulsory to inform in case of preventive detention? No. Whether he has to be taken to the magistrate within 24 hours? No. Okay. So in case of preventive detention, a person can be detained in jail for how many months as per the constitution?
3 months.
3 months. Beyond 3 months, advisory board as per the constitution. But if you want to go beyond 3 months without the opinion of the advisory board, then what we have to do? We have to make a special law for this. So who has been given the power to make the law? Parliament. So Parliament, by using this power, has it made any kind of laws? Which are they? TADA, POTA, NASA, UAPA. Okay, UAPA. So this much superficial understanding would help you to sail through any kind of difficult questions which appear in the prelims, and this content will also be beneficial to address the questions which appear in mains. Okay, which appear in mains. Prohibition of traffic in human beings. Okay, traffic in human beings and forced labor. Article number 23. Okay, 23. So yesterday probably we were discussing about a question. One question. Previous year I think I had shared, right? One question on fundamental rights I had shared. So which of the following is part of the right to equality or something, a question like that. So just at a superficial level, if you know this, you will be able to address that question. If you know just the statement that is prohibition of traffic in human beings and forced labor, only that statement would be sufficient to answer that question. So in right against exploitation, they are not gone to the deeper level. The next level questions they were never asked. Okay, they were never asked, but let us understand. Okay, let us understand. We don't know when they will go to that extent. Okay, so article number 23, it prohibits beggar. So beggar means forced labor. So those who attended history classes, there also we have discussed. Beggar means forced labor. Now whatever the beggary that we see, we should not compare it with here. So beggar means if you ask a person to do some labor but without paying any kind of salary to him, it is called as beggar. Okay, forced labor. So article number 23 prohibits beggar. Prohibits beggar. This right is available to both citizens as well as non-citizens. This is also an important point to note. Okay, it's available to both citizens as well as foreigners. Okay, foreigners. Right available against both state as well as private persons. Government cannot force you, okay, force you in a forced labor or involved in human trafficking. Similarly, private individuals also cannot do it. Okay, cannot do it. So whenever a government does it, you can file a case against the government. Whenever a private entity is involved in this, you can also file a case against a private entity. Okay, available against both state as well as private entities. Okay, entities. Expression traffic in human beings include. Okay, so what does the traffic in human beings mean? Selling and buying of women and children like goods. So this is an example of traffic in human beings. You purchase, buy a woman from one place and sell them at some other place. So this is an example of traffic. Okay, example of traffic. Similarly, children. Immoral trafficking includes even prostitution. Okay, so you sell some person and involve them in prostitution. So that is also an example of traffic in human beings. Okay, traffic in human beings. Devadasi system is also considered as part of traffic in human beings. Okay, traffic in human beings. Slavery is also broadly considered as the part of traffic in human beings. So UPSC will never ask you such kind of questions. Which of the following fall under the definition of traffic in human beings? Okay, you will understand it, but you will not memorize it. So as you memorize like article number 14, 15, 16, in that fashion, you need not make an effort to retain this content. Okay, just at a superficial level you understand slavery is part of the what? Traffic in human beings. Next, Devadas system is a part of the traffic in human beings. At the superficial level you understand, that would be sufficient. To punish these acts, Parliament has made Immoral Traffic Prevention Act 1956. Okay, so whether Parliament has brought any kind of law? Yes, it has brought this law. So this law, if it appears as part of the current affairs, it would be more important. From the static point of view, we shall just assume that Immoral Traffic Prevention Act 1956 was brought to give shape to which article of the Constitution? Article number 23. Okay, article number 23. So beggar means compulsory work without remuneration, as we discussed. Similar forms of forced labor like bonded labor is also prohibited. Okay, forced labor like bonded labor. So bonded labor means we are going to pay, but he will remain with you for fixed amount of period. For 1 year you have to work only with us. So this is an example of bonded labor. So even bonded labor, it comes under forced labor. Okay, that is also prohibited. So in rural areas sometimes we witness there is a system of bonded labor, but as per the Constitution, bonded labor is prohibited in India. Okay, it's prohibited in India. Force means compelling a person against his will. Sorry. So force includes not only physical or legal, but also force arising from the compulsion of economic circumstances, that is working for less than minimum wage. So when we say what forced labor, it means you will be giving salary to him, but whatever the minimum salary a person should receive for his for a fair standard of life, if you are paying less than it, then this is also an example of a forced labor. Okay, forced labor. So if you practically go to India, then in every part of the country you will find forced labor. So these are all theoretical aspects. Okay, these are all theoretical aspects. So we will not try to apply everything practically. Okay, we will not try to apply everything practically. In this regard, the following acts were made. Okay, following acts were made. So Bonded Labour Act, Abolition Act 1976, Minimum Wages Act, Contract Labour Act, Equal Remuneration Act. So all these acts were brought to give shape to which article of the Constitution? Article number 23. So the act which repeatedly appears in the newspaper is Minimum Wages Act. So hence we will focus only on this, rest all the acts we will just ignore them. Okay, you will ignore them. And also Minimum Wages Act, when we look at it from the current affairs point of view, at that time we will be focusing in detail. Now at the superficial level, what we shall understand is Minimum Wages Act give shape to which provisions of the Constitution? Article number 23. Okay, article number 23. Article number 23 also provides for an exception. Okay, so we have seen that every article, none of the articles are absolute. Every article has an exception. So similarly here also we have an exception. Permits the state to impose compulsory service for public purposes. For example, military or social service for which it is not bound to pay. Okay. For example, government may say that so you have to serve for so and so days in army and we are not going to pay you. Okay. If government says that, then that is an exception. Generally what we say, without payment, when you make someone to work, that is considered as a forced labor. But this is an exception. If you ask an army man to work for 1 or 2 months without salary, so that will not be considered as a forced labor. This is an example. Okay, this is an example. So social service, if you ask a doctor to serve in a rural area for 2 months without any kind of salary, okay, so it will not be considered as a forced labor. This is an exception. This is an exception. However, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste or class. So when it is saying that you have to compulsorily serve in military for 2 months, a doctor should compulsorily serve in a rural area for 2 months. You should not discriminate like only Hindus should work, Muslims should not work. Only Muslims doctor should work, Hindus doctor should not work, Christians should not work. So you cannot discriminate on the basis of religion. You cannot discriminate based on the race, that is color of the skin. You cannot discriminate based on the caste. You cannot discriminate based on the class. Okay, class. So this detailed information is not important. Okay, not important from exam point of view. Okay, exam point of view. So next, article number 24. So prohibition of employment of children in factories, etc. Prohibits employment of children below the age of 14 in any factory, mine or other hazardous activities like construction work or railway. So what does it mean? A child who is below the 14 years of age, they cannot be employed in factory, mine or other hazardous activities. Okay, hazardous activities. So here some questions will arise. So if a job is non-hazardous, can he be employed? Can he be employed in a hotel as a cleaner? Okay, so these are the various questions which will start arising in you. Okay, so for some of the questions you will get answers. For some of the questions you may not get immediate answers. So you will not go for exploring of more information to such kind of questions. Because if you do that, what happens? You will be stuck. Okay, you will be stuck. So here they mention in any factory, mine or other hazardous activities like construction work or railway. In such places they should not be employed. Does not prohibit their employment in any harmless or innocent work. The work which is considered harmless, the work which is considered as innocent. Okay, so such work it is not prohibited. But there is no list of work which is considered as harmless. There is no list of work which is considered as innocent. Hence, those confusions will prevail. Now, if you take a person who is working in a hotel as a cleaner, so that is harmless. We don't know. It has not been defined. It has not been defined. Okay, so whether it is innocent, it has not been. It has not been defined. Okay. So in this context, examples of few acts which offer protection. So Child Labour Prohibition Regulation Act 1986, so it offers protection. Employment of Children Act 1938, Factories Act 1948, Mines Act 1952, Merchant Shipping Act 1958, Plantation Labour Act 1951. So these are few of the acts which give protection to child. You need not remember any of these acts. Don't remember any of these acts. When they come as part of the current affairs, at that time we shall think. So just we shall think from this perspective, whether any law exists in India which gives protection to the children. Yes, there are some laws which give protection to the children, and from the mains point of view, among these laws, if you are able to just quote one law also, for example, Factories Act, that would be sufficient. That would be sufficient. Okay, you need not recall all these acts, not important. In 1996, Supreme Court directed that establishment of Child Labour Rehabilitation Welfare Fund. Okay, welfare fund. So Supreme Court has directed this, not important. Okay, not important. In mains you can quote, from prelims point of view, not important. Commission for Protection of Child Rights. So these are important. So there are some commissions which have been constituted for the welfare of the children. There are some commissions which have been constituted for the welfare of the women. There are some commissions which have been constituted for the welfare of the minorities. There are some commissions which have been constituted for the welfare of the for the welfare of SC/ST. So there are various commissions for OBCs and so on. So similarly, some commissions have been established for the welfare of children. So one such commission is NCPCR, National Commission for Protection of Child Rights. National Commission for Protection of Child Rights. Okay, SCPCR is State Commission for the Protection of Child Rights. Okay, child rights. So both of them, they have been established under which act? Commission for Protection of Child Rights Act. Means all the states, they do not have a respective act. Center has enacted an act that is called as Commission for Protection of Child Rights Act. Within this act, one body has been constituted at the center called as National Center for Protection of Child, National Commission for Protection of Child Rights. Similarly, in all the states, commissions have been created called as Karnataka Commission for Protection of Child Rights, Tamil Nadu Commission for Protection of Child Rights, Maharashtra Commission for Protection of Child Rights, and so on, and so on. Okay, and also there are children's courts. Okay, as per this act, there are courts which deal exclusively with children's. Okay, exclusively with children's. In 2006, government banned employment as domestic servants or workers in businesses, establishments like hotels, tea shops, etc. So government, what it did is it brought an order saying that you should not employ a child below the 14 years of age in house for domestic purposes. Okay, as domestic servants, they should also not be employed in establishments like hotels, tea shops, etc. Okay, etc. Now you got a clarity? Yes. So even though these are not considered as hazardous, okay, hazardous, so they are also, as per the government order, they cannot be employed. Okay, they cannot be employed. How about film industry? Yes. Okay. So again, when you start raising the question, more doubts will arise. So we'll stop here itself. Okay, what we'll do? We'll stop here itself with respect to article number 24 as well as today's discussion. Okay, discussion. So if you have any kind of doubts with respect to the discussions that we had till this point of time, you can just raise the doubts. Okay. So we discussed today which all articles? Yes. Article number 19, 20, 21, 22 and 23. Okay, 23. 23 as well as 24 we discussed. Okay, 24 we discussed. So in the next class we shall start with article number 25. Okay, type 25. So if you have any kind of doubts, you can raise. Otherwise, we can close. Shall we close? Okay. Then we shall meet in the next class. Yes. Article number? 24. Huh. No, it is for citizen of India as well as others. Okay, others, to protect all the children. Okay, all the children. Not only for citizens of India, but for all the children. Okay, all the children. Welcome to Paritranaya. It's day 13. Okay. So in the previous class, we were discussing about fundamental rights. To be specific, which fundamental rights we discussed?
23.
23 and 24. So 23 and 24 article number they deal with right against exploitation. Okay. Which are the range of articles which deal with the right to equality?
14 to 18.
14 to 18. Next, right to freedom?
19 to 20.
19 to 22. Next, 23 and 24 deal with
Right
against exploitation. Next, 25 to 28 deal with freedom of religion. Next, after freedom of religion, we have
Constitution and
cultural and educational rights. So which articles deal with it? 29 and 30. Next, right to constitutional remedies is dealt by 32. Abolition of titles is dealt by which article?
18.
18. Next, untouchability. Right to life and liberty. 21. Next, prohibition of employment of children in factories. 24. Trafficking of human beings. 23. Next, equality of opportunity in matters of public employment. Yes? 16. Okay, 16. Next, which article deals with organization of village panchayats? 40. Uniform civil code.
44.
Promotion of educational economic interests of scheduled caste and scheduled tribe, whether it's a socialistic principle, Gandhian principle, or libertarian principle. Yes? Gandhian principle? Okay. So which word in the preamble indicates absence of privileges? Special privileges? Equality. Absence of restraint is indicated by? Liberty. Okay, liberty. Next, whether fundamental duties have ever been amended?
Yes, sir.
Yes. So fundamental duties was whether it is originally part of the constitution?
No. No.
It was added through which amendment?
40.
42nd? Okay. So which all terms were introduced into preamble through 42nd amendment?
Socialist, secular,
Social, secular and
integrity.
Social, secular and integrity were terms added by 42nd amendment. Okay. Next, which are the provisions added to directive principles of state policy through 42nd amendment? Equal justice and free legal aid. Dealt by which article? 39A. Next, 43A. What does 43A indicate? Participation of workers in the management of industries. Next, protection of environment. Which article deals with it? 48A. Next, one more. Healthy development of children. Which article deals with it? 39 or 38? 39. Okay, 39. So next we shall begin with article number or right to freedom of religion. Okay, right to freedom of religion. So around what? How many articles? 25, 26, 27, 28. 4 articles deal with it. Okay, 4 articles deal with it. So there have never been a question to a deeper level. Just at the superficial level they ask question, and that too in the recent past they have not asked any kind of questions on right to freedom of religion. So we need to understand at a superficial level. If we understand, it would be sufficient. We will not go into deeper aspects. Okay, deeper aspects. So when you start reading Lakshmikant, we will encounter so many things. So which initially it appears as important, but gradually when you analyze the previous year question papers, either prelims or mains, you will understand it's not that much important. A superficial understanding would be more than sufficient. Okay, sufficient. Okay. So freedom of conscience and free profession, practice and propagation of religion. So article number 25, it speaks about
Freedom of conscience.
freedom of conscience. So what do we understand by freedom of conscience? It's a very broader term, right? Conscience. So whatever the belief you have, okay, whatever the belief you have. So you have complete freedom for that. For example, if you believe in Hinduism, if you believe in Islam, if you believe in Christianity, okay, you have complete what freedom of conscience. You may have any kind of belief, no one can restrict it. Okay, no one can restrict it. And free profession. Once you have that belief, then you can practice it. Okay, free profession, practice and propagation. You can also propagate the same to others as well. Okay, others as well. If others are not ready to accept, then you cannot force them. But you have the right to propagate. Okay, right to propagate. So here, this superficial information would be more than sufficient for the exam point of view. We will be discussing these things, but this information would be more than sufficient for exam point of view. In the examination, maximum what they can ask. So which article deals with freedom of conscience? Article number 25. Which article deals with freedom of free profession, propagation and practice of religion? Article number 25. Okay, article number 25. They are never asked a question. If at all they ask, it will be at this level. So when it comes to importance, so repeatedly we have to focus on article number 14, right to equality. So that's very important. Article number 21, that's very important. We have seen, right, freedom of press. It broadly falls under which article?
19.
Article number 19. Right to marry a person of one's choice?
21.
21. Right to privacy?
21.
21. Okay, 21. Right to privacy is article number 21. Okay, 21. So next, this right, it's available to all citizens plus non-citizens. So right to freedom of conscience, not only for citizens but also for foreigners. Okay, for foreigners, non-citizens also it's available. Now we will not go to a deeper level whether it is available only for the friendly aliens or enemy aliens. At some point of time we have discussed, but here we will not go into those aspects. Okay, we will not go into those aspects. Okay, aspects. Freedom of conscience. So inner freedom of an individual to mold his relation with God or creatures in whatever way he. Someone knocked? So freedom of conscience indicates inner freedom of an individual to mold his relation with God or creatures in whatever way he desires. Okay, so ultimately all the religions they speak about uniting with God. So there are different ways. So the practice involved in Hinduism is different from the practice involved in Islam, and the practice involved in Christianity is different. So all of them they have their freedom to choose their path. Okay, choose their path. So we will not go into the deeper aspect of this sentence. Even if you are not able to understand this sentence also, just don't waste your time here. Okay, we will go to the next point. Right to profess. Declaration of one's religious beliefs and faiths openly and freely. So you need not fear someone that if I express that I belong to a particular faith, if I express that I have faith in this particular religion, what people might think about me. You need not have such kind of fear. You can openly express that you have so and so conscience. You follow Hinduism, you follow Islam, you follow Christianity, you follow Buddhism, you follow Jainism. Okay, you have complete freedom to express it. Okay, you have complete freedom to express it. Practice. So once you express performance of religious worships and rituals, ceremonies and exhibition of beliefs and ideas. So once you believe in some kind of religion, okay, you have conscience about a particular religion, you have complete freedom to practice it as well. Okay, practice it as well. So these detailed line by line important, information is not important. Here important is profession, practice, and next is conscience, and next is propagate. That is sharing the information with others. Dissemination. So what does dissemination mean? Sharing of information. Dissemination of one's religious beliefs to others or exposition of religious tenets of one's religion. So whatever the belief you hold, you also have the right to express it to others, to propagate the ideas of that particular religion. Does not include right to convert another person to one's own religion. Okay, so this is important. So you have the right to propagate, but if the other person is not ready to accept and you forcefully if you try to convert, so that is not acceptable. So under article number 25, whether we have the right for conversion? No. Okay, it is not allowed. Okay, it is not allowed. It covers both religious beliefs and religious practices. Okay. So when it comes to article number 25, it protects both religious beliefs, it is called as doctrines, and also religious practices. So rituals are also covered and belief is also covered. Okay, belief is also covered. Now for example, if you take an example of a ritual, So every day the puja that we do, it's a ritual. Okay. Belief. What is it? Belief. So if we do puja, then we will become united with the Lord. So that's a belief. So here under article number 25, there is a protection for both belief as well as ritual. Again, this deeper level information, you need not get confused, because some of these aspects are very much spiritual and philosophical. So if at all we are not connected with the philosophical aspects and spiritual aspects, some of these things will not be able to connect very easily. So hence, do not stress out more on understanding these things if you are not able to connect the dots. Rights subject to public order, morality and health. So as I have mentioned, so whether the fundamental rights are absolute?
No.
Every fundamental right is subjected to some kind of exceptions and limitations. Here there are some limitations. Means public order. Now you are following your religion, but it should not cause a harm to public order. Okay, you can practice your religion privately without causing any kind of harm to others. So it should not cause any kind of harm to public order. Okay, public order. Morality. Okay. Next, health. So practicing of your religion should not have a negative impact on your own health. Okay, own health or others' health. So it should not have any kind of negative impact on your own health or others' health. Again, there are certain exceptions. We will not go into those exceptions. Okay. For example, there is a ritual in Jainism. Some of you might be aware of that ritual, Santara. So ritual is Santara, fast unto death. Okay, fast unto death. Now that case has gone to Supreme Court. So whether that fast unto death violates this article number 25, okay, we'll not go into those deeper aspects. Okay, when it appears in the newspaper, we'll think about it. Santara is an important ritual associated with Jainism. This will be important from what? Art and culture point of view. But from polity point of view, yes, decision has been given by the Supreme Court. But we'll not go into those deeper aspects and waste our time, because we want to become jack of all the subjects. Okay. So when you are practicing any kind of religious rituals, so it is subject to what? Health. It should not cause a negative impact on health. But UPSC has never asked a question on article number 25 itself. So there are very rare chances that they may ask about the limitations available. Okay, limitations available. So you will mark it as lower priority at time of examination. Okay, examination. State is permitted to regulate or restrict. State means, what do we understand by here? Government. Which article of the Constitution deals with the state? Article number 12 deals with the definition of state. So in this speak about state, it only speaks about the executive organ of the state, or also it speaks about the legislative organ of the state. Both executive and legislative organ of the state. When we say state, it refers only to the central government, or also it refers to state government as well?
Both.
It refers to both central government as well as state government. So the definition of state does not include the local bodies like Panchayat Raj and municipalities. True or false?
False.
It also includes
Village.
local bodies as well. That is village panchayats and municipalities. Okay, municipalities. State is permitted to regulate or restrict. It means there are some limitations given in the Constitution. On top of that, a government may impose some kind of restrictions on the practice of religion. On the practice of religion. Any economic, financial, political or other social activity associated with religious practice. Okay. So, for example, let's take a temple. So, an economic or financial activity associated with the religious practice. Now, a temple is managed by, let's assume, a trust. Okay, trust. So, who all should be part of that trust? That is political affair. Whether they should be elected or nominated. If they are being elected, who all should participate in the election? So, this is a political process associated with the religious practice. Okay. Now, there are chances that the misuse of fund might take place. Hence, government will form a body. So, who all should become part of that, members of that body. So, all these rules and regulations government can do. Okay, government can do. So, to protect the interests of the people following that religion. Okay, that religion. So, any economic, financial, political or other social activity associated with religious practice. So, state is permitted to regulate or restrict. So, it may regulate. It may say. So, the organizing body should consist of at least minimum 10 members. So, these kind of regulations who can make? Government can make. Okay, government can make. So again, to this deeper level, they have never asked a question, but let's have an understanding whether state government is permitted to interfere in article number 25. Yes, to some extent. Okay, to some extent. For example, when it comes to regulation of economic activity, financial activity, or political activity, or any other social activity associated with religious practice. Okay, religious practice. Now, for example, the famous case is Sabarimala case. Okay, Sabarimala case in Kerala. So there was a case which had been to Sabarimala. So there is a restriction on women of certain age. Okay, so those who pertain to menstrual cycle age, okay, that age, so they are not permitted to enter the temple. Okay, they are not permitted to enter the temple. So this case had gone to Supreme Court. Now, whether this can be regulated by the government, saying that right to equality says that everyone has equal rights. Now, this has a different interpretation, and there are various judgments and different perceptions. So we will not go into those deeper aspects. Okay, which is right, whether permission should be given or not, or whether the permission is being denied, that is correct or not. Because there are a female Supreme Court judge itself has declared that it's the permission that is being denied to women of menstrual age, it's correct. So we cannot comment on it. So we will not go into those deeper aspects now. Okay, we will not go into those deeper aspects. So social activity, right? It's an example of that. Okay, it's an example of now people belonging to certain caste, they should not be allowed to enter the temple. Okay, so that's a social activity associated with the temple. So whether state can regulate?
No.
State will regulate. Yes, whatever you are doing wrong. So irrespective of their caste, all should be allowed to enter the temple. So here, social activity is being regulated by government. It's an example of a social activity being regulated by the government. So the type of people who should become members of the committee, there is a political activity. Who all will maintain funds? So how many accounts should a committee maintain? So all these are financial or economic activity. So in this fashion, government can make rules and regulations for the same. Okay, same. Next, state is permitted for provide for social welfare or reform. Okay, so social welfare or reform. So as I mentioned, now there was a practice. People belonging to some caste, they are not allowed to enter the temple. Okay, within Hinduism, they are not allowed to enter temple. Now, permitting them to enter the temple, creating that provision, that's an example of a social reform. Okay, so whenever we bring any kind of new changes for the welfare of the society, for the welfare of the country, we call them as social reforms. Okay, example, sati system. Prohibition of sati system is an example of a social reform. Okay, prohibition of child marriage is an example of social reform. Next, promoting widow marriage is an example of social reform. Permitting all the people of a particular religion, irrespective of their caste, to enter the temple is an example of social reform. Okay, social reform. So state is permitted to provide for social welfare or reform, or throw open Hindu religious institutions of a public character to all classes and sections of Hindus. Okay, within Hindus, there should be no discrimination like he belongs to a particular caste, only he should be allowed to enter the temple. Okay, such kind of discrimination, if they exist, that should be removed. Who has the permission to remove it?
State.
Okay, state is permitted to do that. Okay, do that. Contains explanations. Wearing and carrying of kirpan is to be included in the profession of the Sikh religion. Okay, so Sikhs, they carry what? The turban they wear, they carry a kind of kirpan. So that is considered as part of the profession of Sikh religion. So if you see, there is a special exception. In army and all, when it comes to other religions, for example, those who practice Hinduism, or those who practice Islam, or those who practice Christianity, so daily they have to there needs to be a clean shave. Okay, clean shave. But when it comes to those practicing Sikhism, okay, there is an exception. So they can leave their beard. They also wear that special turban. So this is considered as part of a religious practice. Okay, religious practice. Hindus in this context include a very important term. So in the constitution, wherever the term Hindu appears, it also includes within its ambit Sikhs, Jains and Buddhists. So in the constitution, wherever the term Hindus appear, it means they are also referring to Sikhs, Jains and Buddhists. So while discussing about the history and art and culture, we'll see that all these religions, they are offshoot of Hinduism. Originally, they were part of Hinduism, but later on they broke away and they started their own religions. Okay, own religions. So hence, when in this constitutional context, whenever we refer to term Hindus, so it refers to Sikhs, Jains as well as Buddhists. Okay, Buddhists. So can you just recall the important keywords associated with article number 25?
Conscience.
Yes, conscience, profession, practice, propagation of religion. Okay. Apart from that, few other keywords. Can you recall?
Discern.
Yes.
Dissemination.
Yes.
Dissemination.
Dissemination. Okay, dissemination of information.
Hindu includes the
Hindu includes these terms. This is an important point. Next,
welfare, social,
public order. Those are
Social
reasonable restrictions.
social welfare.
Social welfare can be brought.
Reform.
Okay, reform. Hindu temple should be thrown open to all. Okay, so these are some of the keywords. If you understand, that would be sufficient. Okay, if you understand, that would be sufficient. Next, freedom to manage religious affairs. Now, some things may overlap with article number 25. There is no clear-cut demarcation between article number 25 and 26. So, you need not worry about it. Now, from the exam point of view, if we think, which article deals with freedom to manage religious affairs? Article number 26. Okay, 26. Every religious denomination. So, here we come across a term called as denomination. So, denomination means a body associated with religion. For example, it may be temple management committee. So, all these are called as denomination. Okay, denomination. Every religious denomination or any section shall have right to establish and manage institutions for religious and charitable purposes. Okay, every religion, it may be Hinduism, Islam, Christianity, all of them, they have the right what? To establish and manage institutions. What kind of institutions?
Religious.
For religious purposes. For example, temple is a religious institution. It's an institution. Temple is called as an institution. But what kind of institution? It's a religious institution. Okay. Now, charitable purpose. It can also establish institution for charitable purposes. For example, orphanage. Okay, wherein you feed the people who are orphans. Okay, orphans. So such kind of charitable institutions can also be formed by what? Means religious under the religious affairs we can establish religious institutions and also charitable institutions. Okay, charitable institutions. Right to manage its own affairs in matters of religion. Now here there is some confusion will arise. So my religion, I will manage my own internal affairs. For example, at what time I should open the temple. Okay, in puja, what all things I have to use. Okay, what all practice has to be used in mosque. So what all rituals have to be followed in church. It is right to manage their own what? Religious affairs. Okay, religious affairs. Right to own and acquire. So this is important, especially in the context of the controversy which took place in 2025, Waqf board and all. Okay, at a superficial level we shall understand. Right to own and acquire movable and immovable property. Okay, so it comes under right to religion. For example, a religious body is there. Let's assume a trust, Hindu trust or Muslim trust or Christian trust. So that trust, what they can do, they can acquire movable property. For example, car. They can also purchase immovable property. For example, land. Okay, land. So right to own and acquire movable property and immovable property. Okay, again we will not go into detail like connecting these aspects to Waqf and all, we will not do it, but at a superficial level you shall understand that right to own and acquire movable and immovable property connotes to which article of the Constitution?
26.
Article number 26. That much information would be sufficient. Okay, sufficient. Because at the superficial level we have seen right to manage religious affairs. But internally when we go, so this is a keyword that we have to remember. Even though there have been no question asked till now, but we shall focus on this aspect. Right to administer such property in accordance with law. So once you acquire property, let's assume you purchase a land. So after purchasing the land, so that land usage should happen as per the law. Okay, as per the law. This detail not important. Okay, just leave it. See here, article number 25, it guarantees the rights of individuals, whereas article number 26, it guarantees rights of religious denominations. It means religious institutions, religious trusts. So this is a fundamental difference. 25, individual right to freedom of religion. 26, right to freedom of religion of religious denominations. Okay, organizations. Okay, organizations. So it protects collective freedom of religion. So which article protects collective freedom of religion? Article number 25 or 26?
26.
26. Which article protects individual freedom of religion?
25.
25. This superficial understanding would be sufficient. Okay, would be sufficient. Subject to public order, morality and health. The same limitation which apply to article number 25, it gets applied here also. So when you are exercising this right, it should not compromise with the public order. It should not compromise with the morality. It should not compromise with the health. Okay, health. Supreme Court has held the following as religious denominations. Okay, Ramakrishna Mission, Ananda Marga, so they are called as religious denomination, not as a religious denomination. Aurobindo Society, okay, it is not considered as a religious denomination. So these examples have been mentioned in the book as a static part. So UPSC will not focus on such kind of aspects. Okay, if you want to retain, you can retain. UPSC, if at all it asks a question, it will be on the current affairs part when it comes to such denominations. Okay, so if you want to retain, just retain it. Ramakrishna Mission and Ananda Marga. So Ramakrishna Mission is very famous. We will see the mission across the country. Okay, across the country, that Ramakrishna Missions, organizations are located almost across the country. So these are considered as denominations, but this is not considered as a religious denomination. Why it is not considered? So all these things are not important. Even if you skip entirely, also not an issue. Okay, not an issue. So article number
20.
25 and 26. 25 is individual freedom of religion. 26 is collective freedom of religion. Okay. Right to acquire property. 26 or 25?
26.
26. Okay, 26. Freedom from payment of taxes for promotion of a religion. Okay. So some taxes are being collected for promotion of a particular religion. For example, it may be Hinduism, or it may be Islam, or it may be Christianity, or it may be Buddhism, or it may be Judaism. For promotion of particular religion, when taxes are being collected from the people, so people are free to say that I am not going to pay the tax, because the tax being paid is for the promotion of a particular religion. Okay, particular religion. So this is theoretical. Okay, this is theoretical, because when the government collects the taxes, after collecting the taxes, it will use the money. Okay, it will use the money for the promotion of Hinduism or for the promotion of Islam. It means India is what kind of India practices what kind of secularism? Positive concept of secularism or negative concept of secularism? Positive concept. We have seen while discussing about the preamble, right? In other European countries and all, they follow the negative concept of secularism. It means state does not support any kind of religion. Okay, so you want to build a temple, you build it with your own money. If you want to build a mosque, you build it with your own money. If you want to go for Makkah and other holy places, then with your own expenditure. But in India, so support is being extended to all the religions equally, whether it is Hinduism, whether it is Islam, whether it is Christianity, whether it is Buddhism, irrespective of the strength or the population in that particular religion. Okay, that particular religion. So here, generally, taxes, when the taxes are being collected, we will not segregate that this tax is being collected for promotion of a particular religion. So it has only theoretical value. Practically, it does not happen. Okay, so this you shall understand. Hence, there has been no question in the examination in the past 30 years on this particular topic. In the prelims, there have been no question, but at least theoretically, we shall understand. No person shall be compelled to pay any tax for the promotion or maintenance of any particular religion or religious denomination. Okay, so no person in this country should be forced to pay the tax for the promotion of a particular religion. Okay, religion. That is, state should not spend the public money collected by way for the promotion or maintenance of any particular religion or religious denomination. So government also, when it collects the taxes, it should not use for the promotion of a particular religion. But whether the government uses in India? Yes, it uses. But whether particular religion?
No.
No, all the religion. Because India has a stance of positive secularism. Okay, positive secularism. So it maintains equal distance with all the religions. Prohibits the state from patronizing or supporting one religion over another. Okay, so state, that is government, should not prioritize one religion over the other. So that is also true in case of India. In India, no religion is prioritized. Okay, no religion is prioritized. Means that taxes can be used for the promotion of all religions. So this is what we have to understand. Okay, so taxes can be used for the promotion of all religions. Only prohibits levy of tax and not of fee. See here, tax is different from fee. When you go to a temple to visit, sometimes your fees will be charged. Okay, so that is different from fee. So fee can be levied on pilgrims to provide them some special service or safety measures. Okay, for example, if you visit some pilgrimage places like Tirupati or some other places, a special ticket or fare will be charged. Okay, so that is for the welfare of that particular place, so that next time when you visit, all the facilities should be easily available. So fees can be charged, but taxes cannot be charged. Okay, cannot be charged. Now entire thing, what you will remember? You will remember only one aspect. What is that? You cannot force someone to pay taxes for the promotion of the any particular religion. Okay, that much information would be sufficient. Okay, would be sufficient. Next, 28. Freedom from attending religious instruction. No religious instruction shall be provided in any of the educational institutions. Okay, in educational institutions, no what? religious instruction means either belonging to with respect to Hinduism, Buddhism, Jainism, Christianity, Islam. So religious instruction should not be provided in the schools. What kind of schools and colleges? Wholly maintained out of state funds. Okay, when I say wholly maintained out of state funds means government schools and colleges. In government schools and colleges, you cannot give religious instruction. Okay, religious instruction. However, does not apply to an educational institute administered by state but established under an endowment or trust requiring imparting of religious instruction in such institution. There are some exceptions. Now there are some religious institutions, okay, started by the government itself. So for the promotion of a particular religion, for example, let's assume the number of people who speak Sanskrit, it is diminishing, it is reducing. So to promote that, they'll start a special education institute wherein everything will be imparted only in Sanskrit. So to such kind of educational institutions, there is an exception. Okay, similarly, if someone wants to teach Urdu, okay, if it is diminishing, then special establishments can be created. Okay, can be created. So there will be an exception. So this detailed information is not important. Okay, this detailed information is not important. What is important here is freedom from attending religious instruction dealt by article number 28. So whether there are some exceptions to it? Yes, there are some exceptions to it. That's it. Okay, that's it. No person attending any educational institution recognized by the state or receiving aid out of the state funds shall be required to attend religious instruction or worship in that institution without his consent. In case of minor, consent of guardians is needed. Okay, needed. Now, for example, there may be some educational institutions wherein, for example, some festivals are being celebrated. Let's assume Ganapati festival. So you cannot force a person belonging to other religion. It may be Islam, it may be Christianity, it may be Jainism or Buddhism, to ask him or her to come and attend the religious festival. You cannot force them. You cannot force them. Okay, so religious instruction, whatever is being given there, so you cannot force such kind of people. Okay, there are some minority institutions. For example, in the nearby institution, I can recall the Bijapur Sikab Institute. So let's assume some kind of religious instruction is being given. You cannot force the other faculty member or students belonging to other religion, for example Hinduism or Christianity or Jainism, to come and attend the religious instruction. Okay, so that freedom we have. Okay, that freedom we have. And in case of minor, okay, if a person is below the 18 years of age, then the consent of the parents will be required to make him appear for the religious instruction. Okay, religious instruction, again not important. Distinguishes 4 types of educational institutions. So here, different types of educational institutions have been given. What I will urge you is, you just ignore all these parts. Just ignore all these parts. Then why I have written? Because later on when you start reading Lakshmikant, okay, so you may get confused that each and every point you will start focusing in detail. But the detailed aspect is not important. Why it is not important? Because when you analyze the previous year, all the question papers, there has never been a question on article number 28. There has never been a question. If at all they ask a question also, it will be at the superficial level, not to this deeper level. And even in the mains also, you will be just quoting one line. What is that? Article number 28, what it speaks about. To just substantiate your answer, you will be just writing one line, and in that one line you will be quoting article number 28. So this detailed information, for example, 4 types of educational institutions, wholly maintained by state. So religious instruction is completely prohibited, administered by the state but established under an endowment of trust, recognized by the state, receiving aid from the state. So all these things, one is it will cause confusion. Okay, it will be very difficult for you to segregate. Second one, it does not have any kind of relevance from the exam point of view. So why majority of the aspirants, they get stuck? Even polity, it starts appearing difficult because they will not be able to make progress from fundamental rights to next topic. Because in one single day, they will be spending on just article number 28. They will not move to article number 29. They will be stuck with so much of confusions that they will not be able to make progress to subsequent topics, very important topics. So here, the important thing is understanding the demand of the examination. Okay, so irrespective of any kind of mode, okay, you may be learning, but understanding the demand of the examination is very important. Okay, so without a proper guidance, what happens? Every line in the book, it starts appearing important. Now initially we have the enthusiasm, we'll focus on each and every line, but gradually over a period of time, after 5 or 6 months of time, what happens? The syllabus will become so bulky. We are supposed to cover the entire polity in hardly 2 or 3 days. We have to focus on other subjects. When it comes to history, again there are modern, medieval, ancient. So when this bulk of that ocean of syllabus, when it stands in front of us, it becomes very difficult to prioritize. So from now itself, if we start prioritizing, then at time of examination, it will boost our confidence like anything, and in a very shorter span of time, we'll be able to revise the entire syllabus. Okay, that too multiple times. So we'll ignore all these parts. Even if you are reading through book also. So what I will urge, if you have Lakshmikant, okay, even if you do not have, purchase it one. What you do is you keep both of them side by side and just try to focus the points, because here I have made it as very crispy. But you should be able to understand the points which have been mentioned in Lakshmikant. And wherever I have explicitly indicated that these points are not important, you will mark there as well. At time of examination, I am not going to focus on those points. Okay, on those points. Okay. Now, can you recall quickly right to freedom of religion? Article number 25 speaks about?
Individual.
Yes. Rights of individuals. What does it say? Conscience, profession, practice, propagation of religion. Article number 26.
Freedom from
Managing religious affairs. Okay, here we will make a comparison between 25 and 26. 25 is upholds the individual right to freedom of religion. 26 collective right to freedom of religion. Article number next 27.
Freedom from payment of
tax. That much if you remember, it would be sufficient. Next, article number 28.
Attending religious
instruction, more than sufficient. We will not go into the deeper aspects. Okay. So next we will move with
20.
Which is the next article? Right to cultural and educational rights. Article number 29 and article number 30. Okay, 30. So next we will begin with the cultural and educational rights. Article number 29. Okay, 29. Protection of interests of minorities. So article number 29 deals with protection of interests of minorities. Okay, minorities. Citizens having a distinct language, script or culture shall have the right to conserve the same. Okay, shall have the right to conserve the same. For example, citizens having a distinct language. So any language, for example, if we take Sanskrit, the number of people who speak Sanskrit has drastically reduced. Okay, reduced. Now we want to protect it so that the upcoming generation should also have an understanding of the Sanskrit. So what we can do, we can take some steps to preserve it. So citizens have a distinct language, script or culture shall have the right to conserve the same. Okay, so whatever is required for its conservation, for example, they can start a new school. Okay, so all such kind of steps can be taken to conserve the same. I just took an example of a Sanskrit. Similarly, there are some tribal languages which are becoming extinct because the number of people speaking that language has almost reduced to zero. So such kind of languages, if they want to protect, what they can do? They can start their own schools and colleges. Next, we will also see government will extend support. So to preserve a language, what is required is basically in the educational institutions, there should be that subject offered as an elective. Okay. So when you are offering a subject as an elective, probably there should be a faculty to engage that subject. So a faculty will be motivated, some person will be motivated to take a particular subject if there are government vacancies available for recruitment. So in this fashion, through this complex ways, what we can do is we can promote a particular language. Okay, promote a particular language. I just gave you an example. So language, script. So whether every language has its own script?
No.
Some of them they use the script of other languages. Okay, script of other languages. So this article number 29, it covers right to preserve language, script as well as culture. And this culture is a very broader aspect. It includes many things as we already discussed. It includes dance, it includes drama, it includes our attire, it includes our food habits. All of them, they are part of the culture. Shall have the right to conserve the same. Okay, so shall have the right to conserve. It protects the right of group. So article number 29, it protects right of a group. Okay, right of a group to conserve the language, script or culture. No citizen shall be denied admission into any educational institution maintained by the state or receiving out of the state funds on grounds only of religion, race, caste or language. Guarantees the right of a citizen as an individual irrespective of the community to which he belongs to. Okay, belongs to. So no person should be denied admission into any of the educational institution, either it is government school or receiving funds from the government. Okay, receiving funds from the government. So not that much important, just superficially you just focus it. grants protection to religious minorities plus linguistic minorities. This point is very important. So article number 29, whether it covers only religious minority or linguistic minority as well.
Both.
Okay, both. So religious minority, it means the number of people practicing that religion will be very less. For example, in India, the religious minorities are Muslims,
Hindu.
okay, Sikhs, Jains, Buddhists, they are all religious minorities. Okay, religious minorities. When it comes to linguistic minorities, for example, the number of people speaking Sanskrit, religious minorities. The number of people speaking some other language, okay, whose if they are less, then we call it as what? Linguistic minority. Okay. If we take Karnataka as an example, in the northern part of Karnataka, there are some people who speak Marathi. Okay. In Karnataka, so they are linguistic minorities. The people who speak Marathi are linguistic minorities in the northern part of Karnataka. So an effort has to be made, okay, to protect all of them, both religious minorities as well as linguistic minorities. Supreme Court held that the scope of this article not restricted to minorities only. Use of word sections of citizens in the article includes majority as well. So in this article number 28, they use the term minorities, right? So Supreme Court in one of the judgments it has said that here minorities also includes majority as well. Means if you are only protecting the rights of the minorities, how about the majority? For example, in India, if we consider Hindus, so they are in majority. So who is going to protect them or their language and their culture? So article number 28 extends to majority as well. But whether it has been explicitly mentioned in the constitution?
No.
No. Through some Supreme Court judgment. But when it comes to Supreme Court judgment, UPSC generally does not focus. When it comes to mains, you can use. Okay. Now, just we should connect the dots. So article number 28. Okay. So it extends to minorities. Whether the minorities also includes majority as well? Yes, it also includes majority as well.
29.
9, sorry, 9. Supreme Court held that the right to conserve language includes right to agitate for the protection of the language. Okay. So now your language is being eroded. The number of people who are speaking that language is coming down. At the same time, government is not taking any kind of step. Now we want to agitate means fight against the government for the protection of your language. Even that right to agitate is considered as a what? A fundamental right under article number 29. Okay, 29. But again, this deeper level question will not be asked in UPSC. Hence, the political speeches or promises made for the conservation of the language of a section of the citizens does not amount to corrupt practices under RPA Act 1951. Okay. Now generally Representation of People Act, we have discussed about this while discussing about Parliament. Okay. We have seen that the various aspects of elections, it is dealt by Representation of People Act. The eligibility criteria to become a member of Lok Sabha, the eligibility criteria to become a member of Raj Sabha, the eligibility criteria to become a member of Legislative Assembly, the eligibility criteria to become a member of Legislative Council. So a person can contest from maximum how many constituencies. All this detailed information is present in Representation of People Act. It also speaks about few more things. For example, in an election rally, if someone uses religion as a tool, so all those who are here belonging to my religion, you should vote only for me. So this is a religious based appeal. Okay, someone might say all belonging to my caste, you should vote only for me. This is a caste based appeal. So this religious based appeal and caste based appeal, okay, it is not permitted under Representation of People Act. If someone makes such kind of appeal, then he can be arrested and he can be imprisoned. Okay, at least theoretically. He can be arrested. But if someone makes a speech saying that in order to protect our language, you have to vote me, then he cannot be arrested, because under Representation of People Act does not amount to corrupt practices. If someone makes a political speech based on language to appeal the voters who speak in a particular language, that will not be considered as a what? Corrupt practice under Representation of People Act. Again, not important from prelims point of view, but in mains you can quote. So during political speeches, if you appeal the people based on religion, based on caste, then that will be considered as a corrupt practice under Representation of People Act. But if you appeal the people based on the language, then it will not be considered as a corrupt practice under Representation of People Act 1951. Okay, 1951. So article number 29. Can you recall the keywords?
Protection
It deals
of
with
the interest
protection of
minorities.
Minorities. Next keywords.
Collective and group.
Rights of minority. Which are the rights? They can protect
Language,
language,
script and culture.
script and
Culture.
culture. Now, which all minorities are included here?
Sikh,
Religious minority plus linguistic minority. So these are the keywords. Okay, these are keywords. Which are the other keywords? Are there any other keywords?
SC held a majority.
Yes, it also includes majority. Minority also includes majority as well. Okay. Next, if at all you want to prepare, right to agitation is part of it. They are never asked, but it can be a keyword. Okay, it can be a keyword. Next. So it was an individual right or collective right? Article number 29.
Collective right.
It was a correct right. Right of minorities to establish and administer educational institutions. Okay. So, right of minorities to establish and administer educational institutions. They can establish their own educational institutions. Okay. So, right to minorities, both religious minorities as well as linguistic minorities. So, there are some institutions we call it as minority institutions. So, as I took an example of SICAB, it's a minority institution in Bijapur. Okay. In Shravana Belagola, we have some institutions which are minority institutions. So, they are under the control of Jain groups. Okay, Jain groups. So, there are some minority institutions. So, which article provides for this provision? Article number 30 provides for the provides this right to establish their own educational institutions. Similarly, linguistic institutions can be established. For example, in the northern part of Karnataka, they can establish Marathi schools. Okay, Marathi schools. So this is an example, right of the minorities to establish educational institutions. Okay. So right of linguistic minorities to establish Marathi schools in the northern part of Karnataka. Similarly, rights of various religious minorities, it may be Muslims, it may be Sikhs, it may be Jains, or it may be Buddhists, to establish their own educational institutions. Okay, institutions. Establish and administer educational institutions of their choice. Okay, of course, of their choice itself, not important. Compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institutions shall not restrict or abrogate the right guaranteed to them, added by 44th to protect the right of minorities in this regard. This act delegated right to property as a fundamental right. So all these things you just ignore it. Okay, just ignore it. We have discussed about the fundamental right, if you remember. So fundamental right, originally it was right to property. We had discussed, if you remember, it was originally a fundamental right. Okay, later on it was deleted. It was deleted as a fundamental right through which amendment?
42nd.
44th amendment. Next, it was placed under which article? 300A. Okay, 300A. So this detailed information you just ignore it. Detailed information you just ignore it. So now this is a minority educational institution. Let's assume SICAB. We took our neighboring example of SICAB. Now this minority institution, the state can acquire. For example, government can take it under its control. So when the government takes the property of a minority educational institution, some compensation has to be provided. Some amount has to be given. So compensation amount fixed by whom?
State.
Government. Okay, government will fix it. Government will fix it. So shall not restrict or abrogate the right guaranteed to them, just not important, just leave all these things. Okay, just superficial level, you understand, that would be sufficient. In granting aid, the state shall not discriminate against any educational institutions managed by a minority. So now state government, it will be granting funds to various educational institutions. Okay, so while giving the fund, it should not discriminate, like it belongs to what, Sikhs, it belongs to Buddhists, it belongs to Jainists, in that fashion. There should be no such kind of discrimination. Okay, discrimination. Protection is confined to minorities only, religious or linguistic, does not extend to any sections as under article number 29. Okay, just leave it. The term minority has not been defined anywhere in the constitution. This is also very important. Whether the constitution defines the term minority?
No.
No. Whether the term minority is present in the constitution?
Yes.
Yes, but the term is not defined. So few of these things we have noticed. For example, office of profit term, whether it is present in the constitution?
No.
It's present in the constitution. Whether it has been defined? No. Okay, no. Next, the term judicial review, whether it's present in the constitution?
No.
It's not present. Which article provides for the provision of judicial review? Article number 13. Okay, 13. Whether the term basic structure is present in the constitution? No. So when did the this concept of basic structure evolve? Keshavanand Bharati case. Okay, Keshavanand Bharati case. So constitution, it does not define the term minority. minority education institutions are of the 3 types. So again, all these things we'll just ignore it. Completely will. Okay. Supreme Court in judgments it has said that right not intended to place minorities in a more advantageous position than majority. So here intention is to protect minorities, not to make them superior to the majorities. Okay. And next, right is not absolute. Even this right is not absolute. Okay. Even this right is not absolute. This is article number 30. So which are the important points associated with article number 30? So it extends only to religious minority or linguistic minority as well.
Both.
Okay, both religious minority as well as linguistic minority. So do we have any other keywords just identified?
Minorities.
Minority term not defined in the constitution. Okay, is there anything else? States have? State should not discriminate. It's very obvious. State should not discriminate while giving funds. Okay, that compensation whatever has to be given, that is fixed by state. Okay, not that much important. So you just focus on these 3 to 4 important points, that would be sufficient. Okay, that would be sufficient. So article number 29, keywords. There also it includes both religious minority and linguistic minority.
Yes.
Yes. Okay, religious minority and linguistic minority. Then what are the other keywords? 29.
Yes.
Yes. Language, script and
culture.
Culture. Language, script and culture. Next.
SC includes majority on that.
Yes. Supreme Court says that minority also includes majority as well.
It is a collective.
It's a collective right. So those are the important keywords which we will focus. Whichever things I have asked you to ignore, you just ignore them. You just don't focus. And here again we revise that thing. What is that? So right to property, whether it is a fundamental right?
No.
No. Originally it was a fundamental right?
Yes.
It was deleted as a fundamental right through which amendment?
44th amendment.
44th constitutional amendment. Now presently it is present in which part of the constitution?
300.
Yes. 300A. Which part? Part 12. Okay, part 12. Now whether right to property can be called as a legal right?
Yes.
Can we call it as a constitutional right? Yes. So apart from the fundamental rights, any rights which are present in the constitution, they can be called as constitutional right as well as legal right. So on that day we saw whether all constitutional rights are fundamental rights?
No.
No. Whether all fundamental rights are constitutional rights?
Yes.
Yes. Okay. Yes.
ಕಾಲ್ ಮಾಡಿದ್ದೆ ಯಾಕೆ ಬಂದೆ ರಿಸೀವ್ ಮಾಡಲಿಲ್ಲ.
Next, a very important part, right to constitutional remedies. Okay, constitutional remedies. So we have discussed from close to article number 12 to what?
14 to
14 to
30.
Okay, 30. So all these are rights. Okay, these are rights. So who should protect these rights?
Supreme Court.
State. The state should protect these rights. Okay, state should give these rights. If these rights are not given by the state, then what the people can do? They can file a case in the Supreme Court and High Court, saying that my rights have been violated. They are not being protected by the government. They are not being protected by the state. Now the Supreme Court and the High Court can take action on government. Okay, on government. So that process is present in article number 32. Right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. Okay, aggrieved citizen. For example, if we take article number 15, article number 15 speaks about prohibition of discrimination on grounds of race, religion, caste, sex or place of birth. Now a person is traveling in a train. Now someone comes and says that you belong to a particular caste. You are not allowed to board the train. Okay. Now his right got violated. Article number 15 got violated. Okay, violated. Who violated it? State or private entity? State. Now he should have some remedy, right? He has faced a problem. So who is constitutional right, that is fundamental right itself, has been violated. Now he needs to have some kind of remedy, some kind of solution for it. So what should be that solution? How the solution should be provided? Where he should file a case? Okay, when his fundamental rights get violated. So that is dealt by article number 32. Okay, 32. Right to remedies. Who? For aggrieved person. We took an example of violation of article number 15 for the enforcement of the fundamental rights. Okay, so someone should come and say that his right has been violated, it has to be upheld, it has to be protected. So this article number 32 deals with it. Okay, article number 32 deals with it. Dr. B.R. Ambedkar said it is the very soul of the constitution and the very heart of it. So generally UPSC does not focus on such kind of statements, but you please retain this statement, very important. Especially Dr. B.R. Ambedkar has made this statement, so very important. They may ask. So Dr. B.R. Ambedkar called which of the following as the very soul of the constitution and the very heart of it? Article number 32. Because all the rights have been provided in the constitution, but if there is no provision to uphold that right, there is no provision to give the remedy when that right has been violated, then it's of no use. Hence, the ultimate among all these articles from article number 12 to 35 is article number 32, because it gives the remedies when the rights get violated. Okay, when the rights get violated. Supreme Court has ruled that it is a basic feature of the constitution. This is very important. Okay, basic feature of the constitution. So whether the term basic feature is present in the constitution?
No.
Whether the term basic structure is present in the constitution?
No.
No. So when did this evolve?
Keshwanand
Bharati case, 1973. So what all provisions constitute part of the basic structure, whether it has been defined anywhere by in any of the Supreme Court judgments?
No.
In no single one judgment they have defined all these things. In various judgments they have said this is part of the basic structure, this is part of the basic structure, this is part of the basic structure. In one of the Supreme Court judgment, the Supreme Court has said that right to remedies, okay, it is part of the basic structure. So hence cannot be taken away even by the amendment of the constitution. Okay, even by amending the constitution, even by you cannot alter the constitution and take the feature of what? Constitutional remedies. You cannot take away article number 32. You cannot take away article number 32. Okay, a very important point to note. Okay. Supreme Court shall have the power to issue directions, orders and writs for the enforcement of the fundamental rights. Okay, so we will be discussing in detail about what are writs later on. They are very important. Now as we took the example, if article number 15 gets violated, if someone does not allow you to board a train, okay, then Supreme Court can issue a direction to the railway department saying that a person's fundamental right has been violated. So whosoever has violated, he should be punished. Okay, there should be some kind of compensation made to the person who has suffered this. So this kind of direction Supreme Court can give for the person who has suffered. Okay, so one is the person who has caused this pain, so he will be punished. Other one is the person who has suffered, he will get the compensation. He will get the compensation from the government. But who, on whose order?
Supreme Court.
Supreme Court's order. Okay, Supreme Court's order. Parliament can empower any other court to issue directions, orders and writs of all kinds. Now by default, who has the power to give directions? Supreme Court. In the constitution they have mentioned that Supreme Court has the power to issue directions, writs, okay, to the government whenever the fundamental rights get violated. But at the same time, constitution is given a power to Parliament. So Parliament, what it can do, it can give the same kind of power to High Court. It can give the same kind of power to Taluk Court. It can give the same kind of power to District Court and so on. Okay, and so on. So when the Parliament is giving such kind of powers, so how it can do? So Parliament, when it is giving power to someone, how it will give? By making a law. It means a bill has to be introduced in Lok Sabha or Raj Sabha, it has to be passed in Raj Sabha, it has to be passed in Lok Sabha, then it has to be signed by President. So by making a law, Parliament can say that apart from Supreme Court, High Court, okay, Taluk Court, District Court also have the power to issue directions to the government. Okay, issue directions to the government. But by default it is Supreme Court. Okay. Right to move Supreme Court shall not be suspended. So whenever your right gets suspended, whenever your right gets violated, as we took an example of article number 15. So you are not allowed to board the train. Article number 16, what does it say? Equality of opportunity in matter of public employment. If they say that people belonging to so and so caste should not apply to this job, what happens? It will be discrimination. Article number 16 gets violated. Okay, someone will not touch you because you belong to a particular caste. Article number 17 gets violated. Okay, someone will keep a title, Rajadi Raja. Article number 18 gets violated. So in all these cases, you have the person who is getting hurted can go to Supreme Court. So that right to go to Supreme Court cannot be suspended. Every person have the right to go to Supreme Court. So again, we will not go into practical aspects. These are theoretical aspects. It's not as easy as we think that directly we can go to the Supreme Court and file a case. It's not that easy. So these are all theoretical aspects. Okay, theoretical aspects. So Supreme Court shall not be suspended except as otherwise provided by the Constitution. But again, for everything there is an exception. Okay, there is an exception. So Constitution provides that P can suspend it during national emergency, article number 359. So we have not yet discussed about the emergency provisions. So in the forthcoming classes, we will be discussing about three important topics. That is center-state relations, interstate relations, and emergency provisions. Okay, emergency provisions. So there we shall see that in certain cases, in certain situations, you cannot go to Supreme Court even if your fundamental rights get violated. Okay. Now, as I took the example, you are not allowed to board a train. So your article number 15 got violated. But during national emergency, you cannot go to Supreme Court and say that my fundamental right has been violated. Okay. Means at that time, your right to go to Supreme Court is suspended. So who can suspend it?
Parliament.
Constitution. Okay. Constitution. Sorry, President can suspend. Who can suspend? President. Okay. In which situations? One situation is national emergency. Okay. National emergency. Which are the other situations? We will be discussing about them later on. Okay. Later on. Supreme Court, defender and guarantor of the fundamental rights of the citizens. So if fundamental rights they get violated, so who will defend them and who will protect them? Supreme Court. Okay, Supreme Court. Supreme Court is vested with original and wide powers. So when we start discussing about Supreme Court, High Court and other subordinate courts, then we'll get a clear picture. Original means when your right gets violated, article number 15 gets violated, somewhere you are not allowed to board a train because of your caste. So original means directly you should go to Supreme Court. Not necessary that you should first go to High Court, and if the judgment given by the High Court is not satisfactory, then you will go by appeal through Supreme Court. No, directly you can go to Supreme Court. So Supreme Court vested with original jurisdiction. Directly you can go to Supreme Court. Okay, and it also has wide powers. Original, aggrieved can directly go to Supreme Court, not necessarily by way of appeal. So this is the meaning of original. Okay, so when your fundamental rights get violated, you can directly go to Supreme Court. Now if your right to property gets violated, someone takes your property forcefully, so can you directly go to Supreme Court?
No.
No. Why?
It is a legal.
It is not a fundamental right. Whether it's a constitutional right?
Yes.
What is the process available for that constitutional right? We'll look into it later on. So when your right to property gets violated, probably first you will go and file a case in the Taluk Court. If the judgment given by it is not satisfactory, then you will go to District Court, then High Court, then Supreme Court. But here, when your fundamental right gets violated, directly you can go to Supreme Court. Okay. Wide power is not restricted on issuing of orders or actions, can issue writs of all kinds. So what are writs? We'll look into it later on. So it can issue all kind of writs whenever a fundamental right gets violated. Okay, gets violated. Only fundamental rights guaranteed by the Constitution can be enforced under article number 32. Okay, so fundamental rights guaranteed by the Constitution. So article number 14 to 35. Okay, 35. All the fundamental rights which are being given here, only they can be guaranteed by Supreme Court. Okay, guaranteed by the Constitution can be enforced under article number 32. So apart from these rights, if any other right gets violated, then you cannot go to Supreme Court. For example, if your right to privacy gets violated, can you go to Supreme Court?
Yes.
It is not mentioned in any of the articles from 12 to 35.
It mentioned.
Right to privacy is mentioned. Right to marry a person of one's choice, it is mentioned.
Supreme.
Okay. So at that time, can we go to Supreme Court?
No.
Okay. So if you look at this statement, no. But through various Supreme Court judgment, it has been an inference has been drawn that right to privacy is one of the right under article number 21. Right to marry a person of one's choice is a right under article number 21. So even when they get violated, you can go to Supreme Court under article number 32. Under article number 32. So you should not get confused. That's why I explicitly used right to privacy and right to marry a person of one's choice. Okay. So, but when right to property gets violated,
Not go to.
okay, you cannot claim that right under article number 32. Okay. Article number 32. Other rights like the following cannot be enforced under article number 32. Non-fundamental constitutional rights. So example, non-fundamental constitutional right. Can you give me one example?
Right to property.
Right to property, okay, is a non-constitutional, non-fundamental but constitutional right. Statutory rights, okay, statutory rights we already seen what discussed about the meaning of the term statute. What is statute? Law. So law is called by different names. We call it as law, we call it as act, we call it as statute, okay. Statutory rights. Now right to vote. Right to vote, whether it is a fundamental right? From article number 12 to 35, nowhere we have seen what the right to vote is a fundamental right. Now Supreme Court, in whether it is given in some of the judgments as part of any article, we are not sure. But right to vote, it's a statutory right available under which law? Representation of People Act 1951. So this is a law, this is an act, this is a statute. Okay, this is a statute. In this law, we have a right called as right to vote. Any person who has crossed the age of 18 is eligible to vote in the election. So now if this right gets violated, someone comes and says you are above 18, but we will not allow you to vote. Now your right gets violated. Okay, but whether fundamental right get violated? No. Our right under
RPA.
what? RPA. Now can you directly go to Supreme Court?
No.
No. First you will go and file a case in what Taluk Court, District Court. Through appeal you will go. So directly you cannot go to Supreme Court. Okay, Supreme Court. Customary rights. Okay. So customary rights means which has come through custom. So every day when you wake up, your children should come and they should take your blessings. Okay. So it has become your right. Okay. So now someone cannot claim that now my son has stopped taking my blessings. Okay, it's a customary right, right? So can you go to Supreme Court and High Court? No. I just gave an example, not important as well. Okay, not important as well. But here, just superficial level, if you understand, that would be sufficient. Cannot be invoked to determine the constitutionality of an executive order unless it directly infringes any of the fundamental rights. Okay. So cannot be invoked to determine the constitutionality of an executive order or a legislative unless it directly infringes any of the fundamental rights. So we discussed about the term judicial review, if you remember. What is judicial review? When any law has been made, okay, when any law has been made, so that law will be studied by the Supreme Court and High Court. So what they will study, whether this law it adheres to the basic law of this country, that is constitution. Okay. If it adheres, then that law will be upheld. If it does not adhere to the basic law of this constitution, that law can be declared as unconstitutional. That is what we have discussed under judicial review. Okay, judicial review. Now, under article number 32, someone challenges a law. So, in one of the examples while discussing about due process of law and procedure established by law, under which article we discussed? Due process of law and procedure established by law. Article number 21. So in India it is due process of law or procedure established by law initially? It is procedure established by law. But in American Constitution what do we have?
Due process.
Due process of law. So in India also we introduced the concept of due process of law through which case? Maneka Gandhi case. So we took an example while discussing, that is executive order. Give one slap. For stealing a pencil, that example we had to right? For stealing a pencil, an executive order says that you should give him one slap. But rather than giving one slap, if a person has been given 10 slaps, then what has been violated? Executive order or a legislative action? Executive order has been violated because the executive order it has been written that he has to be given only one slap. But now he is being given 10 slaps. So executive order has been violated. Okay. Legislative order means the law says that he has to be given a punishment of just what? 5 years. But he is being given a punishment of, let's assume, 15 years. So that is violation of legislative order. Okay, legislative order. That we saw, right? So here, it cannot be invoked to determine the constitutionality of an executive order or a legislative unless directly infringes any of the fundamental rights. Now, I'll just take an example. There is a law. Law 1. Okay. Under law 2. So let's assume law 1, it violates article number 70. We don't know what is article number 70. Law 2, it violates article number 17. There are two laws. Okay, so I'll say imaginary act 1, imaginary act 2. So there are two acts. So what is the process to bring these acts?
Yes.
It has to be passed in Lok Sabha, it has to be passed in Rajya Sabha, and President has to sign it. It has to be passed in Lok Sabha, it has to be passed in Rajya Sabha, and President has to sign it. Now one of them violates article number 70, one of them violates article number 17. Now when we say the process of judicial review, so judicial review can happen for both violation of article 70 and article 17, or only article number 17? Both article number 70 as well as article number 17, because both the laws, they are violating some provisions of the constitution. They are violating some provisions of the constitution. But under article number 32, you want to challenge a law. Okay, you want to challenge a law that it is violating the constitution. It is violating the constitution. Now in this case, you can take only this law to the court, not this law. That is the meaning. So cannot be invoked to determine the constitutionality of an executive order or a legislative unless it is directly infringes any of the fundamental rights. So under article number 32, you can take a law, act to a court saying that it is not adhering the constitution, saying that it is violating the fundamental rights. Okay, fundamental rights. So this first law under article number 32, this law cannot be taken to court, but only this law can be taken to court. Okay, taken to court. Again, on top of this, some confusions will remain initially. Just for time being, ignore those confusions. Okay, just go into deeper. Don't go into deeper aspects. Just ignore it. Okay, ignore it. Next, original but not exclusive. So next we'll be discussing about Supreme Court and High Court. So there again we'll gain more clarity. So original but not exclusive. What does it mean? When a fundamental right is violated, you can go to Supreme Court. But can you also go to High Court?
Yes.
Yes. So can you go to High Court and only through appeal you have to come to Supreme Court?
No.
No. So original means directly you can come to me. But not exclusive means apart from me you can also go to High Court. Okay, you can also go to High Court. So concurrent with the jurisdiction of the High Court under article number 226. Okay. So Supreme Court and High Court, both of them, they enjoy the power to give a remedy when the fundamental rights get violated. So Supreme Court enjoys that power under article number 32. High Court enjoys that power under article number 226. So a person who is facing the problem, he has the option of going either to Supreme Court or he has the option to go to High Court. Okay, High Court. Availability of alternative remedy is no bar to relief under article number 32. However, Supreme Court has ruled that where relief through High Court is available under article number 226, the aggrieved party should first move the High Court. So this will cause a lot of confusion. Now, there are other means available to get the solution. There are other ways to get the solution. So in such a situation, you cannot come to Supreme Court. This is called as bar. This is called as restriction. But there is no such restriction. Even if you may be having some alternative solution for that, but in spite of that, you can directly come to Supreme Court. There is no bar for it. But Supreme Court in one of the judgment, it has said that if any other relief can be available in High Court, then first you have to go to High Court and then come to Supreme Court. See, already we have discussed so many things, it will lead to confusion, so we'll completely ignore this part. Okay, completely just ignore this part. Otherwise, you'll be stuck here itself. You will not be able to make progress. Okay, you will not be able to make progress. So just forget about all these things. Whatever the Supreme Court has said, just ignore it. Now we'll understand that when it comes to violation of fundamental rights, so the aggrieved person, if I am an aggrieved person, I can go either to Supreme Court under article number 32 or I can go to High Court under article number 226. Okay, article number 226. So some of the things which cause confusion, for time being, we just leave it. Because now as we go on moving to the other topics, for example, it may be center-state relations or interstate relations or emergency provisions. Next we will be discussing about Supreme Court, High Court, subordinate courts. So then a picture will emerge. Then we will be able to connect these dots in a much more clear manner. Now this would be sufficient. Okay, this would be sufficient. So we shall take a break for 10-15 minutes. After that, we shall start discussing about the writs. Okay. So whenever your fundamental right gets violated, where you can go?
Yes, Supreme Court.
Either to Supreme Court or High Court. So in order to uphold your rights, in order to protect your rights, Supreme Court will issue some certain kind of orders. Okay, orders. We call them as writs. Okay, we call them as writs. Okay, so these writs are for upholding the fundamental rights of a citizen of this country. So what are these writs and how they are issued? So we will be discussing after a break of around 10 to 15 minutes. A very important concept. In the past 3 to 4 years, there are at least 2 to 3 questions which have appeared on writs. So previously they had never asked a question on writs, but in the past 2 to 3 years they have asked repeatedly. So it's part of the current trend of the UPSC. So very important concept. Okay, very important concept. So we shall break for 10-15 minutes and then we shall meet. So next we shall continue with writs, types and scope. So whenever your fundamental right gets violated, whenever your fundamental right gets violated, you will file a request to the Supreme Court. You will file a request in the Supreme Court saying that my fundamental right has been violated. So you please help me. So when you file this request in the Supreme Court, we will not call it as a request. We will call it as a writ petition. Okay. So who is going to file the writ petition in the Supreme Court or High Court? The aggrieved person, the person who has suffered, the person who has faced the problem of the fundamental right being violated. So he will file a writ petition in the Supreme Court. In the Supreme Court or High Court. Now based on this application, Supreme Court will study so whether really his fundamental right has been violated. So based upon that, Supreme Court will issue the directions to the government, that you are responsible for violating the fundamental rights of so and so individual. Whatever the direction the Supreme Court is giving to the government, it is called as writ. It is called as writ. So often this term we get confused. So writ petition is made by the aggrieved person, and who is going to issue the writ? Supreme Court or High Court is going to issue the writ. Okay, writ. So this basic understanding is very important. Supreme Court under Article number 32 and High Court under Article number 226 can issue the writs of. So there are different types of writs which the Supreme Court and High Court can issue. So they are habeas corpus, mandamus, prohibition, certiorari and quo warranto. So in this class we will be discussing about these various types of writs and what is the difference between these writs and when the Supreme Court and High Court will issue these different types of writs. Okay, writs. So these writs are issued by both Supreme Court as well as High Court when the fundamental right gets violated. Okay, gets violated. Parliament under Article number 32 can empower any other court to issue these writs. So already Supreme Court and High Court have the power. Supreme Court under Article number 32 and High Courts under Article number 226 to issue the writs. Similarly, other courts, for example, District Court, Taluk Court, they can also be given this power to issue writs. But who can give the power? Parliament. So Parliament, when it gives the power, it can give the power only by enacting a law. Okay. For example, it may bring a law like, so writ power to other courts Act 2005, so 2025. So this is an imaginary law. So to bring this law, what the Parliament has to do? Lok Sabha has to pass the bill, Rajya Sabha has to pass the bill, President has to sign. So in this format, Parliament can bring the law by giving the power, by giving the power to other courts to issue writs. Okay, to issue writs. No such provision has been made so far, but till now Parliament has never brought such kind of law and given the power to other courts. So for time being, what we understand here is Supreme Court and High Court are the only entities in India which can issue writs when a fundamental rights get violated. Okay, fundamental rights get violated. Before 1950, only High Courts of Madras, Calcutta and Bombay had the power to issue writs. So this is like a historical background, so not important from exam point of view. Okay, only High Courts of Madras, Calcutta and Bombay had the power to issue writs, but now it's not important. As per the Article 226 now empowers all the High Courts to issue writs. Okay, so once we start discussing about the High Courts, out of curiosity, how many High Courts are there in India? Such kind of questions can be framed. Okay, so that general curiosity we need to have. Again, we will be discussing once we start discussing about High Court, but out of curiosity you can search later on how many High Courts are there in India. So all the high courts in India, they have the power to issue writs. Previously there were only 3 high courts before independence, but now all the high courts are empowered, they are eligible to issue writs. So this point is not important. Currently it's not important. If at all high courts are celebrating some kind of centenary, 75th anniversary, 100th anniversary, in that context if it appears in the newspaper it becomes important, otherwise this specific information is not important from exam point of view. Okay. So this point is very important. Often when it comes to Supreme Court and High Court, so who has more powers? Obviously Supreme Court has more power, but here powers are more, but the writ jurisdiction of Supreme Court is narrower than that of High Court. It means High Court's writ jurisdiction is wider, Supreme Court's writ jurisdiction is narrower. This is a very important point to understand. For example, Supreme Court, it can issue writs only in, let's assume, 5 cases, in 5 different types of cases, but High Court can issue writs in 20 different types of cases. So this just take an imaginary number. So here we understand that High Court's writ jurisdiction is wider than that of Supreme Court. If you are not aware, and in the examination if they make such kind of statement, High Court's writ jurisdiction is wider than that of Supreme Court, generally based on our common sense, we will draw a conclusion that obviously it cannot be true, because Supreme Court is always the more powerful, and we may end up marking a wrong choice. So it's a very exception that when it comes to writ jurisdiction, High Court has a wider jurisdiction compared to that of Supreme Court. Again we will be discussing about these concepts once we start discussing about Supreme Court and High Court. Okay, High Court. Supreme Court can issue writs only for the enforcement of fundamental rights. So whenever a fundamental right gets violated, then High Court can issue writs, but Supreme Court can issue only writs for the enforcement of the fundamental rights. High Court can issue writs enforcement of fundamental right for other as well as other purpose. For example, we shall take an example which we discussed before, right to vote, whether it's a fundamental right. Now someone says that you are not permitted to vote, even though you are above the age of 18, I will not allow you to vote. So your right has been violated, but whether your fundamental right has been violated? No. Your statutory right has been violated. A statutory right available under which act? Representation of People Act. That right has been violated. So when right to vote, it's a statutory right that is violated, you cannot directly go to Supreme Court, but you can go to High Court. Okay, High Court. This is an example. So Supreme Court can issue writs only for the enforcement of fundamental rights. Article number 12 to 35, whichever fundamental rights are there, when they get violated, then Supreme Court can issue writs. But apart from these fundamental rights, if any other right gets violated, then Supreme Court cannot issue writs, but High Court can issue writs. What is that? Writ means direction to the government. So other purpose refers to enforcement of an ordinary legal right. So don't go into technicalities. At the superficial you understand that Supreme Court only violation of the fundamental rights. For violation of any other right, High Court. Okay. High Court, fundamental right violation also it can issue writs. For the violation of other rights also it can issue writs. Supreme Court, it can issue writs only for the violation of the fundamental rights. It cannot issue rights for the violation of other rights. Okay, other rights. Okay. Territorial jurisdiction of Supreme Court with respect to writs is wider than that of High Courts. This is important. Okay. When it comes to subjects, High Court has a wider jurisdiction. When it comes to territory, High Court can issue writs within that particular domain. For example, if Karnataka state, Karnataka High Court has to give the writs, it has to be within Karnataka. It cannot give a writ with respect to a government in some other state, for example, Chhattisgarh or Maharashtra. Okay, Maharashtra. So it is restricted to within Karnataka. So in this case, Supreme Court, it can give writs to any person across India. So when it comes to territorial jurisdiction of Supreme Court with respect to writ jurisdiction is wider than that of High Court. Okay, High Court. Supreme Court can issue writs against a person or a government throughout the territory of India. High Court issue writs against a person residing or against government or authority located within its territorial jurisdiction only. For example, if Karnataka High Court wants to issue a writ, it can issue a writ to a person who is present in Karnataka, who is residing in Karnataka. It can issue a writ to Karnataka government. Okay, it cannot issue a writ to Maharashtra government. Whereas Supreme Court, it can issue a writ to Karnataka government, it can issue a writ to Maharashtra government. So throughout the country, to any government it can issue writ, including the central government. Outside the territorial jurisdiction, only if the cause of action arises within its territorial jurisdiction. You just don't focus on this point, just leave it. Supreme Court is a defender and guarantor of fundamental rights. Supreme Court is a defender and guarantor of fundamental rights. Remedy under article number 32 is in itself a fundamental right. So here a very minute difference is there, very important to understand. Remedy under article number 226 is discretionary. Hence, High Court may refuse to exercise its writ jurisdiction. Hence, Supreme Court may not refuse to exercise its writ jurisdiction. So, from UPSC exam point of view, very important. It often focuses on such aspects. Okay, even though they have never asked a question, but a very important point. That is, whenever your fundamental right gets violated, you have the option either to go to Supreme Court or High Court. Supreme Court cannot say that I don't have time, you go to somewhere, someone else. No, because article number 32 itself is a fundamental right. Hence, Supreme Court may not refuse to exercise its writ jurisdiction. Supreme Court has to take that case and it has to issue the writ. But in case of High Court, it is discretionary. Hence, High Court may refuse to exercise its writ jurisdiction. Okay, so High Court may say, no, we presently don't have time, you can go to someone else. So, at a superficial level, you understand. So, when it comes to writ jurisdiction, whether Supreme Court has that discretion or High Court has a discretion. High Court has a discretion. Supreme Court compulsorily it has to issue the writs. Okay, it has to issue the writs. Okay, so Supreme Court cannot refuse to exercise its writ jurisdiction. So from the exam point of view, how they can make the statement? Consider the following: 1, 2. Supreme Court may refuse to exercise its writ jurisdiction. 2. High Court may refuse to exercise its writ jurisdiction. How many of the statements above are correct? Only 1, only 2, both 1 and 2, neither 1 nor 2. Only 1. So this is how the questions can be framed. Okay, so we look from that perspective. Okay, that perspective. Next, we'll start with these writs. Very important. Okay, so we'll start with the first writ, that is habeas corpus. Okay, habeas corpus. So around 3 years back, a famous movie was released. So if you have not watched that movie, I'll urge you to watch that movie once, so you'll get a clear picture. Okay, so the movie is Jai Bhim. Okay, so it is a Tamil movie, a very interesting movie. So those who are preparing for the UPSC civil services also, once if you watch that movie, you will get a lot of idea about how the processes take place in High Court. And technically, all the technical aspects have been included in that movie. A very interesting movie. The movie name is Jai Bhim. Okay, and that Jai Bhim movie is based on the writ of habeas corpus. Okay, habeas corpus. Latin term means to have the body of. Okay, to have the body of. Order issued by a court to a person who has detained another person to produce the body of the latter before it. Okay, before it. Okay, for example, now a police has arrested someone. Police has arrested, let's say, person A. Okay, person A. So someone on behalf of A, so A's relatives. Okay, A's relatives, they will file a writ in Supreme Court. There we are trying to find our person A, but we are not able to find him. But we know that police have arrested him, but where they have kept, we are not sure. Okay, so now they will file a petition in the Supreme Court or High Court saying that accept our writ petition of habeas corpus. Now Supreme Court and High Court will study that case, and then if they found that it is genuine, if they find that it is genuine, then they will issue a writ to the police or government saying that wherever the person may be, we don't know, you have to bring and make him stand in front of us. Physically you should make him stand in front of us. Okay, in front of us. That is, bring his body, not dead body. Okay, he should be alive. So bring him in front of us and make him stand in front of us. So this is habeas corpus. Okay, this is habeas corpus. So order issued by a court. Which court? Supreme Court or High Court. Okay, or High Court. To a person who has detained another person. So here a person means it can be a police, it can be government, anything. Okay, again later on we will be seeing in detail. So detained means he is forcibly, he has kept another person, he has detained another person. Okay, another person. So now the court will issue habeas corpus. The court then examines the cause and legality of the detention. Once the person is brought, then the court will study whether the detention, whether it is valid or invalid. So after that, it will give the judgment. it would set the detained person free if the detention is found to be illegal. So as I took the example of police, now police have arrested someone and have kept him in some unknown place. Now his relatives will file a habeas corpus petition in the Supreme Court. Supreme Court, let's assume, it will accept it and it will issue a direction to the government or police that wheresoever he may be, you bring him in body. So they will bring him, they will produce the person in front of the court. So after studying, if the court understands that the person has been arrested on no valid grounds, whenever you arrest a person, there should be some valid ground. He should have committed a murder, there should be some proof. He should have been involved in a theft, there should be some proof. If no proof is available, then the person will be set free. Okay, detention is, if it is found to be illegal, then the person will be set free. The writ is a bulwark of individual liberty against arbitrary detention. What is arbitrary detention? So in article number 21 we have seen, what is that? Procedure established by law. Whenever you are arresting someone and putting him in jail, there should be a basis of law. Okay, so according to some law he should have committed the that sin, either he should be involved in murder or theft, anything, then itself he can be arrested. And also he has to be produced before the magistrate within 24 hours. So all these things we have seen. So when there is no law for arrest of a particular person, so in spite of that you have arrested, so that is called as arbitrary detention, means without the base of the law, you have arrested someone, it is called as arbitrary detention. Okay, arbitrary detention. So this writ is a bulwark of individual liberty. So individual liberty means individual freedom. So this habeas corpus, it upholds the individual freedom. Okay, individual freedom. How? Whenever individual's freedom is robbed, when a person without any reason, if he is kept in a jail, are you taking out his freedom? Yes, you are taking out his freedom. So that freedom has to be given back to him. That freedom can be given back to him with the help of which writ? Habeas corpus. So habeas corpus, it will give back his freedom. It will uphold his individual liberty. Okay, individual liberty. So habeas corpus, it's a bulwark. It's a big protection of individual liberty against arbitrary detention. Okay, arbitrary detention. It can be issued against both public authorities as well as private individuals. This is a very important point. UPSC it often focuses on these aspects. So we took the example of a police. Now let's assume generally witness there is some gunda. So he will forcibly take a person and he will keep him in his godown. Now can a writ of habeas corpus be issued against him also, private individual? Yes. So writ of habeas corpus can be issued against a public authority, for example police, as well as private entity, for example a gunda. Okay, a gunda. Okay, in that sense. So every line which appears here is very important, especially keeping in mind the present exams trend. It's very important. Okay, very important. Previously they have never asked questions, but in the past 3 to 4 years, so they are repeatedly asking questions. So hence it becomes a part of the current trend of the examination. So the trend keeps on changing. So whenever the trend changes, we have to change our preparation accordingly. Okay, we have to change our preparation accordingly. The writ is not issued where detention is lawful. Now we took the example of person A who has been arrested. So a police has arrested person A. So a relative of A will file a writ petition in Supreme Court. Supreme Court will study. Okay, it will study. They will come to know that police has arrested person A under IPC section 420. Okay, he has caused some kind of harm to others. So here they have arrested under on some basis, some proof. In such cases, Supreme Court will not issue it because the detention is lawful. Why he has been kept in jail? Because he is involved in some mischievous activities, hence he has been arrested and kept in jail. So when the detention is lawful, habeas corpus will not be issued. When the detention is unlawful, it can be issued. Okay, it can be issued. The proceeding is for contempt of a legislature or court. Okay, so here contempt of legislature, contempt of court. So when we start discussing about Supreme Court and High Court, we will be discussing in detail. When it comes to contempt, there are two types of contempt: criminal contempt, civil contempt. So whatever the judgment the Supreme Court and High Court has given, you are not accepting that judgment and you are not following it, then it's a criminal contempt. Sorry, it's a civil contempt. And if you start criticizing the judiciary, it's a criminal contempt. Okay, it's a criminal contempt. So, sorry, there is a slight difference between criminal contempt and civil contempt. We will discuss once we start discussing about Supreme Court and High Court. Now, whenever you are involved in the contempt of court, at that time if a person is arrested, at that time you cannot issue habeas corpus. Okay. Contempt of legislative, for example, legislative bodies at the central level, parliament, that is Lok Sabha and Raj Sabha. Legislative body at the state level, for example, legislative assembly or legislative council. So they are involved in making such some kind of laws. Okay. Now, one way a person will criticize a parliament, simply they are bringing that law is not important, it's of no good for this country. If he starts criticizing the legislative body, then it will be it will amount to contempt of legislature. So when a person is arrested and kept in jail for the contempt of legislature or for the contempt of court, in such cases also habeas corpus writ cannot be issued. Okay, cannot be issued. Detention is by a competent court. So a person has been arrested and kept in jail, and before keeping in jail, already we have seen the process that he has to be produced before a magistrate. So the magistrate has already given the order that let him be in jail. In such scenario, if the relative will go and file a habeas corpus petition, then that habeas corpus petition will not be accepted because the detention is by competent court. Already a judge has given the order that he should be kept in jail. So in such cases, habeas corpus writ cannot be issued. Okay. Detention is outside the jurisdiction of the court. For example, let's assume Tamil Nadu and Karnataka. So Karnataka also we have High Court, Tamil Nadu we also have High Court. So Tamil Nadu police, they have arrested some person and kept in jail. Okay, kept in jail. A relative of that particular person who are in Karnataka, they will file a case in Karnataka High Court saying that issue a writ to the police of Tamil Nadu. Can Karnataka High Court issue it? No, because outside the jurisdiction of the Karnataka High Court. Tamil Nadu High Court can issue the writ, but Karnataka High Court cannot issue the writ. So detention is outside the jurisdiction of the High Court, then the High Court or any of the judiciary cannot issue it. Okay, cannot issue it. This is just an example. This is just an example. So this was about the writ of what? Habeas corpus. So keywords, which are the keywords? Bring the person in body. So this body will become a keyword. Produce the body. This is the keyword. Next. Individual liberty. Arbitrary detention. This is the keyword. Next. Yes. So public authorities as well as private individuals can be issued against both of them. Okay, both of them. Next, the writ is not issued. These conditions are also equally important. Okay, equally important. Next, mandamus. Okay, next is mandamus. We command. So it means we command. Command issued by the court to a public official. To a public official, asking him to perform his official duties that he has failed to perform or has refused to perform. So here a public official, can you give me an example of a public official? Government servant. For example, IAS is a public official, IPS is a public official. Next, for example, Tahsildar is a public official. Okay, any police inspector is a public official. Okay, next AC is a public official. So all of them, all the entities, they are public official. Even a government college principal is also a public official. He is a public official. So this is issued by the court to a public official asking him to perform his official duties that he has failed to perform or has refused to perform. For example, when someone has faced a problem, let us assume someone has been subjected to a robbery. So someone has robbed a few of his things. Now he will go to a police station and he wants to file an FIR. Now the police sitting over there, he will say that for this small amount of hardly around 1 lakh rupees, why are you filing the case? We are not going to take this FIR. Now what is his duty? Accept the complaint from the person and file the FIR, but he is not performing his duty properly. At that time, what we will do is, we will go and file a writ in the Supreme Court or High Court saying that I had faced this problem, I went to the police station, but they are not ready to register the FIR. So the police sitting over there, they are not performing their job properly. So issue a writ against them. Which writ? Mandamus. Okay, mandamus. So this is an example of police example we took. Similarly, let's assume some pension has to be sanctioned. Some Tahsildar is involved in that. So if he is not ready to sanction, he is not doing his work properly. Okay, he will request the court to issue a what? Mandamus to Tahsildar. Okay, to Tahsildar. Similarly, a government college principal. Okay, so his job is to what? See that all the classes are engaged properly. Okay, if someone is not taking care of that, a writ can be issued against the principal saying that he should take care that all the classes in their colleges are running accordingly. So again, it's an example of mandamus. Okay, so issued by court to a public official. He has failed to perform or refused to perform. Either he is not been able to perform properly or he is not performing itself. In both the cases, it can be issued. Can be issued against. Against whom you can issue? A public body. Okay, a public body. Public body means government body. Okay, a government body. For example, CAG is a public body. Comptroller and Auditor General. Election Commission of India is a public body. Next, later on we will be seeing there are various bodies like, for example, Central Pollution Control Board. It's a public body. Okay, All India Council of Technical Education, AICTE. Okay, Indian Council of Medical Research. All this is a public body. So it can be issued against any of these public bodies. I just took few examples. It can be issued against any of these public bodies if these bodies are not performing their job properly. Okay, properly. A corporation. Okay, a corporation, for example, we can take an example of a company itself. For example, HAL, Hindustan Aeronautical Limited. Okay, next, Life Insurance Corporation, LIC. It can be issued against a government company as well. A tribunal. So in the forthcoming discussions, we will be discussing about a concept called as tribunal. So tribunals are more like courts. Now Supreme Court and High Court, they are overburdened with cases. So to reduce their burden, we have created a special entity called as tribunals. A famous tribunal which repeatedly appears in the newspaper is National Green Tribunal. Next, Central Administrative Tribunal. So these are various tribunals. So to fast track the cases, so that the cases should be solved in a faster manner. So we will be discussing about these tribunals also later on. Okay, more or less they are like courts. Okay, more or less they are like courts. So it can be issued against a tribunal as well. It can be issued against any government. So when I say government, it may be central government, it may be state government, okay, it may be any of the village panchayats, or it may be municipalities. Okay, municipalities. Next, this cannot be issued against private individuals. So here you learn through comparison. Few of the things you learn through comparison. If you compare mandamus with habeas corpus, what is the difference? Habeas corpus can be issued against private individuals as well, but here mandamus cannot be issued against a private individual. Okay, private individual or body. Okay, for example, we shall take VRL as an example. So someone is there whose job is to give the tickets. Okay, you want to book a ticket from let's assume Bagalkot to Bangalore. You will go and you will ask him the ticket. He is not ready to issue the ticket. Now you cannot go and file a case in the Supreme Court or High Court saying that his job is to issue the tickets, but he is not issuing the tickets. Okay, because he is a private entity. But suppose if the person was KSRTC, then mandamus can be issued. Okay, mandamus can be issued. Cannot be issued to enforce departmental instructions that does not possess statutory force. Okay. Now there are some rules and regulations within a department, any of the department. It may be educational department, it may be transportation sector, it may be any of the industries. Some of them are written in law. Okay, some of them are instructions, means they are just plain instructions. There is no law for that. So, for example, to enforce departmental instructions that does not possess statutory force. Now, I will take two examples. FIR. When you go to a police station, FIR has to be filed. So, whenever you go with a complaint. Now, when you go to a police station, okay, so nowhere it has been written that first the victim who comes to the police police station, he has to be served with a glass of water. He has to be served with a glass of water. You please cool down, then we will take our complaint. Nowhere it is written. But probably the departmental instructions they might have given. What is that? When a victim comes to the police department, so first make him relax. So make him sit on a chair, give him a water, cup of tea, and later on you can take the complaint. So this is just instruction. But filing a FIR, It's written in law. Whenever a person comes with a complaint, an FIR has to be registered. Now, if a FIR is not being registered, then a person can file a writ in the Supreme Court and High Court. Which writ? Mandamus. But a person cannot issue. So all of a sudden, when I went to police station, they treated me very badly. They did not even offer a glass of water, a cup of tea. Okay, can you file a writ? No, because it's a departmental instruction. It's not mandated in law. Okay, not mandated in law. When the duty is discretionary and not mandatory. So again, we shall take the same example. Offering a glass of water, it's discretionary. If they want, they can offer. If they don't want, they cannot offer. For that sake, you cannot file a writ in the High Court and Supreme Court. Okay, if it is discretionary. To enforce contractual obligation. Okay, contractual obligation. For example, so some contract has happened between the government and the private body. For example, now government and private, let's assume a contractor. Okay, some civil department will say. So after you construction of the road, if you construct the road, we are going to pay you 1 crore rupees. So this is a contract. After constructing the road, if the department is not releasing the fund of 1 crore rupees, it means that contractual obligation was not honored by whom? By government. Government was supposed to pay 1 crore rupees, but it is not paying. In such a scenario, this person, aggrieved person, he cannot go and file a case in the Supreme Court and High Court saying that the contract is not being honored by them. So give a direction to them. Okay, he cannot claim. For that, there is alternative remedy. We will not be discussing about that. At a superficial level, we shall just memorize these things. So whenever there is a contractual obligation, to enforce contractual obligation, what? Mandamus writ cannot be issued. Okay, mandamus writ cannot be issued. We just took this as an example. It cannot be issued against the President of India or the governors. It cannot be issued against the President of India or governors. So mandamus, it cannot be issued against President. Okay, saying that you have to do your work properly. Governors. Now questions will start arising. How about Prime Minister? Because they are not explicitly mentioned here. So probably in the upcoming year, if they make a statement of Prime Minister, whether a mandamus can be issued against Prime Minister? Yes, because it is not mentioned here, it can be issued against Prime Minister. Can it be issued against Chief Minister? Yes, okay, it can be issued. So generally they will not issue it, but it can be issued. Against the Chief Justice of High Court acting in judicial capacity. Okay, it cannot be issued against the Chief Justice of a High Court as well. So these three things you just remember: President of India, Governor, and Chief Justice of a High Court. Okay, Chief Justice of a High Court. So what are the keywords associated with mandamus? Comment. Do your work properly. Okay, do your work properly. Both public and private, or only public? Only public. So where all it cannot be issued? Departmental instructions, contractual obligation, President, Governor, Chief Justice of a High Court. Okay, Chief Justice of a High Court. So this much information would be sufficient. Next, prohibition. Prohibition. To forbid. Issued by higher court to a lower court or tribunal. See here. Higher court to a lower court. What does it indicate? So higher court may be Supreme Court. Lower court may be High Court or District Court or Taluk Court. It means Supreme Court can issue to High Court, Supreme Court can issue to District Court, Supreme Court can issue to Taluk Court. Similarly, High Court is a higher court. If High Court is considered as a higher court, it can issue it to District Court, it can issue it to Taluk Court. Okay, Taluk Court. To prevent the latter from exceeding its jurisdiction. Okay. So to prevent the latter from exceeding its jurisdiction. Unlike mandamus that directs activity, it directs inactivity. So what does it say? Now let's assume we took the example of what? Habeas corpus itself. Okay, habeas corpus. Now we took example of Tamil Nadu, we took example of Karnataka. Okay. So Tamil Nadu police have arrested person A. So here in Tamil Nadu also we have High Court, in Karnataka also we have High Court. So relatives of A, can they file a petition in High Court? Habeas corpus? Let's assume they will file a petition. Now High Court will issue a direction to Tamil Nadu police saying that you bring him in body. Now, whether Karnataka High Court has that power to issue that writ, whether it is exceeding the jurisdiction, yes, because the High Court of Karnataka, its jurisdiction is within Karnataka. But now you are trying to issue a writ to the policeman of Tamil Nadu. It means Karnataka High Court is exceeding the jurisdiction. So generally it does not happen, but if at all it happens, this is just an example. Similarly, we can invoke so many examples. In this example, what happens? So someone will go and say that they will file a case in Tamil Nadu. Sorry, not in Tamil Nadu, in Supreme Court. What they will say? So the High Court in Karnataka is exceeding its jurisdiction. Okay, exceeding its jurisdiction. Now Supreme Court, what it will do? It will issue a writ of prohibition to Karnataka High Court. What it will say? Whatever you are doing, you just leave it there itself, because you do not have the jurisdiction. You do not have the jurisdiction. So to prevent the later from exceeding its jurisdiction, in this example we saw Karnataka High Court was trying to exceed its jurisdiction. How it was trying to exceed its jurisdiction? It was trying to give a writ of mandamus to Tamil Nadu police, for which the Karnataka High Court does not have power. So now Supreme Court will say to Karnataka High Court, you stop there itself, you don't have the power. You don't have the power. Okay. So unlike mandamus that directs activity, in mandamus what they will do? You are not working properly. Okay. So you do your work properly. But here it directs inactivity. You stop doing your work because you do not have that power. You do not have that power. You do not have that power. Can be issued only against judicial and quasi-judicial authorities. In the previous mandamus we saw. So in mandamus, did we see that only mandamus was issued against judicial authorities? No, it was also issued against corporations. It was also issued against governments and all. But here it can be issued only for a judicial entity or quasi-judicial authority. So quasi-judicial authority means quasi-judicial. Means some of them will be judges and some of them will be others. So such bodies we call it as quasi-judicial. Example of a quasi-judicial body is National Green Tribunal. It consists of few judges and few people who are expert in environmental matters. I am taking an example. So here it can be issued only against judicial and quasi-judicial authorities. A very important point to note. Okay, note. Not available against administrative authorities. For example, prohibition cannot be issued against an IAS officer or IPS saying that you are exceeding your jurisdiction. Okay, so murder has taken place in Bagalkot. So you are a Bijapur SP. So you cannot take action for the murder which has taken place in Bagalkot because you are exceeding your jurisdiction. Now, Supreme Court and High Court, it cannot issue such kind of writ to administrative authorities. It cannot issue prohibition against legislative bodies. Okay, so you are exceeding your jurisdiction. So what does it mean? When does the legislative body exceed the jurisdiction? Can you give me an example? Now, in 7th schedule, we have how many lists?
3 lists.
Union list, state list, concurrent list. Can you give me an example of a union list subject? Defense. Next? Police.
Electricity.
Education. Now, if Karnataka legislative body, if it tries to make a law on defense, whether it is permitted? No. So whether it is exceeding its jurisdiction? Yes. So in such cases, generally they may issue, but here it cannot be issued. Even if Karnataka state legislature, it tries to make a law on defense. So now the Supreme Court or High Court, can they issue prohibition? They cannot issue prohibition. Not available against legislative bodies. Okay, not available against legislative bodies. Private individuals or bodies. Okay, so here prohibition is not available against private individuals or bodies. Can you make a comparison? Habeas corpus, it is available against private individuals. Yes. Mandamus, only public. Here, only public, and that too only judiciary. Judiciary and quasi-judiciary. Okay, quasi-judiciary. Okay, quasi-judiciary. Okay. Next, certiorari. Okay, certiorari means to be certified or to be informed. Forget it. Issued by a higher court to a lower court or tribunal. So it is something similar to prohibition. Okay, almost similar to prohibition with a minute difference. either to transfer a case pending with the later to itself or to squash the order of the later in a case. Okay, in a case. Okay. Now we'll take the same example. Supreme Court. So Tamil Nadu High Court, Karnataka High Court. So scene 1, scenario 2. Okay, scenario 1 and scenario 2. Okay, scenario 2. So let's assume Tamil Nadu High Court, one case is going on. Let's assume a murder trial. Murder trial is going on. Means still hearing is going on. Witnesses are coming, they are giving witnesses and all. In such a scenario, Supreme Court will say that you stop doing it and you transfer it to us, we are going to solve the case. Just compare with prohibition. In prohibition what happens? You just stop doing. There is no scope of transferring the case to itself in case of prohibition. But here you stop working on that case and you send it to us. We are going to give the final judgment. Okay, we are going to give the final judgments. So either to transfer a case pending with the later to itself. So here it is pending with the Tamil Nadu High Court. So it will ask the Tamil Nadu High Court to transfer the case to us. We are going to give the final judgment. This is case 1. Second one is to squash the order of the later in a case. So in one of the case, High Court has already given a judgment. Let's assume murder case itself, it has given the final judgment as what? Hang till death. Hang till death. So his punishment is hang till death. Already order has been given. Okay, given. Now the Supreme Court will say whatever the order you have given, you have to squash it. You have to make it null and void. Okay, null and void. So there are two cases. One is you transfer the case to us, we are going to decide it. The second one is whatever the judgment you have given, you just cancel that judgment. Okay, cancel that judgment. So this is what? Certiorari. Now you understood the thin difference between the certiorari and prohibition. In prohibition, whatever you are doing, you keep it, you just close it. You just don't continue. But here, either you send it to us or whatever the judgment you have given, you have to squash it. Okay, you have to squash it. So this is certiorari. Which are the grounds of this? In case of prohibition, what was the ground? Excess of jurisdiction, which you are not supposed to do, still you are doing. Okay, that was excess of jurisdiction. But here, excess of jurisdiction is also one of the grounds. Next is lack of jurisdiction. Now this will cause confusion. What is excess? What is lack? So you will not go into deeper aspects. So apart from excess of jurisdiction, lack of jurisdiction. They do not have any power, but still they are doing the work. Another one is error of law. So in the example that we took, so let's assume Karnataka government has already given the judgment. They have given a hang till death sentence. But probably for the murder which he had committed, there was only 10 years of imprisonment which should be given. But accidentally they have given what? Hang till death. So some error has taken place. In case of error of law also it can be issued. Okay. So here now because of the exam trend, you will also retain this content. In case of prohibition, what are the grounds? Excessive jurisdiction. In case of certiorari, excessive jurisdiction, lack of jurisdiction. Even if you are unable to find the minute difference between lack of jurisdiction and excessive jurisdiction, don't worry about that. Lack of jurisdiction, excessive jurisdiction, and third one is error of law. Whether in case of prohibition, there was a provision called as error of law? No. Okay? No. So you will also retain this content also. Very important. Okay? Unlike prohibition, which is only preventive, it is both preventive and curative. Okay? In case of prohibition, what you will do? Whatever the case is going on with you, you just stop there itself. Means whatever the mistake you are going to commit in the future, you are going to prevent it. Who is going to prevent it? Supreme Court. The higher court is going to prevent the mistakes that is going to be committed by the what? Lower court. Okay, lower court. But in case of certiorari, it is both preventive. Whatever the mistake it is going to commit, it will make it to stop. How? You transfer the case and send it to us. This is preventive. Another one is curative. Already you have given the judgment. We took the example of Karnataka High Court. Okay, you squash that order. Whatever the mistake you already committed, you will just rectify that mistake. That is curative. So, which among the following is both preventive and curative? Certiorari or prohibition? Certiorari. How about prohibition?
Only preventive.
It's only preventive. It's not curative. It's not curative. This is also very important. In case of prohibition, we saw that it can be issued only against judicial and quasi-judicial entities. Judicial and quasi-judicial entities. But here, certiorari can be issued against judicial and quasi-judicial authorities and also against administrative authorities since 1991 Supreme Court ruling. This 1991 Supreme Court ruling is not important, just remove it. What we will understand here is, one of the difference between prohibition and certiorari is, prohibition can be issued only against judicial and quasi-judicial authorities, but certiorari can be issued against judicial authorities, quasi-judicial authorities as well as administrative authorities, whereas prohibition, it cannot be issued against administrative authorities. Okay, administrative authorities. So can you roughly make the comparison between prohibition and certiorari? Once again, important differences. Prohibition, preventive. Certiorari, preventive plus curative. Next, there is only excessive jurisdiction. Excessive or lack of jurisdiction? Prohibition, excessive. Here, lack of jurisdiction, excessive jurisdiction, and also error of law. Next, third difference.
Can
Only for judicial and quasi-judicial entities. But here, quasi-judicial entities, quasi-judicial entities as well as administrative entities. Okay, administrative entities. Good. Finally, we have quo warranto. Okay, we have quo warranto. Means by what authority or warrant? Okay, issued by a court to inquire into the legality of a claim of a person to a public office. Okay, public office. So public office, again there are numerous things which we can be claimed as public office. So Prime Minister's office is a public office. Chief Justice of India is a public office. Okay, District Collector is a public office. SP is a public office. All of them, they come under public office. So now someone will go and sit on the DC chair and will start claiming that I am the DC of this, the DC of Bagalkot. So all of you should obey my orders. Now someone else will file a complaint against this. He does not have any of the letters to claim that he is a DC, but he is sitting on the chair and he is claiming that he is a DC. Now the court will issue a writ against him. So what authority you have? What is the letter that you hold to claim that you are the DC of Bagalkot? Okay, DC of Bagalkot. So issued by a court to inquire into the legality of a claim of a person to a public office. Okay, it may be DC, it may be SP, it may be Prime Minister, all these things. Okay, hence it prevents illegal usurpation of public office by a person. Okay, to come to a particular post, you should have all the qualifications. Okay, so illegally you cannot go and occupy a particular position. So it tries to prevent such kind of illegal usurpation. Okay, so can be issued only in a case of substantive public office of a permanent character created by statute or by the constitution. So these 2 points are very important. So when it can be issued, substantive public office of a permanent character created by a statute or by the constitution. For all the small posts, it cannot be issued. Now substantive means important positions. But what is that important position? They are not given here. They are not given here. So we shall just assume substantive positions of permanent character created by statute or by constitution. For example, CAG. Can we call it CAG as a substantive public office? Important public office? Yes. If someone goes and sits on the chair of the CAG saying that I am the CAG, so can this writ be issued? Quo warranto can be issued? Yes. Someone will go and sit on the chair of Chief Election Commissioner saying that I am the Chief Election Commissioner, all of you obey my orders. Can we file a quo warranto? Yes. So someone will go and sit on the chair of a government first grade college principal's chair and will say that I am the principal of this college. Can a quo warranto be issued? No, because it's a government public office but not a substantial character. Okay, there may be some other remedy available. Okay, some other remedy available, but here to issue this quo warranto, it should be a substantive public office of a permanent character created by a statute or constitution. For example, if I take CBI director, okay, CBI director. So whether CBI director post is available in the constitution? No. So CBI director, this post is available under which law? Delhi Special Police Establishment Act. There is a law called as Delhi Special Police Establishment Act. Under that law, the CBI director post has been created. Now someone will go and occupy that seat saying that I am the CBI director, all of you follow my instructions. Can we file a writ of quo warranto against him? Yes, because it's a substantive public office of a permanent character which has been created by a statute. So these are the differences that you understood, right? One is DC, another one is, sorry, one we saw CAG, constitutional body. Another one we took the principal of a government college, there we will not issue. Another one we took a CBI director. So a substantive office of a permanent character, created either by a statute or by the constitution. Just these are examples. There is no clear cut which are the offices to which quo warranto can be issued, and will also not focus. So this is the demand of the examination. This superficial level of understanding would be sufficient. Okay, would be sufficient. It cannot be issued in case of a ministerial office or private office. This is very important. So in the initial discussion, I took the example of Prime Minister. Now someone becomes and goes occupies the seat of the Prime Minister. Someone goes and occupies the seat of Finance Minister. Now can we issue this writ of quo warranto? No. In case of ministers, this quo warranto cannot be issued. Private office, someone will go and become the CEO of Infosys. He'll say that I am the Infosys CEO. Okay, so all of you listen to my orders. Can a quo warranto be issued against that person? No, because it's a private office. For ministers and private office, quo warranto cannot be issued. Okay, quo warranto cannot be issued. Unlike other four writs, this can be sought by any interested person and not necessarily by the aggrieved person. This is a very important point. This is a basic difference compared to other writs. We saw totally how many writs? 5 writs. Habeas corpus, mandamus, prohibition, certiorari and quo warranto. In all the other 4 writs, so person who is going to file a request in the Supreme Court or High Court, writ petition, so it will be filed by that person itself. But that person, if he is jail, how he can file? Means his relatives can file. Okay, so our person is missing, they can file a writ. But here only the relatives will be filing those particular writs. But here any interested person, for example, now let's assume person A, he is supposed to become CAG. So he has the official order copy. Someone person B, and he will go and sit on the chair of CAG, saying that I am the CAG, so listen to my words. So it is not necessary that person A has to go to Supreme Court and High Court and file the writ petition of quo warranto. Any other person of this country, including me, I can file a writ in the Supreme Court and High Court saying that saying to issue a quo warranto to person B, because he does not have the official document to claim that he is a CAG. So this is very important. So it is not necessary that it has to be given by the aggrieved person. Anyone in this country can file the quo warranto. But in case of habeas corpus, mandamus and others, it should be by the aggrieved person itself. Now don't go into the technicalities like how will an aggrieved person file a writ petition. In case of habeas corpus, he will be in jail. Okay, don't go into those deeper aspects. At a superficial level, you understand that in case of other writs, only aggrieved person can file the writ. But in case of quo warranto, any person of this country can file, any interested person can file the writ. Not necessarily by the aggrieved person. Even A can also file, but it is not necessary that A should himself file. Anyone can file. Okay, anyone can file. So this is about quo warranto. Okay, quo warranto. Quo warranto. So next we'll be discussing about the armed forces and fundamental rights. Okay, so there has never been a question on this article number 33. Not even a single question they have asked on article number 33. So here there is so much of information. We have to understand how much information we have to extract and register in our brain from the exam point of view. Because there is so much of information, you often get confused. Okay. Now, as an individual, as a civilian of this country, so I have more rights compared to a person who is working in army. So as we took an example, right? So an army person who is working in sensitive areas, he will be having access to so much of information. Means where our sensitive equipments like what radars are there. Okay, where are our guns? So all that sensitive information he will be having access to. So as a civilian, he cannot claim right to freedom of speech and expression. He cannot make a video on that and release it in the YouTube. Okay, his rights are restricted. So which article of the Constitution restricts the fundamental rights of the armed person? Article number 33. So this superficial information would be sufficient in many of the cases because they have never asked a question. It empowers the parliament to restrict or abrogate the fundamental rights. So the constitution itself has not explicitly restricted the rights. It has not said that these are the rights restricted for the armed people. So what it has done, constitution, it has given power to the parliament. Whenever you want to restrict the power of the freedoms of the armed people, you can make a law for that. So now what parliament will do, it will make armed forces Fundamental Right Restriction Act 2005. So 2025. This is an imaginary act. Armed Forces Fundamental Rights Restriction Act 2025. So in this they will say, so article number 19 will not apply to armed forces. Here they will say article number 23 will not apply to armed forces. So these kind of restrictions can be placed on the armed forces by whom? By parliament, by making a law. So how this law will be brought? It has to be passed in Lok Sabha, it has to be passed in Raj Sabha, then president has to sign it. So in this fashion, parliament by bringing a law, it can restrict or abrogate. So restrict means you will reduce the rights, abrogate means completely you will remove it. Okay, you can restrict or abrogate the fundamental rights of the members. So who are they? Armed forces. So also in India we have paramilitary forces, about them we will be studying later on. Police forces, intelligence agencies and other forces. So every word you need not understand. If I speak about intelligence agencies, can you recall one intelligence agency? Yes, RAW, Research and Analysis Wing. IB, Intelligence Bureau. Okay, so these are intelligence agencies. Okay, so paramilitary forces, for example, ITBB, Indo-Tibetan Border Police. Okay, CRPF. So all these are paramilitary forces. So their rights can be restricted or abrogated by whom? Parliament. Okay. To ensure proper discharge of their duties and maintain discipline among them. So why we want to restrict? So that there should be discipline in the army, so that they should be able to discharge their duties properly. Okay, properly. So this line to line not important. This is a very important point, but they are never asked. If at all they ask, it will be at the superficial level. What is that? Who can restrict the power of the armed forces? Whether parliament can make law or state legislatures can also make the laws. Parliament. Only parliament. Power to make laws conferred only on parliament and not on state legislatures are very important. Okay. So power to restrict or abrogate the fundamental rights of the armed forces is empowered. It has been given only to parliament. Only parliament can make laws. State legislature, they cannot make laws. They cannot make laws. Any such law cannot be challenged in any court on the ground of contravention of any fundamental rights. Very important. Now, for example, if we say, okay, Press Fundamental Right Restriction Act 2025. Okay, Press Fundamental Right Restriction Act. Armed Forces Fundamental Right Restriction Act 2025. Okay, so in the first act says that a media person or any of the newspapers should not publish an article criticizing the government. Any of the newspapers should not publish an article criticizing the government. So this provision, it violates which article of the Constitution? 19. Article number 19. So no criticism violates article number 19. Okay. No YouTube video on radar information. Okay. So this also violates which article? Violates article number 19. Because whatever comes to your mind, you should be able to express it. Now, if you want to challenge in the court, okay, can we challenge first law? Yes, first law can be challenged because it violates article number 19, right to freedom of speech and expression. Can we challenge the second law? This also violates right to freedom of speech and expression. To make a YouTube video is my right to freedom of speech and expression. It violates the fundamental rights, but this law, it cannot be challenged in the court. So that's the meaning. So any such law cannot be challenged in any court on the ground of contravention of any fundamental rights. So any law which has been made under article number 33, it cannot be challenged in the court. It cannot be challenged in the court. So whether parliament has enacted such acts, Yes, one example is there. Example is Army Act 1950. Okay, Army Act 1950. So these impose restrictions on their freedom of speech. So they do not enjoy freedom of speech. As a civilian, we can criticize the government, but army people, they cannot criticize the government. Freedom of speech and expression is restricted. Okay, restricted. Right to form associations. So you might have seen many trade unions protesting against the government that we want a hike in salary, we want so and so leaves. So in any of the history of independent India, have you ever seen police together making a strike against the government that we want to get more salary or we want more holidays? Never. Whether army people have formed such kind of associations and made a strike? Okay, in India it has never taken place, but in other countries it happens. We call this army coup. So army will go against the government. Okay, so India is a very completely democratic government. So completely the army and all, they are under the control of the civilian government. But if you look at Pakistan, so it's under the control of the army. Okay, but in India it will never happen. So one of the reason is because there are restrictions. So there are restrictions on the freedom of speech. There are restrictions to form associations. So in India, a person will enjoy that power only as long as he is in position. Okay, he may be a general, but the day he loses his post, none of his subordinates will listen to him. But in other country, we don't know how they have become so powerful. So a person who is working in the army, he will not listen to the prime minister, but he will listen to his general. A person who has even retired, he will listen to him. So such kind of mentality is there. But in India, no. So a person will respect another person as long as he is in power. After that, respect will come in the form of other sense. He may call him for dinner and all. But when it comes to order, he is not going to accept that order. Okay, he is not going to accept that order. So here, Parliament has enacted few acts. Freedom of speech. So freedom of speech is not enjoyed by army person. Freedom to form associations, no. Right to members of the trade unions or political associations, no. So armed forces people, they cannot become a member of trade union. They cannot become a member of political party like BJP, Congress, JDS, etc. Okay, etc. Right to communicate with press. They cannot communicate with press. Only when the government gives permission. So recently we saw after the attack, Pulwama, which attack? Pulwama attack, right? Pahalgam attack. So they address the media. So it will only take place with the government's permission. They cannot on their own go and give an interview to the press also. Right to attend public meetings or demonstrations. So when public meetings they cannot attend, even if they want to attend, it will happen through government permission. But as civilian, do we have this right? We have all of these rights. Okay, we have all of these rights, but armed forces, they do not have these rights. Okay, expression members of the armed forces covers all non-combatant employees of armed forces. Okay, so when you look at army, so all of them will not be holding their gun and standing in the borders. So many of us will be unaware. Okay, those who have not witnessed the army. So what happens is in army, there are every kind of posts. So some are officers, some are jawans, and some are involved in some other profession, like there are barbers in army, there are carpenters, there are mechanics. So these posts are called as non-combatant posts. Okay, non-combatant posts. So these restrictions apply to them as well. It not only applies to combatant forces, it also applies to non-combatant forces as well. Okay, forces as well. Parliamentary law enacted under Article number 33. So, parliamentary law enacted under Article number 33. So, under Article number 33, Parliament can bring what kind of law? The law which restricts the fundamental rights. The law which abrogates the fundamental rights. It can bring such kind of law. So, can also exclude the court martial from the writ jurisdiction of the Supreme Court and the High Court. Very important. Okay, very important. Now, generally here, if any of the officer like IAS officer or KAS officer or SP or DYSP, if someone commits some mistake, he is involved in corruption or theft in any of the cases, so who is going to be the final decision maker? The ordinary courts. For example, now the case will go to let's assume High Court. So High Court gives the decision. If the IAS or IPS officer who has been suspended or dismissed from the service, if he is not happy, what he will do? He will go to Supreme Court. And whatever the decision the Supreme Court gives, that will be final. Okay, that will be final. But in army, okay, in army, let's assume a person is involved in some kind of corruption activity. Okay, corruption activity. So this case will not go to High Court and Supreme Court. This matter will be studied by an internal court. This matter will be studied by an internal court. And if he has committed any kind of mistake, then the internal court of the army will punish him. Okay, it depends. For example, they may suspend him from the services itself. They may not give any kind of benefits. Now, when he is tried by the army court and he has been suspended from the service, now he cannot claim that my fundamental right has been violated. He cannot go to Supreme Court and High Court saying that my fundamental right has been violated, issue a writ to army court. Okay, this process is called as court martial. What is court martial? The tribunals established under the military law. Okay, so whenever a military person commits any kind of mistake, so that will be handled by military courts. Okay, military courts. So whatever the military court, the decision it gives, that will be final. Supreme Court and High Court, they cannot interfere in this matter. They cannot interfere in this matter. Okay, who will say that Supreme Court and High Court should not interfere in this matter? Whether Constitution has said that or Parliament will say? Parliament. So Parliament while making the law, it will say that whenever such kind of decisions are given by the military court, those decisions cannot be challenged in Supreme Court and High Court. So Parliament can make the law. Parliament can make the law. A very important point to note. Okay. So can also exclude the court martial from the jurisdiction of the Supreme Court and the High Courts so far as the enforcement of the fundamental rights is concerned. Okay, concerned. So whatever the military court decision it gives, that will be final. It cannot be challenged in High Court and Supreme Court. Okay. So 33, we saw important points, but there has never been a question on article number 33. Okay, there has never been an question on article number 33. So if at all you expect a question, it will be at the superficial level. Okay, so all the fundamental rights available to the normal citizens of this country are not available to a person working in an army. So those powers can be restricted. Who can restrict those powers? Parliament. The state legislatures can restrict those powers? No. Okay. Who can say that the court martial cannot be subjected to other fundamental rights of Supreme Court and High Court? Parliament. Okay. If these things you understand, that would be sufficient. Okay, that would be sufficient. Okay. So next we will be discussing about article number 34, martial law and fundamental rights, in the next class. Okay, so we discussed till article number 33. In the next class we shall resume with the discussion of martial law and fundamental rights. Okay, fundamental rights. So if you have any kind of doubts regarding the discussions that we had till this point of time, you can raise the doubts. So welcome to Paritranaya. This is day 14, right? So in the previous class we were discussing about fundamental rights, and to be specific, we were discussing about article number 33. So we concluded with the discussion of article number 33. So article number 33, at the superficially, it deals with armed forces and fundamental rights. So whether all the fundamental rights, they also apply to the armed forces as well? No. So the armed forces, they do not enjoy all the fundamental rights like the civilians. There are some restrictions. Who can impose the restrictions? Whether Constitution has imposed restrictions? No. Constitution has given the power to the Parliament to impose the restrictions. Okay, to impose the restrictions. Whether Parliament has brought any such kind of law to impose the restrictions? Yes, Parliament has brought few laws also to impose the restrictions. That was about article number 33. So which article of the Constitution speaks about the definition of state? Article number 12. So the definition of state, it extends only to the central government or also state government as well? Both central government and state government. So which article provides for the provision of judicial review? Article number 13. Whether the term judicial review is explicitly present in the Constitution? No, it's not explicitly present, but article number 13 provides for the provision of judicial review. Okay, review. Next, constitutional remedies is dealt by which article? 32. Okay, so whether High Court also has the power to uphold the fundamental rights? Yes, under which article? Article number 226. Now among Supreme Court and High Court, who can refuse to take the writs? High Court. Okay, High Court can refuse, whether Supreme Court has to compulsorily admit it. Okay, admit it. Now in the previous class we also discussed about the various types of writs. So can you recall the various types of writs? Habeas corpus, mandamus, prohibition, certiorari, quo warranto. Among these, which writ does not necessarily require the application to be filed by the aggrieved person itself? Anyone can file. Quo warranto. Okay, quo warranto. So bring physically the person in front of me. Habeas corpus. Okay. Only can be issued against the judicial or quasi-judicial bodies. Prohibition. How about certiorari? It can be also issued against administrative authorities as well. Okay, administrative authorities as well. Now, whether the habeas corpus can be issued only against the state entity or it can also be issued against private entity as well. Both private and public entity. So, which article deals with prohibition of untouchability or abolition of untouchability? 17. Next, prohibition of employment of children.
24.
Article number 24. Next, equality of opportunity in matters of public employment. Article number 16. Next, right to freedom of profession, practice and propagation of religion. 20? 25? Okay. 25. Okay. Right to life and liberty. 21. Right to education. Right to education. 21A. Okay. 21A. Cultural and educational rights. 29 and 30. So, when we speak about the minorities under article number 29, whether we speak about only linguistic minorities or also we refer to religious minorities as well. We refer to both religious minority as well as linguistic minority. Okay, linguistic minority. Next, we shall begin with article number 34. Okay, article number 34. So, there has never been a question on article number 34 in the previous year question papers. For the past 30 years, there has never been a question on article number 34. Okay, 34. But still, we shall discuss about this article at the superficial level. Okay, superficial level. So, martial law and fundamental rights. So, martial law means it's like a military law. Okay, military law. There is no clear-cut definition, and we will not go into the deeper aspects as well. At a superficial level, we shall just understand that which article deals with the martial law and fundamental rights. Article number 34. So, that is sufficient. Provides for restrictions on fundamental rights while martial law is in force in any area within the territory of India. So, whenever martial law is imposed, whenever a military law is imposed, okay, imposed at that time, which all fundamental rights should be suspended. So, it deals with that. But in India, martial law has never been imposed. So, hence it's not important. Okay, not important. It empowers the parliament to indemnify any government servant or any other person. Okay. Now, when I say about the martial law, across the India, at the same time, never a martial law has been imposed. But there have been some special laws brought in for a particular region. For example, Jammu and Kashmir. Okay, northeast. So, there are some special laws which have been brought. They are something similar to what we call it as martial law. Okay, we will be looking into them later on. So, it empowers the parliament to indemnify any government servant or any other person for any act done by him in connection with the maintenance or restoration of order in any area where martial law is in force. Okay. So, for example, one famous act which appears in the newspaper is Armed Forces Special Powers Act. So, it is prevalent in Jammu and Kashmir. Jammu and Kashmir and also few northeastern states. Armed Forces Special Powers Act. Okay, Special Powers Act. Now, this Armed Forces Special Powers Act, it can be called as similar to martial law. Not exactly, but it can be called as a martial law. Okay, martial law. So, who can bring this law? Whether state legislature can bring? No, only parliament can bring. So, Armed Forces Special Powers Act, for example, in our discussion, we have taken this example. So, to bring this law, what parliament has to do? Lok Sabha has to pass the bill, Raj Sabha has to pass the bill, and finally President has to sign. Okay, sign. So, once the law has been brought, so here under this act, indemnify any government servant or any other person. What does it mean? For example, apart from Jammu and Kashmir, if you take Karnataka as an example, so to maintain law and order, if a police officer or a military person fires at a person and the death occurs, okay, so will there be a punishment for that police officer? Yes, there will be a punishment. You cannot, without going to judiciary, you cannot kill anyone. It's called as extrajudicial killing. You cannot do that. Okay, you cannot do that. Similarly, in a place like Bagalkot, if you want to search any of the houses, okay, if there is some secret information that you have got that someone is involved in some kind of anti-national activities, even in order to search their home, you require a warrant. Okay, you require a warrant. After taking that warrant, you have to go to their home and then you have to you can start searching the house. But under the Armed Forces Special Powers Act, in places like Jammu and Kashmir, you do not require anyone's warrant. So directly wherever you wish, you can go and you can start searching their houses. So this is special power. Now, when someone comes to your house without your permission, if you start searching your house, so whether it is like a violation of your fundamental right, we can say that right to life and liberty, article number 21 will get violated. Okay. So if you brings a warrant, then it will not be a violation because it is as per the law. If you brings warrant and then if you searches your home, then it will not be violation of article number 21. But without any kind of warrant, directly if he comes and if he starts searching your house, it's like violation of the fundamental right. Now in Jammu and Kashmir, under Armed Forces Special Powers Act, so any army person can go and search in any of the houses without any kind of warrant. So will it be considered as a violation of a fundamental right there? No. Why? Because he is a government servant. The person who is searching, he is a government servant. So Parliament to indemnify whatever he does, it is what exempted. It is excused. It is excused. But if the same army person or police person does in Karnataka, it is not excused. But in Jammu and Kashmir, it is excused. Why? Because there is a special law in Jammu and Kashmir, which is that Armed Forces Special Powers Act. Who has brought this act? Parliament. Okay, Parliament. For any act done by him, whom? Government servant. So any act means he may search the house. Okay, he may search the house. If someone is running and he may, even if he shoots and if the person dies also, such acts can also be indemnified. That can also be excused. Okay, that can also be excused. So that's why there are many protest strikes going on that Armed Forces Special Powers Act has to be removed. Okay, has to be removed. But there are again challenges. In a sensitive area like Jammu and Kashmir, where armed personnel are working, if the armed personnel, if our army personnel, they do not have the freedom, then what happens? Their moral will be, they will be demoralized. They cannot work in such kind of situations. Hence, a special law is required to maintain law and order in such kind of sensitive areas. Okay, sensitive areas. So there are both pros and cons. Okay, there are both the pros and cons of Armed Forces Special Powers Act. But for time being, we will not discuss it. Okay, for time being, we shall focus that whether such laws exist in India. Across India, a common applicable law is not there. But there are few laws which are applicable only to few parts of the country. Example, Armed Forces Special Powers Act. It applies to Jammu and Kashmir and few states in Northeast. Okay, Northeast. So this detailed information is not important. Okay, this detailed information is not important. What is important? Martial law and fundamental rights. So whenever martial law is imposed, a person cannot claim completely his fundamental rights. Okay. So a military person, what he can do? He can do any kind of activity and that can be exempted. Okay, that can be indemnified. That can be indemnified. That can be excused. Parliament can also validate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under the martial law in such area. Okay, so now in a martial, for example, if we take the example of Jammu and Kashmir itself. Okay, Jammu and Kashmir itself. In Jammu and Kashmir, punishment inflict, sentence passed. So a military person will say that he has committed so and so mistake. So sentence is he should be hanged till death. Okay, let's assume military people itself, they'll decide that he should be hanged till death. A punishment inflicted, whatever. So whatever it may be, completely it can be excused by whom? Parliament. Completely it can be exempted. The person who is involved, government servant who is involved, he can be completely exempted of any kind of punishment. So for whatever the things he has done, so he can be completely excused. Okay, completely excused. So concept of martial law has been borrowed from English common law. So where we have taken from British, that is called as English common law. Okay, English common law. So the expression martial law has not been defined anywhere in the Constitution. Okay, so whether the term martial law exists in the Constitution, the term it exists, but definition exists? No, definition is not there. Okay, so it literally means military rule. So martial law means it's a military rule. Okay, military rule. So we have discussed few things, right? The terms exist in the Constitution, but the definition does not exist in the Constitution. So can you recall those terms? Yes. The term judicial review. Okay, it is present in the, it is what? It's not present in the Constitution. So tell me about the words which are present in the Constitution but not defined. Yes. Office of profit. The term is present in the constitution but not defined. Okay, not defined. Here this term is also present in the constitution but not defined. Okay, not defined. So it literally means military rule. Okay, military rule. It refers to a situation where civil administration is run by the military authorities according to their own rules and regulations framed outside the ordinary law. So civil administration, what do we understand by civil administration? Now if we take our place as an example, civil administration means where the road has to be constructed. Okay, so who is responsible for supplying of water? Okay, who is responsible for giving the birth and death certificate? So all these aspects, they come under civil administration. Now all these will be, all these aspects will be run by military authorities now. Now there will be some entity in our place, that is who will issue death and birth certificate, municipality. But tomorrow if it goes under the military control, probably they will decide. So one of the departments of the military will start issuing the birth and death certificates. I am just giving an example. It means the civilian administration is run by military authority. Otherwise, now who is going to be appointed as a district collector or AC of a particular taluk? So it will not be decided by the civilian government like chief minister and all. So the military commander will start deciding who is going to become the DC. So administration will be controlled by military authorities. Okay, military authorities, according to their own rules and regulations. Okay, not important because never a question has been framed. It thus implies suspension of the ordinary law and government by the military tribunals. So whatever the ordinary laws are there in this country, they will be suspended. They will be suspended by military tribunals, that is military courts. Okay, military courts. It is different from the military law that is applicable to the armed forces. Okay. No, just leave it, not important. There is no specific or express provision in the constitution that authorizes the executive to declare martial law. So there has been no clear information in the constitution about how and when the martial law can be declared. Okay, there is no clear information, hence not important. Okay, not important. How it is implicit in Article 34 under which martial law can be declared in any area within the territory of India. Okay, again there is no clarity, not important. No clarity, not important. Martial law is imposed under extraordinary circumstances like war, invasion, insurrection, rebellion, riot or any other violent resistance to law. Again, it is not given in the constitution. So these are the various situations when the martial law can be imposed. So these are all generic things, so you need not remember. So in the examination they are not going to ask during what all situations martial law can be imposed, because it is not explicitly given in the constitution. Okay, hence we are not going to focus on this point as well. Yes. Insurrection means throwing over the present government. Its justification is to repel force by force for maintaining or restoring order in the society. Okay, so some evil forces will be there in the society, so to fight them that military law is required, that will be the justification, again not important. During the operation of the martial law, the military authorities are vested with abnormal powers to take all necessary steps. Okay, so they have, military authorities have more powers, that much is sufficient. Line by line information is not important. They impose restrictions and regulation on the rights of the civilians. So as a civilian, so we will not be enjoying complete rights when military that martial law is imposed. Can punish the civilians and even condemn them to death. Okay, so they can punish, they can even kill the civilians. Supreme Court has held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. Okay, so if a martial law is present in a particular place, so can we issue the writ of habeas corpus or not? So Supreme Court has said that even if there is a martial law, habeas corpus petition has to be accepted and it can be given against the government authority. Okay, but this detailed from PLIM's point of view, they are not going to ask. They never asked. This will be become important from mains point of view. Okay, mains point of view. Otherwise, now in the recent trend, if you look at the past 2 to 3 years, they have been asking about the this writs. So if at all they ask, then you can focus on this point. The rest all the points you can ignore. What is that? So during martial law, whether habeas corpus is suspended, writ of habeas corpus is suspended? No. In the martial law, does not ipso facto result in the suspension of the writ of habeas corpus. Okay, you just ignore about this ipso facto. It's a Latin word. So it does not result in the suspension of the writ of habeas corpus. Means even during martial law, any aggrieved person can go and file a writ of habeas corpus in the Supreme Court and High Court, and they can issue that writ against the government authority. Okay, against the government authority. So based on the present exam trend, you retain this information. Rest all the information you just ignore it. Declaration of martial law under article number 34 is different from the declaration of national emergency under article number 352. Okay. So in the forthcoming classes, we will be discussing about emergency provisions. Okay, we will be discussing about emergency provisions, article number 352, 356 and 360, national emergency. So that emergency topic is very important from exam point of view because repeatedly questions have appeared. So now what we have to understand here is under article number 34 that martial law and emergency provisions, both of them are different, they are not same. Okay, they are not same. Article number 34 and the emergency provisions under article number 352, both of them are not same, they are completely different. They are completely different. Okay, completely different.
Under martial law, all the fundamental rights are
No, there is no clarity whether all the fundamental rights are vanished because in the constitution they have not given clarity of that. So in what all situations you can impose martial law, that clarity also does not exist. But in case of emergency, there is complete clarity. So hence, when they are asking questions also, the focus is on the emergency provisions. So in the past 30 years, in the UPSC, not even a single question they have asked on martial law, not even a single question. From that itself, you will understand that it is not that much relevant or that much important topic from the exam point of view. Otherwise, they would have asked at least one question. But if you look at emergency, in the past 30 years, they have asked around close to 7 to 8 questions. Okay, 7 to 8 questions. So in emergency provisions, there is a detailed provision as to when the fundamental rights will be suspended, what are the reasons to declare national emergency, all those reasons are present. But here they are not given. Okay, here they are not given. So now this national emergency, martial law, this comparison is there, right? Now you will not understand. Why you will not understand? Because we have not yet discussed about the fundamental about national emergency. So now directly we cannot start with national emergency also. So once we complete the topic of national emergency, we shall come back to this martial law. Okay, we shall come back to this martial law and just make a comparison. Okay, make a comparison. We shall only look into the provisions of martial law. For time being, we will ignore the provisions of national emergency. Again, we shall make the comparison later on. So it affects only fundamental rights. Now for time being, you ignore it. Okay, because here center state relations and all are there, but these things you still don't know. Because we will be discussing a topic called as center state relations. After that, we will be discussing a topic called as interstate relations. After that, we will be discussing a topic called as emergency provisions. Okay, emergency provisions. So here, whether martial law impacts the fundamental rights? Yes, but to what extent? Which all fundamental rights? There is no clarity. So at a superficial level, we shall understand whether martial law affects fundamental rights? Yes. Now, they will not frame an extreme statement like the martial law impacts all the fundamental rights. Okay, false. They are not going to make such kind of statement. Okay, they are going to make a simple statement called as it affects fundamental rights. It suspends the government and the ordinary law courts. Yes. Okay, so government means Council of Ministers headed by what? Prime Minister, or Council of Ministers headed by Chief Minister. That government will be suspended. So it will be under the completely rule of military. Okay, military. But such situation will never arise in India. Okay, never arise in India. Hence not important. Okay, hence not important. So if in the examination if they ask you whether the martial law suspends the government, yes. Whether the martial law suspends the ordinary law courts, yes. It is imposed to restore the breakdown of law and order due to any reason. Okay, so whenever a law and order in any place has been broken, to restore it, so they can use what? Martial law. Martial law. It is imposed in some specific area of the country. So what we were discussing? Residence as a condition. So if Karnataka state government it wants to notify saying that for some employment only the residents of Karnataka can apply. So Karnataka government has got this power. So who has given the power? Karnataka state legislature or parliament? Parliament. Okay. So these are some special conditions which can be given only by, special powers can be given by parliament. Courts other than Supreme Court and High Court, empowering them to issue directions, writs, etc. of all kinds for the enforcement of the fundamental rights. So while discussing about the writs, we discussed that presently who can issue writs? Supreme Court can issue writs, High Court can issue writs. Whether District Court, Taluk Court can issue writs? No, they cannot issue writs. But who can give them the power to issue writs? Parliament. Whether state legislature can give the power to District Court and Taluk Court to issue writs? No, only Parliament can give this power. Okay, this is a special case. Next, armed forces, special forces restricting or abrogating the application of fundamental rights. So under article number 33, we saw that the fundamental rights of the armed forces can be restricted. The fundamental rights of the armed forces can be restricted. Who has the power to restrict? Only Parliament. State legislature cannot restrict the rights. Okay, restrict the rights. Next, we also saw under article number 34, indemnifying the government servants or others, act done during martial law. So during martial law, whatever the act he is going to perform, so that will be indemnified, that will be excused. So who has the power? Parliament. Okay, Parliament. Untouchability, laws prescribing punishment for this act. So which article deals with untouchability? 17. So there will be some acts which deal with untouchability, especially Scheduled Caste and Scheduled Tribe Atrocities Prevention Act. It's one act. Okay. So now such act, they cannot be brought by state legislature. They can be brought only by Parliament. Okay, Parliament, very important. Trafficking in human beings and forced labor. So which article deals with it? 23. So laws prescribing punishment for this act. If anyone is involved in trafficking in human beings, if anyone is involved in forcing the others for the forced labor, so there should be some punishment for it. Who can make laws? Parliament. Okay, Parliament. Article 35 extends the competence of the Parliament to make a law on the matter specified above, even though some of those matters may fall within the sphere of the state legislature. This is also very important. So the above matters, few of the matters which we have discussed, even though some of the matters may fall within the state legislature, means 7th schedule, 2nd list. Few of the matters which we have discussed above, they may fall within the 7th schedule, 2nd list. But in spite of that, who can make the laws? Only Parliament can make the laws. Okay, Parliament can make the laws. But to this deeper level, so whatever we have discussed about the article number 35, right? So not even once they have asked a question. Okay, not even once they have asked a question. So even though they are not asked, but while preparing, at least at the superficial level, let's have an understanding. Let's have an understanding. What is that? There are some fundamental rights. There are fundamental rights. So with respect to them, if you want to make any laws, only Parliament can make the laws. So which are those provisions? Yes, which are those provisions? Residence as a condition. Next, untouchability. Next, writ issuing other than Supreme Court and High Court. Next, armed forces restricting of fundamental rights, indemnifying the government servants under article number 34. Next, So the important point to note here is under article number 31, it used to apply to citizen as well as non-citizens. So this is the point which UPSC may focus. So presently, right to property is not a fundamental right, but where it has been included? So we'll discuss here. It has been included in article number 300A, part 12. Okay, part 12. But before that, we shall look into this point. Most controversial and caused confrontations between Supreme Court and the Parliament. Most of the litigation concerned around the obligation of the state to pay compensation for acquisition of or requisition of private property. Okay, so this right to property was the most controversial. Okay, and it led to a lot of confrontation, fight between Parliament and Supreme Court. Okay, so again, this is important from mains point of view, not from prelims point of view. This entire statement, it does not carry that much weightage from the prelims point of view, from the mains point of view. From the prelims point of view, what is important? So originally it was a fundamental right. So originally when it was a fundamental right, it was applicable only to citizens of India or also non-citizens of India. Non-citizens of India as well. Okay, so it led to a lot of confrontation because of the obligation of the state to pay compensation. So why right to property was removed as a fundamental right? I will give an example. Now if you want to construct railways, you require land. Now you want to purchase the land from the private party. Okay, Now if the private party is not ready to give his land, then will you be able to construct the land? Will you be able to construct the railways? No, the railways will never materialize. If all the people who own the land, if they are not ready to sell their land, then railways will never happen. Hence, there was a lot of confrontation, and finally they removed the right to property as a fundamental right. Okay, fundamental right. Next, when it comes to compensation, so when you acquire the land of the private person, then you have to pay the compensation. That compensation related problem also they were facing. So these problems led to a lot of confrontation issues between Supreme Court and Parliament. Okay, between Supreme Court and Parliament. So again, not important. So this is important. 44th Constitutional Amendment of Act of 1978, we already discussed, abolished the right to property as a fundamental right by repealing. It repealed article number 19, article number 31. Okay, so one provision in article number 19 was removed and article number 31 was completely removed. Okay, from part 3. Act inserted new article number 300A in part 12 under the heading right to property. So provided that no person, citizen plus non-citizen, this is very important. So presently, right to property, it applies to citizens as well as non-citizens. When they say no person, it means even a foreigner is covered under it. So sometimes they'll use the term no citizen. It means it applies only to citizens of India. But here the term no person has been used, indicating that it applies to both citizen as well as non-citizen. So presently, right to property under article number 300A in part 12, it applies to both citizen as well as non-citizen. Okay, non-citizen. So shall be deprived of his property except by authority of law. It means you cannot take property from a private member, okay, generally, but you can take the property if there is a proper law to take that property. Okay, means the process which is mentioned in the law. Okay. Thus, right to property still remains a legal right or a constitutional right. So we have discussed about this legal right and constitutional right. So right to property is a constitutional right. It is also called as legal right, though no longer a fundamental right. Okay, though no longer a fundamental right. It is not a part of the basic structure. This is very important. They never ask, but they may ask. So whether right to property is a part of the basic structure? No. Whether the basic structure word is present in the constitution? No. Through which judgment the concept of basic structure evolved? Keshwanand Bharti case. Okay, Keshwanand Bharti case. Next, right to property as a legal right, as distinct from the fundamental rights. How are legal rights different from fundamental rights? Okay, can be regulated without a constitutional amendment by an ordinary law of the Parliament. So if you want to restrict the legal right, constitutional amendment is not required. Just through ordinary law itself, you can restrict the rights. Okay, restrict the rights. It protects private property against executive action, but not against legislative action. This is a very important keyword. This is a very important keyword. What is that? Now, you can take property of others, private property, for the construction of railways, but not based on executive decision. Just Council of Ministers will take a decision saying that let us take the land of so and so person. That cannot happen. But if the Lok Sabha and Rajya Sabha, they will pass a bill saying that for the construction of railways, we can forcefully, the government can forcefully take the land from so and so people, then they can take it. So this is important. So legal right means here, it protects private property against executive action, but not against legislative action. Means just Council of Ministers cannot decide whose land we have to take and how much compensation has to be paid, but it can be decided by legislative action, that is by passing a bill, by Lok Sabha passing a bill, Rajya Sabha passing a bill, and it received by receiving the signature of the President. Okay, President. So this is a very important point to note. Okay, very important point. Next, in case of violation, the aggrieved person cannot directly move the Supreme Court under Article number 32 and Article number 226 to High Court, because it's not a fundamental right. When a fundamental right gets violated, a person can move either directly to Supreme Court or High Court. But in case of the violation of the right to property, as it is not a fundamental right, he cannot directly go to Supreme Court and High Court. He can go to Taluk Court or some other court, and by appeal he can go, but directly he cannot go to Supreme Court and High Court. No guaranteed right of compensation in case of acquisition or requisition of the private property by the state. Okay, if it was a fundamental right, if right to property was a fundamental right, suppose government wants to take my property, whatever I will demand, the government has to pay. But now, whatever the government offers, I have to take. I cannot demand, saying that it is my right. So, no guaranteed right to compensation. So they are going to compensate, but whatever they are going to offer, we have to accept it. Okay, we have to accept it, because right to property is not a fundamental right. Okay, not a fundamental right. Though the fundamental right to property under Article Part 3 has been abolished, Part 3 still carries two provisions which provide for the guaranteed right to compensation in case of acquisition or requisition of the private property by the state. These two cases where compensation has to be paid are when the state acquires the land held by the person or the cultivation within the statutory steering. Okay, you just ignore all these things. Whatever comes here next, you just ignore these things. Okay, just ignore, because it will lead to unnecessary confusion and it is not important from the exam point of view. Okay, now we shall just revisit once again right to property. So which are the important provisions associated with right to property? Which amendment removed it as a fundamental right? 44. Okay, 44th amendment of 1978 removed it. So when they removed it, which were the articles impacted? Article number 19 and article number 31. Next, so the new this amendment added the right to property at in which part? Part 12. Okay, which article was introduced? 300A. Okay, 300A. Now next, the right to property, whether it extends to only citizens or non-citizens as well. Citizens as well as non-citizens. Okay, citizens as well as non-citizens. Now, right to property is a legal right or a constitutional right. So how this right to property, legal right, is different from the fundamental right? We cannot directly go to Supreme Court and High Court. One. Next. So the right to property, it extends against executive actions or legislative action? Only executive action. It does not extend against legislative action. Okay, legislative action. Next, one more last point that we saw. Yes, there is no right to guaranteed compensation. There is no guaranteed compensation. This superficial information is sufficient. Rest all the things which follow here, you just ignore these things. Okay. So while reading, it may appear that these are important, but just you ignore them. I am saying just ignore them. I said that 3 to 4 questions have appeared on right to property, and all these aspects, they are repeatedly focused on the same thing, whether they apply to citizens or not. The same thing they are focusing. So that is the theme, that is the core, that is the crux. So we will not focus on the unnecessary other aspects. Okay, unnecessary other aspects. Okay. Exceptions to fundamental rights. So all these parts just exception to fundamental rights, saving of laws providing for acquisition of estates, etc. Article challenge related grounds, contradiction, laws made here not immune from judicial review. Provision for compensation, validation of certain acts and regulations. So until this point, this second point, right, you completely ignore it. just I'll indicate here. Starting from this point, so in the notes also, exceptions to fundamental rights. Point number A, completely will ignore it. Point number B, completely will ignore it. Okay, completely ignore it. So we'll come to point number 3. Okay, Supreme Court IR Coelho case. Okay, this even name is also not that much important. If you want, you can retain it from the exam point of view, but from mains point of view, but from prelims point of view, not important. But here, few provisions, they are important. Okay, they are important. We have discussed about some schedules. So how many schedules are there in the Constitution? There are 12 schedules. Okay, there are 12 schedules. So which schedule deals with union states and its states and union territories? 1. Next, representation of states in the Rajya Sabha? 4. Scheduled languages? 8 schedule. Next, distribution of powers between the center and the state? 7th schedule. Okay, so various schedules we have seen. Next, anti-defection is dealt by which schedule? 10th schedule. Next, Panchayat Raj? We have not discussed, I guess. 11th schedule. Okay, municipality list, 12th schedule. So one more schedule is 9th schedule. We have not discussed. Okay, we have not discussed. So the 9th schedule, whether initially it was present in the Constitution? No. Initially in the Constitution there were only 8 schedules. In 1950, when we got the Constitution, there were only 8 schedules. Later on, 9th schedule was added, 10th schedule was added, 11th schedule was added, and 12th schedule was added. So in the examination, they asked such kind of questions. During whose tenure 9th schedule was added? Means when the 9th schedule was added, who was the Prime Minister of India? Out of curiosity, they have added. Okay. So at that time, Jawaharlal Nehru was the Prime Minister. When 10th schedule anti-defection law was brought, who was the Prime Minister? Rajiv Gandhi was the Prime Minister. When the 11th schedule was brought and 12 schedules were brought, so P.V. Narasimha Rao was the Prime Minister. So out of curiosity they have asked. Okay, out of curiosity they have asked. So in the 9th schedule, what it says is, we have heard about a concept called as judicial review. What is judicial review? Not articles, it checks the law. Whenever the parliament makes a law, or whenever any of the state legislature makes the law, what the Supreme Court and High Court will do, whether both of them have the power of judicial review? Okay, again we will be discussing in detail once we start discussing about Supreme Court and High Court. But for time being, you shall understand that Supreme Court and High Court both have the power of judicial review. Okay, judicial review. Now, when a law is brought by, let's assume Parliament, okay, an ordinary law. Okay, ordinary law. So this law has to be passed by Lok Sabha. It has to be passed by Rajya Sabha. It has to be passed by It has to be signed by President. After this, someone will file a case in the Supreme Court saying that this law violates the Constitution. It does not adhere to the Constitution. Now the Supreme Court will study whether the complaint that has been made is correct or wrong. It will study and check whether the law violates the Constitution or not. That process of studying, okay, the process of evaluating whether the law brought by the Parliament violates the Constitution or not, this process is called as judicial review. This process is called as judicial review. Okay, judicial review. Now, whether all the laws brought by the Parliament can be subjected to judicial review? Yes, all the laws can be subjected to judicial review. Okay, even including the constitutional amendments. We have seen the previous topic. Even the constitutional amendments, they can be subjected to judicial review. Because in Keshavanand Bharati case, what they have said? Even constitutional amendments which alter the basic feature of the Constitution, that has to be declared as null and void. Okay, null and void. So all the laws brought by the Parliament can be subjected to judicial review. It means any person of this country can file a case against the government saying that the law brought by the government is violating the Constitution. Okay. Even when the Parliament amends the Constitution, such amendment can also be challenged in the Supreme Court saying that it violates the Constitution. It violates the Constitution. From this, what we understand? Any law which has been brought by the Parliament can be challenged in Supreme Court and High Court. Okay, can be challenged in Supreme Court and High Court. But at one point of time, government was facing lot of problem because every law was being challenged in the Supreme Court and High Court. So they brought a 9th schedule. In the 9th schedule, they started adding few laws. For example, Marriage Act 1971, 2, Education Act 1963, and so on. Just I have taken two imaginary acts, Marriage Act and Education Act. Apart from this, I will take two more acts. One is Corruption Act 1975. Next, 2, Agriculture Act 1965. Okay. So we are seeing two lists. One list consists of Corruption Act, Agriculture Act. Another list consists of Marriage Act and Education Act. So these two acts are in 9th schedule. So these two acts are not present in 9th schedule. So government introduced a special schedule called as 9th schedule. Parliament, by constitutional amendment, it brought a special schedule called as 9th schedule, and it said that whichever law is placed under 9th schedule, it cannot be subjected to judicial review. Parliament said that whichever law, now suppose if I want to indicate that Corruption Act should not be subjected to judicial review, means Supreme Court, High Court should not study it and declare it as invalid and all. So what I will do, I will place this law in the 9th schedule. Okay. So special provision was made, a 9th schedule was brought. So whichever law, if the government thinks should not be challenged in the court, so they place that law in the 9th schedule. Okay, place that law in the 9th schedule. So now what the government can do, what Parliament can do, it can place all the laws in the 9th schedule. So again, this case it went to Supreme Court. Okay, this case it went to Supreme Court. So no blanket immunity from the judicial review of laws included in the 9th schedule. Laws placed under 9th schedule after April 24, 1973 are open to challenge if they violate fundamental rights guaranteed under Article 14, 15, 19 and 21 or the basic structure of the Constitution. So in IR Coelho case, what the Supreme Court said? No blanket, means you cannot say that none of the laws placed here can be exempted from the judicial review. If there is any law here which violates Article number 14 or 15 or 19 or 21 or basic structure of the Constitution, such a law can be subjected to judicial review. Okay. And also they placed a condition. What is the condition? All the laws which are placed under 9th schedule after April 24, 1973. After April 24, 1973. Why April 24, 1973? Because on that day, Keshwanand Bharati judgment came. Now, if 1960, for example, whether these two laws can be challenged? Education Act, it cannot be challenged because it has been placed before 1973. It cannot be challenged. Now, if I bring a new law, Corruption Act 1975, can it be challenged? Yes, because it has been brought after April 24, 1973. Okay, April 24, 1973. So here we shall once again revisit the things. So what is 9th schedule? Any laws which are placed in the 9th schedule, they are exempted from the process of judicial review. Judicial review does not apply to it. Okay, does not apply to it. But this was overturned by which judgment? No. IR Coelho case. In the IR Coelho case, what the Supreme Court said? No, there is no blanket ban. There are some laws within the 9th schedule which can be subjected to judicial review. There are some laws in the 9th schedule which can be subjected to judicial review. Which are those laws? The laws which violate Article number 14, 15, 19, 21 or the laws which violate the basic structure of the Constitution. Okay, basic structure of the Constitution. And that too which laws? The laws which have been placed in the 9th schedule after April 24, 1973. After April 24, 1973. Okay, 1973. So this is an important aspect that you have to remember. Now, you did not focus specifically like Article number 14, 15, 19 and 21. Not important. Just understand that if a law placed in the 9th schedule, after April 24, 1973, okay, a law placed in the 9th schedule after April 24, 1973 can be subjected to judicial review. And can be declared as invalid by the Supreme Court and High Court if it violates the fundamental rights or if it alters the basic structure. Okay, if it alters the basic structure. Okay, we shall revisit the same point. Any law placed in the 9th schedule after April 24, 1973 can be subjected to judicial review, and after subjecting it to judicial review, the Supreme Court and High Court can declare such a law as invalid if it violates the fundamental rights or if it alters the basic structure. Okay, alters the basic structure. So this decision was given in which judgment? IR Coelho case. Okay, Coelho case. Why they have taken April 24, 1973 as the base? That is the date when the Keshwanand Bharati judgment we got. Okay, Keshwanand Bharati judgment we got, and that is the judgment where the concept of basic structure evolved. Okay, concept of basic structure evolved. So this is very important. See here. Now so much of information we have eliminated. I asked you to what? Just ignore all these things. I asked you to ignore 1 and 2, but this one is very important. You have to focus. So this is called as understanding the demand of the examination. So when we prepare by understanding the demand of the examination, what happens? Automatically the unwanted information, it will get reduced, and repeatedly our focus will be on the important aspects. This will boost our confidence. Okay, this will boost our confidence. Now see, these are complex things. Line by line is not important. The final, whatever the present condition is there, that is important. Okay, but whatever the present condition is there, for that to understand, we need to go to that basics itself. But this is important. Okay, what is it? What is it important? We'll just look into it. But line by line is not important. The final conclusion is important. So, Article number 31C not important. 25th Constitutional Amendment Act of 1971. This is also not important. So this 25th Constitutional Amendment Act 1971, what it said is, laws that seek to implement socialistic directive principles of state policy specified in Article number 39B or C shall not be void on grounds of contravention of Article number 14 and 19. So what does Article number 39 deal with? Article number 39, right to adequate means of livelihood. Next, the operation of the economic system should not result in the means of concentration to the common detrimental. Can you recall those points? DPSPs. Okay. Now, if you are implementing DPSP, just let's take an example. Okay. Let's take an example. So, adequate means of livelihood. Now, adequate means of livelihood. So article number 39 speaks of that. Adequate means of livelihood. All the people should get what? A good means of livelihood. Okay, good means of livelihood. So now if the government brings a scheme to provide adequate means of livelihood, can you give me an example of a scheme? Manarega. We have come across Manarega scheme. Okay, Manarega scheme. Now when you bring Manarega scheme, the Manarega scheme, whether it will be applicable to all the rich person or only people below the poverty line? Only people who are below the poverty line. So when you bring such kind of scheme, whether it violates article number 14? It violates article number 14, that is right to equality. Okay, right to equality. So this 25th Constitutional Amendment, what it said is, whenever a law is implementing socialistic directive principles, and if it violates the fundamental right, okay, it shall not be declared as void. It means this Manarega is a law. Let's assume this is a law. Now this law, it gives shape to which article? Article number 39. It implements directive principles of state policy present under article number 39. But because of this Manarega, which article it violates? It violates article number 14. We shall take article number 14. So, as the Manarega violates article number 14, fundamental rights. So, generally when a law violates fundamental rights, what we will do? We will declare it as null and void. It will declare it as unconstitutional. But in this case, we should not declare it as unconstitutional. Why? Because it is implementing DPSPs. Which DPSP? DPSP present under article number 39. Okay, 39. So this provision was brought by 25th constitutional amendment. But this is not important. Then why we are discussing? Because we want to go to the final point. To understand that final point, this is important. Next, provision 2. This 25th Constitutional Amendment Act, it brought two provisions. This is the first provision. Second provision said, such laws shall not be questioned in any court. It means this Manarega Act, it should not be challenged in any court. Okay, it cannot be taken to Supreme Court or High Court. So this was the second provision. So next, what happened? In Keshwanand Bharti case, declared second provision as unconstitutional. So we discussed two provisions as per the 25th Constitutional Amendment Act. Which was the first provision? Whenever you implement a DPSP, whenever you bring a law to implement DPSP, if that law violates fundamental right, then such law should not be considered as unconstitutional. First one. Second one is, no such law should be challenged in any court. So in Keshwanand Bharti case, it upheld the first provision. It said the first provision is correct. It's correct. But the second provision, you said that it cannot be challenged in the court. That is wrong. So they said declared second provision is unconstitutional because judicial review is a basic feature. In Keshwanand Bharti case, they said that you cannot take away the power of judicial review from the Supreme Court and High Court because the judicial review is a basic feature. So now which one is valid? First point is valid or second point is valid? Only first point is valid. Second point is not valid because any law can be challenged in the court. Now this Keshwanand Bharti is also not important here. The provision is important. The provision is important. The 42nd Constitutional Amendment, what it said is, scope of article number 31C extended to any law to implement any DPSP. Okay. So there they said that to implement only the DPSPs present in article number 39. But in 42nd Amendment Act, they said that it extends to implementation of any of the DPSPs. So Minerva Mills case, this extension declared as unconstitutional and invalid. So in Minerva Mills case said that extension is invalid. It means what is the final conclusion? Now presently, when you are bringing a law to implement a DPSP, to implement which DPSP you can bring the law? To implement all the DPSPs you can bring the law. Okay. But implementation of which DPSP cannot be challenged in the court by saying that it violates the fundamental rights? 39. Okay. Implementation of article number 39, for that whatever the law you bring, that cannot be challenged in the court saying that it violates the fundamental rights. Okay, fundamental rights. So even after this discussion also, you will not gain complete picture. There will be some confusions which will prevail. So it will take its own course of time. Okay, it will take its own course of time. So when you go back, again you read this once again. Okay, again if there are any confusions, you can come back to me, we shall have a discussion. But here what we'll understand here is, starting from this point, C, okay, C, so this line by line thing is not important. Only we shall understand that to implement the DPSPs, government will bring laws. To implement DPSPs, government can bring laws. But specifically when the government will bring a law to implement article number 39, okay, 39, and if such a law violates the fundamental rights, then such a law should not be declared as unconstitutional because it is implementing the provisions of article number 39. Okay, 39. So on this aspect itself you will focus, rest all the things you will ignore. Okay. In the mains you can quote the various cases like Minerva Mills case and all, but from the prelims point of view it's not important. Okay, not important. Next, while discussing about the DPSPs, we have not completed the discussion. I said that after discussion of the fundamental rights, we shall come back to DPSPs. Okay, because once you understand about the DPSP and fundamental rights, then the comparison and discussion will be much more healthier and we'll be able to comprehend. Again, we shall go back to the DPSPs because we already completed with the discussion of fundamental rights. So, criticism of fundamental rights. Okay, so these are important from mains point of view. You can quote here. From prelims point of view, not important. Excessive limitations. There are a lot of limitations. Okay, so fundamental rights impose limitations on whom? Executive or legislative? Both. Fundamental rights impose the restrictions on both the executive power as well as the legislative power. No social and economic rights. Okay, so again you can quote, not important. No clarity, no permanency. So none of the fundamental rights are permanent. They can be changed. Suspension during emergency. So we'll start discussing about emergency later on. Expensive remedy. So we say that we can go to Supreme Court and High Court, but it's not that much easier. Okay, it costs too much. So expensive remedy. Preventive detention. So some of the other nations, they do not have a provision of preventive detention, but in India we have provision of preventive detention. So we discussed about preventive detention under which article? Article number 22. Okay, 22. Next, no consistent philosophy. Okay, so none of these are important. You can just ignore them at time of mains. So gradually over a period of time, some information or some knowledge which will be built, based upon that you can answer the mains questions. So you need not focus you need not memorize these points. Okay, you need not memorize these points. So significance of fundamental rights. So in book they have mentioned the importance of fundamental rights. So again, not important. Okay, so the importance of the fundamental rights from a mains point of view, it is relevant. So what you can do? So selectively you can, based on the current affairs and all, we can write the importance of fundamental rights. So here, whatever is there in the book is not important. Okay, so hence I have included it as question mark and not important. Okay. Rights outside part 3. So there are some rights which are present in the constitution but not as part of the part 3, that is fundamental rights. So they are called as right outside part 3. So known as constitutional rights or legal rights or non-fundamental rights. Can you recall one such right? Right to property. Okay, right to property. So no tax shall be levied or collected except by authority of law. So article number 265 part 12, not important. Okay, not important. So it means if you want to collect a tax from anyone in this country, then there should be a law for that. The law should indicate that from whom you should collect the tax and how much you should collect the tax. So without the law, you cannot collect a tax. Okay, without law, you cannot collect tax. It's also a fundamental right, but which is present outside the part 3. Where it is present, not important. So the same is repeating. No person, citizen plus non-citizen, shall be deprived of his property save by authority of law. Which article? 300A. Okay. Trade, commerce and intercourse throughout the territory of India shall be free. So again, we will be discussing about this provision in interstate relations. Okay, interstate relations. So 301 part 13, not important. So it means trade, commerce and intercourse throughout the territory of India shall be free. For example, if you are selling some goods from Karnataka to Maharashtra, so Maharashtra should not impose any kind of extra tax to the good which is coming from Karnataka. That is what? That is the meaning of free. No extra taxes. They are also justiciable. Now fundamental rights, whether they are justiciable? Yes, fundamental rights are justiciable. DPSPs? Preamble? Fundamental duties? No, fundamental rights are justiciable. So similar to fundamental rights which we have discussed, so whatever the rights we discussed here, so these are also justiciable. If these rights are violated, a person can go and file a case in the Supreme Court and High Court. Okay, High Court. Difference between fundamental rights and these rights. Violation of fundamental rights, aggrieved person can directly move Supreme Court under article number 332 or High Court. But for the violation of these rights which we discussed now, a person cannot directly go to Supreme Court. Cannot directly go to Supreme Court. Can move High Court through ordinary suit or under article number 226 with respect writ jurisdiction of High Court. See here. When these above rights get violated, which can you recall those rights? Territory of India free. Next. Right to property. So when these rights get violated, you cannot directly go to Supreme Court, but you can go to High Court. Why? The writ jurisdiction of whose is wider, Supreme Court or High Court? High Court's writ jurisdiction is wider. So you can go to High Court, but directly cannot go to Supreme Court. Okay, Supreme Court. Okay, Supreme Court. So with this provision, we have come to a conclusion of the topic called as fundamental rights. Okay, fundamental rights. So the last part, for example, whatever we have discussed here. So here repeatedly the focus has been on right to property. So they have never asked about the rights available outside fundamental rights, part 3. If at all they have asked, they have repeatedly focused on right to property itself. So at the time of examination, you can just indicate here, so this entire part, it enjoys less priority. Why? Because already right to property we have discussed at some other point. At time of examination, when you do not have sufficient time to go through each and every point, you can mention here that it enjoys less priority. Okay, less priority. So these things you just focus, because it's a basic understanding. So apart from the fundamental rights, if any other legal right or constitutional right, it gets violated, a person cannot directly go to Supreme Court, but he can go to High Court, because the writ jurisdiction of High Court is wider than that of Supreme Court. Okay, wider than that of Supreme Court. So with this discussion, we have concluded with the topic of fundamental rights. Okay, fundamental rights. So if you have any kind of doubts, you can raise with respect to discussions that we had till now. Okay, and also you just go through the content, and also if possible, you go through the Lakshmikant book also. Wherever I have mentioned points as not important, now itself you start marking it, because at the time of examination you should not get confused. What to focus, what to ignore. Okay, what to ignore. So we shall take a break for 10-15 minutes, and after that we shall begin. So we already discussed about directive principles of state policy, and also we have discussed about fundamental rights as well. So as we have discussed both fundamental rights and directive principles of state policy, now it will be very easy for us to make the comparison. So this part which we had skipped while discussing about the directive principles of state policy, so we'll come back to this part. Okay, this is not part of the fundamental rights topic, so this is part of the fundamental rights and DPSP. So if you refer the DPSP related notes, so there this content is present. Okay, here the content is present. So few of the things which we have already discussed, again we'll be repeating here. So fundamental rights, they are justiciable. DPSP, non-justiciable. It means if the fundamental rights are not implemented, then you can file a case against the government. But if the DPSPs are not implemented, you cannot file a case against the government. Okay, you cannot file a case against the government. Now, if there is a conflict between fundamental right and DPSP, now we took an example, right? So, for example, equal justice and free legal aid, article number 39A. Okay, it means you should hire some lawyers for the people who cannot afford a lawyer. Okay, afford a lawyer. Now, you are implementing a DPSP. You are implementing article number 39A. Let's assume you are making a provision wherein you will be hiring the lawyers for the poor people. But it violates article, which article it will violate? Article number 14, right to equality, because all the citizens of this country should be treated equally. Now, a provision which is implementing the DPSP is violating the fundamental rights. Now, which one should get priority? Fundamental rights should get priority, or directive principle of state policy should get priority? Okay, so that we cannot decide it. Supreme Court will decide. So Supreme Court, the various cases have gone to Supreme Court, and Supreme Court has given judgments. About those judgments we will be discussing. So the first such case is Champakam Dorai Ranjan case 1951. Okay, 1951. Okay, even in the mains also this much detailed information is not required. Ultimately, what is the final conclusion, that is important. But anyhow, we will also discuss about its history as well. So in this case, conflict, whenever there is a conflict between fundamental rights and DPSP, so in Champakam Dorai Ranjan case, Supreme Court said that fundamental right should prevail. Means as per this judgment, which one is supreme? Fundamental rights or DPSP? Fundamental right. Okay, fundamental right. It means that law has to be declared as invalid, and you should uphold the fundamental right. DPSP has to conform and run as a subsidiary to fundamental rights. So in this judgment they said that, which is subsidiary to whom? Directive principles of state policy, they are subsidiary to whom? Fundamental rights. Okay, fundamental rights. However, fundamental rights could be amended by parliament. So they said fundamental rights can be amended. Okay, fundamental rights can be amended, but DPSPs, they should run as a subsidiary to fundamental rights. So amendments to implement DPSPs. So what the parliament did is, it wanted to implement DPSPs. So hence it started amending the what? It's brought some amendments. First amendment, fourth amendment, seventh amendment. So none of these amendments are important. You need not focus on them. Okay, you need not focus on them. Golaknath case. So the first case, which was the case? Rajat case. So what did the Supreme Court say? In case of conflict between fundamental rights and DPSPs, which one will prevail? Fundamental rights. हाँ है इसमें. Yes, yes. Yes, ma'am.
मुझे है ना यहाँ पे ट्रेडिंग का कुछ बोर्ड लगा था, वो कहाँ है?
वन ऑफ माई फ्रेंड रन करते हैं उसको. मैं बाद में आपको कॉन्टैक्ट नंबर दूंगा उनका. हाँ, ट्रेडिंग के बारे में सीखना था. ओके ओके, मैं उनका कॉन्टैक्ट, उसका ऊपर नंबर होगा, देखो शायद कॉल कीजिए. हाँ, उसी नंबर को कॉल कीजिए. हाँ, ये IAS का क्लासेस चल रहा है, लेकिन वो यहीं पे आते हैं, क्लास यहीं पे लेते हैं कभी कभी, तो उनको कॉल कीजिए एक बार. क्या मैडम? राजेश बिरादर. हाँ, बोल दो. So the previous case what we saw, which is supreme, fundamental rights are supreme. But if you want to implement DPSP, okay, it is a subsidiary, somewhere DPSP is subordinate to fundamental rights. In that sense we can take. So if you want to implement DPSP, what you will do? You will first change the fundamental right itself. So if you want to implement DPSP, you are violating fundamental right. Okay, let's assume you are violating article number 14. I will remove this article number 14 itself. Then you can implement DPSP, because it will not violate any of the fundamental right. So this was the judgment given in that particular case. Okay, which one is supreme? Fundamental right is supreme. Okay, but if the fundamental right is becoming a bottleneck to implement DPSP, so what you can do? You can amend the fundamental right itself. You can amend the fundamental rights. So that was given in the first case. In Golaknath case, they said fundamental rights cannot be amended for implementing directive principles of state policy. Okay, just to implement directive principles of state policy, you cannot amend fundamental rights. Okay, amend fundamental rights. So this is the process that we are going through. Each and every line is not important. Final judgment, what is the present situation, that is important. But just we shall go through the basics. So 24th Constitutional Amendment Act 1971, Parliament has the power to abridge fundamental rights by Constitutional Amendment Act. Then Parliament, it brought a Constitutional Amendment Act. It said that we, Parliament, have the power to abridge, means to take away the fundamental rights. To take away the fundamental rights. 25th Constitutional Amendment Act 1971. So we discussed, right? While discussing about fundamental rights. What was that? Law to implement socialistic DP is in article number 39B and C. Not void on grounds of violation of article number 14, 19 or 31. So previously we were discussing about fundamental rights we discussed. Such a law cannot be challenged in court. In Keshavanand Bharati case, what they said? First one is correct. Second one is unconstitutional, because judicial review is the basic feature of the constitution. Next, again in 42nd amendment, provision 1 extended to any law to implement any DPSPs according to legal primacy and supremacy to DPSPs over fundamental rights. So in 42nd amendment we said DPSP has supremacy over fundamental rights. Okay, fundamental rights. Next, 44th Constitutional Amendment, right to property was abolished. Minerva Mills case, provision 1 extended by 42nd Constitutional Amendment held unconstitutional and invalid. Already we have discussed. DPSP is again made subordinate to fundamental rights. But fundamental rights conferred by article number 14 and article number 19 were accepted as subordinate to DPs in 39B and C. Indian constitution is founded on the bedrock of the balance between the fundamental rights and DPSPs. So whatever we have discussed until this point is not important. This is understanding the demand of the examination. Majority of the aspirants, what happens, they will get stuck there itself. Which one is supreme? What is present condition, that is important. So this is important for exam point of view. Okay, so whatever the judgments we discussed, which are the judgments? Okay, Champakam Dorai Ranjan case. Next, Golaknath case. 24th, 25th amendments, Keshwanand Bharati case, 42nd constitutional amendment. So 44th constitutional amendment, Supreme Court Minerva Mills case. None of this is important. Now, majority of the aspirants, they will be stuck here itself. They will not be able to make progress. They will not be able to make progress. So I am saying very confidently that whatever we have discussed until this point, you just ignore it. Now, whatever is present here, this is important from exam point of view. In the mains, if you want, you can quote those judgments, not detailed provisions. You can quote those judgments, but every line is not important. But ultimately, this final is important. What is final? Fundamental rights enjoy supremacy over DPSPs. So who are supreme? Fundamental rights or DPSPs? Fundamental rights. Yet, Parliament can amend fundamental rights for implementing the directive principles of state policy. And also at the same time, Parliament can what? It can amend the fundamental rights. Okay, amend the fundamental rights for implementing the directive principles of state policy. And top of that, look at this. So long as it does not impact the basic structure. Okay, so these 3 points are important. What is that? So which one is supreme? Fundamental rights or DPSP? Fundamental right. Whether Parliament can amend fundamental rights for the implementation of DPSPs? Yes. So while amending the fundamental rights for the implementation of the DPSPs, can Parliament alter the basic structure? No. So whatever amendments it is bringing to the fundamental rights to implement the directive principles of state policy, it should ensure that it does not alter the basic structure. So in which article of the Constitution is the term basic structure present? Nowhere. So nowhere in the Constitution we have the term called as basic structure. Through which judgment the concept came? Keshwanand Bharati case. Okay, Keshwanand Bharati case. So this provision is important. So whenever there is a conflict between fundamental rights and directive principles of state policy, okay, directive principles of state policy and fundamental rights. So can you amend the fundamental rights? Yes, you can amend the fundamental rights. But between fundamental rights and DPSP, which one is supreme? Fundamental rights is supreme. When you are amending the fundamental rights to implement the DPSP, can it be challenged in court? Yes, it can be challenged in court. So can the court invalidate it? Yes, if it violates the basic structure. If it does not violate the basic structure, then it will not be invalidated. Okay, invalidated. So this is the crux. Okay, this is the crux of comparison between DPSP and fundamental rights. So all the 44th, second amendment, 24th, 25th amendment, none of them are important. Okay, none of them are important. The detailed line by line provision, Minerva Mills case, all those detailed line by line things are not important even from the mains point of view also. In mains also hardly 1 or 2 lines you will be quoting. So this much detailed information is not important. Okay, not important. So with this we have concluded the comparison between fundamental rights as well as directive principles of state policy as well. Okay, state policy as well.